Hi everyone, welcome to Immigration and Jobs Talk Show. I'm Rajni Bharara, your host, and before I move ahead, let me read out this very important disclaimer by watching our videos. You agree and understand that the information provided by our attorneys and guests, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, after this important disclaimer, welcome back everyone to Immigration and Jobs Talk Show. I'm your host Rajni Bharara, and today we are here to unpack the ever-changing world of immigration with expert insights and a lively discussion. Whether you're navigating the complex maze of visas or just curious about immigration trends, you have come to the right place. Today's topic: EB2 NIW visas. Are USCIS making it harder to get it approved in 2024? Buckle up because we are diving deep into this hot button issue. And trust me, we have got the dream team to break it down. Yes, but first, let's give a warm welcome to our wonderful audience, whether you're watching us live or catching the replay. Thank you for tuning in. Be sure to stick around because this episode is packed with valuable insights and maybe a sprinkle of humor too. And don't forget to drop your questions in the comments. And yes, after we get answers from our dream team, we will be asking your questions to them. So now, without any further ado, let's meet the dream team, our incredible guest for today's show. First up, we have Rob Melvin, a 26-year veteran in the legal arena and a licensed attorney by the Texas Supreme Court. Rob's journey has taken him from litigating in Texas courts to serving as a Foreign Service Officer for the U.S. Department of State, where he held consular commissions under 3 U.S. presidents and adjudicated over 9,000 visas. From diplomatic scrutiny trainings to managing high-profile visits from the likes of Hillary Clinton and Mike Pompeo, Rob has done it all. Today, he's a powerhouse in employment, business, and investment-based immigration. So, Rob, welcome to the show.
Happy to be here. Thank you for the invite. And we're humbled to be on your show and thankful for the opportunity.
Of course, it's a pleasure having you on the show. And after Rob, everyone, let's meet our second guest, Philip Rodriguez, who might just be the Clark Kent to Rob's Bruce Wayne. Philip is a partner at Dos Rodriguez, PLLC, and brings 13 years of stellar experience to the table. He's represented clients globally, tackling everything from family-based petitions to removal proceedings with finesse. With a Juris Doctor from St. Mary's University and a knack for delivering personalized legal solutions, Philip is a force to be reckoned with. Philip, we are so glad to have you here. Thank you so much for joining us today.
Yes, thank you very much, Rajni. It's a pleasure to be here.
Well, thank you so much to Rob and Philip. And guys, let's get into today's topic. The topic, like I said, is the EB2 NIW visas. Yes, EB2 National Interest Waiver visas. With the USCIS rolling out the new guidelines, are these coveted visas becoming harder to secure? Are we entering a new era of red tape? Or is this just a bump in the road? Let's find it out from Rob and Philip. So now, without any further ado, Rob, I would like to come to you first. You know, while I was introducing you, you have this 26 years of experience. I might have accidentally called you a 26-year-old, which you also look like, the both of you.
My
but Rob, also I would like to know from you, recently the US presidential elections results were out and the Trump is back with his very aggressive team and his administration, because every day he's giving us a shocker with picking those controversial candidates and making it harder for immigrants to actually think that is it going to be possible for them to get into the US now, or is it going to be more difficult? How is the situation going to be? So it's so chaotic and it's all over the place right now. So were you happy with the results? Let's first come to you and then we can see how Philip felt about it.
Okay, well, I mean, to my knowledge, I don't consider this bad news at all, especially for Indian nationals. It may be bad news for people from the Western Hemisphere that have come over irregularly, because I could see removal practices being very more difficult. But there's some things that I think that maybe your audience should keep an eye. I mean, listen, there's 3 people close to Trump now that have his ear and will have it regularly. You have the second lady, Usha Vance. You got Vivek Ramaswamy, and then you have Kash Patel. All 3 of those people are going to be talking to him every day. And believe me, they've been in the U.S. for a long time. They know the plight of the Indian retrogressed visas and the problems that people have been having coming from India to here. As for like the comment on the adjudications becoming more difficult, we've actually seen in our practice, 2023 was the dream years. Those were the golden years for the EB2 NIW. We were shooting 3-point shots, getting approval without a lot of pushback. 2024 actually turned into a bit of a quagmire. That I don't know what happened. I don't know if USCIS was pushing back against the administration because of all of the irregular immigration coming in, maybe as kind of I don't know, retribution, if you will. But we have seen in 2024 more pushback, more stringent, more new requirements, almost pre-Danisar analysis to the EB2 NIW than we did in 2023. So I have high hopes for 2025 for the Indian national population. They're some of the smartest applicants that we have, the most highly educated, the most qualified. And I mean, in my opinion, everybody's got an opinion. I think Trump and his team are going to be looking for people of that caliber that are going to come in and kind of lift the boat of the U.S. economy with especially STEM, financial investment, those types of visas coming in. So I'm actually super hopeful that 2024 will go away for the EB2 NIWs because it's been a rough year. And that 2025, once things start rolling, we're going to see a better improvement. Again, that's if USCIS, each agency kind of has its own culture, does its own thing. I worked for state under Trump. They pretty much ignored Trump and just kept doing their own thing. I mean, of course, they had to do some policy and economic and political moves that he made them do. But I was in the consular section, and they just kind of, they're like, yeah, whatever. So I don't know. I don't know if that is too much information or answers the question, but I think that we're going to see, I hope that we're going to see an improvement, especially in the fields of STEM and cases where we can make a really good argument that addressing a very specific national interest for the United States.
Philip, what about you? Because, I mean, Rob said that it's going to be, with Trump coming back with his team, it's going to be good for the market and good for the economy. And, we have seen that Trump is already talking about putting those percentage of tariffs on those countries, especially Canada. And, recently Canada's Prime Minister Justin Trudeau, he met President Trump, and he actually joked with him for becoming, Canada becoming the 51st state of and merging into the US. And he said, you are more than welcome to become, you will not be the Prime Minister, but then you can become the governor of the 51st state. How about that? So, he has really scared Canada. And, there are talks about putting 100% tariffs on the BRICS countries if they think about, getting another, if they are getting those, instead of, if they will give priority to some other, anything else apart from dollar. So what do you think? Because, there are so many talks about that. So how do you see? Do you think it's going to be good?
Well, yeah, I agree with Rob in terms of the EB2 NIW visa, right? Because that visa is for people who can show that their work is in the national interest of the United States. And touching on what Rob mentioned, how we have seen, so under a Trump administration, we may see a stricter interpretation of USCIS policies, but I don't necessarily think that that's because it's the Trump administration. If we go back, let's think about DANISAR, which is the guiding framework for an EB2 NIW petition. DANISAR became law in 2016 under Barack Obama. And since then, and think about that, 2016, that's only 8 years ago. So that framework hasn't been in effect for very long. Prior to DANISAR, we had a much stricter framework for EB2 NIW under the New York State Department of Transportation, and that went into effect, I believe it was 1998. But the point is, we may see stricter interpretations of USCIS policies under Trump. I don't necessarily think it's a function of Trump. I think we'll get into this a little bit later, but I think it's more a function of the fact that a lot of people are learning about EB2 NIW now, and a lot of people are filing those types of applications. It's become highly competitive, and that is why USCIS has to do a better job of sifting through all of these applications and finding out which ones are truly in the national interest of the United States. And I think what we're probably going to see is the industries that will be favored under a Trump administration are going to be manufacturing, I think national security, and I think technology, which may not be good news for those who would like to apply under the humanities or the arts. They may have higher hurdles to jump.
Okay. Well, thank you so much to the both of you for that amazing answer, and also for sharing your point of view. But with this, Philip, I would also like to know from you that what do you think? Do you think that USCIS gets influenced by who takes the office? Let's suppose, because earlier it was the Biden administration and now it's going to be Trump administration. So do you think they make plans and they make the policy changes or whatever updates that they give in? It somewhere gets influenced by who takes the office?
I think the leadership does have an effect on policy directives and adjudication standards. However, I don't think it's necessarily going to be a complete shift, right? I mean, USCIS is a relatively large organization. It has its own culture, right? So because a new leader comes into office who may have a differing opinion on policy, sure. I think it is fair to say that might influence some adjudication standards. However, I don't think that it's necessarily going to just make it impossible for people applying for EB2 and IW. As I mentioned, what we may see is a shift in the industries that are favored by this administration, because it's no surprise. Trump and his team have come out and said that they want manufacturing in the U.S., technology, and national security. And so I think we may just see a shift in the types of industries that are favored. Would you agree?
Rob, what about you? What do you think?
Definitely. I mean, it does depend who's put in charge of DHS, and then it flows down from there. And then they'll have the director of USCIS and the deputy director, and they will push downwards. But I've been inside the belly of the beast. I work for state, and I know they do have their own corporate cultures. I think, in my opinion, they're going to be more in line with, if these predictions are right, with the emphasis of Trump and his team continuing to be on manufacturing, tech, STEM, anything like that. I think it will influence the adjudicators in favor of pleasing their bosses. These people are all bureaucrats. I was a bureaucrat, right? So what's the one big fear to a bureaucrat? It's your career. And what is that? That's your review at the end of the year, okay? these are all civil servants. In fact, they're all graded on a G scale, which means you don't just get promoted. You actually have to, if you want a higher, better job, you want more pay, you have to apply for a higher scale, a GS 14 instead of a 13, right? Mm-hmm. So the only way that they're going to do that is they're going to have to show that they have a track record of pleasing their bosses. If their bosses are telling them, look, Trump says X, we need to go in this direction, and that's the order they're getting from the top, they're going to need to move that way if they want to eventually secure a higher level government service job and keep continuing on. There's some that'll be perfectly happily being a GS-12 and couldn't care less and just want to draw their check, do their 40 hours and build their pension, right? Mm-hmm. But there's some go-getters, and the hustlers are going to want to see, they're going to want to comply. So I think it's going to be a great year for EB2 and IW. 2024 has been a challenge for us in our practice, and I know it's not specific to us because we're members of ALA, and we have our distros with thousands of immigration attorneys all over the United States, and we constantly keep an eye on it because it's one of our areas of emphasis is employment, business, and investment, immigration. So we really keep a close eye. And I think it's going to influence them. Yes, I think there's a misperception that it has as much influence as it actually does, but that's just my experience in working for state. And I have a lot of friends at USCIS and DHS, so I kind of keep my thumb on that pulse as well.
Okay. So, but then, Rob, when you say influence, do you think that influence is going to be good or is it going to be bad?
I think for the Indian national community, it's going to be fantastic. Mm-hmm. It's one of the smarter applicant pools, one of the more ambitious applicant pools or countries, and just more qualified, and they're more hustlers. I mean, they just are go-getters. And I think that's going to be what the policy that they're going to want to be pushing downstream at DHS, down to USCIS and everybody else, to the adjudicators, is look, we're kind of changing the way we look at immigration. We want to do, as you've mentioned before, kind of a merit-based system. The family system will always be there, but they want to improve our economy. And the only way to really do that is to do a brain drain away from other countries. And India's got plenty of brain drain power to provide to the U.S. I think it's going to be good for India.
Okay. But then what do you think about the visa? I've still not delved into our questions that actually we have prepared for you, but I'm still coming up with the follow-ups. But then I would like to know from you, Rob and Philip, that then what about the wait times that India actually sees, from whenever the visa bulletin comes, the processing times and the wait times for India specifically are very long. So why do you think that happens? Philip, I would like to start from you.
Well, the reason you see these retrogressed visas and the wait times is because of the per country caps on green cards. It's a 7% cap on green cards from any country, and you have a lot of applicants from India. 7%, I believe that works out to around 9,000 visas, 9,500, something like that per year. Mm-hmm. But because we have so many applicants, that's what leads to the retrogression. And something that I think maybe we could see, there's legislation pending right now to remove the caps on green cards. And so that's something that we could see help with these retrogressed visas. But that's a great point that you bring up. And that is the biggest India-specific challenge, is that we're seeing retrogression decades.
11 years to visa availability and 12 to adjust.
Yes.
Wow.
Yeah. So that's a very good point. And what you do in that instance, and what we advise our clients is, well, let's look for, if that's what you're going for, let's look for other ways to keep you in the U.S. lawfully, keep you working. Let's look for other options, because the EB2NIW visa is just one tool in our toolbox, just one. We have so many available options out there. So that is key when it comes to an analysis for an Indian national who is seeking the EB2NIW.
Okay. And Ram, okay. So now I would like to actually ask from you that, but do you think in 2024, I mean, it's just about to end and 2025 is about to start, right? So do you think in 2025, EB2NIW is still going to be that golden ticket, you know, for the immigrants?
Yeah, I mean, so here's what's happened, and Phil can put in his 2 cents. I think the H-1B program, the CAP H-1B program, has become such a disaster over the last 2 cycles that everybody kind of flooded from H-1B over to EB2NIW, and I think that's what's caused the problems in 2024. So what I would like to see happen, what I hope to see happen, is they actually fix the H-1B, because people have been gaming the H-1B so badly that the percentage of the lottery winners, I think, was 10% last year and 17% the year before. So people are opting for other ways. So they're going to the EB2NIW. EB2NIW is definitely the golden ticket. I mean, same with EB1, but you got to have a good package, you got to have a good plan, and you have to be qualified. It's not the golden ticket for everybody. We usually can knock out the first part relatively easy to the EB2 analysis. It's when you get into the national interest NIW analysis, substantial merit, they usually just give it away, because the ones we're throwing up there, we're not throwing up to open up a McDonald's restaurant, right? We're opening, we're doing naval inspections and maintenance on cargo ships, oil platforms, logistics and supply chain cases, warehousing and distribution. I mean, those types of cases, you're not going to just get an EB2NIW for any reason. But we usually, substantial merit, usually they just kind of give that one away, because it's easy to articulate how something might be in the substantial merit. So then there's 3 prongs, but there's actually 4, because the first one has 2. Then you get to the national importance. This is the one where they're currently really sticking it to applicants. Okay, so what? Your program, your subject matter expert has substantial merit. So what? How is what you're going to do going to be in the national interest? We have to now lay out the breadcrumbs piece by piece from their business plan, from their proposal, to the substantial merit piece, and connect the dots very explicitly for the applicants. And then you drop down to is well-positioned. Before, well-positioned was kind of like, well, they've got a master's or they've got a good professional history. Now they want more. They're even asking for kind of like, okay, you're going to do this. Do you have the financial wherewithal? Where are you going to get those funds? Do you have any kind of track record in doing this particular endeavor? So they're making that one a little bit harder, but that one is usually we're able to overcome relatively easily. But then they jump to the last one, which is the most nebulous of them all, whether on balance it would be in the interest of the U.S. government to waive the labor certification. Well, what the heck does that mean? I mean, I thought we answered that in the first three questions, but basically we're making the argument that this is so necessary that we need to just move away the year and a half labor cert process, which is currently just getting longer and longer and longer, and just get this person in. Let's get him in. Let's get him going. Let's get him improving the country. whenever there's a national crisis that or an international crisis that we can link to and cling on to, that's related to our client's deal, we do that to, and try to file as quick as we can to, to hit that particular piece. Like, we need this person in now. So anyway, I don't know if that answered your question, whether it's the golden ticket. It's not for everybody.
Yeah.
Not for everybody. It's not the Willy Wonka chocolate bar. You have to actually, come in with merit in this deal. When we make you look as good as you can possibly look, but you have to have some juice behind you as well.
Right. I mean, if this is not the golden ticket, maybe US can also come up with, golden visas like Dubai or maybe, other countries. They offer golden visas, right? So maybe US can come up with something like that. Right, Portugal. So, okay, coming back to my questions, Rob, I would also like to know from you that with President Trump now returning to the office, what do you think? What are the risks of reversing the more lenient policies recently adopted by USCIS regarding EB2 NIW applications? And how do you think that this might impact applications who already have begun their petitions?
Well, first of all, the more lenient policies, maybe that applied in 2023. We are not seeing that in 2024. So I think the question may kind of presume an erroneous answer. We think they're stricter now than they have been for the last couple of years. Although on paper they might be lenient, in as applied, they're much stricter. So everybody who's already in play, they're going to get adjudicated under the standards when it's on that person's desk. So whatever the policies are at that time, there's not going to be any kind of grandfathered in, because DONASAR is the standard, right? And has been since, what'd you say,
2016.
So that standard hasn't changed. The way they implement the standard, that's changed. Couple things that have been problematic or troubling to us that we've seen is, we've read a lot of articles and tracked a lot of things that it looks like they're adjudicating a lot using AI tools, which everybody uses AI tools now, right? Problem is, I used to work for the government and I know what kind of software they usually get. And let's just say it's not ChatGPT 4.6 or whatever, we're seeing RFEs that are misspelled, incomplete sentences, jumbled, garble, repeat boilerplate clauses just that maybe don't even apply to the same case or the same subject matter. That's a problem. We also saw the recent article did. They've subcontracted a lot of their work to Chase. So here you have civilians adjudicating these cases. I can't say for sure that they're adjudicating EB2 NIWs, but by the RFEs we've received, it wouldn't shock me, because it seems like the person making the decision doesn't even know what the heck they're talking about for the case.
Yeah, it's Rob brings up. So a request for evidence, just for viewers that don't know what that is, that's what USCIS sends to us after they've reviewed our initial submission, our initial visa submission. If they would like to see more evidence about our application, they'll send us a request for evidence. And it is no exaggeration to say that we have seen, I would say, of the RFEs that we see, about 50 to 75%, they literally make no sense. And just like Rob pointed out, grammatical errors throughout, requesting evidence that was included with your initial submission. So on the topic of the AI and RFEs, I totally agree with Rob. And then as far as going back to the leniencies, I also agree with Rob. In our practice, we don't see any leniency. These applications, this visa is a very tough visa to get approved. Thankfully, we've had great success with that. One item maybe that could be considered a leniency is premium processing, and that may have been a leniency early on, but now you ask almost any immigration attorney who's in this area who handles these types of cases, and they will tell you maybe it's not such a good idea to file premium processing, because that's almost like you're putting a target on that application, and it may draw greater scrutiny from USCIS. I would say in our practice we see that more likely than not. Certain applications that are just stellar applications, maybe they could benefit from premium processing, but again, what we see frequently is that premium processing, which could be considered a leniency, wasn't so lenient.
Not only, I mean, why would you pay $2,800 and probably some extra attorney's fees to do premium processing when your visa category is retrogressed by 11 years? So you're going to get a yes much quicker. People were doing that because of the elections. But now, I mean, we recommend our clients don't even utilize it at all because of the negativity. We think it's like a boogeyman out there that if you use premium processing, you're more likely to get a strong RFE, and they're really going to come at you because it's a war of attrition, right? A lot of people don't respond to the RFE on time, or it's much more work or much more cost. They just go away. So that's just that many less petitions that they have to adjudicate. But if there's no, like, it would be very difficult for me to imagine the benefit of a premium processing especially to an Indian national, a Chinese national, a Mexican national, any of the ones, Philippines, that are very retrogressed. Why do you care when you get your approval? Because you still got a long wait before you can do anything else.
Wow. Okay. As they say, nothing comes easy, and especially, if it is something really good. So I think those EB2 applicants, will really have to buckle up, and maybe they can start binge watching some stress management videos. How about that, Robin Phillip? So, but Philip, I would like to come to you and ask you, but do you think that with this, do you think there will be rush among applicants to file their petitions before, any anticipated policy changes? Because people, especially now that Trump has won, because they are every day thinking that some or the other policy change might happen. So do you think that there will be rush among applicants? And if people are considering that, what advice would you like to give them?
Well, I can tell you that, the short answer is yes. And I say that because we've seen that. We have seen a rush in applicants trying to get their applications in before the change in the administration. We've had any number of applications, but also the EB2 NIW. We have people calling us every week, 10 to 15 possibly calling us a week, trying to get this EB2 NIW petition, trying to get it filed. So we do see a rush, and we're seeing a rush from all countries in all areas. People want to come to the U.S. And so what I would advise anyone who is in that position that would want to get their application in before this current administration, I'd say, talk to a lawyer as quickly as possible. Give us or someone else a call. However, be realistic about your timeline, because in all likelihood, the EB2 NIW, because as we've outlined, it is a difficult visa to apply for and come up with all the evidence. So it's not necessarily going to be filed before the new administration begins. So just be realistic about your timeline. And also, again, I know there may be some anxiety out there about the change, but come on, we change every 4 years almost. Whether it's the same political party or not, there's change in the administration every 4 years or so. And we've seen that in our practice, in Rob's employment with the government, in my practice in immigration law, in both of our practices. Change is going to come no matter what. You just have to select a team that is prepared to handle that change.
Right. So I think we are going to see a lot of people more than the attorney's office. They are possibly going to go to the astrologer's offices now, especially for these 4 years. Rob, I would like to come to you and ask you that what do you think? What do you think about the Muslim majority countries? How are people dealing from those countries? And are you also getting calls from those countries? Because Trump with Project 2025, I mean, Trump and his administration are thinking of putting a ban in the Muslim majority countries, travel ban. So if you can please tell us about that too.
Yeah, I mean, we haven't seen a lot of that in our practice. I've seen zero. We both take calls and we usually interview the clients together. So we really haven't seen that as an impact at all. We have many clients from Muslim countries and it's like the boogeyman effect. It's like that's something that may never happen. Maybe it will happen. If you're that afraid of it happening, then get in. Let's get your case filed and go. But I can't predict with any certainty that that's going to happen again.
Yeah, we don't. On the topic of the boogeyman approach, we cannot advise our clients based that are rooted in fear. Right? We try not to use fear. We do not use fear to influence the way we handle our practice. Again, change comes every 4 years, and sometimes faster, depending on what the judicial system is doing and what new case law is coming out. I mean, really, as Rob mentioned, we're members of the American Immigration Lawyers Association. Mm-hmm. It's over 1,000 immigration lawyers across the United States. And we are on listservs and distribution channels and emails. And so we follow this all day, every day. And I mean, new cases come out every day. Every week you get 3 or 4 or 5 new cases that change the law. I think the judicial system, it's on its track. It's going the way it's going to go. And I don't think that there's necessarily major influences on who's in charge.
Okay. Thank you so much again for answering the question, Rob and Philip. Now, I would like to come to you again, Rob, and I would like to ask from you, given the historical context of, the heightened security scrutiny during Trump's first term. So do you anticipate that the USCIS will revert to a more stringent interpretation of national interest? And if so, what evidences might applicants need to provide to counteract this?
Well, I sure hope they don't get any more strict than they already are, because they're at a pretty high level, and Trump's not even in office, and they've been at that level all year this year. So, like I said, the strategy is you have to have a strong business plan. So you need a professional business planner, right? And they're going to take all of your strengths and all of your history and then articulate the national interest. But now we can't just say, okay, great, this person is in cybersecurity and has a good professional background. This is a national interest. We're getting hacked by Iran and China and North Korea. So that's a good match. Now we have to show this person is cybersecurity. The first 3 months they're going to do this to implement it. The second second quarter of the year, they're going to tie into these certain key areas of the economy or of the national landscape, and then these are going to be the results, right? So you really have to, more than ever before, for national interest, just lay down a crumb trail, paint a picture exactly how what you're going to do is going to help each aspect. It's very easy to articulate a national interest, but the way that they're saying national interest now is show me how your person is going to hit that national interest. It doesn't matter that, we've had the Panama Canal problems and problems in the Suez Canal. I want to know how your naval engineer is going to actually fix those problems. So then you've gone from just saying, hey, I've got a great naval engineer and I got a great there's huge problems that are causing supply chain worldwide, massive damage. Now you got to say, this is what my naval engineer is going to do. He's going to go over to XYZ spot, address, ABC issue. It's going to result in DEF result. I mean, it's a lot more work and a lot more intensity. And quite actually, as a law firm, we have to raise our rates a little bit to correspond with the amount of time that we're having to put in these. I mean, because these are getting to be, much more intense cases than they were before already. Again, my hope in 25 is that what we're presuming is going to happen is going to actually be the opposite. I want to see, like with Elon Musk involved and the emphasis on STEM, that they're going to be seeing, hey, this candidate's great. We know what the national interest is. Approve this, this petition. I can't say that's going to happen. Those are my hopes, but it sure as heck can't get much harder than it is right now. And we're under Biden. We're under the Democratic Party. This year has been awful for national interest. So, I don't see how it gets much harder than it's been. Philip might have a different opinion, but
no, I agree. I think what we're seeing with national interest and heightened scrutiny has been coming down the pipe for a while now. And what we see is a focus more on immediate economic and job impact rather than long-term concontributions. So part of the question was, what key evidence can we provide? Well, some key evidence is we need to have a quantifiable economic impact. What I mean there is we need to show the job creation, the impact, the benefit to the GDP. We also need to show that our applicants that they have industry recognition and they have endorsements within their industry. And we need to show specific examples of how their work aligns with the U.S. priorities, which we see as going more toward infrastructure and other critical industries like healthcare, like technology. That is some of the key evidence that we will have to show to show that these applicants will contribute to the U.S. national interest.
One more thing I want to interject, Raji, is that we've kind of taken a tact on our EB2 and IW cases, treating them almost as if they're EB5s. So we like to see at least 10 direct job creations under the business plan. And then we also want to show at least some significant impact on what's called the TEA type zones, the high unemployment, rural, those areas, because those are what, in the government's mind, those are, kind of policies that they want to address. We're trying to use that mindset from over here in the EB5 world, implement that into our EB2 and IW cases to kind of make that extra link on the national interest. Say, hey, not only is our person going to do XYZ resulting in DEF, but look, they're also going to create 15 jobs, 20 jobs, direct jobs, which will result in a downstream of 75 jobs, and they're going to help rural or economically disadvantaged or high unemployment areas in this way too. So we're just kind of having to try to get sophisticated, a little more sophisticated, and change the way we think about and approach these cases to kind of try to outthink the adjudicator, if you will. I don't know. It's, if you try the same thing and get the same result, then that makes no sense, right? We want to get ahead of the game.
Okay. Well, thank you for the answer, Rob and Philip. And Rob, you mentioned Elon. So I really hope that, he actually takes the national interest to the next level, but doesn't dodge it.
There's things that need to be dodged, Raji. Believe me, I was inside the belly. That could be helpful to us in our interest and your clients' interest. So anyway.
Yeah, that could also happen. So, but Philip, I would like to come to you, and I would like to ask you, but what about the applicants, in the fields outside STEMs, like maybe arts or social sciences? How can they stand in their case to potentially the stricter definition?
Sure. Well, so applicants that are in the STEM fields, if we're thinking more, which I think USCIS and immigration law on a whole is going toward more of a merit-based system. We know we're pretty certain that under the Trump administration, it's going to be more merit-based. And so taking that into account, and taking into account the effect that might have on applicants that are in the arts or the education or social sciences, I think what we need to do is we need to have a clear, measurable benefit to the U.S. interests. We need to show evidence of these applicants' exceptional ability, and we need to show their national awards, their publications, their broad societal impact, how they're going to help the U.S. national interest. And so really the analysis is the same as any, STEM versus non-STEM, but we may just have to go deeper. As Rob mentioned, a key part is preparing this case as if we're applying for the big EB-5 visa. And for anyone who doesn't know what that is, that's the big investor visa where an applicant needs to invest a minimum of $800,000 and needs to provide or create at least 10 U.S. jobs. That's a high threshold. And so I think part of the success that we've had with the EB-2 petitions is that we take that framework and we try to apply it to these applications that have a lower threshold. But if we can hit that higher threshold, then that's great. And I think that's part of why we've had, and not just us, other immigration attorneys have been doing the same thing. But that's how we would show that a non-STEM applicant can contribute to the U.S. national interest and be successful with an EB-2 petition.
But so, like, if you had somebody in the arts and social sciences, you just got to think, okay, what's a major problem? All these wars we've had in Afghanistan, all these soldiers that we've had come back with PTSD, part of their plan is going to be, we are going to go out into the veterans community and help kind of, rehabilitate and I don't know what the word is I'm grasping for, but kind of ease the pain of these soldiers through the use of our art program or our social
basically like coping mechanisms.
Social sciences, sciences, yeah. So you got to think about how you're going to tie what would otherwise be, hey, this is just a great artist, this will improve our culture. If it was me, I would say, yeah, we're going to do that. But they're also, like, I'm just making this up, we're also going to help all the veterans with PTSD because we're going to go out to them, do outreach to them as a way to help them ease and recover, from the pain, mental pain that they have still from being in war.
Yeah. Mm-hmm.
Gotta get creative.
Mm-hmm. Yes, Rob, you were saying.
You have to be creative. You're just going to have to get very creative in those specific areas. It's not going to be good enough, I don't think, just to say, oh, I'm great at social sciences or great at art. You got to think about doing some other things and tying in some other aspects that you normally wouldn't do, but that are important to the Trump administration.
Right. Okay, thank you so much for that insightful answer. Well, we really hope that national interest, doesn't become, whatever that makes USCIS less bored today. It doesn't change to that because, that also happens, right? So thank you so much for that insightful and detailed answer, Rob and Philip. Now, a lot of people are actually posting their questions. So before I take my questions, how about if we move to the viewers' question?
Sure, whatever. It's your show. You tell us what you want to do.
Thank you so much. Okay, Andre is here and he says, I am Brazilian. And he says, hello from Brazil. And he says, this rule is not God or good. I'm not sure what he means by that, but Okay, let's take Asim's question maybe. So Asim says, one of my friends applied for an EB2 NIW visa last year and got denied. He's now thinking of applying again, but the process seems more complicated with the new guidelines. Do you think the new rules are making it harder to qualify? And if so, what different should be done to qualify? Rob, let's start with you.
Well, like we said before, Andre, the rules haven't changed. The way you approach the rules, you may need to change your approach because you don't see it. Your Brazilian friend doesn't see it because they just were a one-shot player, right? They just came up to the plate, they swung 3 times, and they struck out. You can retool those same cases, but use a firm like Rajni's or us or whoever you want to hire and rethink as to how they're being adjudicated now. What can we change differently? What can we change in your business plan? What can we emphasize more? And what different national interests can we try to hit and link to in a different way and maybe amplify the impact of your proposed endeavor so that you will be successful this time? Resubmitting it the same way you did it last time, you're going to get the same result, right? But the rules have not changed. The way they're implementing the rules have changed. So you got to stay current with that. You got to stay in the mind of USCIS. You have to stay, have your pulse, your thumb on the pulse of how they're adjudicating, not just your cases, not just Rob and Philip's cases, but the whole nation of cases. Mm-hmm. And it's not something that a layperson would know because they're just, just throwing it in there.
Yeah. We've got to. I agree with Rob. The guidelines haven't necessarily changed. The bar has moved a little bit higher, but again, EB2 NIW is not an easy visa to qualify for. Yeah. We often tell our clients that it is a superhero visa. We need to show how they are going to be a superhero to the U.S. interests. And so if it didn't work the first time, that's okay. We wouldn't discourage you from trying again if you can do it in a creative way where you can really bring to the forefront and highlight your experience, your knowledge, your record of exceptional ability.
Okay, thank you so much for that great answer, Rob and Philip. Asim, I hope you have got your answer. In case you're looking for a follow-up, continue posting it in the comments below. Meanwhile, let me quickly take Sanjay's question too. Sanjay says, I have been told that supporting documentation plays a crucial role in the EB2 NIW process. Has the evidence required changed with the recent updates from USCIS? And if so, what kind of documentation is now essential? Philip, would you like to answer it?
Sure. I think documentation and providing the key evidentiary documents is key. It is key to an EB2 NIW application. And the biggest one is a professional business plan, a business plan that outlines every single aspect of the applicant's proposed endeavor. We need to show that they will contribute to the national interest of the U.S., that they will have a substantial impact, that they are that they're well placed to follow through and execute their endeavor. Okay, so a business plan is key, and maybe not stop there. In several of our cases, what we've done is, sure, it's a requirement. Any client that we work with, it is a requirement that they submit a professional business plan that is prepared by an independent company who looks at our applicant's record, CV, and is able to interpret that is able to create a professional business plan based on that record. However, again, we don't necessarily need to stop there. We can provide expert opinions. So in several cases, we have gone out and looked for U.S. experts on the particular industry or topic that the applicant would like to apply based on, and have those experts explain how the proposed endeavor would impact the U.S. national interest, how it would improve, how it would bring significant benefit to the U.S. interest.
Yeah, the average, to answer your question on paper, our average filings in these cases are minimum 500 pages up to 700, 900 pages. Okay, so yeah, documentation is important. There's critical pieces that Philip's already mentioned. Number one is the business plan. Number two is if you're advanced degree, obviously you have to show that. If you're not advanced degree and you're going for exceptional ability, you're going to have a ton of documentation to prove up because you're going to have to hit 3 of the 7 requirements, and you're going to have to do those through letters of reference, from colleagues or people highly positioned within the government, business, or academic sectors, as high up as they can, but they got to know you. They got to know your past accomplishments and what were the outcomes of your efforts, and then also give a really strong prognosis of your future, your potential, your potential energy, so to speak, because these aren't letters of you should give XYZ a job because they're a great person. No, these are letters of hyperbole, like to the maximum. This is the best person I've ever known. They resolved all these problems for this industry. It had an impact on the actual industry overall. And wow, what a great day when they become a U.S. resident, because they have the potential to take their proposed endeavor, shoot it to the moon. So yes, minimum business plan, letters of recommendation, and then all your paperwork you need to back up either your extraordinary ability or just your master's or PhD or your bachelor's plus 5 years advancing professionally in your area. And the thing I like about the expert opinion letters, those are kind of silver bullets. I mean, that doesn't mean you're going to win because of it, but they are very impactful because they're from industry experts in your area of expertise, totally independent. They don't even know this person. They're just reviewing the record and writing a professional opinion. Many times the CVs that they attach to theirs are like 20 or 30 pages long themselves for that particular expert. So, I mean, these are heavy hitters. The other thing I want to tell you is expect an RFE. You're going to get an RFE on everything. Oh my goodness, I got an RFE. I have a horrible case. I thought you guys said I had a strong case. That's not what they're doing. They're beating you down by attrition. So don't give them all up front, right? One of the strategies is to just hold back a little in anticipation of the RFE, because then when they bring the RFE, you still have some bullets in your gun that you can fire at the RFE, plus maybe go to some of these extraneous sources like an expert opinion letter.
Okay. Thank you so much for that answer, Rob and Philip. So no nepotism. It will all depend on the skills and right. So Sanjay, I hope you have got your answer. So make sure that you have all those documents ready that were mentioned by Rob and Philip, and you have to keep in mind that the nepotism will not work, especially not anymore. And yes, Rob is nodding. He is completely against it, right, Rob? Especially with the EW12 visas.
If you're talking nepotism as far as like reference letter, hey, if you can get a reference letter from Trump, you get that reference letter. We've had cases where we've gotten reference letters from presidents of other countries for the national of that country. So don't shy away from that. But it can't be just, hey, this is my niece or nephew, let them in. They got to know your professional abilities, your professional history, and your potential. So they got to speak professionally to that. It can't just be, well, Raji's a great person, so she should really be a resident. It's got to have some depth and substance to it.
Absolutely. And I think that's the reason why President Trump also endorsed, he said now if you are skillful and if you are adding to the US's economy, you will be eligible to get the green cards, and no longer because you are applying and because you are in the wave lines, you'll be able to get the green cards. Only you are skillful, and if you are, getting graduated from the good universities of the United States of America, you'll be eligible to get the green cards. Is that why he also endorsed that, Rob?
Yeah, I believe so. I think, I mean, I just read an article, it was a Politico, right?
Mhm.
Which is no friend of Trump or anybody on the right.
Right.
Yeah, so far left article basically saying, look, they are going to be looking for people with skill sets, especially in STEM. And sorry, I got a little off track. What was the question? Rajni, what was it?
No, even I forgot. I was too invested in your answer. Even I forgot what I was asking. But actually, is that the reason why actually Trump endorsed, the skills,
More of a merit-based system. And in reality, I'll let you go ahead and finish your talk on the article.
Yeah. So the article was saying, look, Trump is an Indian national's best friend because they have the skills, they have the intelligence. They're going to bring, they're going to bring the heat on the areas that he wants. They anticipated the biggest pushback is maybe a problem with Congress getting heat from their constituents because we've had so many problems in the U.S. with irregular immigration that I think people kind of got fed up with immigration and lumped it all together, whether it's legal or, irregular. And so Congress might be more of a problem than Trump and his cabinet. But yeah.
Yeah, and the thing with the merits-based system is, I think the benefit that I see to the way it's being laid out, or we anticipated it will be laid out, and how it was laid out during Trump's first administration is, I believe we're dealing with the merit-based immigration system as is, at least under the administration. Is they're giving you the guidebook, they're giving you the blueprint. Here are the 10 items that we're focusing on, and here's how you can qualify under each of those 10 items. Whereas to me, it may be a little bit more laid out, a little bit more transparent versus what USCIS may have been doing in the past, where it seems more discretionary, right? So if it's more discretionary and USCIS decides, well, we'll put more weight on this one item versus this other item, a merit-based system that is clear, that is transparent, could do a lot of good for visa applicants who do qualify, as Rob mentioned.
It might be bad for us as attorneys because it won't be as complicated, but I think it's much better for the clients.
Yes,
because they maybe just have a scorecard, right? And I don't know. I think it's going to be good for a lot of people groups around the world. Others not so much, but for certain people groups, definitely.
And of course, and that's how it should be, right? If you have those skills, and if you are a merit-based person, and you should be eligible to get the green cards, and if you're adding to the US's economy, you should be eligible, to get the green cards. Whereas, but then, talking about Trump, that's a whole another conversation, because then what he sometimes says, then his actions are, complete against what he's saying, because, he wants to have the merit-based system for the immigrants. But then coming to his own team, he's picking Linda McMahon as the Secretary of Education Department. So, I mean, that's a little controversial, right? Robin, Philip, I mean, I know that's a conversation for...
Rajni. He's a non-traditional politician, but still a politician at the end of the day.
True.
I won't defend him on that, but I do like Kash Patel and Vivek. I'm not gonna apologize for that.
Well, even I not just Kash Patel and Vivek Ramaswamy, but even Tulsi Gabbard and then Stephen Miller and then Tom Hooman as the border czar. I think those are some great picks, right? Whether you agree with his policies or if you disagree with what he says, but then some of his candidates are really amazing. And thank you so much, Rob and Philip. But I would again like to maybe take a few more questions. Hari is here and he has posted a question from LinkedIn. He says, I'm eligible to apply for this is actually for an H4 EAD. So would you like to take this?
No, we really shy away from giving case-specific advice to a non-client for ethical reasons. We don't know the facts behind their. If you want to speak generalities, it's fine, but maybe this one's not the greatest one. Yeah.
So maybe, Hari, what you can do is the details of Rob and Philip are scrolling below. You can directly, if you want to get in touch with them, you can get in touch with them, discuss your case with them. And yes, I'm more than happy to help you out, and you can, directly write to them. And let's quickly take Madhavi's question. Madhavi says, can you analyze the recent USCIS policy changes and court decisions impacting EB2 and IW visas and provide specific examples of how these changes have affected the approval rates and processing times for NIW petitions?
I'll start. So sure, as far as the new cases, and so the biggest case that we've seen come out with EB2 NIW is the Matter of Danisar case. That's what provided the three prongs that we've been discussing all along that gave it a more streamlined approach to the pre-Danisar era, which was guided by another case, U.S. New York State Department of Transportation, which that required, it was a little bit tougher under that standard because what it required was proof of national scope and specific labor market unavailability. That was challenging for many applicants. And so what Danisar did in 2016 is it now focuses more on substantial merit and national importance. So we were talking about work by an applicant that it has inherent value and can be important to the U.S. interests. So what we've seen is a shift from the focus of market unavailability to the applicant's unique contributions to the U.S. And how I think that has affected the EB2 and IW petitions is it has like we were talking about with a merit-based system, it is laid out. Now you have a playbook with specific guidance as to how you can meet those requirements and have a successful visa application. And what we've seen is there has been an increase in the rates of approval. It's still a tough visa, but we think now we have a clear standard under which to apply.
As far as the court decisions that was mentioned in the last question, one thing that I see all the time on our distros, one thing to keep in mind, the NIW piece is completely discretionary. Completely discretionary. You cannot challenge that in federal district court, the U.S. Supreme Court, whatever. You will get knocked out at the knees immediately on a motion to dismiss your case. So if you lose your EB2 NIW case and you want to fight them in court, for wrongfully denying your case, and if they made that decision based under the NIW piece, it's a loser case, we call it. So if there was other key legal factors in the EB2 qualification part, you may have a case to go forward. But the NIW piece itself, it's in the adjudicator's hands. I don't remember the name of the case, but there was a recent case that came out speaking to vice consul, the inviolability. I always have trouble saying that word. It's inviolable. You can't violate the vice consular's decision, right? They're the judge, jury, and executioner in let's just call it the B1, B2 context, but really in adjudicating consular process cases. This recent case that came out totally strengthened that position. Before, there was a lot more challenges you can make to the consular decision, the vice consul decision-making process. But now they've been narrowed down tremendously, which was weird because just before that, there was a case coming out limiting administrative, the Chevron case, limiting the administrative ability of agencies to basically legislate upon, us.
Mhm.
So, but since we're specifically talking about this concept, the cases are against any type of appeal to a district court in a federal lawsuit context.
Yeah.
It'd just be a refile would be your
Yeah, and just to add to part of the question was how has it affected processing times? We've seen shorter processing times in general for EB2 and IW. As a matter of fact, right now, as of this morning, we're looking at 10 to 13 months processing time for the Form I-140 for an EB2 and IW case. And then, of course, you think if you do premium processing, which we've discussed some pros and cons about that, then you're looking to a shorter time period of 15 days. So what Danisard has done is it's created a clearer path to the EB2 and IW visa.
Mm-hmm.
If there's one thing I can add to, when we file our cases, we always put for consular processing, even though we hope we don't have to, because you can always adjust status even if you put consular processing on the petition. All you have to have is your receipt number from the approved petition. And if you have a legal way to stay in the U.S. And your case and your category is current, then you can adjust status from within the U.S. If you have to run the gauntlet of consular processing, you're basically going to get re-adjudicated again by the vice consul. You already got adjudicated by the USCIS officer.
Mm-hmm.
But that's not the biggest issue. The biggest issue is it's got to run through NVC first in Washington. There's going to be administratively a couple months to get you documentally qualified. And then they just wait. And they wait for post to have an interview available for you. We have cases that have been ready for interviews since September 2023 and still have not had an interview date yet in that country. And I don't know what the case is in India at the embassies or consulates there, but in general,
Mm-hmm.
I think they're taking low priority on scheduling interviews versus the immediate relative family member immigrant visa, which is means the most to Congress because that's the people that vote for them,
Right. Okay. Thank you so much again, Rob and Philip, for answering the question. Let me quickly take Trisha's question because she has also posted one question over here. She says, I'm considering submitting a waiver of job offer for the EB2 NIW visa, but I'm uncertain about how USCIS is viewing these types of cases under the new guidelines. Can you explain how they assess the waiver and what strategies might help to improve the approval odds in this area? Philip, let's start with you.
Sure. Well, with the NIW, of course, as we know, the benefit of applying for EB2 NIW is to waive the job offer, going through the perm process, which is, time consuming, a little bit, more expensive. So what we have to do is we have to show why it's in the best interest, why it's in the national interest to waive the job offer. And explanations of how the way we do that is we need to show that waiting for the job offer is not feasible or practical for this particular endeavor, for the proposed endeavor. We need to show that the applicant's skills and expertise, that they're highly specialized and they're not readily available in the U.S. workforce. That's another way to do it. And finally, a third example is we have to explain how waiving the job offer would accelerate the project's progress. If you make this applicant wait the 2 to 3 years, you're delaying this really important work that they could do in the U.S. So if you waive that job offer, what you're doing is you're accelerating that progress. You're accelerating the benefits that this applicant is going to bring to the U.S.
One other thing along that line on the whether or not it'd be in the best interest of the U.S. to waive the labor cert is to hit if you have a case where it's impracticable Like say this person, if they take a job offer at a certain place in this industry, will have a non-compete clause automatically because that's the industry standard. So they won't be able to benefit the industry as a whole. They will be pigeonholed into one specific employer, which will not help the national interest. So therefore, it's in the U.S. best interest to waive the labor cert. Or this person holds a patent on a widget that, it's impracticable because they own the patent, on the widget, and, no one else is going to get it. So let's bring them in and let's get them started and let's get them helping the U.S., thrive.
Okay. So, Trisha, thank you so much for your question. I hope you have got your answer. Now, Rob and Philip, there are a few questions posted in a Facebook group by our viewers. So, if you don't mind, can I share my screen and maybe take some of the questions from there?
Sure.
Great. Thank you so much. Okay, I'm quickly sharing my screen. Okay, can you see the screen? Okay, so this person, I think Javier, has posted that he says, I'm a Spanish teacher. I have applied for EB3 and IW I-140. Does anybody know if there is any possibility to be approved? What would you like to say?
I would say no, because there's no such thing as an EB3 NIW.
EB3. EB3. Yeah, we assume she meant. I'm going to assume she means EB2 and IW, and we like to say that no case is impossible, right? We would need more details, but speaking hypothetically, a Spanish teacher isn't automatically ruled out from an EB2 NIW. However, what we discussed earlier, you've got to be creative. We've got to show what experience does she have? How would she benefit the U.S.? In the U.S. here, we're dealing with an ever-increasing Hispanic population, right? And unfortunately, sometimes a lot of the Hispanic population is in underserved communities where someone like the caller, the questioner there, could potentially benefit the community. We'd have to show how does her experience as a Spanish teacher improve the U.S. economy, U.S. national interest. So again, we don't like to say any case is impossible. That could potentially be a tough case, but it's not impossible.
Yeah, I think if she's got especially if she can hit the advanced degree portion, I think with some creativity and a good business planner, you could easily weave that into a strong national interest argument because of the just like Philip said, the segment of our country right now of the Latino segment is humongous.
Mm-hmm.
Yeah.
Or maybe having the right attorney might help in cases like these, right?
Sure, that is key. Having the right legal team at your side to help you navigate something that complicated.
Right.
Yeah.
So,
sorry.
No, please go ahead, Rob.
Identify the need and then connect the dots. That's what you got to do. Identify the national interest and then connect the dots in the proposed endeavor. It's just very explicit, and that one alone, I think I could come up with about 35 different ways that we could make a strong argument on her behalf.
Well, Javier, if you're looking for an attorney for yourself, maybe get in touch with Rob and Philip. The details are scrolling below, so you can note them down. And you're also going to, I'm also going to read out the details for you. So if you are looking to get in touch with Rob, you can give him a call on the number 512-293-3023. I would like to repeat the number, 512-293-3023. You can also email him. His email ID is robmelvin@melvinlawgroup.com. Rob Melvin at melvinlawgroup.com, and his website is www.melvinlawgroup.com. And if you're looking to get in touch with Philip, you can give him a call on the number, which is 979-776-1325. I would again like to repeat the number, 979-776-1325. You can also email him. His email ID is Philip PHILIP at dosrodlaw.com. Yes, and you can also visit Philip's website, which is www.philiprodlaw.com. So make sure to get in touch with Rob and Philip. They'll be able to help you with your case. I know it will be a little complicated and a little tough in comparison to others, like Rob and Philip mentioned, but they are the experts and they are surely going to help you. Thank you so much.
Just to let your viewers know, Rajni, both of those telephone numbers for Philip and I are also WhatsApp numbers. So if you have any WhatsApp users out there, they can send WhatsApp messages through those channels.
Well, perfect. What's better than that? Rob and Philip are just a WhatsApp message away, guys. So get in touch with them right now. Right. And also, I have one question which was actually posted 2 hours back, and it is from a girl named Kripa. And she says, I have an approved I-140. I'm waiting to file my I-485. My current employer told me that they won't file my I-485. Can I change my employer for I-485?
Well, Kripa, it's not clear what visa you're talking about there, unfortunately. Because what we're discussing is an EB-2NIW visa, which does not require an employer. So maybe some clarification would be helpful. As Rajni mentioned, if you'd like to, you can reach out to us, offline, and we can get some more information about your particular situation and do our best to answer your question.
Perfect. Let me take one last. Rob, Tamer says, does the premium processing affects the approval percent in the EB2? What do you have to say?
Back when I was young, it was the $64,000 question. Now it's the $64 billion question, right? Depends who you ask. I know some very well-seasoned attorneys, immigration attorneys, that have done tons of EB2 NIWs. They say premium processing is the biggest joke, the biggest waste of time, and it's just a throwaway of money. I know others that say it will actually prejudice you because you're putting heat on them. Remember, these are bureaucrats. I was a bureaucrat. You want to do the least amount of work that you can to get the day over so you can draw your check and build your pension. These are not go-getters. If they can kick you back an RFE in a premium processing case and then kick the can down the road, it's probably what's going to happen. I can't say it with 100% certainty that it will prejudice you. I've heard others speculate that it will. My opinion is they're worthless because of the retrogression. So why, unless there's some insane pressing need to know the answer in 45 days that I would be glad to discuss with anybody offline. We try to talk our clients out of using it. Some people were so afraid of Trump winning that they insisted we used it. We used it, and they had to go through all the same stuff that anybody else had to go through. Thank goodness they were approved.
Yeah, and let's think about what premium processing does. What Rob mentioned is USCIS. You can't blame them. They've got a lot of work on their desks. And what we're asking them to do with premium processing is cutting down a 10 to 13 month process into less than 45 days, 15 to 45 days. You've got to think about what that does. If we had a project that normally takes 10 to 13 months and we had to cut down that short period of time, they may have a lot of questions. And so what that may lead to is a request for evidence. So again, you're going to get a different answer based on who you ask, which immigration lawyer you ask. But yes, in some cases, maybe premium processing is the way to go. But what we have seen is in the majority of cases, it may not be the value that people think it is.
In that vein, of all the comments I've heard on premium processing, and I've heard hundreds, if not thousands, I have never heard somebody jumping up and down saying, yay, I'm so glad I chose premium processing because it was so wonderful and it was so beneficial to me. Not once.
But Rob and Philip, people are so scared of RFEs. As soon as they get the RFE, they panic and go into that chaotic zone and chaotic mode. So but RFEs can sometimes also be helpful for their cases, right? So in situations like this, how should they deal with? I mean, what should they do, and how should they deal with that?
As Rob mentioned early on, you go into, and we always explain this to our clients, potential clients early on, you have to go into it expecting an RFE, right? What we're proposing for our clients oftentimes is a very complicated endeavor. They're highly specialized, they're highly skilled. So there are going to be questions about the process. So we tell our clients an RFE is probably going to come, just expect it. What we do is we're going to be ready with additional evidence if we need it. For example, Rob mentioned the expert letters earlier. Those aren't required in the initial submission. They're not required. The business plan in most cases is sufficient. So sometimes some clients, in order to preserve resources from the initial submission, may say, let's not submit the expert letters right now. Let's submit the business plan. Let's submit the best initial submission we can. And if and when we get the anticipated request for evidence, well, then we provide that additional evidence. Like Rob mentioned, we keep a little bit back just so that we can respond effectively to a request for evidence and provide a clearer picture to USCIS of what our client is trying to do. So again, the takeaway is, in this visa category, a request for evidence is likely to come. Just be aware of that up front so that you're not surprised by it when you get it.
The only case that I can remember us having where there was no RFE was the proposed endeavor had a direct impact on the amount of filing fee income generated to USCIS at an exponentially humongous amount. For some reason, that case sailed right on through without any RFE. It was amazing.
Yeah.
Well, I think that's a great way to actually put it. You should go with the expectation that you will get an RFE. I mean, expect the worst and you will never be disappointed, how they say it, right? But thank you so much, Rob and Philip. It was so great having you both on our channel and on our show, Immigration and Jobs Talk Show. We had an amazing show. We were actually supposed to have this for an hour, but we actually did it for an hour and a half and we didn't even realize it. So thank you so much for being here. And even after doing it for so long, we couldn't even cover half of the questions that we actually planned for you. So maybe how about we do another episode on the same topic and we get into the depth of it.
Anytime.
Perfect. So guys, if you're looking to get in touch with Philip, you can give him a call on the number 979-776-1325. His email is philip@dosrodlaw.com. His website is www.philiprodlaw.com. So make sure you give him a call, WhatsApp him, email him, and also check out his website. And if you're looking to get in touch with Rob, you can give him a call on the number 512-293-3023. His email is robmelvin@melvinlawgroup.com and his website is www.melvinlawgroup.com. So make sure to get in touch with the both of them. And like they said, their numbers are also available on WhatsApp. So make sure that you also send them a text on their WhatsApp numbers. They are just a text away. So again, thank you so much, Rob and Philip, for being here. Any closing note from the both of you?
No, thank you very much for having us on. It's been a pleasure. It's an honor to be on this show. We know you have a lot of viewers. We know that your show is putting out a lot of good information to all of your viewers, and we're honored to be a part of it.
My only thing to say is, India, keep your chin up. It can only get better, and I think it's going to get better for you. I think you have a lot more people in your corner than you think you have, and I am very hopeful for you, not only just in the EB2 NIW category, but also hopefully bringing down the retrogression numbers and the weight that you have for your visas or your adjustments of status. So keep your chin up. Let's keep in there. Let's keep fighting. And we're here to help you out.
Thank you so much. Thank you so much to the both of you. Can't wait for the both of you to be back on the show with our next episode. And thank you so much again for being here. You both have a great day ahead.
You too.
Thanks. You as well.
Ciao. Thank you.
Guys, thank you so much for tuning in, and thank you so much for posting those amazing questions in the comments below. You can continue posting them whenever Rob and Philip are going to be back. Maybe we can take those questions and ask them in the second episode, or whenever they are back for the next episode. Or maybe we can get in touch with them, write to them, and get a reply from them, and we will post the reply in the comments below. So you make sure that you are continuously posting your question in the comments below. But for now, I'll have to take your leave. But you make sure that you are always tuned in to Immigration and Jobs Talk Show. So stay tuned with Immigration and Jobs Talk Show for every immigration update. I'm Rajni Bharara, your host, signing off for now. I'll see you very soon. Bye. Keep watching and keep subscribing.
All right.
Bye.
Hello, everyone. Welcome to Immigration and Jobs Talk Show. I'm Napasa Pradhan, your host for today, and I'm very happy to have you join us, for this very amazing discussion that's lined up for you. So, before we start off, I have this important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, once again, friends, thank you so much for joining us on Immigration and Jobs Talk Show. And our topic for this session is going to be all about family visas, how Trump 2.0 could change the future of family immigration. As we look ahead for potential shifts in immigration policies, it's essential to understand the stakes, challenges, and what might be on the horizon or on our plate for families hoping to reunite in the United States. So, to help us unpack this complex and dynamic topic, we have a very special guest who's going to join us for the first time here on Immigration and Jobs Talk Show. Please help me welcome him, Attorney John Q. Khosravi. And John is not only the managing attorney at the JQK law firm specializing in family, business, and talent based immigration, but also an adjunct professor of immigration law at Pepperdine Law School. So, as a first generation American with immigrant parents, John brings a unique and deeply personal perspective to his work. And his expertise is unmatched, and it's going to be great to have him join us today in our show. So, without further ado, please help me welcome John Q. Khosravi. Hi, John. Thank you for joining us.
Hi, Nipasa. Thank you so much for having me in the wonderful intro.
Thank you so much. But we'd love to get to know you better. So, anything else you want to tell us about yourself would be great.
Sure. I just happened to become an immigration attorney 15 years ago because it's just the first job I got. A lot of American lawyers don't go into immigration directly unless they're working with asylum applicants, but they fall into it and you kind of fall in love with it. The people you work with always have very interesting backgrounds. It's like reading the best biographies every day in a meeting. Everyone comes and has a exciting life, and it's a blessing to be able to do this work. And especially with the technology that we have nowadays, to reach out all across the world and talk to people. So I really enjoy it. I'm really happy I got this job, and it opens opportunity to speak with people like yourself.
Absolutely amazing to have you. And you're a professor, you say. So, how long have you been teaching immigration?
So I started teaching immigration law first at Loyola Law School, then at Pepperdine there in Southern California. I don't know, it was like 7 or 8 years ago. And then when COVID happened, they had us all do our teaching through video. So I stopped that because the fun of meeting students in person was gone. But instead, I
Yeah.
started a different program. Instead of going for law students, I started a program called the Immigration Lawyers Toolbox, where I train other immigration lawyers, either new to the field or who wanted to learn more about certain aspects of immigration law. So now I have a program called the Immigration Lawyers Toolbox. This is intended for other professionals, other immigration lawyers. And so I just direct professional business-to-business training and business lawyer training more than students nowadays.
Wow, that's amazing. That's
Thank
amazing.
you.
So good to have you. And I think, yes, what can we expect in our discussion today on this topic, all about family visas, how Trump 2.0 could change the future of family immigration?
Well, when I first started doing immigration laws, it was really happy because always helping people, and we figure out the way to get them going. Since the Trump administration began last time and this time, I kind of feel like I'm a doctor giving people bad news because it's just going to be depressing to a large extent. But it's better to know what you're dealing with. Go to the doctor early to catch any issues is the main thing. The biggest problem is going to be delays. There's very few things we can say for certain because we don't know exactly which direction to go. The government is going to be sued and pushed back on certain things. And Elon Musk is helping the government. Who knows if he has a more pro-immigrant idea, and especially from large parts of the country, including India, a lot of his skilled workers coming. It might be different, but delays are going to be there for sure. There's numerous ways they're going to do that, and it's already evident it's going to happen. So that's like the thing to expect. And by knowing it, at least you can plan out your life properly. So if you don't quit your job or sell your property immediately, you know that there's going to be delays. So don't rush into things in this process.
Right, right. And we are going to unfold more under this topic for sure. And before we move ahead to our questions, I have this important thing to tell you. Folks out there, you can join us also on call. The phone number is displayed on the screen. The number is 425-436-6335. And they'll ask for an access code. And that's when you dial in 988-888. And just say hello after that. We'll be able to hear you. So, yes, I'm excited. I hope you can join us. And otherwise, you can also comment wherever you're watching us. We are streaming live right now on YouTube, LinkedIn, Facebook, and also on X. So please feel free to drop your questions in the comments and we will address them today in our webinar. So, yes, John, coming back to our discussion, recently Tom Hooman suggested that, he said that he would deport families together as a way to enforce stricter immigration policies. So, John, how do you interpret this statement from a legal and practical perspective?
Well, I didn't hear the beginning of the statement. Who was it that made that statement?
Tom Hooman,
Tom.
the Baudazar.
Oh, yeah, that guy. So, I mean, a lot of his stuff is going on with what's going on at the border, the southern border of the United States, where millions of people have been coming the last couple of years. And essentially, they haven't been managing and organized really well. It's become very chaotic. And unfortunately, it's led to a lot of people, abuse happening, cartels running wild. So that's going to be a major issue on trying to figure out how to stop that. And the people who have already here, or at least create a manageable system, the people who are here, how to connect with families, do stuff. It looks like they'd be very harsh on it. But there's one aspect of U.S. immigration laws. Most people have to have a court hearing. And there's not enough judges to even handle the amount of court hearings. And it's very difficult to hire judges, train them, all this kind of stuff. So there's already delays in being, again, if they want to kick anybody out, they got to go to court first. And the courts are backed up like crazy, like 3 million cases right now backed up. If someone has an immigration court hearing today, or they get caught or something like that, they might say, come back in 7 or 8 years and we'll see your hearing. So if they get all these troops and amount of people try to, take people in the U.S. to kick him out, essentially, it's going to take 15 years for that to happen. So inevitably, a lot of this rhetoric has to be very harsh as a bargaining tactic, which seems like something Trump does, because to scare people, because I've had people call and tell me they're just going to leave themselves because they're afraid. So it has a goal in it. Practically speaking, because of the way the system is designed, they can't really do much because everything is frozen stiff. It's just the system is going to break, and there's nothing you could do about it. But they could prevent people from coming in, adding to it, which is a lot is at the border, and then again slowing things down in the legal immigration end. And changing things up there, which we're going to get into. But I think a lot of the rhetoric is to scare people to kind of self-remove themselves and to kind of set the tone so people are afraid. And that gives them more leeway in negotiations with Congress and new immigration programs. I think that's a lot of what's happening.
Right, right. Well, thank you so much, John, for giving us your perspective on this.
Yeah.
And now let's move on to our set of questions. And I have this first one. So, how could a potential Trump 2.0 administration impact the family-based immigration system in the U.S.?
Sure. So there's the family-based immigration programs that we have in America are several types. So there's, if you're a U.S. citizen, you're applying for a spouse, a parent or minor child, those are called immediate relatives. If the child's in the United or the family members in the United States, the changes aren't going to be that different other than some delays and forcing interviews for people to go to interviews where in the last 4 years, they would just approve the case based on paperwork back and forth. If they're outside the United States, and this goes to all family cases, those are probably going to see additional delays in processing for background checks. Last time around, we had a lot of consular officers, people who work at the embassy who were against President Trump leave. So all of a sudden, they were understaffed. There's less funding going towards that, so they had less money to even hire people and staff. So you're going to see a massive slowdown. If you're overseas, this already takes a while. It's going to be even longer. Now, when it comes to other categories like brothers and sisters of U.S. citizens, adult children of U.S. citizens or green card holders, those are things that have been discussed to be on the chopping block, to get rid of them for many years for people that are against as wide of a family-based immigration system that we have. Those are part of the statutes. Those are the laws in the United States. So the president can't come directly and say, we're just going to cut this out. But again, that as I was talking about the rhetoric earlier, by having a position that's so strict, potentially they can negotiate these and get rid of them in the future. But right now, as it is you can't really change much other than just throwing wrenches in there and creating problems to slow it down, to just make frustrating for everybody. So that's the thing they're going to do. And then there's this other family employment-based stuff. Is if someone's in the United States, they got a green card through work. And while they're getting the green card, they go and get married back home. To bring that spouse here, that process is backed up because the bureaucracy, like a year or two, that's going to probably get backed up again. So it's like they're not going to stop that process. Someone's here, CEO of a tech company, they got a green card and they just went back home and got married. The spouse could get a green card based on the employment, not even based on, it's not a direct family case. It's a family member of an employment-based person. That has slowed down with the forms and stuff that exist. And that's probably just going to get worse and worse the way things are going. Because in the last 10 years, it just, even under Democratic administrations, they've been slow. So it doesn't look good to a large extent. And again, it's going to be delays more than anything.
Sounds frustrating already. And I can only imagine.
Yeah, we've had couples engaged and they decide, and I tell them it's going to be how much time, they end up breaking up. They're like, I can't wait 2 years. And if you're from Iran or Pakistan, you might have to wait 4, 5, 6 years to get your case through. And so people are even getting divorced or even breaking up. It's very sad that these delays are just tearing apart families. People are not seeing their children for 5 or 6 years because of it. It's terrible.
It's terrible, really. Well,
I'm sorry.
Do you think that they're going to make it that frustrating that they would also give up on this situation? I mean, you've already mentioned, of course, the divorce and separations and everything.
Yeah, on the employment side, sometimes employers will be like, I can't wait 4 years for a guy to come or a gal to come here and work. So if that's a problem, and for couples, they do, because if they're planning on where to go, a lot of times they would say, I'm just going to go to Canada instead. But Canada is getting bad too. So people are kind of stuck. And when it comes to fiance visa holders, we got a question from Mango over there. Can you clarify follow-on benefits? You married a green card holder from India. What about K1? So we'll talk about the K1. The K1 fiance visa is if you met someone overseas, you're a U.S. citizen is the first requirement. You can't be a green card holder, be a citizen. And you met someone overseas in the last 2 years, physically met them. There are exceptions to that rule, but they're very hard. You could file for a fiance visa for him. And that process is already delayed. It's not much faster. People think it's faster than the marriage case, but not really. And that part's going to be delayed. And again, it depends on what country you're from. Pakistan cases could take extra years, for example. Iran cases, if there's a travel ban, it's going to be horrendous. And so you're waiting for a fiance to come for 4 years. People fall apart. So that's a major issue to happen. Now, when it comes to follow-on benefits or follow the joint, as they technically call it, this is the one I was referencing earlier. If someone, a person got an employment-based green card and their spouse and kids are overseas, fall to join is a benefit there. Those are already seeing massive delays, and they're just going to get more delayed. So I think I'm going to be repeating myself a lot here, but it's really important. Even in my consultations, I repeat myself a lot on this. Delay. You have to accept it mentally because it's so frustrating. I hear clients call me and they say, my friend got it done 3 months in 3 months. I'm like, maybe 5 years ago, or maybe they got lucky, but there's just delays. There's no way around it. So that's what we're seeing. It's going to continue to get worse.
Thank you so much. Thank you, John, for the detailed explanation and for taking up Mangu's question as well. Thank you, Mangu, for participating on YouTube. You can keep commenting. Let's move on to our next question, John. So this one is, what specific changes do you anticipate in the way family-sponsored visas are processed under the Trump 2.0 agenda?
Oh, great. Thank you, Shachi, for the question. If you have more specifics of what kind of family case you have, it'd be great. But you can expect processing delays on the first part of the case where we prove your relationship is real, whether it's like a family member or a marriage, being more strict on that and just delaying their review of it. And then secondly, if they're overseas, on the embassy, just having more and more delays just to schedule an interview for you. And those are just getting worse and worse. So for large parts of the world, unless you're from Europe or Japan or Australia, even Canada has delays. Canada takes a year to get an embassy interview for a marriage case. So it is a lot of times it's what they used to call first world countries. They're hitting them as bad too. But just the delays are going to be so bad, and them being picky about paperwork and just not paying attention to your paperwork and making mistakes, that stuff's going to get worse.
And well, Mangu says, thank you for the answer. By the way, you look like a Hollywood star and explain so well. That's so sweet.
Thank you
of
so
you.
much. I get
There
that.
you go.
There's a Bollywood star that people always comment like, you look like this guy. I forgot his name. But everyone's like, you look like that guy from that actor from Bollywood. Yeah.
From Bollywood. Oh wow.
I can't remember.
Hamrick, is it? I don't know.
Somebody, I can't remember.
But yes,
Every once in a while, I'll get that comment.
oh, great. So, folks out there, maybe you can tell us who does John look like in Bollywood? Would be great to know. But yes, thank you, John, for that explanation as well. And now, let's take up this next one. How would a renewed focus on family immigration limits affect the wait times for applicants in the family preference categories?
Sure. The family preference categories is if a green card holder, so these could be citizens. So these are non-immediate. So preference there are the main categories, which are if you're a citizen, you're applying for a parent, spouse, or minor children. Those technically don't have additional delays. They're supposed to be fast, but they're still slow. The preference categories are preference because there's annual limitations on how many green cards could be issued in those categories. So I don't remember the exact numbers. Let's say if you're a U.S. citizen, you have a child that's over 21, and his unmarried child, there's only 40,000 of those green cards that you give out every year. And there's probably like 150,000 people asking for it. So that means it's going to be, as soon as the 40,000 are done for the year, you have to wait till next October 1st to start again. And so there's backlog there. It's just a mess. They'll intentionally find ways to not approve them, to say we just don't have the staffing for them, and just delay. And how they calculate the numbers of these visas being used is a system that they don't really let us know what's going on. So we really don't know how much the timelines are. For example, there's a preference category called F2A, spouse of a green card holder or minor child of a green card holder. Right now, for them to approve those green cards from beginning to end, it's taking 3 to 4 years. About a year ago, there was no extra delay. Then all of a sudden, one month, they announced there's a 3.5 year backlog in these cases. Like, what happened? 5 years, no backlog, then 3.5 years. And it was really bad because we didn't expect it. So we have green card holders here who had their wife and kid overseas, and they're like, well, wait 4 years. So, and the green card holder has to live in the United States and maintain their residence here. So they're not going to see their kid growing up overseas because they got to be in the U.S., work, and live their life here. If they spend too much time outside, they could take away the green card if they want to bother them. So all of a sudden, families are separated, and you think they make an exception for kids and stuff like that. These are minor children, like babies, to at least they're green card holders, legit, everything. Speed it up so that their family could be together, the kid could grow up with both their parents. But that's one of the difficulties we're seeing happening.
All right. Thank you so much, John, for that detailed explanation. And yes, we are going to take up questions from all you folks out there, from Ajay, from Sachin as well, but a little later in the show. So please stay with us, all right? And also, you can call us on this number 425-436-6335. And when they ask for the access code, dial in 988-888 and just say hello. We'll be able to hear you. Thank you so much, John. And moving on, let's go on to our next question. And that is, what do you think would happen to the F2A category, spouses and children of green card holders under Trump 2.0 policy shift?
Yeah, so it's not clear particularly what will happen this category. This one has gotten really backed up that I spoke about a second ago, and it's been a big problem. This category, the delays are really being difficult. Now, during if the family member was in the United States during President Obama's time, he changed the system up so it's easier for them to stay here while the case is pending. So if people are here, for example, a green card holder marries their spouse, comes on a tourist visa and decides to stay in the United States, potentially they could stay here while the process is pending. At least they could be together. But because President Obama just put that in on his own without any congressional work, this isn't publicly talked about. I probably shouldn't say it, but it's a thing that President Trump and his people could just take away too, because it wasn't something by statute put in. It was just a presidential edict. This is how we're going to do it. So that could really shift. So for people that are in the United States doing it, that could be a problem. So because they'll lose the opportunity to stay here while the case is pending, being with their spouse and their kids together. And so that could be a shift. That's an easy one for them to get, and they might be looking to. But they might, what happened alternatively is all these groups would sue them on that, and it'll be stuck in the court for 2 or 3 years of fighting it. And then by that time, they'll either give up or new administration comes. So lawsuits are going to be a big thing that happened last time. People would sue, and the courts would stop everything and say, okay, don't change anything yet till we go to Supreme Court. That takes a lot of time. It also takes a lot of money. So these groups are spending millions and millions of dollars trying to support the community that's going through this process.
Well, it looks like it's just getting harder and harder in every step.
Yeah, essentially. More and more people are hiring us. That's for the immigration lawyer. I was interviewed by the New York Times during last administration, and I said it's almost like it's being an eye doctor, and you're getting a lot of business. Like, oh, my business is good, but the reason I'm getting business is because there's a crazy person poking people's eyes out, and so I prefer to have this business. I prefer people who are not terrified and could just live their lives, and even they don't need to knock on my door or my business door. But if it is what it is, and we're here to support people that are going through this process.
Right. Well, now let's take up this next one. How might the current proposals, for limiting family reunification impact U.S. citizens seeking to sponsor their relatives?
For sure. So U.S. citizens could do several kind of relative cases. As I mentioned, the parents, spouse, and minor children. The administration has been talking for years of people that are supporting Trump to get rid of the option to have parents to be able to be part of the case. That requires, and everything I'm about to talk right now, requires Congress to act and change everything. But yes, stopping parents of U.S. citizens from coming, brothers and sisters of U.S. citizens from coming. That's the F4 preference category. There's a backlog for that. It takes 15 to 20 years to get a green card, maybe longer for that category. But and adult children of U.S. citizens coming. So they'll say, okay, a citizen can bring their spouse and minor children, but they don't need to bring their parents. They don't need to bring brothers, sisters, or their adult children. Adult children can figure out a way on their own. That's what their goals are. And that would be something that would be negotiating in any immigration reform. That would be like the law that the Congress would change, the official law. But changing that kind of stuff is so difficult. But there's negotiations that could possible. Every day as I get older, all these things I never thought were possible are becoming possible. So I can't put it. We have AI talking to me on the computer. It sounds like a human being. We have all sorts of wars going on with technology. That's crazy. So at this point in life, I just say, this world, every day I wake up, it's something new, and I can't put anything past anything. So that's all these are possibilities, really.
Yes. And I guess we have Mangu back with the correct guess. You do look like a Ranbir Kapoor, actually.
It might be Ranbir Kapoor.
Yes, you got it right. Our team was like, you also look like Akshay Khanna, but I guess Ranbir Kapoor is the right one.
Thank you.
Well, yes. Getting back, in a scenario where family visa caps are reduced, how would it affect individuals currently in the queue waiting for a family visa?
So, it's not clear how that's actually going to happen because these people already paid money for this and it was a law. So for them to change it, it'll be kind of like there'll definitely be lawsuits against it, which would stall things. One, option they would say is the people who are already in queue would get certain additional benefits in the new system. So if they change it, they'll say if they create a point system like in Canada, where like if you're a relative and you have education, you speak English, you get more points and it's faster. They may give you benefits that way. Or they may say like whoever's already in the system, you'll go in the old system, but then from today on, it's the new system where it doesn't work or something like that, and they'll just finish off what's going to happen. That's probably the more practical way of doing it, but it's going to be a problem. People are going to be suing, and it's going to be caught up in court and litigation. And so a lot of these lawyers who go to court, I don't go to court and do lawsuits myself, but those who are going to have a busy 4 years, just going to court every day, fighting this stuff out.
Right, right. And what do you have to say about, outdated rules or laws? Do you think some of these laws may be changing soon?
Some of them, if they want to, it's so hard. I mean, right now the Republicans control all the aspects of government, but even then, it's when it comes to immigration, it's not always clear cut black and white. So we might have a Republican who's for certain immigration and another one who's against it. You never really know. And one main problem is the way immigration regulations are written. Language is so technical that you have to be an immigration expert to write it the proper way. And the problem is most of the time, inevitably, these laws get written by people who don't practice immigration law and don't know all the aspects of it. So even when we've had situations where someone's anti-immigration, they wrote the regulation, the law, made it the law, and then they didn't realize how they wrote it. Actually did the opposite. It created more immigration because the language has to be so technical and you have to be so aware of it. And they just mess up. So changing anything with regards to how the laws are and this and that, it's just so hard. First of all, getting the political will and the people together to approve it. Even if it's approved, we never know how it's going to actually be until it starts coming out, because the way these things are worded and the technical legal language has certain meanings that there are certain different ways. And there's errors in them constantly. You think they would have teams of lawyers to analyze this and talk, but there isn't. And they just make things up as they go along. And that's, again, as I get older, I had a professor in law school who used to say, when you're a kid, you think there's this big dad in the world that's going to take care of things and is going to fix things. And you get older, you're like, no, it's just a bunch of kids running around. They have suits on and they make money. And you think they're very sophisticated because they have PhDs, but it's just a bunch of kids running around making things up. And that's the way the world's running. And it's pretty much always been run. So there's going to be a lot of unknowns. So whatever rules change, we won't even know what the rule is until 6 months, a year go into it and realize, oh, it doesn't play out the way they thought it would, or the rule they made, it goes against another rule, so it can't even be valid in the first place. And there's another aspect that a couple of years ago, the Supreme Court, let's put it this way, in the 1980s, there was this court case that was unrelated to immigration, but the Supreme Court of the United States said that if American agency, so America passes laws based on the Congress, like the Parliament in many countries, and they have the final law. But because essentially people in Congress who pass laws are lazy and they just don't want to do much work, they'll say, we made a law that says help brothers and sisters of immigrants. And then they'll say, let the agencies, these people that the president picks in the bureaucracy, let them figure out how it actually works. And the Supreme Court said, yeah, that's fine. Just let other people who are not elected make the laws and decide what it is. Congress just kind of gets paid and just speeches, but they don't do anything really. It's just corruption, essentially. So they let this happen for 30 years and then 40 years now. And Supreme Court finally, 2 years ago, made a decision to undo this, where the agencies can't just make up the law. If it's a law, the Congress has to vote on it, and then it becomes law. They can't vote on some general statement and then say somebody else who's not elected make a decision. And this affects immigration hardcore way, because most of immigration law is agencies. They just kind of say, well, we're the agency. We say this is the law. And they wouldn't let us challenge it because they would say, oh, the agency made this rule. And based on that court decision in the 1980s, Chevron deference is what they call it. We're going to defer to what the agencies say and let them be the Congress that you're making the laws. Supreme Court say, you know what, that's not right because they're not Congress. They're not supposed to be making laws. They're supposed to be carrying out the laws. But as this system has developed the last 40 years, they're making up the laws too, which is unconstitutional. It's not, we're voted a democracy allegedly, so we got to vote for people who do it and not have these agencies make things up. And so that's going to have a massive change in the entire system of America, frankly. This is what Elon Musk and Vivek Ramaswamy of the DOGE, the Department of Government Accountability Office, or whatever they named it, are going to be using a lot, because they'll say pretty much all of America is being run on agency actions, not the law itself. So that means they could undo everything, essentially. And that's going to have major effects in the immigration system. Like, it's going to affect environmental laws. It's going to affect all this kind of stuff. And immigration, it's been kind of a unique point that a lot of immigration lawyers are frustrated because the agencies, USCIS, and they just mix up stuff, and you're like, wait, that's not the law, and they fight us on it. But we're gonna see what happens. It's Wild West. Anything's possible in the next 4 years with all these changes.
Absolutely. And friends, I'm sure you are also, you probably need professional help with regard to your immigration case. And why not contact attorney John Khosravi himself? You can even call him up on his number, 818-934-1561. Otherwise, you can email him. His email address is info@jqqlaw.com. And you can go visit www.jqqlaw.com to get to know more about him and his firm. Well, thank you so much, John. So far, so good. We also have Willie Haggins on Facebook. We are going to address your. Okay, let's take it up. So, John, how may this impact someone already in the U.S. with active status who may be getting married soon and planning to file I-130 and I-485 to adjust status?
Well, thanks for the question. This is the main type of case our office works on. I love helping people in this situation. One thing that'll happen right now is you have to do a medical checkup before you file the case. That's an update they just did last Monday. And you still have to get a COVID booster shot. We're realizing now they keep updating the medicals without even telling us. But I just found out this week that you have to keep getting COVID shots, vaccines. But it depends on if your spouse is a U.S. citizen or green card holder. That's going to affect the filing and how that works out. So, Willie, if you can, let me know if the person you're marrying is a U.S. citizen or green card holder. But what you could expect under the Trump administration is to finish off what he tried to do last time, which is a portion where they want to make sure the person coming here is not going to become a public charge. That means the government doesn't have to take care of them. They can support themselves. So they're going to go hardcore into your credit history. They're going to go hardcore into your education. They'll want language exams to show you speak English to the extent that level that they want. They're going to go into your finances, your debts, all this kind of stuff. And most people will be able to still get the green card, but it's going to create tons of work, essentially doubles the work that we do. And it was one of the worst parts of the last administration, filling out this, doubling the casework. And, there are people here who have to get credit reports, but they have no security numbers, no credit history. So we have to figure out how we could ask credit reporting agencies to even give a credit report to somebody. And that would take so many hours, and it causes more expenses and everything as well. So Willie replies saying spouse U.S. citizen. If you're planning on getting married and things are close, just get married now. File it. Contact their office for a consultation. But it's the number one thing we know, delays I spoke about earlier. Secondly, interviews happening. There have been waiving interviews for the last 4 years. You'll probably have to do an interview. And third, if you don't get the case in time, you're going to have probably more hardcore background checks when it comes to public charge, financial issues, which you'll probably still pass. But it's just going to create so much more paperwork, headache, and delay and be able to get your case in. And the more paperwork there is, the more chances that something's going to be missed, or the government's going to make a mistake, or just problems come because there's just more to deal with. I had a consultation the other week with somebody who got their green card like in 1990, 30 years ago. I'm getting old, and these years things seem so far away. And we did what's called the Freedom of Information Act request, a FOIA request. We asked the government for a copy of the person's file. They wanted to get citizenship. And I'm like, let me get a copy of your whole immigration file to see what happened in the past if you filed your paperwork correctly. And we got it back in just one application from I-485 adjustment of status that's for applying for a green card. Back then was 4 pages. Right now it's over 20 pages, and it's probably going to be 25 pages next year. So it's just, it had like 10 questions about your background. Right now we have 90 questions about your background on the form. It's just, they keep adding, maybe it's 105 or something like that now. So it's just, the more you delay, the more questions they're going to ask, which leaves more errors happening and more things that it just makes it difficult. It just makes it difficult. So when you have a good case, if you have no criminal history, your finances are good, your relationship is real, you want to just get it in sooner rather than later, because in these kind of cases, waiting longer is just going to create more problems for yourself.
Absolutely, yes. Thank you so much for addressing that to John. And folks out there, it's really important to stay updated because there are updates every now and then, just like John mentioned about about medical reports, right? I mean, updated.
Yeah, out there, because when you get a green card, you have to file. You have to do a medical checkup to make sure you don't have tuberculosis, gonorrhea, or syphilis, and make sure you don't have any mental health disorders. You don't have any drug abuse issues, and you have to get a list of vaccines. And these vaccines, like especially with COVID, you think that if you got the initial one, you're fine, but now they're saying no, you have to still get an updated booster shot. Still in 2004, coming in 2005, where really the whole situation is not on anyone's radar. it's hard to tell a couple. Yeah, you have to get these vaccines. Who knows who's making them or what's in them? What in the world's going on with these things? Essentially, we don't need it. If it was a pandemic, still okay, I'd be scared. Okay, let's do it. But at this point, forcing people to get this, and one of my clients said the doctor's charging $200 extra for it. And it's like, well, it's $20. We have to work to make this money just to get some vaccine that doesn't make a difference. So it's just annoying, and it brings the costs up. And people, the economy is all over the place. If you're making money in foreign currency, $200 is a lot of money. Even in the U.S., a lot of money. But let alone if you got to translate the money and bring it from overseas, it's just. And this is during the Biden administration. This isn't even a Trump thing. This is a Biden administration thing. So it just it's sad, and just it's sad to have to tell people this stuff, that they're just being annoying about it. That they're not being easygoing. It's very annoying, obnoxious. The best way to put it at least.
Yes, so much to do just to get your permission
Yeah.
for the visa or the green card for that. Yes. Let's go on, John. Now, my next question to you is: if the new administration pushes for stricter public charge rules, how might that complicate the process for families applying for visas or green cards?
Yeah, that's going to be a big problem because a lot of people, not making enough money. And right now, the standards for the income aren't too high. For example, if you're a person who's married, no kids, no dependents, or something like that, to bring the spouse, I think it's like 27,000 ish you have to make. Some people make much more than that, but some people barely make that amount of money, so it's hard. But the other end of the public charges, what I spoke about earlier, is not only will they look at the U.S. citizen's income or the green card holder's income, they're going to look at the ability of the foreign national to make money in the United States. And sometimes you might have somebody who's 18, just out of high school, who got married. They don't have any education history. Their language skills might not be that good. They don't have any skills or certificates. And how strict they're going to be. Because last time Trump came and they made these rules more strict, they said we want to see all this, but they never create a standard. So it's like, what is the line? How can I tell my clients you're good or not good? They're saying, we're going to ask for this, then feel it out. And I'm like, what kind of laws is this? It's feelings. It's like one person may get approved with nothing, and one person has everything get denied. And so that's going to lead to lawsuits because of the inconsistency of how they'll deal with that, which creates another problem. I talk about the agencies have discretion too, even despite that Supreme Court rule that I said. The Immigration Department has discretion to make decisions with who they think is good to come to the U.S. is not. At the end of the day, they have a background. They can do whatever they want. So usually they're not as strict and they're cool with it and everything. But especially if you're dealing with the U.S. Embassy, those people have all the power in the world. If you're doing your case in the U.S. with USCIS adjustment of status, getting a green card, even a work visa, because you're here, you have extra laws and lawsuits you could do. But if the person at the embassy says something based on, the fact that 100, 200 years ago, every country had embassies overseas, but there's no communication ability because everything was far away. So they put the rule back then where they said, if you're going to the embassy or a consulate and the officer there is making a decision, just let them do what they want to do, because we don't have the ability to check what they're doing. So we give them all the power, just make the decision that you want to do. Fast forward 150, 200 years later, they still have this policy called consular non-reviewability, and Supreme Court said it's okay. So they said, if consulates make a decision, we're not going to review what they're saying. So even if they make mistakes, which they do pretty frequently about the law, about the person, they'll say, well, consular non-reviewability, we'll let them do what they want to do. So it's a big, major disaster if you're going through consular processing and you're outside the United States, because you never know until you get the green card in your hand. You don't know what in the world's going to go on with it. Whereas in the U.S., if you're doing it here inside the U.S., if they make these major mistakes, we could sue, we could complain, we could show up at the office and say something, a worst case scenario. But that's going to be a big issue about how they're going to handle that.
All right. Thank you so much, John, for taking that up, for addressing this issue as well. And we have Willie saying thank you for addressing replying to Willie Haggins himself. And we also have ZQ with a question. So, Mr. Khosravi, is it going to get better under the Trump administration by removing these unnecessary tests and vaccines, even after one is vaccinated?
I highly doubt that. We have RFK, that was the nephew of President Kennedy, who was assassinated, and son of the former Attorney General, was assassinated as well. And he's famous for being somewhat skeptical of a lot of the vaccines, and you think that would come on here. But I don't know. This the vaccine situation is based on the CDC mandates and things that the Center for Disease Control in the U.S. and the health agencies, which he's going to oversee if he's if RFK Jr. is going to be in that position. I don't know if they're going to be getting into the immigration aspect too much. Maybe actually, maybe depends on what RFK Jr. is going to do. He's going to actually be the person inevitably in charge of hiring who's the people who are going to make the decision are, and so potentially they'll say, immigrants maybe don't need to get boosters at this point. We shouldn't make that requirement. That's going to depends if he gets elected and if he wants to use his time to focus on the immigrants as opposed to other communities. But that's maybe a bright spot in there to kind of ease up on all these vaccines. There's like 10 or 12 vaccines you got to get. A lot of times people have the vaccines already. Sometimes the doctors say you don't need it, but there's a lot.
Yes, that's a lot. Just to immigrate to the US, right?
Yeah. And my client the other day, he's like, I got 2 on his shot, 2 on this elbow, and they're all swollen. He's like, we have to get the booster, but I can't really take it. My hands hurt, my arms hurt too much. So I'm like, okay, wait till Monday to see if you feel better, if you get the booster. If not, we'll figure something out to do it later somehow.
Whoa, you can only imagine. $200 for a booster shot, that bites. Ouch. And imagine how many? 13. Well, thank you so much, John, for taking that up for ZQ. And ZQ, thank you for your questions. Let's move on now to our next. So, how could a potential Trump 2.0 policy shift affect applicants who are facing delays in consular processing for family-based visas abroad?
Yeah, it's going to make it worse. One thing that happens is when a lot of times people are facing delays in getting an interview, even though they should be getting an interview, or after they had an interview, the government just doesn't make a decision. 3 months, 6 months, a year, 2 years go by, they don't make a decision. What has become mainstream now is to sue the government for the delay once this is happening too much. And probably more than half the time, the government, once they get a lawsuit, they don't feel like dealing with this, so they just give in and issue the visa or do the interview. But we're seeing more and more judges, especially judges in Washington, D.C., denying these cases, saying embassy, that's up to them. They want to do what they want to do. And potentially the Trump administration's lawyers will fight this more and say, well, these delays are necessary and it is what it is. We're going to do it. So we're going to have to see, but potentially they might fight the lawyers who are suing the government delays much harder. And when they fight them, increases the cost because they got to go to court, this and that. A lot of times right now, the government just gives up, it gives in and just says, okay, we'll schedule the interview or give the visa. So the lawsuit is just the first step of the lawsuit. But if they want to go and litigate it, fight it out, that's just going to hit fees. So it comes like a very expensive filing fee for families. So it really hits disproportionately people are lower income and those with a lot of money could pay for it, but they're out $5, $10, $20,000 on litigation. And it's not clear which way it's going to go. It's a lot of money just to be able to get an interview or get a visa issue that's going to be issued anyways.
Right. Thank you so much, John, for the detailed explanation. I think we should address some of our questions from our audience. Let's take up Ajay's question. I've been hearing a lot about potential changes to family visa policies under the next administration. In your opinion, what do you think will be the most significant impact on individuals trying to bring family members into the US? I think we've been talking a lot about this, but yes, a few more points.
Yeah, the delays that would be one thing I forgot to mention are the potential travel bans because we have an international audience here. Last time around, now this is kind of controversial, and then a lot of my colleagues don't agree with me, but Trump instituted what's commonly known as a Muslim ban because there's a lot of people from Muslim majority countries. But in practice, that list of countries who were part of the so-called Muslim ban were created under the Obama administration for a different situation. If someone had visited this list of 7 or so countries, they wouldn't be able to use what's called the visa waiver program. So if you're German, you could just come visit the United States with what's called a visa waiver for 90 days. But if you visited Iran or Iraq or something like that, or Syria, you have to apply for a full tourist visa. So they could ask you why you went to these countries and check you out first. And so that list was created during the Obama administration. President Trump just made that list part of the travel ban. But when you look at it, the Muslim majority countries in the world, whether it's Saudi Arabia, Lebanon, these are the countries that are associated with the 9/11 terror attacks, Pakistan, Indonesia, these are the majority Muslim countries. They were not on the list. It was primarily a list of Iran and its colleagues, and essentially in the Cold War that we have between the U.S. and its allies, and Iran and its allies. And you can probably throw Russia in on that too now. So it is really more of a strategic defense maneuver that doesn't really, to my opinion, it wasn't based on Islam. A lot of my colleagues don't agree, and they sued saying it's discrimination. But I think it was a strategic thing against certain countries that potentially are rivals to the United States. But that's going to probably be instituted very quickly, and they have full right to do that. The courts have said that, and they can add people. So on the one thing that is President Trump first created a travel ban on certain countries like Iran, and then he increased it and added countries like Nigeria, for example, which has a lot of Muslim people as well. And the requirement, one of the main requirements, is that these countries share their information that they have on people with the United States databases. So essentially, you open up the books and make yourself a vassal of the United States. Say, here's my books, and it are people. So it is a issue of sovereignty and stuff. But putting that political science stuff aside, Nigeria opened its books and they got back on the list. Now, if you are going to go through visa processing in Nigeria, Kenya, you might be experiencing 3-4 years of wait time just to get an interview. Same with Pakistan or Iran too. A little bit less than those. Those are terrible in Nigeria and Kenya and a lot of parts of Africa. But the delays are out of control, and they're just probably going to get worse and out of control, like years. And just to get an MC interview, once everything is almost at the end of the line, you're almost at the finish line. So bans and delays, that's what's going to be happening for all cases, really.
Right. Thank you for addressing that. Yes, that was another important thing to keep in mind, travel ban from various countries, Muslim countries especially. So, folks out there, you can also join us on call. You can call us on this number 425-436-6335 and dial in this access code 988-888 and just say hello. We'll be able to hear you. I mean, you can just join this discussion. Thank you so much, John. Now, moving on, let's take up Sachin's question. With the possibility of policy changes under Trump 2.0, how likely is it that my family's immigration process could be delayed or complicated? Are there any steps we can take to prepare for this?
Well, I got to see what particular kind of cases that you have, what kind of family cases is it, what are the relationships, how many family members, their ages. One thing that's going to pop up with these delays, which is a problem potentially, is people who have kids that are nearing the age of 21. So for a lot of cases, if you're getting a green card and you have a child that's under 21, they could get a green card with you as part of the case. Depends on what kind of case you have, but most of them. But the kid starts going over the age of 21, they could fall out of that case. Now, there's regulations that help potentially, a couple of years, 22, 23, 24, you're a little bit older, you still stay in the case. But if certain delays happen or the government messes up the systems, makes it hard to function, to find out how to do, especially if you don't have an immigration lawyer, finding out how to lock in the kid's age in different ways is very complicated. I've done videos on YouTube explaining it, but it's very complicated. And for most people, they can't figure it out. So what happens is you got to spend a bunch of money hiring a lawyer, essentially, and hire a good lawyer that knows what they're doing and is going to pay attention to you, as opposed to get some money and disappears. That's a major problem too. Putting aside the Trump administration, finding good help when it comes to doctors, lawyers, plumbers, whatever it is in life, more and more I'm seeing it's hard. It's hard because people are too busy with their own lives and they don't care about their work or the people they're working with. They'll get the money and run. So finding good help to guide you through it, and the cost of it is going to be a major problem. If there is even something that could be helpful that could help this kind of stuff. So doing your own research, studying, and be able to judge. If you talk with a lawyer, you really always should. It's hard, it's annoying, and it's potentially costly. Talk with 5 different lawyers. What you'll see is if you talk with 4 immigration lawyers, you're going to get 5 different answers. And half the answers will be the opposite of what the other lawyer said. Now, how is that possible? It's a mess, but it's possible. So you got to be able to talk with those people, have discernment to see, are they making sense or not? But before any of that, go and study, watch these videos, come to these Q&As, ask your questions. So when you go to the actual lawyer to talk with them, you have good questions to ask. You don't waste your time on simple answers or something like that. And you can tell if this person knows what they're talking about, if they're being honest or not. You got to do your homework to protect yourself. Even if you hire a lawyer, you're paying all the money you think you just hand it off to them. Nothing in life. You got to keep your hands into it. You can't rely on other people. This is such an important thing in your life. You can't just take one person's. You got to get different opinions, study for yourself, and be ready to fight it out and be prepared.
Absolutely, 100% agreed. So do your research, friends, and absolutely get help from an expert and an immigration lawyer, that is, and do your research properly. And yes, you can also contact Attorney John Khosravi himself. You can call him on his number and even email him. And his number is.
So it's 818-934-1561. Now, it'll be an answering service. You give your info. Probably the simplest way for you to do it is just go to our website, jqqlaw.com/contact. Put your name in there. Briefly describe, your situation, because we don't do every case. We don't do asylum, for example. If you tell me you're doing an asylum case, I'll say, no, I just can't help you. But if it's something we do, I'll reply back with information on schedule consultation. We do have consultation fees, and we decrease it for certain cases to make it easier on people. So we always want to know what is the case, so you see if we give a lower fee if possible, and we'll respond to you within 24 hours and get you on the way of what you need to do.
Yes, and please don't forget to let him know that you are joining him from Immigration and Jobs Talk Show. Just to
Yeah, I
know.
would love it.
Yes, for sure. And Sachin, if you have more details about yourself and your family, it would be great so that maybe John can give you better answers as well. Thank you, John, for addressing that.
Yeah,
We have more questions. Let's take up a few from our Facebook groups, if you don't mind.
sure.
But before we move on, I think we can address one more. So, what changes, if any, could be expected for U.S. citizens sponsoring parents or adult children for green cards in the event of stricter family visa policies, John?
Yeah, so the income requirement for the U.S. citizens to have more ability to show, because that's a flexible one. I won't always push against. Back in like 1880, there were a lot of Chinese people coming to the United States. The numbers were less than from Europe, but there was a lot of discrimination happening against the Chinese people coming here. So they started the first public charge rules that say if you're coming in and we don't know if you're going to be able to afford to live here or what's going on, we're not going to let you come in. And the law is in the statute, the Immigration and Nationality Act. It's very vague and open-ended about what they could do about that issue. Currently, what you have to do is just show you make a bare minimum amount of income, and that's enough, and it's really easy to get through. There are issues if you've been in the United States and you get long-term institutional care. For example, you didn't have status, but you're getting health care long-term. You have a disability that requires, like nonstop medical attention. They won't give you a green card because it's going to be too expensive. But most people are not in that situation. But that regulation is very vague, so they could up the ante and make it more difficult if they want to. And so they're probably going to do that to show that the U.S. citizen makes more money, and also the foreign person can support themselves here. It's not going to be a public charge. That's definitely something that they could easily, just turn the knob on and switch it off. And that's something that we can see happening for people in that situation. It's still a lot of people could get it past it, but the paperwork becomes tremendous after that point. And for people doing the case on their own, that's when a lot of problems happen because they can mess up. They don't understand the forms. It's badly written. The rules are badly written. And so the thing is, if they change these rules, no one even has experience on it. So even the lawyers are doing it for the first time. And the government's doing it the first time. So they'll make up a new form for this stuff. We'll send it in. And because the government officers, it's the first time they're seeing it, they'll make mistakes. They'll read it differently than we read it. And there'll be lawsuits. So it becomes a mess. Like it's like a complete unknown of what's going to happen. It's going to be difficult. That's the easiest way to say it. But the simplest way to say it, it's going to be difficult. So you got to be prepared. Make more money, get more education. That's going to help. But inevitably, just talk with experienced people. And just be mentally prepared for the thing's going to go difficult, and that kind of sets a tone so you don't get your hopes up, you get too excited thinking you're having fast. And be careful for people that give false promises. There's a lot of people that lawyers that just tell you, yeah, we'll get your case in a week, we'll get it approved in a week. They'll tell you like things are too good to be true. You got to be skeptical. There's a lot of people act like lawyers online or on WhatsApp groups to say, hey, pay me extra $2,000. I'll have somebody, I'll hook it up. Don't trust these people. Talk to different people, get different opinions. I was doing a consultation yesterday, and the person, it was a marriage green card case. And I was a third lawyer they spoke with, and they're saying everything I said was the exact opposite of what the other two lawyers said. Well, I'm like, well, here's my proof. My Instagram page, here are my approval notices I put there that show the timelines we have. And I cited the statute. This is what the law says. So, I put in the email I sent to them. Like, go and tell those lawyers and get a different opinion. If you think I'm wrong, this is what the statute says. This is what the regulations say. This is my approval notices. I block out the people's names in the case numbers, but I have the proof out that what was happening. So if some people are saying differently, I don't know, maybe, the government's crazy. They do opposite things at the same time. So maybe they had different experiences. But from my experience and what the law says, this is how it is. So you got to, talk to different people and get, get the real proof and evidence and feel comfortable with who you're going to be working with.
So, John, would you suggest, waiting for a couple of months maybe for these changes to get settled and for folks, dealing with these kinds of changes, get familiar with the changes? Would you suggest
no, if
them
you got a
waiting?
good case, do it as soon as possible before they have the chance to make these changes. A lot of times when the government makes these changes, they have to announce it and give at least 60 to 90 days for people to have time to adjust to it. And so if you have a case, get it as soon as possible. We're inundated with work this month, December, because everyone wants to get their case in before January and when President Trump comes in. So we're slammed, and we're probably not going to take a break for the end of the year because we're just going to be filing stuff before that happens, because the day he comes to the office, there'll be different bans, there'll be different issues, there'll be this and that happening. People are going to quit in the government, so it's going to slow down. There's all sorts of problems that are going to happen. So if you have a good case that's solid, sooner you don't put it off. We have people who have been married for 20 years could get a green card. They're living in the U.S. without permission, without status, but they could fix it, but they're just putting it off. Just now calling me and saying, "Oh, Trump's coming back. I want to fix it now." I'm like, "Well, you've been doing it for 20 years. You could have got it 20 years ago. You started now." But there's a lot of people like this. They got to get off the chair and in the car and or get up the phone to figure this out. Just to live in peace, not have to deal with this stuff. Live above board. So a lot of it now starts to happen. People a lot of times have problems they're not even aware of. They made mistakes in the history that they didn't even know was a problem that an immigration lawyer would be able to understand. So talk with a couple of qualified people. You get a feeling for who you trust and who seems most competent.
Right, right. Thank you, John, for taking that up and for the
You're
detailed
welcome.
explanation.
You got it.
Let's go now with our Facebook question. So this is from Kashaf. Willing to relocate from current country to USA family-based immigration program for advanced degree and exceptional abilities. We are, okay.
So this is the
I
kind of thing you
think,
got to be careful of when people say this kind of stuff. This is exactly the kind of stuff you see online, and they post this, and people, fall prey for it. This person, we don't know who they are. They're gonna get, they're making up a case probably. They're saying we do the forms and stuff like that. Okay, like did you ask?
Mhm.
This is an immigration lawyer, a lawyer in general in the United States is not allowed to solicit and say, "Hey, come and I'll like." I mean, I can say we do this work, but you got to be careful how they word it. So if some random person tells you like this, you got to be very careful. So I'm glad you brought it up so people see this is not something
Yes,
you should respond.
call for it.
There's a lot of lawyers. They should be very careful of this kind of stuff.
Yes, thank you so much. Thank you so much. Let's go on with Ankita's question now. Hi, I'm single. I'm a single mother and have recently got my permanent residency through family-based immigration. I'm originally from Fiji. I went to USA for 3 months and now I'm back in Fiji and waiting for my daughter's visa. I filed for a I-130 petition for alien relative for my 2-year-old daughter. I just wanted to know approximately how long will it take for her visa to get approved? Thank you.
So that's a big problem there because if you go by the way you just did it, it's going to take 3 to 5 years. It's going to be pretty bad. And you might lose your green card by not living in the United States because you want to be with your child. Now, we'd have to have a consultation because you have to know how you got your family-based green card anyways, because your child should have been part of that case in most instances. So there's a major problem, a major error that happened in your case that your child was not part of it because they could have got a visa somewhere or another expedited based on the original case. So the fact that your child was not included in your case seems like 90% there's a major problem, a major error happened in your case. And now if you don't fix it in time, or if it's not fixable, you're stuck. It's taking 3 to 5 years for the F2A preference category on what you're dealing with. And since you're a green card holder, you have to be living in the United States. These absences, although they'll probably be lenient about it, but the more you're absent, it's going to delay getting citizenship in the U.S. But more importantly, next time you come in, if it's long enough absences, at the border, they might try to take your green card away, and that'll cancel out the daughter's case. So this is 100% the kind of case you want to have a good immigration lawyer talking with, at least a consultation to figure out what happened as your child doesn't have a green card already or is not already in line for a visa, instead of you having to file an I-130, which is the last thing you want to do with the current delays they have. Plus, it doubles. I mean, you just added a bunch of costs and expenses that were needed potentially. So, I mean, in the thousands of dollars. So, you definitely should consult with a couple of attorneys to figure out what happened, have a copy of your file and what you did so we can figure out what went wrong there, because that doesn't seem right that you needed to do that.
Right. Thank you so much, John, for taking that up for Ankita. Let's go on to our next one. Control, if you could display. This is from an anonymous participant. Hey, my boyfriend waited until way past the expiration date to try and renew his work authorization in Dhaka. Would applying for asylum be a good move? He came to the States when he was a baby and doesn't know any family from where he's from. Please help.
Well, that's a big problem. DACA was a special program that President Obama did to help people who came as kids to be able to live here and work here. And you have to renew it. If you didn't, it's a major mess up. You could try reapplying late if it's less than a year. Sometimes they say they may approve it as a discretionary matter. So that may be one thing to do. But if you're dating and you have a serious relationship, potentially looking to getting married, if your boyfriend entered the U.S. lawfully and you're a U.S. citizen, potentially that could solve things. They'll just get a green card. If again, marriage is in the plans, it's a legit marriage. If not, they may need what's called a waiver, a 601A waiver. If they had DACA and they entered without permission and they had DACA, they could have got a special travel permission that would fix a lot of things up called advanced parole. But this kind of scenario, I wish they had a lawyer they talk with, a family lawyer, someone in there that they could tell this stuff to. it could have saved you a lot of headache and saved your life from issues that's going to happen. So then I would just consider consulting, schedule a consultation time, thoroughly talk to an attorney, know exactly what happened, and know all your options. Asylum is a problem because you should be able to file for asylum within a year of entering. They have exceptions where if you file asylum later, but it's a complicated case. There's backlogs. It could take 3 months to get the case decision. It could take 10 years. And it's an expensive, complicated process. You have to have a valid asylum claim. And so I don't even know if there's a valid asylum claim there. And we don't do asylum, so we don't consult on that. But these are exactly the scenarios. Now, immigration lawyers, some have consultation fees. We do. It's pretty expensive. Some don't. So first, contact people, 2 or 3 people who do free consultations, see if they're worth it or what kind of guidance they give. Then save up money and talk with 2 people who do charge. Compare those 5 people. Spend the time on it. It's your life. And your boyfriend's life is your future. It's worth the investment to get down to business and see what's going on to help save yourselves.
Thank you, John, for addressing this one as well. Let's go on to our next one. We have a couple more minutes. Yes, this is from Maheen. We are a British family currently living in London and want to migrate to US. My husband is IT consultant, works with big firms here, making good money. My husband wants to look for jobs in US now, so we can be close to the family as both of our families reside in the US. Please suggest which visa category is best for us other than H1 as it requires job offer and lottery system, which is not guaranteed. Any other visa category we can apply so that he can get working rights in the USA and start applying for IT jobs there. Yes, any UK based. Okay, this is forget it. Yeah.
Yeah. So in the UK, there are immigration lawyers in the UK, are friends of mine that could potentially help as well. The H-1B problem, yeah, it's a lottery. Is a limited number of people who could get those work visas. You have to have an employer. The EB2 and EB3 green cards normally require employers as well. There's an exception called the national interest waiver, EB2, which is if your work is in the national interest of the United States and you're very successful, you get a green card based on that. Depends on your background. Now, there is an E2 visa option, as you kind of referenced there, that the listener referenced there. That's an investor visa. If you start a small business in the United States or buy a small business, you come here and run it if you're from certain countries. And UK is one of, if you have a UK passport. So that may be something to look into, especially the spouse of the E2 investor gets a full work permit, can work wherever they want. So maybe one partner, husband or wife or whatever partner, takes their money, invests, starts a small business, and their spouse gets an unlimited work permit. They can work wherever they want. And as long as that business is operating, making money and growing and everything, you stay in the United States with your family members under 21, your children under 21, and your spouse. So that may be an option, but you got to look into investment, starting a business. It's not a small affair. It's your life savings potentially. You want to make a right choice on that. But that may be an option for a UK citizen to open it up to come over here and take their life to the next level.
Thank you so much, John, for addressing that for Maheen. Now let's go on to our last question from Facebook, if that's fine. This is from an anonymous participant. Control, if you can display it, please.
Okay,
all right, so I guess we are done then. Thank you so much for that, for addressing all of those Facebook questions and questions from our audience. And I think it's now time to almost wrap up our show, John. So what would you like to say to our folks out there as an end note on this discussion today?
I said thank you for listening. The first step is to get the education, knowledge of what's going on, and just being open to it. Many times people will have the cases destroyed, and then they start calling me, asking up. I'm like, well, if you called me yesterday, I could have done something, but at this point, it's too late. So if you're listening to this, is the first thing is seeking and to have understanding and seeking wisdom. And that's the number one thing in life and outside of immigration you got to do to have a better life. Seek wisdom and understanding. And this is a part of the process, and continue it for your future well-being, especially if you're in this field that you're trying to go on the immigration side. So I really appreciate it that you're watching this, and definitely reach out to, if you want to reach out to us, our contact information, jklaw.com/contact is there. But keep studying. YouTube is wonderful, has all these videos. Now, note that there's a lot of immigration lawyers that I know say wrong stuff on YouTube. Who knows? I may be saying some wrong stuff too. You got to do your homework, talk to different people, and get down to the bottom of it to make the best decision for you and your family.
Absolutely. Thank you so much, John. It was really enlightening, the session. We learned so much. I'm sure all the viewers out there also gained a wealth of knowledge really today joining us here. And thank you so much for doing this, really.
I appreciate it. Thank you for having me on.
I'm really looking forward to have you join us again, maybe in the coming week or the coming weeks. And also, we have our show, Daily Immigration Dose, folks out there, 4 p.m. Eastern Time. So if you can join, and maybe even John, if you can join, it would be great. It's a an open discussion. Anyone can join. So anyone, if you're free, please feel free to join. But thank you so much, John. Otherwise, for doing this today, it was really great having you.
I appreciate that. I wish you the best.
Have a great day. Bye bye.
Thanks so much. Bye bye.
Thank you, folks, for joining us today on YouTube, LinkedIn, Facebook, or Twitter or X. Thank you so much for your questions, and I hope that you enjoyed this discussion. Please do not forget to like, share, and subscribe to our channel, especially if you resonated. Don't forget to like this content, and of course, don't forget to also contact Attorney John Khosravi and go check him out at www.jqqlaw.com. And you can even call him up on his number, 818-934-1561. And his email address is info@jqqlaw.com. Thank you, folks, for joining, and stay tuned on Immigration and Jobs Talk Show, because we are going to be back with more. And yes, 4 p.m., we are going to join you with Daily Immigration Dose. So stay tuned. Bye-bye for now. Hello, everyone, and welcome to another episode on Immigration and Jobs Talk Show. I'm your host, Napasa Pradhan, and I'm very excited to have you join us today. But before we move ahead, I have this important disclaimer, and that is, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. And today is going to be another exciting session today, friends. Thank you so much for joining us. We are streaming live right now on YouTube, LinkedIn, Facebook, and on X, also known as Twitter earlier. So thank you so much for joining us. And let me tell you that you can also participate on this session by commenting, and not only commenting, because I have this number where you can dial in to call us, to participate and have a direct conversation with our attorney. And that is the number is 425-436-6335. And when they ask for the access code, all you have to do is dial in 988-888 and just say hello. We'll be able to hear you. So thank you so much, friends, for joining us. And yes, as many of you know, that H-1B visa is a very critical pathway, for foreign professionals seeking to work in the United States. And it's been subject to various updates and changes over the years, and even in this year itself, when we saw when we look back. So in today's webinar, we will be diving into these new requests for evidence, or RFEs, that are expected in H-1Bs in the year 2025. And these RFEs can be quite challenging, and understanding what to expect is key to ensuring a smooth application process. And of course, to help us understand and explore these better, especially this topic better, I'm really thrilled to have with us none other than a very experienced and knowledgeable immigration attorney who has been, with us for a long time. And yes, it's very nice to have attorney Chand Parvathaneni from Dallas, Texas, SPB law firm. Chand, has been a trusted expert in business immigration, and he's here to shed light on the potential RFEs, how they may affect H-1B petitions, and most importantly, how to prepare to avoid them. So, thank you so much, Chand, for joining us today. I'm really excited for today's session.
Sure, Nipasa. Thank you so much. And in general, I mean, we're entering a new year, 2025. And what's different this year is we're going to have a new president. We're going to have a new administration. So a lot of things, more than likely, are going to be done a little bit differently. Nothing is going to change drastically because there are rules out there. There is a process out there. But the way the things are handled could always change. The priorities of the new administration could be different. So what that means is the way things are done are slightly going to be different. Will they completely stop H-1B? No, it's not going to happen. So things will still continue. The only thing is the parameters, the way the regulations are interpreted. So those kind of things might change. And what that also means is in the last 4 years, we had a Democratic administration. And prior to that, we had a Republican government under President Trump. And we have seen how things happened between 2016, 2020 time period. We have seen a lot of memos, USCIS memos being released during those 4 years, also during last 4 years, and so on. And what that means is every time you have a new administration, they're always looking at how things were done in the past. They're trying to look for ways to refine the process. And every administration has a different way of doing things in a format where they think they're going to get things more refined. And from that perspective, and from the priorities that the new administration is coming out with, we do anticipate maybe some challenges, maybe some refinement. Some things will get a lot better, some things will get a lot worse, and so on. And we're going to use this time today to discuss the upcoming challenges and what kind of RFEs, especially as it pertains to the H-1B world, what kind of RFEs employees can expect and how they can try to be ahead of the curve and be proactive in making sure they're not completely caught off guard and doing things the right way, complying with the law. Because as long as people comply with the law and they meet all those requirements, in general, nothing majorly should change.
Mm-hmm. Right. Thank you so much, Chand, for giving us an overview, kind of, for what we will be covering today, and we are looking forward, definitely. And well, we have Mayan, who has a comment already on Facebook. I would say just stay with us, Mayan. We are going to address your questions, and all you folks out there, yes, you can comment, and remember, you can also dial in. You can call us to have a conversation with us, and especially with Attorney Chand today. So the number is on the screen, and we are here. And I think without further ado, Chand, let's move on with our questions that we have for today. And my first question to you is, what new trends are emerging in the types of RFEs being issued for H-1B petitions in 2025?
So the trends in request for evidence issuance for H-1B petitions, they keep on evolving. And as we approach 2025, I think we're already seeing some emerging patterns that could shape the process. And I think what's going to happen in the last 4 years, so prior to 2020, when we had the old President Trump's administration, and also when we had President Obama in the office, there was a lot of focus on employer-employee relationship. So pretty much majority of the RFEs were about employer-employee relationship, looking for client letters, looking for vendor letters, looking for contracts, and so on. And starting 2021, the focus on employer-employee relationship decreased a lot, at least in the terms of the RFEs that we are seeing. The reason is there was a lawsuit in 2020, and then USCIS went back and rescinded a couple of the old memos. So the focus changed from employer-employee relationship to a lot of other things. And what we have been seeing in the last 4 years, a lot of focus on the beneficiary qualifications, a lot of focus on the degree requirements, the educational qualifications of employees, the work experience, the nature of work experience of the employees, sometimes specialty occupation. So these are the kind of things that we have been seeing in the last 4 years. Starting 2025, I do expect more focus again on employer-employee relationship, and especially when you have jobs involving a third-party work site. So a third-party work site is where you have an IT services company or an IT consulting company. They place their employees at a third party, so at a client location. Those kind of cases, I do expect renewed focus again on employer-employee relationship. How that will happen, we don't know. Whether we'll have some memos or whether the government is going to follow the Administrative Procedure Act and change a couple of things. How they will do it, we don't know. But I can definitely expect some additional RFEs on employers' supervision, their control, and how the control happens, especially when you're on a third-party work site. So definitely renewed focus on employer-employee relationship more than likely will come back again. And also the specialty occupation scrutiny. So we are slowly seeing trends where we are seeing more and more RFEs again slowly increase on the specialty occupation side. So the specialty occupation RFEs, their entire focus is this job, even a complex job, that you really require a H-1B? That is what is typically what a specialty occupation RFE says. They are targeting the nature of the job. That they're trying to see if the job is really a complex job that really requires a bachelor's degree in a specific field. So these kind of RFEs tend to ask for more detailed job descriptions, look at what exactly is happening in the industry, look at the industry standards on the entry-level job requirements, and so on. I definitely think that seeing the recent trends, recent kind of RFEs on specialty occupation, I do suspect that that will again come back in 2025. In 2017, 2018, we saw the same problem. So back then, they used to argue that computer programmer, for example, is not specialty occupation anymore. So we saw a whole bunch of RFEs, a whole bunch of denials back in 2017 for computer programmers. So if there is renewed scrutiny on specialty occupation, what is going to happen is we will have to wait and watch and see what kind of occupations will be challenging, because USCIS can come back and change a few things around specialty occupation and argue a few occupations are not specialized. And going back to the historical evidences that we have, the computer programmer is a good example, because in 2017, we had a huge problem with computer programmer specialty occupation issues. And then the wage levels. 2017, when President Trump first took the office, all of a sudden, we suddenly started seeing wage level RFEs, wage level 1. So until then, we have never seen wage level 1 RFEs. And all of a sudden, USCIS was arguing that wage level 1 is probably not appropriate for specialty occupation. We still see it, but on a very, very reduced level. So more than likely, I think we might see a renewed focus on wage level 1 cases. It will not be a blanket denial, but I can expect more RFEs on the wage levels. And the usual things that normally happen, the degree requirements, beneficiary qualifications, experience of the employees. So those kind of things, I think, will still happen with renewed scrutiny. So that's pretty much what I think we definitely can anticipate in 2025.
Yes, definitely. And we are looking ahead, like you have mentioned earlier, Trump's second rule, and we can expect many things to come back. And well, he may make it a little more difficult for, immigrants out there, if possible, maybe making it harder with RFEs. But let's see what can we expect, and
Yeah.
we will unfold this further as we keep on discussing today in this episode. And we also have Balakrishnan, who has another question. And Balakrishnan, thank you so much for joining us on YouTube. Please stay with us. We will address your questions. But yes, for now, Chand, another question, is that in cases where an employer is a startup or a small company, what specific documentation might USCIS request in an RFE to prove the viability of the H-1B position?
So so on the I-129 form, the form that is used for filing for H-1B, there is a question that talks about the number of employees that the company has and also the income of the company. So upfront, USCIS will be looking at the nature of the company, whether it's a small startup or whether it is a big company or the revenues are low and so on. Apart from that, USGS also does a vibe check. So they do a check where they do a background check to see the nature of the company. Things like what's coming up on the on various reports, the DNB report, and so on. They typically will be analyzed. And if USCIS, they feel that the company is a very small company, or the company is a small startup, it is pretty normal to question whether the position is even viable, because the salaries on H1B, they are very high salaries. It's very common to see a six-figure salary for a IT professional on H1B. The average salary nowadays is around like $95,000 to $100,000 on an average for IT professions. So when you are required to pay such a high salary to your employee, and the company's financials, or the nature of the company doesn't look like it has the money to pay for such a high-tech employment, it's only normal that USCIS will question the startup. So when that happens, so what you are supposed to do is you're supposed to submit a detailed business plan. Sometimes USCIS may just come back and ask for a comprehensive business plan. Lately, we have not been seeing those RFPs, but in the past, it was very common where USCIS came back and put a lot of emphasis on marketing analysis, cost analysis, financial projections, the nature of funding for the in-house projects, if it is an in-house project, the nature of the contract, if it is a third-party contract, the duration of the contract, whether it is a short-term duration, whether it's a long-term duration. So all the things are possible. And USCIS, these kind of documents help USCIS to understand the company's operations, and it also helps to prove to USCIS that the position offered is legitimate and bona fide. And not only that, it is also essential, and it is a position that is in the regular course of the company's business. So that is very important. And what that means is small and startup companies, they should always ensure that their financial documents are readily available and logically prove that they have the resources to support the H1B employment. So things like bank statements, profit and loss statements, tax returns, and sometimes if the company is a very, very brand new company, maybe things like investor funding or capital funding, because sometimes it's a startup. The people who are starting the business, they're actually investing into the company. So evidences of investor funding. So these are all good evidences, because we do want to show that the company is financially stable or financially able to support this H1B position. So that's very important. And for small companies, another important thing is the detailed job description. So the detailed job description specifying what exactly the employee is doing and how that is relevant to the company's line of business. Sometimes a small company could even be an IT consulting company. Sometimes it is a product company. Sometimes it could be an implementation partner. It could be anything. And it has to be, this job description has to be relevant to the regular course of business. It should also show how the employee can supervise, how the employer is supervising the employee. Because if it's a very small startup, sometimes USCIS will question on the specialty occupation. Because if the company is so small, USCIS wants to know who's doing the other non-specialized tasks, such as payroll, such as other non-technical functions that are required in the company. So sometimes you have to have an org chart to show how you're splitting up the specialized duties and non-specialized duties, and who's doing the non-specialized duties. Because a small company sometimes tend to put all kinds of duties to the employee, because they're only 2-3 people shop. So USCIS, we need a very good demarcation of the duties, and only specialized duties have to be assigned to the employee. So these are the kind of things that USCIS is very interested, because their goal is to make sure the position is legitimate, the position is bona fide, and apart from that, they also want to make sure that the employee is not given all the tasks, such as HR, marketing, all those non-technical tasks to the employee, because the company is a small company and they're trying to get everything done by this employee. So the bottom line is the job description should be very, very unique, specialized, and should focus on the technical part. Employee can only be assigned those duties that are a part of that occupation. So these are the kind of challenges that a small startup company could have. And the best way is document the nature of the company, provide various financial documents. Doing so, normally we typically don't have a problem. I've seen a lot of companies who have 1, 2, 3 employees and look for H1Bs, file for H1Bs. As long as the company is legitimate, the position is a bona fide job offer, Even if it's a small startup, yes, you can get an RFE, but in general, USCIS is pretty okay as long as there is a logical reason, logical answer to the need for that position.
Absolutely. Thank you so much, Chant, for highlighting that and very important things to keep in mind. Thank you so much. And moving on, Chand, I have another question. And now this is, how has USCIS's scrutiny of the employer employee relationship changed in the recent RFEs for H1B petitions? And what should employers be mindful of?
Yeah. So 2010 to 2020, so during President Obama's administration and President Trump's initial administration, those 10 years, USCIS had a lot of scrutiny on employer-employer relationship, especially for any IT consulting or IT services company that had a third-party work assignment. So anytime you have an IT consulting company where they had a full-time employee, their full-time employee was providing services at a client location, so that's a third-party work site. So for any of those cases, 2010, 2020, the scrutiny was very, very high. When I say the scrutiny was high, USCIS was asking for client letters and letters from every vendor that was involved in that chain. And if the client did not give a letter, denials were common. This used to happen. And the reason for that was they wanted to know what was the role of the client, what was the role of the vendor in that whole chain. And they wanted to look at all their letters to see how that supervision happened. So that was what used to happen. And in 2020, so there was this lawsuit by IT Serve against USCIS, the government, and IT Serve prevailed in that lawsuit. And what happened was, because of that lawsuit, USCIS went back and rescinded 2 of the prior USCIS memos. And that changed the entire definition of the employer-employer relationship. And because of that court case, what happened is, USCIS said, as long as you can show at least one of the factors, such as like right to pay or something, you are good to prove the employer-employer relationship. So if a company pays the employee, treating him as a full-time employee, that is enough to show employer-employer relationship. We don't need client letters, we don't need vendor letters, etc., to prove the employer-employer relationship. So what that meant is, starting from 2021 to 2000 right now to current timeline, the focus is very low on employer-employer relationship. The reason is, we don't need client letters to prove employer-employer relationship anymore. If the employer is just attesting to paying the salary, and employer is actually paying the salary, that is more than enough to prove the employer-employer relationship in the current format. So what that means is, the burden of proving employer-employer relationship has come down drastically in the last 4 years. That being said, we don't know what's going to happen in the next 4 years, because there are already proposals out there to change a few things, to change the definition of bona fide job offer, to change the definition of specialty occupation. So these were draft proposals that were published during Biden administration. And if President Trump's administration decides to make those rules finalized, the drafts finalized, things could change. So we don't know, but at this point of time, employer-employer relationship is not a huge factor like it used to be in the past. But starting next year, more than likely, it could again come back, where we might again have to submit client letters, vendor letters, clearly stating what is the role of each and every party in the chain of relationship.
All right. At least we know now what can we be ready for. So thank you so much, Chant, for highlighting that as well. And we also have Charwak with comments on YouTube. Charwak, please stay with us. We are going to address your questions in a little bit. Okay. For now, some more questions from my end, Chand. So this is, if an applicant has held multiple roles with different employers under the H-1B visa, how can they prepare for an RFE questioning the job's specialty occupation status?
So again, we have this question a lot. The employee is working for one employer. He has a particular role, and he's transferring to a new employer. And when he transfers to a new employer, the role might not be the same. Sometimes the role could be different. For example, the employee is working as a software developer in the prior company. When he's transferring, he's changing his role. Maybe he has to work as a network administrator. Maybe he has to work as a data scientist or something different. Or sometimes what happens is, the role the wages might be different. Maybe he's working in a very, very senior level role in another company with a wage level 4. And when he's doing a transfer and is coming to this new company, maybe he is not getting the same salary. Maybe it's a junior level role. So the role is different. And a lot of people get concerned and ask us, will that cause a problem that the role is different because it's a different employer, the role is different, and he has so many different roles in the past, and now the role is not similar to what they had in the past. Will that cause a problem? So per se, every role is different, every filing is different. And what that means is USCIS, I've never seen USCIS come back and say, in the past, in a different company, you worked in this role, your role is now different, explain. USCIS does not do that. But what USCIS does is they treat every petition independently. So if they have a petition in the past where the employee got an approval, and now you have another petition where a new employer is filing for a H-1B, they treat this new petition independent, and they don't really use the old petition and say, because we approved that, we'll approve this. This new petition is independent. They will still look at the job duties. They will still look at the wage levels. They will still look at the nature of the company. And when you talk about specialty occupation, if the job description is not clear, USCIS routinely comes back and says, hey, you're this new employer, whoever has filed the job, they will argue that this is probably not a specialty occupation job. And at that point of time, what the company has to do, or if you want to even avoid that kind of an RFE, the new employer will have to provide clear, detailed job description that aligns with the specialty occupation requirements, that aligns with the work experience or the education of the employee. The new employer has to explain why the employee has the relevant skills, either through an academic program or through a combination of academic program and work experience, why he is qualified to do this job. And by doing so, normally what happens is the specialty occupation RFE risk is minimized. So if the employer is not able to clearly define the job duties, clearly expand the job duties, and clearly able to articulate how the employee is qualified based on his education or work experience, we're going to see these kind of RFPs. So the bottom line is every job is different, every petition is different, but every time the company goes and applies for a H-1B, give very, very detailed job description and explain the relevant fields of study that are relevant for the job. So if the employer goes and says, we just require a bachelor's degree in any engineering field, that is probably not specialty occupation. So the employer has to go back and specify a bachelor's degree in a specific field. For example, computer science, information technology, etc. is required. The fields have to be very, very closely related. So you cannot say this job requires mechanical engineering, civil engineering, and computer science, because then the fields are not specialized. They're like very diverse. So the way the employers should be attacking the whole H-1B filing is clear and nice job descriptions. Be very specific on what kind of degrees you require, and make sure that the degrees that they require are actually what are normal as per the industry standards. So you cannot go and say, for a software developer, I require a civil engineering degree, because that is not what the industry standard is. The employers also have to align their degree requirement to the industry standard. So by doing so, they can minimize these kind of RFEs.
Right, right. Thank you so much, Chand. Those were very, very important points, and thank you so much for highlighting them. It's very important to address these issues correctly and in detail so that they work. I mean, why are they asking for an RFE? They just need more explanation on what you're stating there, and being more specific is more important, right, Chand?
That is correct. And again, whenever you get an RFE does not mean it's a bad thing or you're going to get a denial. Majority of the cases still get approved. So RFE is where the officer has a couple more questions and he's trying to get more answers and more evidence back from the petitioner. So RFE is not bad. Whenever somebody gets an RFE, you have to carefully look and see what's going on, and then try to explain and provide more information. And the best way is try not to even go to that situation, be in that situation. So try to be as detailed as possible. That being said, sometimes even if everything is perfect in a case, sometimes the officer might just issue an RFE because he might have some other additional questions. So RFE always does not mean that the petition filing had some issue. Sometimes it also means that the officer probably has some additional questions. and sometimes it might be just a mistake in the filing. But RFE is one good way because people typically don't get a direct denial. RFE is one way where you're getting another chance from USCIS to explain your stand. So the beauty of H1Bs is you always get an RFE, you always get a second chance. That being said, everybody's goal should be to minimize the RFE. So more detailed explanation, more clear filing is the best way to minimize an RFE. But if you do get an RFE, you're in that unfortunate situation, try to explain as clearly as possible. Majority of the cases, I see them getting approved after an RFE.
All right, that is good then. So, Chand, we should address some of our questions from our viewers, and we should take up Dheeraj's question. He says, "Hi, Chand, I have a question regarding my H1B transfer." Hi, Dheeraj. Thank you so much for joining us on YouTube. So, currently, Dheeraj is on H1B and he got a new opportunity in new company, and he says he would like to transfer. But initially, when he was filing the H1B in June, he filed the H1B as future employment starting from October 2024. But due to few reasons, he could not join the current company on October 1st, but joined on November 1st. So during the transfer process, will he be having any issues or will he be facing any RFEs for this reason?
Uh, so again, this is a very common situation because when you have people on H1B, they're working for a company, and then sometimes they get a better offer. And when they get a better offer and the company applies for a H1B transfer, what happens is an employee is working at this company, a new company files for a transfer, and once the new company files for a transfer, the common question that I get is, when do you have to start working for this new company B that has filed your transfer? And the answer for that is, you can file immediately after the company files the case, and the receipt is receipted. So you can start immediately once the case is filed, or you can wait until you get an approval. Number two. Number three, even after you get an approval, you can join them down the line if you're continuing to work for the company A, the first company. So as long as you're working for the company A, you can continue to work under the terms of company A's H1B, and down the line, you can go and join company B. So from a USCIS perspective, as long as you're maintaining your status, you're good, which means you can continue to work with company A and join company B down the line. Only thing is, the day you join them, you have to stop working for company A, and the day you join company B, you have to make sure that H1B is still valid. If you do it, the timeline is probably not a big issue. So you don't really have to start on the day you get the receipt or the day you get the approval. You can join them later on, assuming that you're still maintaining status with the first employer.
All right. Well, Dheeraj, best thing is, I hope you got your answer, by the way. And if you still have any more questions or you want to have a conversation with Attorney Chand right now, you have this opportunity. You can dial this number on the screen, which you can see on top. The number is 425-436-6335, and they'll ask for an access code. And when they do, you just have to dial in 988888 and just say hello. We'll be able to hear you. Thank you, Dheeraj, for your questions. Thank you, Chant, for taking that up. And let's go on to this next one. This is on Facebook from Mia Abu. I received the RFE on the November 2nd, 2024 about educational background. I think we will need more information on this, but anything you want to say on this, Chant?
Sure. I think Abu, I think what has happened is he probably got an RFE for beneficiary qualifications. This is one of the most common RFEs that we see nowadays. RFEs asking for beneficiaries qualifications and asking us to prove that the beneficiary has a US equivalent of a bachelor's degree in the required field. So the way you answer it is in two ways. One, you have to look at the education of the employee. So if your education is in the right field, is in say for example, you have a degree, for example, from India in computer science, for example, and your job is in a computer profession, say for example, as a software developer. If that is the case, all you have to do is you have to do an evaluation of your education. So you send it to an evaluations company, a credentials evaluation company. you get an education evaluation done, and that's all you require to answer your RFE. If your education is in the right field. If that is the case, it's a very simple RFE. Simply get an evaluation done, evaluation of your foreign degrees, send it back. One way. The other thing is, what if your education is not in the right field? Say, for example, you have a degree that's not in a relevant field. Say, for example, you have a degree in mechanical engineering and your job is as a software developer. When your education is not relevant to the job in question, if that is the case, what you're supposed to do is you are supposed to gather all your experience letters. So gather each and every experience letter where you had worked in the past, and gather your educational documents, and then have your employer send them to a university professor. So university professor in US. So there are a lot of companies that will help with professor evaluations. And what you're supposed to do is do something called a combined evaluation of both your academics, your education, plus your work experience. So when you do a combined evaluation of your academics and work experience, the US professor will be able to do an evaluation and see if it is equivalent to a US degree in computer science or a relevant field. And if that is the case, when they add up your experience, if they see that you have an equivalent degree, then you can use that to send it to USCIS, and USCIS typically will agree to a professor evaluation. So your RFE is not a very complex RFE. You just have to see if you have the right education, and if you don't have the right education, do you have the relevant experience? And based on that, get an evaluation done, provide the evaluation copy back to USCIS. And that is the way to tackle this RFE.
Thank you so much, Chand. Thank you so much. And thank you, Mia Abu. I hope you got your answer. But if you have any further details about your case, you can keep commenting. And Peter Reven, you can just call us on this number, which is displayed on the screen above.
Yeah, I think
Yeah.
he's added a comment. He said education is not relevant to the job. So if education is
Okay.
not relevant to the job, what you will do is you will gather all your work experience letters. So do a evaluation with education and work experience together. So together, when you combine the experience, the professor might be able to see if you're qualified or not. And if you have the right experience in the past, definitely you should not have a problem.
All right. There you go, Mia. Thank you so much, Chand, for taking it up. Now, moving on, let's take up Balakrishnan's comment. This is also on YouTube. He's asking, do you think USCIS will focus more on RFEs about the employer-employee relationship in 2025? We've already touched on this a bit. His next part of the question is, what steps should employers take to avoid these kinds of RFEs?
Sure. Because right now, if USCIS gives an RFE on employer-employee relationship, we can just use the right to pay to prove that there is an employer-employee relationship. So right now, it is like very easy to prove. So what could happen is, if you see what has happened in 2010. In 2010, there was this USCIS memo called Newfield Memo. So they issued a memo. And once the memo was issued, they started issuing RFEs on employer-employee relationship. Same thing happened again in 2017-18. They again issued another memo. And based on that, they used to issue RFEs. So right now, before USCIS can again issue RFEs on employer-employee relationship, when I say RFEs, complex RFEs, they more than likely will have to do some rule changes. So if the rule changes happen, then yes, we might see these kind of RFEs. Will rule changes happen? It is a possibility. But what happened in the past is USCIS came out with these memos without following the proper APA, Administrative Procedure Act. So without following the proper APA procedure, they came with memos, which is why they lost in the court. So there was a court battle, and in the court, they did not prevail. So next time, I think if at all they want to renew focus on employer-employee relationship, especially for the third-party worksite kind of companies, they will have to basically do a lot of things. A lot of things, as in follow the proper procedure. They have to basically tell what their proposed rule is. Let the public comment. Once that is over, publish what is the final rule, and again give some time, and then finalize the rule. So if they follow the entire procedure, yes, it is possible. So I don't think it is something that is going to happen very quickly like it happened in the past, because in the past, they just came out with a memo and all of a sudden they started issuing RFEs. And because the court said, no, that is a violation of APA, more than likely they probably will not take a hasty decision this time, but probably do sequentially, follow all the procedure and do it. If they do it, then definitely I think we will see RFEs. And to see what kind of steps employers should take to avoid these kind of RFEs, that is where we see before they make the rule changes, there is a big process. They will publish the draft. They will let everybody that is impacted comment on the rules. So USCIS looks at comments. They try to kind of reason and do things the proper way, which is why we even have this entire APA, this Administrative Procedure Act. And by doing so, I think we will know what kind of steps we have to take before the rule gets finalized. But at least as of now, it is not something that will happen overnight. So we have time, because we will have to wait and watch and see how the rule making process will happen, to see how to basically legally show that we maintain employer-employee relationship if something is going to change in the future.
All right. Thank you so much, Chand, for taking that up. And we are going to address Balakrishnan's next question, but we have a caller right now, so I'm very excited about this. Hi, hello, can you hear us?
Yeah, I can hear you. Can you hear me?
Yes, we can. So may I know where are you speaking from and what is your name? And please tell us what is your question.
Oh, sure. This is Dheeraj here, and I'm from Dallas. I'm in year 2 Denton. And I think I have posted a comment before, but I need few more clarification on that. So that's the reason for calling you. Hi, Chand. So I have Sorry.
Yeah, thank you so much, Dheeraj. Yes, very, very lovely to have you. And Chand is also from Dallas itself. So yes, please go ahead.
Hi, Chand. Good afternoon. Nice to speak to you. And
hey,
I have a question regarding my H1B transfer, Chand. So basically, I'll say a whole scenario so that you can get a better understanding of what I'm facing, and you can answer on that. So currently, I'm on H1B,
sure.
And I got H1B this year in October. So in my I-797A, the effective date is from October 1st, but I did not join the company, filed my H1B on October 1st, but I joined from November 1st. So basically, now I got a new offer from another company, one of the top company. So I just want to transfer my H1B to the other company. So I just have a question, because in I-797A, the effective date is from October 1st, but I could not join on October 1st, but I joined on November 1st. So during this transfer process, will there be any issues? Because I should join on October 1st, but due to the reasons I could not join. So if I transfer to the new company, will they be asking any documents, or they'll be asking any kind of information about why there is gap between October 1st to October 31st? So I just want to know so will there be any issues in the future,
sure.
or anything like that?
I think it makes sense to me now, and I'll explain. I think what you're asking. I think you had a new cap filing, and the cap filing, the approval start date is from October 1st. I'm assuming you have a change of status approval. So when you have a change of status approval that starts from October 1st, what needs to happen is you're supposed to start on October 1st. And in your case, you started on November 1st. And when you apply for a transfer, one of the primary things that USCIS is looking for is, did you maintain status in the past H1B period? And the way they see that is they ask for your pay stubs. So when they ask for your pay stubs, and if they see that there is a major issue, sometimes what they do is they cause a problem, and they can still approve the case. And more than likely, that is what will happen in your case. They can still approve the case because you are eligible for transferring, and the case will get approved. The place where you might have an issue is getting the I-94. So USCIS can deny the I-94 and ask you to go for stamping. So USCIS will not deny the H1B for the reason that you mentioned, but USCIS could ask you to go for stamping if they find that for a certain amount of time you did not maintain status. In your case, it is less than 30 days, so you might get lucky. But again, the worst that could happen is USCIS will say, because you failed to maintain status, we will approve the case without an I-94. And that is what I see happen when there are major violations with maintaining status. And what that means is you go out of the country and then come back. Even last year, I had some cases where people did not join on time. And again, if it's a major issue, USCIS will say go out for stamping and come back. They will not issue the I-94. And sometimes if the violation is not big, in their discretion, they might let it go. So the summary is your transfer will not have a problem. They will approve the H1, but whether they will issue the I-94 where you don't have to leave the country, or they will not issue the I-94 but make you go out for stamping, that is where the issue could be. But again, from a transfer perspective, because you crossed October 1st, the transfer by itself will not be a problem. You are cap exempt. Okay, so whether you have to go out for stamping or not is probably the only question that USCIS might come back with because of the issue you mentioned.
Okay. So what are the remedies should I follow to avoid that, or will there be any
I mean, what I would do is just document what happened for that 1 month. I mean, again, there is no remedy. You did not work, you did not work. But again, if there is any logical reason, I mean, try to basically just document that part. Since it's only 30 days, I mean, I don't think long-term you'll have very severe repercussion. But again, document your reasons to minimize the damage, because the reason that you said is not a reason to deny your H1. So they will not deny your H1 for that reason. Okay, so but again, because one of the things that the attorney for your transfer company, they will more than likely ask for your pay statements, and they will let you know what to do. At this point of time, I think you should probably, I mean, continue with your transfer. I don't think it's a fatal mistake.
Okay, sure, Chan. So, I mean, I'll be getting the pay stub for November month in 4 to 5 days. Like from November 1st to November 31st, which I have worked, I'll be getting that pay stub in 2 to 3 days. So that would be fine, to submit to the USCIS. I mean, I have the previous 3 pay
Well, I think your attorney will tell you more. There's a little bit more than that. I mean, your case is a little bit more complex. From your side, I think what I will tell you is it is not. I mean, your transfer probably will not get denied, but your attorney is probably going to work with you. Okay, because the pay statement is missing, so you'll probably have some documentation to do with your other attorney, the company that's filing the transfer. But on a high level, I think you're still eligible to do a transfer. It is not that you're ineligible for this reason.
All right. So thank you so much, Dheeraj. And I think if you have any further questions, you can also contact Attorney Chand directly, have a one-on-one discussion. And his phone number is 817-523-8247. It's on the screen. You can also email Chand. You can tell him that you contacted him on Immigration and Jobs Talk Show, and let him know that you're the same Dheeraj. So his email address is law@spblawfirm.com, and you can also go visit www.spblawfirm.com to get to know more about Attorney Chand Parvathaneni. And thank you so much, Dheeraj, for calling in. And
Thank you so much. Yeah, thank you so much, Shan, and thank you so much.
Thank you, Dheeraj. Yeah.
Thank you.
Thank you, Dheeraj. So thank you, Chand, and for addressing that and taking, giving us what we needed, especially Dheeraj. So moving on now, Chand, we have Charwak's question. Oh, sorry. I was saying about Balakrishnan's another question. It's very interesting, actually. It's about AI. So for tech jobs like AI, will USCIS make it tougher in 2025? Sorry about that. 2025 to prove the role qualifies as a specialty occupation, and how can we handle RFEs if the job is in a rapidly changing field?
Right. And I think that is what, I mean, I think only time will tell. But again, in the past, we have seen where all of a sudden USCIS will change an occupation, and all of a sudden an occupation which was very specialized all of a sudden becomes an occupation that is not that specialized. And to give an example, just recently in last 2-3 months, there is this occupation called computer systems engineers. There is an ONET code for it. And the entry level requirement was a bachelor's degree till 2-3 months back. And all of a sudden that got changed to something where it does not require a bachelor's degree on entry level. So things like that could happen. And because the IT profession is so dynamic, so within IT profession, there are some fields like web developers. Web developers, USCIS stand, the Occupational Outlook Handbook stand is that it is not, I mean, at entry level, it does not require a bachelor's degree. So the yardstick for USCIS currently is they go and look at the Occupational Outlook Handbook, they will look at that occupation and they will see what the OOH is talking about the occupation. For example, if you go to this Occupational Outlook Handbook, you look for software developer, or you look for data scientist, or you look for computer programmer right now. The entry level requires a bachelor's degree. So upfront, it says that it requires a bachelor's degree. So USCIS more than likely will not question about specialty occupation. But again, there are some occupations in IT industry which are pretty popular, but OOH on an entry level does not require a bachelor's degree. So those kind of challenges are possible. And since AI or the tech industry is so dynamic, what is a specialty occupation today might not be a specialty occupation down the line. So this is going to be a challenge. And normally, as a lawyer or as a legal professional, what we do is we look at the industry standards. We look at the same set of standards that USCIS sees. And normally, when I see a job that comes in an occupation that could be challenged, we let the employers know that this is an occupation that could be challenging. And sometimes maybe it's a very senior level role, not an entry level role. So even though at entry level, it does not require a bachelor's degree, maybe at a higher level, it requires higher wage level, it requires a bachelor's degree. So there are so many things that could go on. And there are rules on what USCIS should look for. So there are ways to prove an occupation is a specialty occupation. And I definitely think in 2025, we will at least see some challenges with some of these occupations. And to give an exact equivalent, in 2017, we had a challenge with computer programmers. Computer programmers, which we thought all along was a specialized field. Back in 2017, we had a challenge. And 2017 to 2020, we had so many challenges with computer programmer occupation. After 2020, computer programmers, again, I think was accepted. So when I say computer programmer, this is different from software developer. Software developer never had a challenge. Computer programmer had a challenge in those years. So hopefully, all of us will keep up with what's going on in terms of rule changes next year. And we just have to look out, and employers have to be careful, because if it's an occupation that USCIS does not treat as specialized occupation, they have to think twice before filing a petition in that occupation.
Right, right. Thank you so much, Shant, for addressing that and for also giving us a few examples. And at this moment, I would like to address a few questions from our Facebook group. So I'm sharing my screen. And we have this first one. This is from an anonymous member saying, I just want to share my experience on my AOS process as a B2 holder who married USC. Came here last year on a B2 visa, married my long time BF after 30 days since I got here. Filed all the forms after 90 days since we got married. And finally, I got my approval. God is so good. Just waiting for my green card to arrive. Thank you to this. Okay. I did my DIY, no lawyer, compiled all the RFEs asked. Okay. I think there's not much here. Let me take this next question. This is from Joseph. Hello, I got laid off from Intel Corporation and I'm almost at the end of my H1B grace period. I have to transfer my H1B to a new employer by December 20th to legally stay in the US. Other visa options like B2, F1 are not applicable for my case. Please let me know if you know. Okay. My background is mechanical engineering and manufacturing engineering. There are IT, CS consultancies out there to do my H1B transfers. Well, the question is, well, if you have anything, anything to say to Joseph Chand.
Yeah. So I think what he's trying to do is he's trying to find a IT, just a consulting company just to transfer his H1B. And he's talking about, I can run my own payroll. Upfront, that is illegal. I mean, if they're trying to do something where he's running his own payroll, what that means is he's paying somebody to stay in status. That is more than, I mean, that is upfront illegal. And you cannot transfer to a company and start paying your own payroll taxes, because that is fraud. It's fraud and misrepresentation. There is no bona fide job offer. So you have to be cautious. And then again, like if your background is in one field and an IT company is filing for an IT job, US is going to question on the nature of your qualifications. So overall, I mean, again, the rule is you have 60 days. Within 60 days, you have to find a bona fide job offer, not like any H1B transfer, because you get a H1B transfer filed and it is not a bona fide job, and USCIS tomorrow finds out about it, or at the consulate, the consular officer digs into your petition. Tomorrow you could have a lifetime ban. For any misrepresentation or fraud, you can run into issues. So don't just go to any random companies because you want to stay in status, pay them money, or tell them to run your payroll. Running payroll, that is illegal. I mean, when you say I'm paying my taxes to run the payroll, that is illegal. If the company is filing a H1B, you're working for them, they're supposed to pay you. Benching is illegal. So a company cannot bench you and say, you pay the payroll taxes, we'll run the payroll. So that is illegal. So just be cautious and stay away from any kind of things that could get you in trouble. And misrepresentation will get you in trouble with a permanent bar to US down the line.
All right. Thank you so much, Chant, for taking that up for Joseph. All right, moving on, we have another one. This is from an anonymous member. I need help. My case status for all family members, 4 of them, shows that an RFE has been issued on 4th November. Though I received only one kid RFE and never received other 3 RFEs. Called chatted agents, okay. They said they don't have digital copy of other 3 RFEs, so can't send on email. It's been almost 1 month, and no one in USCIS knows that what is RFE about. And they said office that has file has been notified. What should I do?
Yeah, I think when he's like trying to like call or chat with the agents, they're probably like, I think they're just the front end staff, so they're not able to see what's going on. But what he should do is go to USCIS website, and under USCIS website there is an option to create service requests. So create a service request, and one of the things is lost or not received notices. So you'll see that option clearly. Click on that option, create a service ticket, because that is your evidence. Once you create the ticket, you should get an email back saying that they've received your ticket, and within a certain timeline, USCIS should respond back. Because when you create a ticket, it goes into the ticketing system, and somebody will research on what exactly is going on. So give the receipt number, create a ticket with that information, and then internally they will check and they'll have to investigate what's going on. And USCIS always will respond before 30 days, most of the time. So instead of chatting with the agents, where tomorrow you might not even have any proper log or proof, go to the USCIS website and look for this option that says the creating a ticket, and create a service request. And there is a clear service request option for lost or not received notices. So make sure you create the ticket. That's also your proof. Down the line, if something happens, you have notified USCIS that you have not received the notice. And normally, if you create that kind of a ticket, they usually respond back, and they usually will resend the notice back to you.
Right. So thank you so much, Chant, for taking that up. And I think we can have the next one from Control. Thank you so much, Chant, for taking that up. So we have this next one. If it's been almost 4 months since USCIS received my application, but they haven't sent my RFEs, does that? Sorry, Control. Can I have it back on the screen, please? All right, so let me just read it out from my screen. It's been almost 4 months since USCIS received my application, but they haven't sent any RFEs. Does that mean everything we sent is enough? Or could they still ask for more? PD 8/8/2024 biometrics are done. So far, my interview is waived. I know this can change. I'm just curious. Okay.
Yeah, since I think the post is talking about priority date and biometrics are done, my guess is this is for more than likely a green card filing, adjustment of status filing. And for an adjustment of status filing, 4 months is probably just, I mean, it's just recent application. And right now, it does not mean everything is enough, or it does not mean something is wrong. They're still processing the application, and hopefully in the next couple of months, you will hear something about it. But 4 months is too early for these kind of applications. And in the next couple of months, hopefully you'll find something. And again, if you get an RFE, you get 87 days in general. Respond back quickly. If you don't get an RFE, you get a direct approval. That is also very good. And I think, like you mentioned, that more than likely your interview got waived. That is a very, very big possibility, because nowadays, not many people get interviews. because of the interview waivers for AOS applications. So hopefully your interview is waived and you get a very speedy approval. But again, 4 months I think is like too early. So next couple of months you should have an answer.
All right. Thank you so much, Chand, for taking that up. Now, moving on to my next one. This is um, okay. I think I have to do it from my screen. So let me just. So this one is, what are probable RFEs for EB1C on H1B?
Uh, so when we talk about EB1C, what it means is somebody has worked as a manager in a foreign office and they're coming over to US office to work as a manager. So even if somebody's on H1B, they don't have to be on L1A. Even if somebody's on H1B and if they are qualified, you can always do a EB1C I-140. So the most common things that we see on EB1C is whether the foreign office and the US office, are they properly connected? Because there is a specific way in which the companies have to be connected to qualify for EB1C. So the relationship between the foreign entity and the US entity. So this is one of the common RFEs that we see. And another common RFE that we normally see is the managerial duties. What kind of managerial duties did you have back in the foreign office? What kind of managerial duties do you have in the US office? So it's typically on the managerial aspects we see RFEs, or on the company to company relationship, how the companies are related. Are they affiliates? Are they subsidiaries? Is it like a parent company owning a child company? So these are typically the most common RFEs that we see. And if most of the time, it's also with the duties, because it is a managerial intra-company managerial transfer. So they want to make sure somebody worked as a manager, somebody's going to work as a manager in the foreign, is coming to work in US office from a foreign office to work as a manager. So that's where most of the scrutiny is going to be.
Thank you so much, Chand, for taking that up. And let's go on to this next one. This is from an anonymous member. Help. I just got married end of last month. We want to get in line ASAP for AOS before Trump sits in. We trying our best to complete the I-130 and I-485 package, and my husband is cooperative, but we wanted to avoid RFEs too. Does it even matter at this point if we submit it this year versus next year?
So what will happen is even if they apply this month or next month, I don't think the package will be opened and the officer is going to be like reviewing that application immediately. And that's why there is a processing time. The I-130s and I-485s take a couple of months to be approved or even issued an RFE. So whether they apply today or tomorrow, say for example, come February or March, there are some rule changes. I mean, again, the new rule changes probably will not be retroactive, but the scrutiny will always be there. So again, if in the future, if you don't apply now, the rules could change and it could complicate your process. To give an example, what happened during the last President Trump's administration was they changed the I-485 application. They added a lot more public charge questions. So doing that public charge, they even added a form. So it became a very complex process. And right now in the I-485, the public charge part is pretty simple. So if you ask me whether if you wait, things will change, they can definitely change the process. They can pretty much change the forms and ask for more information, and it could complicate the form. So from that perspective, yes, do it as quickly as possible. But even if you do it today, you're not going to get an approval in like a month. It's going to take a couple of months, and it all depends on what kind of rule changes we'll get in the future, what kind of additional things they might ask in the future, and so on. But I definitely would file it as soon as you can, because at least now we know that the forms are not changing anytime soon. And if the forms change, you have to redo all the forms, and the forms are complex. So again, whether you get an approval in a month or not, it doesn't matter. I think go ahead and finish it off. So that way it's one thing out of the way.
All right. Thank you so much, Chan, for addressing that. And if you have a couple more minutes, I think we can go on. Yes, we'll take this one from Mona
Sure,
Lisa.
sure.
Hi, I recently received a request for evidence from USCIS requesting details about my employer and the e-verify number. I'm feeling a bit unsure about how to structure my response and would appreciate any advice or guidance. If you have experience with responding RFEs, navigating USCIS process, I would be grateful if you could share and help me with any tips, insights, or examples of successful responses.
This RFE is I mean, I've seen this RFE a lot of times for STEM OPT extensions. So when somebody who's on OPT is trying to apply for a STEM OPT, that E-Verify number is pretty important. And if sometimes some employer accidentally puts a number wrong and USS is not able to see a result for that, they issue these kind of RFEs. So the easiest thing is like just show that RFE to your employer, check with them on the E-Verify number, make sure they're able to re-verify, give you the documentation, and attach the documentation as a part of your RFE response and respond back. So, I mean, it's probably a simple RFE where they got some digits wrong. Confirm with the employer, send them the right E-Verify number, and more than likely should not have an issue.
Okay, great. Thank you for taking that up for Mona Lisa. Now, this last one, this is from, let's have it on screen control. Trivikram. Hi all, I am on H1B and working as a contractor. My spouse is on H4 EAD and she is working for another client as FTE. My current client has offered me the FTE role. If I switch to a new employer, will it impact my spouse's visa status? Please let me know.
So anytime somebody is on H1 and then doing a transfer, the transfer from one employer to another employer, if the spouse is on H4 and H4 EAD, you don't have to really again apply for H4 and H4 EAD. If the H4 and H4 EAD is still valid, when the principal H1B spouse transfers his employment, the H4 EAD automatically transfers over. So the H4 EAD is still valid till the end date on the H4 EAD. So you can just, if you get a better offer, you can move your employment to this new employer. Your spouse who's having a current H4 and H4 EAD, they are still valid to use that H4 EAD till whatever time that H4 EAD permits them. Only thing is look at the H4 EAD closely, H4 closely. Make sure you file for an extension before they expire. You don't have to file for a transfer right away. So they are good to go. So the H4 EAD spouse should not have any problem at all.
Awesome. Thank you so much, Chand. That was great. You know, you patiently took up so many of our questions, addressed so many of our viewers' questions, and it was so exciting to have Dheeraj on call, our first caller. So thank you so much, Dheeraj, for joining us. And please contact Attorney Chand Parvathaneni for further consultation and to get to know more on your case. Thank you so much, Chand. And maybe, you know, we can cover this topic again in the coming week if you want to, Chand. But for now,
Definitely.
I think we'll have to wrap up. And whatever you have to say as an end note to all our viewers who are watching us right now, it would be great to know.
Sure. And I mean, I think the big thing is, I think, again, compliance, we talk about compliance a lot of times. Everybody has to comply with the regulations, the government regulations. So, I mean, again, a lot of people, I think there's a lot of scaremongering going around all around. And President Trump, we have seen President Trump in 2016 to 2020. He definitely appreciates the value of H1B program. He's not going to abolish that program. He is more about refining the program because I think in some ways, they're correct. There is fraud in H1B program. We always see issues. We see this RFEs talk about fraud, misrepresentation. So the administration is more concerned about the fraud, misrepresentation, those kind of issues. They want to refine the program. And what that means is they keep changing rules. And sometimes the rule changes because they come all of a sudden. People are taken aback. And in short term, it causes a lot of issues. But I think nobody's trying to abolish this program or nobody's trying to completely cut this program because H1B program adds a lot of value to US economy. It adds a lot of value to the tech industry. US tech industry will not survive without the H1B program. There's a lot of value addition that happens because these employees who are highly educated, highly specialized, bring a lot to the technological innovations that are happening in US. So H1B program will always be a valued program. I think they might try to cut the fraud that is happening in the program. They want to strengthen this program. And I think the administration, the rule changes that you see will all be towards refining the program. What that means to all the employees is work for a reliable company. Don't work for any random company which you think is probably not a reliable company. As long as you're working for a reliable company, even if it's a small company, even if it's a consulting company, even if it's a full-time startup or a big company, it doesn't matter. It has to be a legitimate company. As long as it's a legitimate company that is doing business and it's been in business, you know that they have other employees, you are good. But again, if a company is a fraudulent company, you will know the way they talk to you, the way they're paying you. So don't work with any company that is not following the regulations. If a company is following the regulations, it doesn't matter. Small company, big company, doesn't matter. You'll be okay. So the bottom line is try to work within the framework of the regulations, work for a legitimate employer, and more than likely you should not have any issue.
Absolutely. Thank you so much, Chand, for joining us today. It was really great having you in this discussion. Very, very insightful discussion, and so much we got to learn from you today. And I'm excited to have you back. I hope you can join us again in the coming week.
Sure, Nipasa. See you again next week.
See you, Chand. Have a great day ahead. Thank you once again.
You, you too.
So, folks out there, thank you so much for joining us, and really great to have you all. If you want to contact Attorney Chand Parvathaneni and have a one-on-one consultation regarding your case, you can call him up on this number, 817-523-8247. And you can also email Chand. His email address is law@spblawfirm.com. And you can also go visit his website, www.spblawfirm.com. And thank you, each one of you, for joining us. You can also contact me, by the way. My phone number is 408-335-6444. And you can also email me. My email address is nipa@staffingly.com. And another very exciting thing is that we have daily immigration dose from Monday to Friday at 4 p.m. Eastern Time. So in, say, about 15 minutes or so, we are going to join in again. So stay tuned to Immigration and Jobs Talk Show. Thank you, each one of you, for joining us once again. And bye-bye for now. Hello and welcome back, everyone, to Immigration Talk. I'm your host, Pastor Pradhan, and today we have an exciting and highly informative session lined up for you. But before we move ahead with what our topic of discussion is going to be, and I even introduce you to our guest for today, I have this very important disclaimer, and that is, by watching our videos, you agree and understand that the information provided to you by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. Once again, friends, thank you so much for joining us. We are streaming live right now on YouTube, LinkedIn, Facebook. And let me tell you that you can also participate in this session by commenting. So, whatever questions you have, especially with regard to the topic of discussion for today, it'll be very nice if you can comment them. And we will definitely make some time later in this session to answer to your questions. So thank you so much for joining us. And definitely, I mean, the 2024 US presidential elections have really stirred up a lot of discussions, and people are really anxious also, especially when it comes to immigration policies. So, with potential changes on the horizon, many of you are wondering maybe what will happen to US study and work permits in 2025. So, to help us, navigate and dive into this really very critical topic today, I'm really thrilled to introduce you to our esteemed guest who is going to join us today for the first time on Immigration and Jobs Talk Show. None other than Attorney David Garson. David is the founding partner of Garson Immigration Law, one of Canada's premier immigration firms, and he is a certified specialist in citizenship and immigration law, recognized by recognized by the Law Society of Ontario and is ranked among the top 9 immigration lawyers in Canada by Chambers and Partners. So, David's extensive knowledge and expertise and experience in this field definitely makes him the perfect expert to help us in this topic today. So, without further ado, please help me welcome David Garson for the first time on Immigration and Jobs Talk Show. Thank you so much, David, for joining us.
Thank you so much for having me. It's a pleasure to be here.
Absolutely lovely. And maybe you would like to tell us a little more about yourself, something you may want to highlight or tell us about yourself, anything at all.
Sure. I've been practicing immigration law for over 30 years. I'm dual licensed in Canada and the United States. We help individuals enter Canada and we help them go to the United States. So, I mean, we've seen a lot of what has been going on over the years, and immigration as it's been influenced by politics, and frankly speaking, politics has been influenced by immigration. So it's a very interesting time that we're facing right now, without a doubt. There's an old curse, though, may you live in interesting times. So I imagine that there's a lot of anxiety and a lot of questions that people have, including me, because I know we're going to get into questions and you may hear this a lot from me going forward, but we really don't know much yet. We know what the intent is. We know what this administration had done previously when it was in power, or this president, but we don't know necessarily what is going to happen in the next 4 years. But there have been some indications. There's been some statements on the campaign trail, and I think we can try to piece together or guess, prognosticate as we go. So I look forward to it.
Me too. And definitely with your expertise and experience, I'm sure your perspective is going to add a lot to the viewers out there. I mean, who are all anxious, want to know more, what is going to happen. And some of them are even maybe, fired up to even acting quickly. So maybe you might want to warn them or give out some tips to relax them. So thank you so much, David, once again for joining us. And as we already have said about the topic of discussion, today's topic is U.S. study and work permits, what to expect in 2025 after the elections. So I'm sure folks out there are very, very excited. And I can already see some comments popping up. So thank you so much, Supriya, our first viewer who has commented with a question. Please stay with us. We will address your question a little later. So, David, are you ready for our questions now?
Sure, let's go.
Let's go. So, how do you anticipate changes in U.S. study and work permits under the new administration, particularly for international students and foreign workers?
Well, it's an interesting question because, as many people may remember, under the last administration, they did try to enact legislation or presidential orders stopping people from coming or stopping students from coming and regarding work permits, but the courts overturned them on various occasions. So whenever they were attempted to try to sort of enact things or move forward, the courts sort of made them take a step back. So in the end, they didn't really get a lot done legislatively, meaning they didn't pass a lot of laws with regard to be restrictive. But what they did do, and what they can do again, is you can work within the system to make things more difficult if you're so inclined. I'll give you an example. If somebody makes an application for a student visa, as many people who are watching probably know, you have to satisfy the State Department or the consulate of a few things, one of which is that you have temporary intent. Now, that's a very broad concept, temporary intent, right? You have to show that you are willing to go back to your home country at the end of your studies. So to do that, you present a lot of documentation. You show you have bank accounts, or you have ties, you have family, you may own property, job offers, things of the sort. So you keep doing this and you go to the consulate and you say, okay, I've been accepted to for University of Pennsylvania. And here's the proof that I've been accepted. Here's my I-20, which is the document you have to present. And here's my proof that I have ties. A consular officer can look at it, because it's very discretionary, and say, okay, I'm satisfied with those ties. Fine, we're going to give you the student visa. Or a consular officer can say, no, not satisfied, not good enough. Now, if an administration wanted to curtail the number of students that come into the country, then what they can do is simply tell the State Department, which tells its officers, perhaps look at these applications a bit more critically. Maybe don't there may be another set of criteria we want you to examine in that regard. So they can make things more difficult without changing any legislation for people from getting student visas. So let's say that somebody does get a student visa and they come into the country and they go to school. As many people know as well, at the end of their schooling, they can get something called an OPT, optional practical training, for a year. And then subsequently, under the Obama administration, they said they can extend that by 2 years, okay, if you're in a STEM field, okay? They could take away that. That was something that the Obama administration put into effect. That's not something you have to have. And certainly that means that in terms of being able to work at the end of your studies, they could make that of 1 year, they can make it shorter, they could play with the STEM time frame, they could play with the OPT time frame. So I guess what I'm saying here is, what do we think is going to happen? I think that if they want to make it more restrictive, they can do a lot just with what the legislation and the rules that are on the books. And then subsequent to that, in terms of working afterwards, they can make it more difficult based on how they want to work the work permits after you graduate.
Okay. So we can definitely expect another layer of scrutiny or maybe tightening of.
I was going to say, and there may be a question going forward that we want to, yes, I think based on previous experience, but remember when I started, I said that politics play a huge role in immigration, meaning especially the people that advise the president with regard to this. In his last administration, there was a fellow named Stephen Miller who was advising President Trump on immigration. Now, Stephen Miller was a pretty restrictive guy with regard to immigration. He had thoughts and policies that meant you couldn't, he wanted to narrow the ability for people to come to the United States. I don't know, or I haven't heard that he's advising President Trump, this administration. In fact, he's taking a lot of advice from Elon Musk. Now, I'm a guessing man. If you guess, Elon Musk would know the value of foreign workers, and especially people in STEM fields, with regard to what he does. So if he's advising President Trump and he says, okay, listen, we need people, let's say, with regard to the H-1s or OPTs, because these are the individuals that we need in the tech sector or the manufacturing sector or the innovation sector. And so maybe let's not be as harsh as we were previously.
So there we go, friends. And I think along these lines, we are going to definitely dive deeper and we have more questions and more people joining us. So I'm really happy. Hello to George, if I'm pronouncing it right. Hello, George in LinkedIn. And we have Namrata Reddy, Jayakumar. Please stay with us. We are going to take up your questions for sure. So David, my next question is, what specific policies do you expect Trump administration to implement in 2025 that could affect students applying for F1 visa or those already in OPT?
I'm thinking, as I said before, that they are going to be more restrictive with regard. This is what I expect. Everything I'm saying here is I'm just guessing the same as you, but based on what I've seen and based on what I've heard, I do expect them to be somewhat more restrictive with regard to issuing F1 visas than they have been. I also expect them to be somewhat more watchful. I mean, I don't think they enjoyed seeing, and especially they spoke out on the campaign trail, all of the occupied at the universities in terms of the encampments. I think that was something that was not something that this Republican Party, or certainly this president, wants to see going forward. So I think there may be somewhat more restrictions and or variations that are imposed on individuals with regard to what they do when they do come to the United States, if they get their F1, and if they do act in a certain way when they're here that doesn't exactly or expressly have to do with going to school, then there may be further actions that can be taken against them with regard to leaving the United States. In terms of work permits, you know, as I said, they got slapped a lot last time they were in power with regard to changing the law. So they acted or created situations that gave them what they wanted to do. They slowed down processing. They made it, the amount of denials increased in terms of the percentage. So they can do things like that. I would guess, based on what they've done before, that's what they'll do again.
Okay. Okay. But it's really nice to have, your point of view, your perspective on this. So thank you so much, David, for doing this with us today. And also, since we're talking about students, maybe you could tell us what challenges should students be prepared for, especially student visas on F1 and work visas H1B.
So when you're coming in, and as I said, when you're asking, I mean, if somebody's applying for an F1, the easiest way to refuse a person, if they have the money to pay and if they have the money to support themselves and if they have been accepted to the school, the easiest way to be refused is on temporary intent. So if you are applying for a visa, to document yourself with regard to temporary intent and your ties to your home country, I think is going to be crucial. I think you have to have as much documentation as you possibly can with regard to your case and with regard to your ties, so that when you go to the consulate and you apply, that you are able to convince the officer that you do have that temporary intent and you can come to the United States and you will leave. I think that's going to be paramount with regard to that. In terms of the student visa, I mean, once you get a student visa and you get your OPT at the end, the issue is that, of course, with the lottery on the H1s, and it makes it difficult to get an H1 in any event. And we are, for instance, contacted by companies all the time that have an individual who is in OPT status and has applied, and they've tried to get that person in H1, and they can't. They've not been picked. And a year goes by, and if they're on STEM, they have the extension, but they don't get picked. And so the company is looking to see if they can go work in another place for that company elsewhere in the world or something of the sort. So the advice I would have, realistically speaking, is that once you're here on the OPT, I mean, it's not, you don't really have control of this situation. And unless they expand the number of H1s that they're willing to give in a year, realistically speaking, I would probably look at, on practical advice, working for a company that maintains as a multinational corporation that can send you other places if they need to, if that's at all possible.
That's good advice. I think that we should consider for sure, folks out there. I think you should look onto that too. And, David, I think we'll quickly take Jaya Kumar's question, if that is fine.
Sure.
So let's go with it. I got 221G issued with white slip, and after a week got an email that intend to revoke from consulate in India. What are the chances of getting approved if my employer responds back?
Oh, that's a very good question. So first of all, for anyone that wants to know, 221G means they need more information. So there's various ways that a consulate can refuse you. It could be under a section called 214B, which is that temporary intent section. The one you don't want is something called 212AC, because that's misrepresentation and that's horrendous. 221G means that they need more information. So they're refusing the case pending more information coming in. It's a refusal, but it's kind of not a refusal, because it means that they're still considering the case and are okay to get more information. Now, I don't know the background of this case in the sense, why is there an intent to revoke? Is there an intent to revoke because they came upon other information that sort of speaks against what was previously submitted? Have they perhaps done an investigation and figured out that there isn't something here that they need that didn't occur or something of the sort? So in answer to your question, what are the odds? It depends on why they're going to revoke. If they're going to revoke because they have definite objective information that's not good, then the odds may not be that high. But if the intent to revoke is based on a misunderstanding or information that they didn't get or thought or they misread, then it could be fine. Realistically speaking, I mean, whatever you do, when you file that information that is supposed to, that they want, please make sure it's as fulsome as possible, because you're going to get one crack at this. So if you're filing that information that's in addition to what they want to try to address the revocation, make sure it's as fulsome and as packed with whatever you need as possible. Don't play games with it. Because also, and again, I don't know the background, if you submit information that isn't helpful and they are looking at it and saying, well, we're revoking this because we think there is misrepresentation, then you could get slapped with that 212A6C, which is never a good thing. And it could be very deleterious to the case.
Right, David. Thank you so much for taking that up for Jaya. And Jaya, thank you for your question. Really great question. If you have any further questions, you can keep commenting. And we have Jorge saying hello, and he has a question. What can an experienced engineer in the IT industry that is a non-US citizen do to get a working visa, any type?
In the US or anywhere, I guess, in the US?
Yes, that is a non-US citizen, maybe in the US. Yes, in the US.
Yeah. I mean, realistically speaking, it depends on your citizenship, of course. If you're Australian, for instance, you may be able to get an E3 visa. Or if you are, let's put it this way. So there's different types of visas you can get depending on citizenship as well. So if in the normal course, everybody knows about the in the US. Okay, good. Everybody knows about the H1. Right? You have to have an employer. The employer has to register. You have to register that expression of interest. The rates of acceptance haven't been that high. They've had a lot of applications, and a lot of people have not been chosen. But that is the normal way that most people do get visas. There's something called an L1, an intercompany transfer. So if you, for instance, are an engineer and you go work for a company overseas for a year, and that company then wants to do this L1 intercompany transfer, they can do that to send you into the United States. If you go work for a company that has your nationality, there's treaties of navigation and trade. It's commonly called the E-visa. So if you have the same nationality as the company ownership, then they can try to get you a visa under the E-visa category. If you're Canadian, then you have the free trade agreement that you can look at, or Mexican for that matter. So there are various possibilities. That being said, the most common way an individual gets to the United States, all things being equal, is if a US company petitions for them under the H1 category. Actually, there's one more as well. If you are a person of extraordinary ability, and in that you are one of the top individuals in your field, you've written articles, there's been news about you, all that kind of thing, then you can apply for something called an O1, which is extraordinary ability. You have to be a very high level, though. It's not, they realize with the cap on H1s, a lot of people are going to try for O's. So you can't do it if you don't have at least, unless you've written a lot of articles or some scholarly, and unless you've been featured in a lot of different ways, it probably wouldn't be relevant.
Definitely. And by free trade agreement, you mean NAFTA, right?
Well, it used to be NAFTA. The US calls it the USMCA now. Canada calls it the CUSMA. And to be honest, they have no clue what Mexico calls it at this point.
Okay, but Jorge, you have a lot of options out there. Depends where do you actually fit. So you might as well go consult an expert. And I would always say, yes, you need an attorney. So it'll be good to be guided by an expert. Thank you so much. And now going on to our next question. And definitely, if you want to have a one-on-one consultation with David, you have his contact details on the screen. You can email David at garsonil.com. And you can go visit www.garsonil.com. Thank you so much. And let's go to our next question, David. And that is DJ4496 asking, hi, my husband is primary. We are from India on EB2. We got our green card EAD for 5 years. Our priority date is September 30, 2014. So my question is, when can we expect green card?
Yeah, it's going to be a long time. It'd probably be within that 5 years. Well, right now, I'll take that back. Right now, it could be within the 5 years, but it is taking 5 to 7 years in that regard. However, that is also something else that may change come the new administration. These things could get elongated out. As you probably know, many people find themselves in a priority date that is current, or you think it's almost current, and then it doesn't move for a long time. The issue is that come the new administration, one of the things they can do as well is slow down the priority date processing. So that takes a while. I mean, the fact that you have a green card EAD for 5 years is good news. I mean, that keeps you there for a long time, and hopefully, there is also the president-elect did go on radio and talk about the fact that people that graduate from U.S. universities should be eligible for green cards as long as they do everything right and they've done everything that is appropriate. So, you can't always think that he's going to, or they're going to do anything that's that detrimental. It could be that if he's looking at who is applying and that they need individuals in that field that are applying, and he may speed up green card processing in certain situations. He may be tougher in others, but to your point, your husband has the EB2 approval. You have a 5-year work permit. Hopefully, within the next 4 years or so, you should be able to get a green card.
I think 4 years is not so bad. For
Not
many
easy.
folks out there, it's decades.
But again, we don't know.
We don't know.
That's the problem with having this in November when a new president is taking office in January, and you have no clue what he's doing. Somebody asked a question about Tom Holman being appointed today as the new border czar. Yeah.
True.
I'll answer. I was just looking at that. What are your views, Tom Holman being appointed as a border czar by Trump administration? Should people be scared given his known stance on immigration and mass
Deportation, Drive 10, yes.
Well, he was the head of ICE before, and he is a tough guy on this. In terms of being scared, I think that Trump is sending a message, certainly. One of the cornerstones of his campaign was talking about deportations, right? I think Vice President-elect Vance talked about deporting 1 million people a year. I don't think they're going to be able to do that. Let's be blunt. They're not. First of all, how are they going to find them? Where do you, if they're out of status in the States, where do you go? You have to locate people. But I think Mr. Holman is a very tough guy. I think that it is sending a message. I think that if you're going to look to deport people and you're going to look to be restrictive, he would be the man for the job. Yeah, I think that's what he's doing there. That all being said, the courts are there for a reason. And as I said, in the last Trump administration, a lot of what they wanted to do was thwarted by the courts. So once somebody is taken into custody and they move towards deportation, I'm not a deportation lawyer, an enforcement lawyer in that regard, but there is access that a court can comment on with regard to any of this. But yes, I think sorry to go on, but I think having Mr. Holman as the border czar will mean that the Trump administration is going to try to do what they said they were going to do.
Right. And this could be one of the biggest mass deportation in the history of the United States, I guess. Let's see what it holds.
I think that he wants to try.
Let's see.
Yeah, and then somebody said they were talking about deporting illegals. If you're there illegally, there's nothing to fear. I agree with that.
Right.
I agree with that. I think if you're in the United States legally, I don't see anybody wanting to deport you. I don't think they can. To be good, they can't if you're there legally. The question is that they could create situations where you can't extend your status, or that it would be too difficult to extend your status. And in those situations, then you have to leave. But in terms of being gathered up by ICE and deported, no.
True. Thank you so much. David, for taking that up for Drive 10, and even Jorge, thank you again. So we have our next question. This is Akshay. Akshay is on YouTube asking, would the consulate officer check my past employment history after my MS? Now, if I am applying for a PhD, what should I be careful about?
So they're going to check my employment after my master's degree. Well, yeah, if they have information. Realistically, when you fill out, when you're at the consulate and they're asking you questions, after you got your master's degree, I'm assuming you did your OPT. If that's the case, then they may look at that. Certainly, yes. If you're applying for your PhD, if you're not extending status and you're going to a consulate and apply, then it pretty much is what I've just discussed, and that is the temporary intent issue and the fact that you're transparent with regard to what you're going to be doing and what you're doing and how you're going to be doing it. The fact that you're going for your PhD should, by practicality, make it easier to get a visa, because it does show you have certainly serious intent towards your education to get a PhD. And it's normally, when you get higher in the educational sphere, it normally would make it not easier per se, but the officer would understand you've had, especially if you've had visas there before, that you've adhered to U.S. immigration policy, and that you've been someone that is credible. Okay, and I think that has a lot to do with it, credibility when you're applying for any visa, because if you do things that they don't particularly care for, or have done things they don't care for, then you lose your credibility with immigration, and that's when things go awry. And that's good. You did your OPT in STEM and then return back to your home country. I think that's very good. It shows that you adhere to U.S. immigration, that you follow the rules, and that they can count on you to follow rules. And I think that having a track record like that is important.
True. And I think that is a plus point for you, Akshay. Thank you so much for your question. And if you have any more questions, you can keep commenting. Well, he says, yes, I did my OPT in STEM and then returned back to my home country. Very nice. Following the rules. There you go. And thank you so much. Even DJ4469 says, thank you for answering the question. Great. Well, David, now I have another question, and that is, if an F1 student's OPT is set to expire in 2025, what options do they have for extending their work authorization, especially with the potential changes in U.S. immigration policies? What do you suggest?
Yeah, this is an easy answer, not much. There isn't that much to do in the sense that if your OPT is expiring, and you don't have my phone's going up here, sorry. If your OPT is expiring and you don't have a STEM OPT extension that you can look at, or you can't get another type of work permit based on nationality or a treaty or something of the sort, then there really isn't that much for you to do. As I said, though, we have seen companies, multinational companies, where somebody has an OPT and they're with them for a year, and then the company says, you know what, we are going to put you and you're going to work for our subsidiary or our parent or our affiliate in another country. Then that being the case, if they do that and you're with that company if you're with that company in another country, then if you work there for a year, they can then look for an L1 intercompany transfer to bring you back to the United States. By the way, that is another possibility where they may be more restrictive going forward. There's such a visa called an L1, and an L1 is an intercompany transfer. And you can do an L1 for a manager or executive or a specialized knowledge person. And specialized knowledge usually means a unique knowledge. It's both proprietary to the company and a knowledge of the field. So if they wanted to slow down people who are coming to the United States in specialized knowledge L1s, they could do so, again, not by changing legislation, but simply by making the criteria more rigorous and saying it's going to be harder for you to get an L1 because we want to see a lot more within what you've done and your history and your experience and things like that. So that could be something else that they look at. But if you're in OPT and you don't really have any, you can't extend it, and you can't qualify for another type of work permit based on, as I said, other factors, and unfortunately there isn't really much that I can see that you can do.
Well, thank you so much for that, David. But I think that's all we can do for 2025 then. And I'd quickly like to say hello to Jemshid. Thank you so much for joining us on LinkedIn. And then we also have Ezzy Lydia. Lydia, thank you so much for joining us. Hello, everyone. I am Lydia. She says, hello. Now I have my next question to you, David, and that is, what impact will the expected changes to work permits and student visas have on industries that rely heavily on international talent, such as technology and healthcare?
That's a good, well, and this is what I was talking about before, that it would be I think it could be pretty detrimental in those situations, which leads me to believe that there will be individuals surrounding the president-elect that could talk to him about this, i.e. Elon Musk or someone of the sort. I mean, he doesn't want to, cut off his nose to spite his face necessarily. He understands that there are areas where people need employees, and if you don't have them, then things are going to not be as I guess you could say, they won't be they won't go as well as they should for that industry and for that company. So realistically speaking, I think it will have a deleterious effect on those companies and that industry, which leads me hopefully to believe that they will see that and make allowances in certain areas.
Okay, but definitely, I mean, people, I mean, especially where US needs talent from, I mean, different countries where, US may not have theirs. And I think this is something that is going to be affected for sure. So, David, thank you for highlighting that. Now, I have another question, and that is if a university student on an F1 visa receives an unexpected job offer before graduation, what immediate steps should they take to ensure compliance with the new work permit regulations under the Trump administration?
Yeah, well, they won't be able to do, again, they'll have to, I mean, realistically speaking, they can do their CPT, which is part-time work within the context of when they're studying, and that's fine. But, and they have to be able to do that and get approval to do that. But realistically speaking, if you, under this administration, we don't know what they're going to do with the OPT and what they're going to do with regard to the student visas, because in the normal course, you can't work. If you're on a student visa, you have to go to school. In certain circumstances, a spouse may be able to, if things go very bad and in hardship circumstances, there may be ways for a person to get a EAD. But in the normal course, they can't do much in that regard. They have to be compliant. I think that is a lesson that going forward is going to be as important as anything. And that is, under this administration, you have to remain compliant to the letter of the law. Because I think that if you do anything that's not going to be completely by the book, you could find yourself in a situation where you will be removed from the United States, or put yourself in a position where you could be removed from the United States. So in any event, if you get an offer of employment, you can't necessarily you can't necessarily start working. You have to wait until you're eligible to work. You wait for that, then you can start to work. And any employer that is interested in hiring you, and frankly speaking, has worked in the system before, will understand that. Remain compliant. More than anything else, remain compliant.
Thank you, David. I think that is a great advice. And folks out there, you definitely need to stay vigilant, compliant, go by the rules, be on the right track, and stay hopeful. I think that is what I can say for now. And yes, absolutely. Go contact Attorney David Garson, and he's definitely going to direct you at least how to go about it if you have any confusions, or especially that every case is different and you might need special attention. So why not email David? His email address is david@garsonil.com. And you can also go visit his website, www.garsonil.com. Thank you, David. And okay, Akshay is back saying, I'm sorry I missed the first 15 minutes of this session, but I wanted to ask about the implications on OPT and STEM OPT going in the future. Do you want to say that?
Sure. As I was saying, we don't know. There's been a lot of discussion regarding it, to be honest with you. In fact, this is probably the area that has been focused on the most by pundits and newspaper reporters and things. Sort of, what is this administration going to do with the OPT and STEM OPT? The STEM OPT was established by the Obama administration. I think that the Trump administration, in this first go around, tried to get rid of it, as I recall, or tried to limit it, and they weren't able to do so. That doesn't mean they aren't going to try again. The OPT, I don't see them really. I don't see them stopping the OPT. I really don't. I don't know why they would. I think that it's helpful to employers. It's helpful to the individuals. But I don't know that it would be expanded in any way, shape, or form. Unless, and I mentioned this at the beginning, as I said, under the last administration, the person who was responsible for advising the president was a fellow named Stephen Miller, who is pretty restricted. I don't know that this person is advising the president under this administration. I think Elon Musk is having a lot of say in this. And that being the case, if he listens to that kind of individual, then he may understand the importance of people who are in STEM, or technology or even trades, to be honest with you. I mean, let's be honest, a lot of people, they say there's 11 million people who are out of status in the United States. I don't know. I haven't looked at the statistics, but I'm kind of thinking that a lot of them are in construction and in trades in places that need them. So for instance, there was just a hurricane in North Carolina. There's always hurricanes in Florida, things like that. They have to rebuild their infrastructure. And I'm not sure there's enough people who are US citizens or green card holders who can do that. So I think practically, and I think this, I don't want to say it's a secret, but I think most people believe or think that a lot of the people that are working in trades and construction and well, I was going to say technology, not so much, but trades and construction are probably people who are out of status. And so if the president or this administration wanted to look at something like that, there may be a possibility of I don't want to say an amnesty because people freak out when I say the word amnesty, but of a possibility of creating a pathway for individuals who work in certain sectors and have worked in those sectors for a while to get permanent residence, especially if they're needed.
There you
Somebody
go.
just-
Akshay. Thank you. Yes.
Somebody just put a comment that Elon will be the savior of the STEM people.
He's the same guy. Akshay is the guy only. So he was also saying, also it is true that you can use STEM OPT only once. For example,
That's
if I
true.
used STEM during my master's, then I
No.
cannot use it after my PhD. Please clarify.
Correct. Yes.
That's true. That's true, Akshay. So there you have it. Thank you. Thank you so much, David, for taking that up. Jorge says, just want to thank David for this session. He's very well spoken and knowledgeable. Definitely. Thank you so much, David, for joining us and making time for this.
That's very
Now,
nice.
my
Thank
next
you.
question, yes, thank you. Next question for you, David, is how will the proposed restrictions on OPT affect international students pursuing STEM degrees, and what steps can students take to mitigate these changes? We've been discussing this over and over, and maybe if you have any more points to...
Yeah, no, I think I pretty much said everything I can say. We don't know what they're going to do. Everything may change or nothing may change. You know, I know I sound, that's an easy thing to say. It gets me out of a lot of questions, but
No, but
I do think based on previous experience, meaning the government's previous governing, or this government's previous governing, that things will get more restrictive. It will be tougher to get cases approved. They don't need to change the law to do that. The L1s, the H1s, they could take away spousal. I'm going away from OPTs, I apologize, but they could take away spousal work permits from the H2s or the L2s. I'm sorry, the H4s and the L2s. They could take away, meaning if right now, if I'm on an H or an L, my spouse can get a work permit. They could take that away. And by taking that away, it lessens the, I guess, desirability of people coming to the United States. Because if their spouse can't work, then what are you doing? That's not very fair. It's fair, but it's their country. But what I'm saying is it's not as attractive to somebody who's coming. So they could do all sorts of things. So in terms of the OPT, I don't know that they'll do anything significant. I think the STEM OPT, that in itself is up for grabs. And to that person's point of view, Elon may be the savior. Who knows?
for sure. Okay, well, what do you want to say about the H-1B lottery? Maybe of course, we are going to expect changes, everything immigration related. But do you have anything to say on that H-1B lottery system?
Yeah, I mean, the 65,000. It's always it's a mad rush when cap season comes and employers file the expressions of interest and wherever it's usually 15, 20, 25% that get picked. I can't see them going a lot higher than that. You know, if they wanted to do things that were, I guess you could say, innovative, and then they could change that cap for the various industries that people go into. So for instance, there's a lot of people in STEM, a lot of US citizens and a lot of green card holders in that sense. So if you have if you have a degree in a STEM field and they need STEM people, then they can absolutely say, you know what, we can raise a cap in this area. We can get more people in this area. Why do we need them? Or it could be another field or something of the sort. In the sense of that. So they could be innovative. You never know. Things could go better than it has been before. In that way, they could be somewhat creative and think outside of the box when they're doing these kinds of things, or they may just be completely restrictive. In other words, it may be a very good hedge, and it would be a good legacy for this administration if they changed the immigration policy and made it something that was more utilitarian for everybody, so that it's functional and practical, not necessarily a one-size-fits-all.
True, and maybe everything you say cannot happen. I mean, even Trump cannot say that whatever he has said can happen, right?
Right. No, that's exactly the case. I mean, in the end, it will depend upon who the president surrounds themselves with, right? It goes to the fact that if you are in a field or in an area that the president believes is important to the country, then he could basically do it he could do things that would be a great help to the U.S. And then, as I said, he's very concerned about his legacy. It could really help his legacy.
Right. Thank you so much, David, for that. And, I had some more questions from people who keep commenting on our groups and YouTube channel. So I think I would like to share that. But hold on, not this one. Okay. So this was on nationwide protest on Canada 2 months back when they were talking about deportation. But if you find it relevant and if you want to take them up, you may want to give out some views or perspective on this. So when you apply as an international student in Canada, you are required to write a letter stating you will return to your country once you complete your studies. That was the agreement they signed.
Yep. Sorry, is there a question or?
It's just a comment. I mean.
Oh, yeah.
Then we have. Let me take this up for now. This is from Dixit, asking urgent. I went for my first H-1B visa stamping yesterday and learned that my F1 visa was revoked. I was sent for second interview on same day, but my visa is cancelled. The interviewer told me that I was involved in a fraud with my first OPT employer. My other friends have worked with this employer, but they had no visa issues. Did anyone else? Do you want to say anything on this?
Yeah, I've seen this before. It's a scam.
Okay.
So what it is that I've had people consult me on this, and that is they get an OPT for an employer that they're not really working for. And so, but the employer says that they're working for them. And so, and they go ahead and they have their OPT, and then they can get the extension on the stamp and things of the sort. But realistically speaking, they're not working for the employer, and either I think in the worst case scenarios, they pay the employer to basically say that. So, that unfortunately is a fraud scheme that I've seen before and keeps turning up. It leads me to believe that the authorities or the State Department or USCIS or CBP have been alerted to it and are now looking for it. So when somebody gets an F1 and they get an OPT and then they say, okay, I'm working for Mary's company, being a systems analyst or a software developer, and they're not really working for Mary's company, they may be working at the Walmart or something of the sort, but they get that letter, and then when they go to get the H1, if they're picked, or they go to get a STEM extension, and it comes out, then that's pretty bad, because then you do get charged with misrepresentation, and you lose your ability to stay in the States and or go to the States.
Okay. Thank you so much, David, for taking that up. And now I have my next question. And that is also from, this is with regard to the I-20. Got admission offer for spring, haven't filed I-20 yet. Now wanted to change my term to fall. At what point should I request for change of term before getting F1 visa or after I get F1 visa? Or should I select defer in I-20 form to next term and submit and get confirmation from uni for fall, university for fall, file the new I-120 then, or submit I-120 for spring now, get visa, and then ask university to change term to fall? Which one of the options will be better?
So I need to see it. Can you make it bigger so I can read it? I can't.
Sure. This is, I think, how it goes.
Okay. So I'm going to do it myself here for a second. Sorry. Got an offer for spring, haven't filed it. Now I want to change my term to fall. At what point should I change? No, don't go to the consulate if you're not going. Should I select defer in I-20 the next term and submit? If conference or submit I-20 for spring. Well, I would advise, I mean, this is my opinion. And again, it's not, I can't give you legal advice, but if you got admission to the offer for spring, and when you say file your I-20, or you mean going to the consulate, I'm assuming. Now, if you're changing fall, don't go to the consulate with an I-20 saying you're going to spring term, because that's misrepresentation. You're telling them you're going to it and you're not. So in the I-20, when you go to submit, get confirmation of the fall, fill in, I would get a proper I-20 for the session you're going to before you go to the consulate, and then apply to go for that session. I wouldn't go at all. I wouldn't play with going to, especially now. I wouldn't go to the consulate with an I-20 that has a different session than you're actually going to attend.
Okay. Thank you so much, David. I think that will be very much helpful. Thank you for that advice. And now I'll quickly take up my next question. And that is, my wife got admission in MBA in US. Should we apply F2 visa for spouse and kids along with her F1 visa application in one go? Or after she gets F1 and lands in United States, then we apply for F2 visa?
It's a very good question. I get this a bit in the sense, what strategically is probably the better way to go. I mean, either way, they're going to be looking at it in the sense of temporariness of intent, right? So if you're going to your MBA, and it depends, realistically, this is going to sound, not fair, but it isn't. It depends where you're applying from, and it depends on your monetary situation, and it depends on the circumstances surrounding yourself. Meaning, let's say you you apply from a country that the US has, their statistics show that people don't come back or they stay, and meaning you are not from a family that is wealthy or you have wealth. And in that regard, it's again, it doesn't sound good, and it kind of makes people say, well, why can't I go if somebody else goes? But the truth is, if you're applying for a visa and the consulate is convinced you will return to your home country, or you have the resources to support yourself and go to your home country, they're going to be a lot less restrictive. So to your question, if somebody's applying for an F1 and the F2 and for your spouse and children, you can all go at the same time if you are confident that you are from a certain situation that make this, again, less restrictive. If you go separately, it's no guarantee that your spouse is going to get it if you didn't all go together. I guess my point is that I don't know if it makes too much difference. I think what matters most in that circumstance is whether or not you are of a certain individual or person that the consulate is confident that everybody will come back. So in the end, if you are from a certain strata that unfairly is treated a bit differently, then you can all go together. If not, then you can go separately, but it doesn't mean that your spouse and kids are going to get the visa if you go separately. You're still going to be subject to those issues and that kind of scrutiny.
Thank you so much, David, for such a truthful opinion and help. Thank you so much. I wish I knew this participant's name, but it's anonymous post, so thank you so much for taking that up. Now, moving on, this is my next. This is, hi guys, I need your suggestions. I am admitted to UT Dallas for master's with a scholarship. However, I realized that I could have applied to UT Austin, Rice, UIUC. However, my visa is scheduled later this month. Do you guys recommend me to defer it and apply to these universities? Is it worth it? Or should I just go to UT Dallas? What do you
I don't
suggest?
think it. I don't think it much matters. To be honest, I don't know that it matters. Somebody asked a question about, do you expect positively, negatively affecting any
Yes,
policy?
Hari Guru, let's take that up. Yes.
Okay.
Thank you.
Yeah. I don't know, to be honest with you. I don't see anything. If you are in valid status and you have the 485 is a change of status, by the way. And then you've made application to change status and you're in valid status and you're doing everything right. I don't know that it'll affect it negatively or positively. I don't think it'll affect it at all. I think it's being slow as it is, to your point. You've been there for 3 or 4 years waiting for your priority date. So I guess only negatively if they decide to slow down processing instead, which they have the ability to do. So if that's the case, then sure, that's negative. But in either event, if all things being equal and they're not looking to cause trouble to people in that situation, then I don't think I think it's a neutral answer. The only way it will affect negatively, as I said, if they decide to slow down processing as a means to limit immigration, meaning they don't have to change legislation to change processing and the law and how many people come, because they can make it more difficult within the parameters and the tools that they have already.
Okay. Thank you so much for taking that up, David. And now I have another question. You know, this was on our YouTube channel. This was asked by Vijay Kumar. I am on my F1 visa OPT and recently got approved for H1B I-797B consular services. Since I am in US and working for employer on OPT, can my employer refile for new I-129 as change of status so that I can continue working on H1B and no need to travel for stamping? Thanks.
Yeah, they could, but I'm curious as why they didn't. To be honest, I mean, I don't know why they wouldn't. To begin with, there must have been a reason necessarily. The second is that even if you do get you change your status, you can't travel at all unless you get that visa. So once you get a 797 and you don't have a change of status, then you have to travel to the consulate that you need to go to even to travel. So it probably wouldn't be a bad idea to do it, to be honest with you. I would go and do it, especially if you get the approval and you were in the States and you went to school in the States. There's no temporary intent for an H1. So that's a good thing. So you don't have to satisfy that. So the only thing they could really refuse you under is if they think that it wasn't a real job offer, or you don't have the qualifications or things like that. But given that you went to school in the States, given that you work for the employer in the States, if it's real, then I wouldn't be afraid of the consulate.
Okay. Thank you so much for taking that up for Vijay Kumar, David. And I think we'll just go on with one last question. And I think that should be, let me just see if this is the one. Or I think we've taken up all of them for now. Yes, but if you want to give a view on this. Hello, in my case, I have an F1 status to H4 status. I am in USA, but I just have the status, not a visa stamp. Would this process be the same for me? And once I upload my documents, do I need to keep studying during the processing time?
So if they've already changed their status to H4, they don't study at all because they can't. They're on H4 unless they get approval to do it. But that's what I was just talking about, in the sense that they have a visa, they have status, so they can't go anywhere. And until, I mean, you're changing status from F1 to H4, and they're asking, okay, well, can I keep studying? You have to keep studying? No. Are they studying? I mean, did they finish? You know what I mean? Every situation is as it is. If they are still in F1 status and they file the change of status to H4, realistically speaking, they should stay in F1 status until they get an approval to H4, right? They shouldn't. So should they? If they're supposed to keep studying, yes, keep studying. If you are done, then you nothing to study. So you are in that status until you change your status, until you get an approval to change your status. By just filing the application to change status does not give you the new status. So you have to wait until the new status is approved before you can do whatever you want to do or not do whatever you want to do. In this case, not study. And in terms of travel, correct. They can't go anywhere. And if they do, they need a new visa.
Thank you so much, David. I mean, that was really wonderful, taking up all these questions so patiently and giving us all your point of views and expert advice, I would say. So thank you so much. And maybe we could wrap up if you want to say anything about maybe AI or these latest things that are trending right now, technology-wise or student-wise. And maybe even Akshay's last question. DHS says you can use STEM OPT twice. Please confirm.
Yeah, actually, do you want to contact me on that? Because I want to look at something. So if you want to contact me, I'm happy to answer it. Okay?
Absolutely. And so, yes, David, maybe you would want to say anything with regard to AI.
Well, it's funny. As I said, I'm dual licensed in Canada and the US. And Canada uses AI a lot in adjudication. And frankly speaking, I hate it. It's just because what happens is that if anything is out of the ordinary, it picks it up. Meaning, if you have a difficult case, and then it makes it more difficult. It goes to the officer becomes increasingly suspicious. And when the officer becomes increasingly suspicious, they're harder on the case. And AI as well is refusing a lot. Refusals have gone up, I think, by 12% using AI. So the US isn't quite there yet. It isn't really using AI per se, but it will. And I can only say that when they start using AI, refusals will rise. Because just psychologically speaking, right? If you get a case as an officer and you adjudicate it, fine, that's great. It can be a yes or no. And then when you have AI, if AI says, yeah, you should approve this case, you should approve this case, you should approve this case, you start to rely on it. But then when AI takes a case and says, well, there's something different here, you should look at it, the officer's perspective right away becomes negative, thinking, well, why didn't AI approve it immediately? And so that creates a harsher result, in my opinion, with regard to adjudication.
Thank you so much, David. Really such a great session. I wish we didn't have to wrap it up as quick, but thank you so much. And folks out there, do contact Attorney David Garson, and maybe when you do, let him know that you found him here on Immigration and Jobs Talk Show and tell him about your case, and maybe for sure he's going to be happy to help you. So his email address is david@garsonil.com, and his website is www.garsonil.com. So definitely go visit and contact David. Thank you so much, David, for doing this today.
Pleasure. Have a good day.
You too, have a good day, and I hope to see you again very soon.
Thank you. Myself as well.
Thank you. Thank you, David. And folks out there, thank you so much for joining us once again. It's really lovely that you did. And please do not forget to like, share, and definitely subscribe to our channel. It's Immigration and Jobs Talk Show. You can hit that bell icon so that, whenever we have sessions like these, you are notified. And definitely, if you resonated and if you think that your friends and folks out there can also resonate with this kind of content, don't forget to share, please. And also, my number is where you can also contact me on WhatsApp. This is my number, 408-335-6444. You can also email me. My email address is nipa@staffingly.com, and go visit www.staffingly.com to get to know more about us. Thank you so much for joining us. Y'all out there have a great day and a splendid week ahead. See you again. Stay tuned to Immigration and Jobs Talk Show. A big hello and a warm welcome to all of you to Immigration and Jobs Talk Show. I'm really happy and thrilled to have each one of you join us. I'm Nipasa Pradhan and I'm going to be your host for today's session. And we are streaming live right now on YouTube, LinkedIn, and Facebook. And before we start with our webinar today with our guest, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, very, very thrilled today to be here with all of you to explore this topic that impacts countless lives out there and the future of our workforce. Definitely, today is election day, and we are looking ahead to ask, what will US immigration look like in the next 5 years? I'm sure this is very, very exciting, overwhelming for all of us today. And with so many recent changes today, we are going to discuss and basically talk about what does America's future look like. And joining us today in an expert with decades of experience in immigration law is, for the first time joining us here on Immigration and Jobs Talk Show, none other than Mr. Charles Cook, who is the founder and managing partner of Cook Baxter LLC, where he leads the firm's global immigration practice. So it's really very, very exciting and such an honor to have you with us here, Charles, today. Thank you for joining us.
It is a joy to be with you today. Thank you so much. What an exciting day in the United States.
It is. And I'm sure, I mean, you are a new face in our channel, but folks out there know you and they would love to know you better. So could you please tell us more about yourself?
Well, thank you. I'm actually the former national president of the American Immigration Lawyers Association, otherwise known as AILA. I'm also a founder and former president of the Alliance of Business Immigration Lawyers. I've been doing immigration law for 36 years. As you can tell by how old I am and all this gray hair. I've represented more than 75,000 people in their immigration journey through all types of immigration, not just H-1Bs and labor shirts and Ls, but literally everything from asylum to adoptions to naturalization. I've done it all. Including lots and lots of federal court litigation. I am one of America's leading immigration lawyers in the area of litigation and bringing justice to people whose cases have been pending for a really long time. I've also done a lot of lobbying in Congress. I've testified in Congress a couple of times. And I do a lot of commentary on the Twitter machine as well as it relates to immigration. But most of all, I am the grandson of immigrants. I grew up in an immigrant household, obviously not from India. Obviously, you look at me. My grandparents are from Germany. My dad's first language was German. He was born in Brooklyn. I was born just over the river in New Jersey and spent my growing up years there living in my grandparents' house. And today, as quintessential American story, I don't speak German.
Okay.
I speak Spanish fluently. So quintessentially, I am the American experience. I mean, you look at me, I know I look like, well, he looks like an American. And in reality, I'm the grandson of immigrants, like everybody here in America is. So for me, America is a very special place. It is a place where you can truly make your dreams happen, regardless of who the president is. Just sometimes it's easier than other times.
It's really, truly an honor and a pleasure to have you here with us today, Charles. You look vibrant and radiant and so full of knowledge already. I'm super excited to have you burst out whatever you've got to say today.
I should be nervous because of the election, but oddly enough, I'm not nervous about the election. I have a feeling of confidence in a good outcome. So it's where we stand.
Definitely. So what can folks out there who have joined us expect from us today?
Well, let's talk about what immigration is going to look like. Obviously, where immigration is going depends on who the president is. Now, keep in mind, only Congress can change the law. And the law is 40,000 green cards in EB3, 40,000 EB2. That's the law. No president can change that. Presidents can change interpretations of the law, however. So, for example, a long-time interpretation of the EB1, EB2, EB3 numbers is that it includes family. So it's not 40,000 EB3s a year for 40,000 workers. It's only 18,000. because the average family size is 1.1. So the numbers are drastically reduced by counting family. That is an interpretation of the law. It can equally be interpreted to say, no, it's just people. Congress clearly didn't think that only 18,000 foreign nationals should get a job and a green card in America each year. It's a silly interpretation. But that takes a president who believes in it to get that interpretation changed. So a lot of what's going to happen in the next 5 years really depends on who's at the helm of the USS United States. And so today is the election. And although I think something like 73 million Americans have already voted early, America's very weird on elections. There's not just an election day. It's an entire season that starts 3 weeks before the election. And Trump's been campaigning since he lost the last election. So a lot will depend on what happens today. We don't know the vote total. So 73 million people have voted, but we don't have any idea how they voted. They don't release those numbers until after 7 p.m. Eastern time, which is tonight. I'm on Eastern time in the United States. They begin releasing the vote tallies from those that close. And each state controls when their polls close. Sometimes it's 7, sometimes it's 9. Sometimes judges order they stay open because there's long lines. American elections are a mess. But here's what happens. If you're elected, let's say Trump wins, he doesn't become president right away. He doesn't become president until January 20th. That's when our presidents are sworn in. So Biden would remain president really for the next almost 3 months, and then Trump would take over. Same thing with Harris. And we're not going to know tonight it's possible we know tonight, depending on where Georgia goes, where Florida goes. But unlikely we won't know until 2 o'clock in the morning, 4 o'clock in the morning, when we get poll results out of Wisconsin, Pennsylvania, and really further west out in Arizona and Nevada. So we don't know. I mean, it's just literally a toss-up. Every pollster says 50-50. One thing I will tell you this. Our law firm, we have 45 folks that work here. 40 of them can work and can vote. 40 of them are citizens. And every one of them already voted. Every single one. That's highly unusual in the United States. And they all voted for Kamala Harris. And that should tell you something about where we think and who will be a friend to immigrants and who will not be. I see far too much on the Twitter machine from folks from India who think that somehow Donald Trump is going to be really good on immigration. And Nabasa, that's just not going to happen. The very first plank in his platform on immigration is, day one, issue an executive order that children born in the United States to parents who are not citizens themselves are not citizens, which of course is illegal because we have a constitutional amendment that says they are, but that lets you understand who he is as a person and what he believes about immigrants. Now, why Donald Trump hates immigrants so much, I don't know. He married 2 of them. Once again, immigrants doing jobs Americans won't do. Pretty funny.
We don't know.
And of course, Kamala her mom's from India, right? So she is half Indian. She is the quintessential American. Dad from Jamaica, mom from India. How does that even happen? How do they even meet? So, and the thing about Kamala Harris is that she actually understands immigration law, which is crazy. Very few presidents do. But she has delved into the area. She was involved in it as a lawyer. She was involved in it as a prosecutor. And she was one of the best friends that immigrants had when she was a U.S. Senator. So she gets it. Now, unlike Biden, honestly, he's a nice guy. He's a nice old man, and he saved us from Trump. But he doesn't get immigration. He was never, ever, even when he was in the Senate, he was never good on immigration. He just wasn't. And same thing with Obama. He was never good on immigration. So we have a lot of hope for Harris. But let's talk about these policies, all right? So in the United States, there are 4 ways that you can come here legally and immigrate. You can get asylum. It's not happening right now from India, right? You can win the green card lottery, which of course India can't participate in, and you have employment/investor immigration and family immigration. Now, family immigration itself is pretty fixed, delineated by Congress. Congress has written the laws. There's not much you can do as a policy perspective on family-based immigration, except you can do what Trump did the first time, which was stop adjudicating cases. I know that because I sued him hundreds of times for not adjudicating cases. They just don't do them. They just put them in a box and don't do them. So you have to get courts to intervene. That's all they can really do. On employment-based immigration, however, there's a lot of bad things that can happen in a Trump administration and some good things that can happen in a Harris administration. So, for example, if Trump is elected president, one of the things that could easily happen on this employment-based immigration stuff is he can get rid of STEM OPT. So you're in the country, you're in a STEM field, STEM OPT gone. They are definitely going to do that. They're going to publish a regulation. STEM OPT is gone. One proposal written by Vice President Vance when he was in the Senate actually bars anyone from immigrating under EB-1, extraordinary ability, or EB-2, naturalization waiver, until they have lived outside the United States for 10 years after they graduate from a U.S. college. That would be crazy. That would eliminate a lot of people, including many Nobel Prize winners, from getting green cards in the United States. They can change how the H-1B lottery works. Right now, this next year is the first year of the higher fee, $215, I think. And you're gonna pick by the foreign national. So you, not your employer, but you are going to put in for the H-1B. Whereas what Trump will do will say, no. H-1Bs are by bidding. It'll be like the eBay of H-1B. Who will get paid? We will give H-1Bs to the highest paid people. That was his proposal last time. They just didn't get it published in time. That's going to be published in February of 2025. We're going to see drastic changes to the L visa program, where they're going to make it very hard, not that Biden hasn't done a terrible job with the program anyway, but make it much harder to prove who's a manager or executive. H-1Bs are already now more limited under the new Biden administration. They're going to crack down on what jobs require degrees. One of the things that's been happening in the United States over the last 10 years is there's been a movement away from requiring degrees for jobs that have historically required degrees. A great example is a software programmer. Why do you need a bachelor's degree to be a software programmer? You don't. Heck, look at all the people losing their jobs because AI is doing it, right? So a lot of negative things can happen in a Trump administration on employment and family-based immigration. Now, Harris, on the other hand, obviously will keep in place the program for STEM, obviously, probably expand it to a certain extent. But what she will also do is look at the H-1B program a little more critically so that it works more effectively for the United States. Because she's a prosecutor, I think they're going to go after job shops, companies that just throw in thousands of applications for visas that don't really have work for them. Or where they abuse the employee and say, we're not going to pay you. I think there's going to be a massive crackdown under the Harris administration for H-1Bs in that regard. I think we're also going to see some attempts to change some of the interpretations of how regulations work. We're also on family-based immigration with her. The new Biden family parole program will keep going if we win the court case, which is today, by the way. And I don't think a lot of people in India realize this, Napasa, but there are a lot of undocumented Indians in the United States. Do you realize that? There are a lot. There are hundreds of thousands of Indian nationals in the United States who do not have immigration status, who came as students and overstayed, who came illegally. Hundreds of thousands. Many of them are helped by the Biden family parole program. And so I think that will definitely continue if we win the case today. Literally, the hearing is today on whether that program is legal. I think it is legal, but we'll see. I'm not the judge. So a lot of these key immigration issues will be drastically impacted negatively if Trump wins, and not at all, or positively if Harris wins.
You're absolutely right. I mean, if Trump or, they have similar stances like what you have just said, and on immigration, everything is going to be heightened with a lot more scrutiny and stricter enforcement. I think it's going to be even more hard with regard to immigration, for sure. But thank you so much. I mean, those were great insights. I mean, so much in the first 15 minutes already, so much processing and so much happening, I'm sure.
There's so much going on. Now, one of the questions you gave me was on, what is going to happen today? All right. So I don't know. I mean, I'm not a prophet, but I will tell you
discuss on the questions, but I think I'll just quickly say hi to our folks who already have questions, and you might see some of the comments
I love
popping up there. Right. So big hello to Anjali and Luan Dial, Luca. I think we should pick up a few before we go
that's
on
great.
with our
Anjali's got a great question here. How might the election outcome impact the likelihood of establishing a pathway for undocumented immigrants? Well, I think you hit the nail on the head. If Trump is president of the United States,
Anjali, yeah, we're taking your question.
There is 0% chance that there will be anything to help undocumented immigrants. 0%. In fact, there will be a crackdown, as he has promised, to deport 11 million people. Now, that is a great way to destroy an economy. That's how it works. You want to destroy an economy? I don't know if you know this or not, boss, but we've done this before. This wouldn't be the first time. We did this in 1957 and 1958, and 1959, 1960, on something called Operation Wetback, which today is, of course, a slur. Back then, we deported over 1 million Mexicans who had come to the U.S. during World War II to work in our fields and work in our factories while we sent men abroad to fight. Eisenhower created this, and we deported over 1 million Mexican men and 500,000 U.S. citizens. So it's not like the U.S. is fully capable of doing stupid things, which then led to a recession. Because that's what will happen. So, yeah, there's nothing coming from this. Now, Harris, on the other hand, has said repeatedly she voted for bills that were pro-reform when she was a senator. She will advocate for them. And think about this. This is actually really important to understand. Biden was always walking a tightrope on immigration because he wanted to run for re-election, and he knew he was running against Trump, who was anti-immigrant. If Harris wins, there's a whole new dynamic. Trump's not running again because he's probably going to be in prison. So he's not going to, maybe not. Maybe she'll pardon him, but he's not running again. So, and I believe that as Trump is defeated, so will we defeat this anti-immigration rhetoric. So it puts her in a much better position to work with Congress on not just passing this border bill on asylum that she says she'll pass. By the way, that bill would never pass again unless you add in some sort of legalization and take away the per country limit. Increase, and it's not just, hey, taking away the country. I mean, I've been an advocate for hey, the limit's the limit, and that's it. And people have really ragged on me about that. Because if you're going to take the women away for employment, you got to take it away for family. But that doesn't solve the problem. Right. Because all that does is share the pain, right? And now, and now the ROW is the same, is terrible too. You have to increase numbers. You know, if I've got a lot of clients who applied for their green card in 2012, 2013, 2014 from India, and they're not getting a green card for another 10 years, 15 years. Even if we reduce the number, even if we said, okay, everybody, Indians can get them all, it's still 20 years. And then that cuts the rest of the world off, which makes no economic sense to anybody. So there's a really good thing that would come from a Trump defeat, is that would be a defeat for anti-immigration forces. That would relegate them back to the ash heap of history and would embolden the president, I would hope, to work with Congress and look, let's fix this problem once and for all. We can do that. So there you go.
Thank you so much for taking that up for Anjali. Very passionately answered, I would say. Thank you, Charles. Well, let's go on. We have a lot of comments on LinkedIn as well. So let's take this Luan Dial, if I'm pronouncing it right. Do we pay for visa or trips when we get jobs in USA?
Well,
Okay.
that's a great question. And the answer is no, you should not be paying for the visa. So let's say, I'm going to assume you're talking about the H-1B visa. So the H-1B visa, the employer is required to pay for that, the lawyer fees and the filing fees. You also should not be paying an employer for the job. That if immigration knew about that, they would deny the visa. I can assure you. I know people do it, but it's and I can't tell you it's illegal. I can tell you that immigration thinks it's fraudulent. But the trips, the airplane fares, that's on you unless you've got a really good employer. I mean, that's been my experience. You got to differentiate out the visa fees, the lawyer fees, and then travel expenses are different things.
Thank you. Thank you for taking that up for Luan Dial. Thank you for your question. Now let's take up Luca. This is on, today. Trump's advisors are already preparing massive cuts to legal immigration as soon as he enters office. That's what we were discussing. And everything from families and refugees to skilled workers is threatened. Economic insanity. What do you have to say about this comment?
What do I have to say about that is 100% accurate. Keep in mind, our refugees, there were essentially no refugees that came in 2019 and 2020. None. And keep in mind, that was when there was massive refugee crises abroad. Remember Syria? People forget about Syria. Germany took in 1 million Syrians. Not us. Not the Great White Hope. Not the Statue of Liberty. Not under Trump. So, yeah, it's America will revert to a 1924 close the borders, shut the system down kind of country, and we will enter a massive recession, the likes of which we probably have not seen since 1929. That's a reality. And then tariffs on top of that, which of course are taxes on U.S. citizens. So there you go.
It's crazy what can happen today. But what do you think? Let's take on when can we expect the election results to be out?
That's a great question. So in some states, so America has 4 time zones. I don't know how many time zones India has, but America has 4. How many time zones does India have, Napasa?
One only.
You have one? You have one time
Yes,
zone?
just one only.
That's crazy. It's a huge country.
It is, but we are under one time zone.
We have 4. So we have East Coast, Central, Mountain, and Pacific. What that means is, and about 70% of the population lives on the time zone Eastern, on the Eastern time zone, up and down the Eastern seaboard. Those polls, no election announcements are after the first polls close. The first polls close at 7 p.m. in some states. Some close at 8, some close at 9. Some states like Florida and Georgia count during the day, and then you will get initial results, especially on early votes, right at 7 o'clock. And but you won't get final results for Florida and Georgia until 8 or 10 o'clock at night, maybe midnight. States like Pennsylvania will give you initial results for maybe 20% of the votes at 7, but you won't get final results till 2 o'clock in the morning. Some states, we already know who won, like New York. Paris is going to win New York. All right. She just is, because that's just the way it is. I mean, it's most of the states in the Northeast are going to go for the Harris. So these swing states are what matter. So I have a home in Tennessee. Tennessee is red. It's as red as red as red as red. Trump wins it. So, and then you move every hour more in the night, you get the next set of polls. So this, if you've never watched an American election result, go online to one of these news sites like CNN and watch their video, because it's just fascinating. By the time California, and I will tell you, Western time zones, the last time zone, Pacific, we call it Pacific time, California, Washington, and Oregon, Hawaii, Alaska. probably go Trump, but they don't have a lot of power. Hawaii will definitely go Harris. California Harris, Washington Harris, Oregon Harris. Then there's Arizona, which is the only other state in the Pacific time zone. They're a toss-up state, but the election may well be decided by the time their polls close, which are at 11 o'clock Eastern time. I will likely be in bed because I like waking up at 2 a.m. and seeing what the results are or what they aren't. I will tell you this. In 2016, Florida reported at 9 o'clock that Hillary lost. I went to bed because I knew the election was over at that point. She was the first Democrat to lose Florida. If she lost Florida, she lost the election. Now, that's a different thing today. Now we know Florida is going to go Trump. We know that. So we don't really care about Florida's result. It's Georgia, Pennsylvania, and Michigan all in the Eastern time zone. And then Wisconsin in the Central time zone. And if or North Carolina as well. If she wins 3 of those states, she's won. It's over. It's just over. And then the rest is just gravy. So that's kind of what to look out for.
Great, but still, again, so that's what we are expecting, folks out there. And I know how exciting this is and overwhelming at the same time. But I hope you're all vigilant and doing the right thing and practicing your right. Well, we have Bikram's question now. This is also on LinkedIn. We should take this up. But Charles, who is better precedent for tax cut for green card holder and citizens?
Well, if you're a billionaire, Trump. But if you're not a billionaire, not Trump. It's Harris, because Harris is not going to tax anybody. Taxes are going to go down for anybody under $400,000. Now, I know that sounds like a lot of money, and it is a lot of money. I get it. But in the United States, there are millions and millions and millions of people making more than $400,000, and billionaires that are paying essentially no tax. So she's going to go after very, very rich people. If you're, the average, ordinary American green card holder, citizen, Harris is your best friend on tax cuts, because Trump only wants to cuts for the rich people. And that's you can Google it. It's a proven fact that the people that benefited from his tax cut were, in fact, people that were billionaires. I will tell you this, something that a lot of people don't realize, Napasa. If you're a green card holder in the United States and you die here, basically all of your assets are taxed at 50%. Whereas if you're a citizen, there's a $4 or $5 million exception. So if you're a green card holder and I don't really want to get a citizen, and you've got assets, you're a fool not to naturalize, because your relatives that you leave behind are going to be paying a lot of taxes. Just FYI.
Thank you for that very important information, Charles. I think that's a very important point you pointed out to be kept in mind. I think we should take up some of our questions now, Charles. Yeah? So let's go with mine. How might the election outcome directly impact key immigration policies such as family-based and employment-based visas?
Oh, we talked about that. I talked about that for the first 10 minutes. I mean, the reality is there's going to be impacts either way. But Trump, they're going to be mostly negative, and with Harris, they're going to be mostly positive.
Right. Well, and now let's take up another question. Let's take up Vikas's question.
I love
this is on YouTube.
Question. This is a great question. Great question.
Right. Indian Americans have historically favored the Democrats, but there has been an incremental shift in the community's voting behavior in favor of the Republican Party this election. Do you agree? And what, according to you, is making this change, Charles?
Well, this is 100% true. We've seen a lot of Indian Americans that favor Republicans. And that's because Indian Americans are very entrepreneurial. They are the wealthiest immigrants in the United States by far and away, wealthier on average than many native-born Americans. And that's just reality. And when you have wealth, you tend to go towards the Republican Party. Because historically Republicans have taken care of wealthy people, and Democrats have historically, and I'm talking since about the 1960s, not before. Before 1960s, it was reversed. The parties kind of switched positions, and Democrats will kind of focus on the poor, the disadvantaged, and help people, which means taxes. You got to take money to pay for that, and so we've definitely seen that, which is with Trump kind of an irony, because he clearly does not like immigrants. It's just clear he doesn't like them. And so it's just the irony doesn't escape me, but it's absolutely true, especially over the last decade or so. And I would think that if Republicans had nominated a normal Republican who actually believed in Republican policies, because in many respects, Trump's not a Republican. He was a Democrat most of his life. Did you know he gave Kamala Harris $2,500 when she was running for Attorney General like 15 years ago? Yeah, he was a Democrat for most of his life. So he's not really a Republican. But the reality is Republicans tend to be more favorable towards businesses, and that's why.
Well, thank you. Thank you so much for taking that up. And Vikas, such a lovely question. Thank you for participating. You can keep commenting if you have any further questions. Let's get back to Luan Dial. She's back with another question. I applied for a job in USA, New York, and they told me that I must pay for work permit. Is that legal?
No, that is quite illegal. And in fact, if you really want to burn it, make a complaint to Wage and Hour. Go online to the Department of Labor, Wage and Hour, H-1B complaints, just Google that, and file a complaint against this employer so they stop doing this.
There you go. There is a permanent solution to that. Thank you, Charles.
I like this question. Go to this question from 1233. It's a great question.
Let's take this one.
It's a great question.
Anonymous, I wish we knew the name, but yes, we have seen a lot of reduction of tech jobs, which was caused by mass layoffs in the last 2 years. Which candidate could be the one trying to get back those jobs and stabilize the job market again?
Well, you have to ask yourself, this is a great question. Why were there layoffs? Were there layoffs because the economy reduced? No, the economy's growing like crazy. We're at 3%. Worldwide envy for the growth of our economy. The problem you have with a lot of these tech jobs is they can be done by AI. This is a problem. This is a big problem for tech. I don't think either president is going to say, you can't use tech to do this work. Let's use Elon Musk as an example. Elon Musk buys Twitter and eliminates, 80% of the people working there? Now, initially, that meant the platform was garbage, but now it works again. What do you think the lesson learned from big tech was? You don't need all these people. And I'm going to tell you, tech jobs in the United States are not necessarily the future. First of all, you're not going to be able to get within about 10 years, H-1Bs won't be available to many tech jobs. They just won't be, because we won't be able to prove that you need a degree to do the job. So the reality is, I don't think either president is going to do anything to stabilize the tech market, because both presidents, to me, seem all in on technological advancement. Maybe the better question is, how are they going to help people who are displaced by modernization, mechanization, and AI? That's the better question. And the only party thinking about that is Harris and the Democrats. Republicans are like, well, go shovel poop at the chicken house. That's what they think. Go find a job somewhere. Whereas the Democrats are planning for that with retraining and rehiring and things like that. So Democrats, I think, your only option in that respect. Now, keep in mind, I'm a lifelong Republican. I've got a picture of Ronald Reagan hanging on my wall over here. But the reality is, the party of Ronald Reagan is dead. It's gone. That's the reality.
But too much of everything is scary. Look at technology advancement. It's scaring us now.
Well, I could be talking, in a year, I could be talking to AI for this interview, an AI video, right?
Yeah, they would need me.
You can
Who knows, you would have an AI version of yourself doing your job online.
Yeah, you could just put me as an avatar, and they're talking to me, and they're talking about that. There's no doubt that that's the future. If we can build enough power plants, we have to build more power plants, so that's going to happen. But the reality is, what does that mean for human beings? Does it mean that we're all going to be online playing video games all day long? Or does it move us to the next level? Hopefully it moves us to the next level. I'm a big Star Trek fan, so I believe in the future. I believe in the future. These things make us better. So there you go.
Definitely. Thank you, thank you. And Lawan Dial is back with saying thanks, Charles.
You're
Then-
welcome.
And we have another question. Do we have to pay for anything when you meet all the requirements for the job after the interview?
No, you don't pay for anything other than your plane ticket. No.
I think she's making her budget, but definitely thank you for your question.
Wanda, don't be deceived by this. The internet in the job market is full of scammers. It's full of scammers. And you know, sometimes you just hire a lawyer, have a consult with a lawyer who's got a good reputation, so you can get an answer if something's real or not. That is not real. That is a scam. Don't do it.
Now let's take up Shubham's question. There are two parts to this. Could the judiciary overturn immigration reforms passed after the 2024 election, potentially influencing policy implementation and enforcement?
Well, the courts do not overturn statutes in immigration law. It's actually, I'm actually a law professor in my free time. I've been teaching for 25 years at Emory Law School. And the courts have a doctrine called the plenary power doctrine. What that means is that when Congress legislates on immigration, that's it. That's the final word. The courts will never overturn an immigration statute. What they will overturn are executive branch or presidential policies and regulations. And we have a very conservative Supreme Court that is not necessarily friendly to immigrants, but generally speaking, they have not been super hands-on on immigration policy. For example, DACA is a great question. I mean, they could have ended DACA years ago and they didn't because, you know, they realized this is going to hurt people. So could they overturn it? Yeah. I mean, they let a Muslim ban stand, right? The Muslim ban stood. So I would not suspect there's going to be a lot of overturning. And there's been a couple of recent cases out of our Supreme Court that limit different parties' ability to actually sue, whether they have what's called standing, whether they're actually allowed to sue, and then what jurisdiction the courts have over those cases. So there's a lot in play there, but I don't see them invalidating any congressional reforms. I do see them playing a hand in permitting some regulatory policy changes.
And he was continuing to say that the federal courts, including the Supreme Court, have the power to review and invalidate reforms deemed unconstitutional or non-compliant with existing laws.
Well, yeah, they clearly have that power in certain circumstances. There's actually an immigration statute that limits the power of the courts. Our courts, what they call jurisdiction, is defined by Congress. It's not defined by the Constitution, except as it relates to constitutional matters. And immigration issues are rarely, very rarely, constitutional, except when it comes to things like immigration detention and some deportation contexts.
Right. Thank you so much, Charles, for taking up all these questions. And thank you, folks out there, for participating. Keep commenting. We're really happy to have you participate. And maybe, Charles, you could tell us more, since we were talking about DACA. What could the election outcome mean for DACA recipients and other undocumented individuals who are in the U.S. currently?
DACA, if Trump wins, DACA's gone. It's gone. It's history. It's over. He will end it with a regulatory publication in February. It's gone. If Harris wins, it's still kind of hanging in the ether sphere. It's still kind of, and you know, there are something like 50,000 DACA recipients who are Indians, from India. So it's not, this doesn't just affect Mexicans. There's a substantial number of Indian nationals who have DACA. Right now, DACA exists for people that received it before September 2017. Biden republished DACA and allowed new applications between January and May of 2021, but then a court stopped it. And that case has been ongoing now for 3.5 years. And there was oral argument in the Court of Appeals of the Fifth Circuit last month on DACA. That court will likely find that DACA is illegal, but will allow DACA recipients to keep renewing. And then it will go to the Supreme Court, and we will get a decision probably sometime in late 2026 or early 2027 from the Supreme Court if Harris wins. The hope, of course, if Harris wins, Congress just says, look, if you've got DACA, first of all, the youngest DACA recipient today is 22 years old. 22. The oldest DACA recipient is 42. These are not children anymore. These are adults, many with families, many with kids, and it's just time. They're not going anywhere. This is their home. Fix the problem. The refusal to fix this is not just frustrating, but it's immoral. This is a morality issue at this point. When people have spent essentially their entire lives in the United States, deportation becomes banishment. It becomes maybe an unconstitutional punishment for them. And, an argument we can go into in the future.
And I mean, there's so many families who are breaking apart just for this reason, and it's so sad to see.
It's outright. I had 2 consults this morning for 2 people who had criminal convictions, unfortunately, both long-term, one from Vietnam, one from Mexico, long-term residents of the United States. They got addicted to drugs. They made some bad choices. They're gone the rest of their lives. They're never coming back ever. Our immigration laws are mean. I don't know if you've ever seen the play Les Miserables. Les Mis. I don't know if you've ever seen that play. It's a great story. And
I think it's Jackman, and it was like a musical.
The story of Jean Valjean, who represents mercy, and Valjean, and then Javert, who represents justice. Our immigration laws were written by Javert. They're all about justice. There's no mercy in our immigration laws, and that's what makes them so terrible.
We have Shubham back again. He has another question saying, thanks for taking my question. I would also like to know, how will the outcome of the 2024 US presidential election impact the future of immigration courts and the processing of asylum claims?
Well, there's a lot of Indians that come to the United States in the last couple of years seeking asylum. Honestly, I don't know where they're seeking asylum from. I don't know. Good question. I don't want to be in a pro-growth country. I don't know. Something. But our asylum system is completely broken. We have two different asylum systems. We have a defensive asylum system in immigration court, and then we have an affirmative system with the Immigration Service. There are over 1.6 million asylum cases in the affirmative part of the process. There's only 300 officers. 10 years. If you file today, 10 years before you get an interview. If you're in immigration court, there are over 3.5 million cases in immigration court. We have 675 judges. So if Trump comes in, they're going to want to hire judges. But here's your question. Who wants to be an immigration judge? What kind of person do you have to be that would enjoy the job that requires deporting people? You have to be a lawyer for 5 years. I'm not sure there are enough lawyers willing to sell their soul to do that 24/7. That's just awful. Harris wins. The reality is they will find more positive judges who will want to grant asylum and work these cases more efficiently. But we're never going to be able to deport our way out of this problem. And of course, if Trump really does win and want to deport people, you just can't pick people up you can't pick them up on the streets and deport them. If they've never been in proceedings before, you actually have to put them in front of a judge. And now you have 3 million people in front of you. That's why I said the system is entirely, completely, and utterly broken. There you go. All right, any more questions?
I think we'll quickly go for a short break and be right back. And by then, we'll take up a few more questions, Charles, if that's fine. Welcome back, everyone, to Immigration and Jobs Talk Show. I'm Napasa Pradhan, and this is the second half of this webinar we are having today on Election Day. What will U.S. immigration look like in the next 5 years? And we have with us none other than the very, very amazing guest for today. We have none other than Charles Cook. Thank you so much for this very insightful webinar so far, Charles.
My pleasure. It's great to be with you today. I love talking immigration.
Absolutely. And so are our, viewers out there. They have such amazing questions. It's really lovely having your questions and have you participate with us. Thank you. So, Charles, I think, yes, we have Luandi thanking you. Thanks for the eye opener, Charles. Thank you. Well, I think I would have this next question. If you can tell us, how might enforcement priorities at agencies like ICE and USCIS shift depending on who is elected?
Well, for USCIS, it's really important to understand that Trump has promised through the individuals in his campaign who have immigration background and will work in the agency that every application will have to go through a fraud review and supervised review before approval. That's not currently happening. That will slow things down to a crawl and will result in a lot of false claims of fraud by the Immigration Service because they are notoriously bad at identifying fraud. So it's going to be very, very slow at USCIS if Trump wins. I don't expect any changes if Harris wins, other than hopefully getting better management. Immigration, USCIS is so terribly managed right now. They basically promote from within, so they don't really have people that have outside business type of experience, how to run a large organization. And as a result, they're really bad at their job. ICE, on the other hand, as for the last 4 years, they've kind of just been twiddling their thumbs like this, waiting for the chance to deport people. So ICE, which we call ICE, will be very proactive in looking and searching out people with removal orders and working with local police as they arrest immigrants for various crimes or driving violations and put them in removal proceedings. It's going to be big changes for both agencies.
I would also like to know, what impact could this election results have on the backlogs? I think that's what most of us are concerned about. And also the visa bulletin and family-sponsored visa categories.
Well, of course, the visa bulletin is constrained by the law. Only Congress can fix the visa bulletin. It can't be fixed by anybody else. So you could, as I mentioned earlier, the administration could reinterpret who is included in the 40,000 in each of the EB3 category, EB2, EB1 categories to only include actual workers. They could do that. I'm not sure they will, but they certainly can do that. We tried to get Biden to do it, and he wouldn't bite. But I don't think he had the right people on the bus. I think we might have better. I know the person currently advising Harris on immigration. He's fantastic. And I think we've got an in on getting that interpretation done. But as far as the other aspects of immigration, Trump's going to make it worse. The backlog you have today will be much worse under Trump. And Harris, keep in mind, Indian nationals have a friend in the White House, right? This is, how does it get better than that to have someone with an Indian mom in the White House? It doesn't get any better than that. And she loved her mom. So I think there's going to be a movement, and I think we will see aggressive movement by the White House to kind of cut back on that backlog and increase legal numbers. But ultimately, it's Congress that controls it, not the president.
Definitely, but America being land of immigrants, I think we are so much excited to know what changes will happen in the immigration front, and I'm sure that's going to be a lot.
Rich guy. All I can tell you is what should happen, not that it will happen. I've been fighting for immigration reform since the last time Congress destroyed our immigration area in 1996. So it's almost 30 years that I've been going to Congress every year, lobbying them, talking to senators. The thing is, most of them know what they have to do. They're afraid of losing an election if they help immigrants. And that's why defeating Trump is so important, because it will allow us to throw that anti-immigration rhetoric out the door, out the trash can, and embolden some Republicans to say, I love immigrants, like George Bush always did. I want to fix this. So that's what will happen.
mean, we really need some solutions for so many of these loopholes to be covered and be fixed as soon as possible. But definitely talking about those, I mean, the visa bulletin, the dates changing, I don't know when will that happen. But yes, we have some comments. Let's take up Dheeraj from LinkedIn. He's asking, will there be any effect on H-1B holders after the elections?
Not after the election, but if Trump wins after he takes office in January, you will see rapid changes to how immigration works. I would suspect they will immediately republish their rules, which I was one of the lawyers that beat back the rule on prevailing wages. And they will publish right away, probably with immediate effect for the March lottery, the H-1Bs based on job income, so that people with the highest salaries will get H-1Bs. I think that will be an immediate thing in February and March of 2025 if Trump wins. If Harris wins, you won't see any changes. None at all.
Thank you, Dheeraj, for your question, and thank you, Charles. It's been lovely having you. I wish we didn't have to wrap up so early, but I think this is it. And thank you so much for joining us today. But before we leave today's discussion, if you could leave all of us, especially our viewers, with an end note, it would be great.
All I can tell you is this: America is a great country. It's a great place to live. It is an land of opportunity for immigrants. One of the things I've dedicated my career to doing is helping immigrants achieve that American dream. You know, not everybody can come legally. Not everybody has that opportunity. Not everybody's got a degree. Not everybody's got a relative here. Some people come seeking refuge, and that's okay too. America's got room. We have room to grow. We have room to be. The only thing we have to worry about in America is if people stop coming here. People stop coming here, we do have massive problems. But until then, until we talk again, good luck. Pray for America tonight. Pray for a Harris win, and we'll move forward.
Thank you. Thank you so much, Charles. It was really lovely having you. I'm really looking forward to having you back as soon as possible for such passionate discussions on immigration. Lovely having you. Have a great day ahead and enjoy your day ahead.
Thank you. Bye-bye.
Bye-bye. Thank you, folks. Thank you so much for joining us here on Immigration and Jobs Talk Show on today's discussion on Election Day. So, who is going to win and what is the next 5 years going to look like on the immigration front for the US? Well, I think we'll just have to stay tuned, and you have to stay tuned on Immigration and Jobs Talk Show because we are coming up with a lot more updates on today, Election Day. Thank you so much for joining us. This is Nipasa Pradhan saying bye for now. Hello, everyone. Thank you for joining us once again here on Immigration and Jobs Talk Show. I'm your host, Nipasa Pradhan, and it's seriously an absolute pleasure to be here once again with another very insightful webinar lined up for you. But before we move ahead with today's discussion, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, friends, thank you once again for joining us here on Immigration and Jobs Talk Show. And this is a great place for you to be in, especially if you want to know more about US immigration and business opportunities, because we are going to dive into a topic that has definitely sparked significant interest. So, how entrepreneurs and investors can be on the ground doing business in the US in under 6 months. And yes, to help us, dive deeper into the key insights on E2 and L1 visas, we are going to be honored by the presence of none other than our guest for today, um, Mr. David R. Fulmer, an exceptional immigration attorney and a leader in his field. So, Mr. Fulmer is a partner at WR Immigration with over 2 decades of exclusive practice in immigration law. He's been recognized as Immigration Lawyer of the Year and is celebrated for his expertise in assisting companies, entrepreneurs, and even entertainers, navigate immigration challenges. So, for all our viewers, whether you are an entrepreneur, dreaming of setting up a shop in the United States or your business, or maybe an HR professional overseeing visa processes. Well, thank you so much, all you immigration enthusiasts, for being here. And without further ado, please help me welcome our guest, Attorney David Fulmer. Thank you so much for joining us.
Thank you very much for having me, Napasa. I'm thrilled to be here.
Absolutely lovely. And I'm so excited because this is the first time you're here. And we would love to get to know you better. Maybe tell us more about yourself and anything else is something interesting to share if you have any.
Well, I'm lucky enough to live in Los Angeles, and it's an amazing place to live. Our offices are steps from the beach, and I also live about 5 minutes from the beach. So it's an amazing place to be. It's an amazing place to welcome immigrants from other countries, and I think it really exemplifies the best that the United States has to offer. So I'm really happy to be here.
It's an absolute pleasure to have you here. And I can only imagine what a great vibe you must be surrounded with. I mean, the beach always gives you good things, I think, the sunshine and a lot of palm maybe. But yes, I can only imagine. So thank you so much. And well, with regard to today's topic of discussion, how entrepreneurs and investors can be on ground doing business in the US in under 6 months. So, what can folks out there who have joined us or will be joining us in this session, what can they expect from us today?
Well, today we're going to talk about e-visas and L visas, and these visas really do present an opportunity for people to kind of direct their own destiny. A lot of times people think about coming to the United States on an H-1B visa, which is amazing and it's great, but it requires them to find a job offer. Or they think about maybe being petitioned under EB2 or EB3, and those are amazing as well, but it requires both a job offer and a very long wait. But E2 and L1 are really opportunities where if you're from the right country, in the case of an E2, and if you have the funds and if you have a business plan, that you can actually direct your own destiny and move to the United States, bring your family to the US. It's an opportunity for people's spouses to work or for their kids to be part of the US education system, all based on their own funds, their own business plans.
Absolutely, friends. Today we are going to discuss about E2 and L1 visas, and especially all you folks out there who are businessmen and who want to maybe expand your business or go start a business. Great place to be in. So, yes, I think without further ado, I have my first question for you, David. And this is with regard to this change of administration. How might President Trump's immigration policies impact pathways for entrepreneurs and the processing of L1 and E2 visas, considering the administration's historical focus on stricter visa regulations?
That's a very good question, and the answer is not necessarily straightforward. There's two things we can look at. First of all, we can look at the prior Trump administration and what they did. And then we can look at some other issues relating to the incoming Trump administration. So first of all, looking back historically, the prior Trump administration implemented a policy called Buy American, Hire American. And the idea of that policy was that in relation to any visa or any immigration process, they wanted to make sure that issuing a visa for that individual would not hurt the wages and working opportunities for U.S. citizens. So it was always a part of, during the Trump era, we always had to demonstrate that jobs would be created. With E&L visas, that's already part of the program. So that's one thing. Next, over the last few years, a lot of U.S. consulates have been waiving in-person interviews. And what that's done is, I wouldn't expect that interviews would be waived for E&L visas, but waiving of interviews for, say, people who are getting extensions of their H-1B visa has kind of opened up resources for quicker processing of other visa types like E-2s. And so getting rid of interview waivers will probably cause some delays. If you'd want, I can talk a little bit about some another interesting aspect of it, Napasa, which is
Sure.
Everyone knows that Donald Trump has been very close to Elon Musk. Now, Elon Musk is a business leader from Silicon Valley, and so we're also hoping that Elon Musk will have President-elect Trump's ear, and he might influence him to be a little bit kinder and gentler and a little bit more efficient when it comes to visa issuance. So on one hand, we can expect things to be stricter and slower, but we're hoping possibly that Elon Musk might have some influence and might be able to influence things in a positive way.
Absolutely. And looking at how close they are, I think he might as well. And both of them business minded, they would love to soar with regard to business. So I'm sure this is going to be good. And right. Right. But yes, on the other hand, like you were saying, like stricter rules, and maybe they are going to just make the situation even harder, that they, finally drain out or give up and just go away to their own countries. Who knows?
Absolutely.
So,
I mean, I think that we will have more RFEs. Normally, when you file an L1 petition, there's always going to be a chance that you could have a request for additional evidence. During the prior Trump administration, there were a lot more requests for evidence. And so I think we can expect more requests for evidence, which will cause processing times to extend a little bit.
right, right. All right. So, folks, we have mixed things to look forward to, but I think it's always best to stay on the right path and do the right thing and keep your documents right. And there is no limit to your dreams. So keep dreaming high and work for it. Yeah.
Absolutely.
All right. At this moment, I would like to say hi to Sneha. Thank you so much for joining us here on YouTube. I can already see your comments. Stay with us. All right. We are going to address your questions a little later in this webinar. Now, moving on, David, I have the second question, and this is, for entrepreneurs looking to establish their presence in the United States, quickly, especially, they don't have time to wait or don't want to wait that long. What are the critical steps to secure an E2 or an L1 visa within 6 months? Is it possible?
It is possible. So first of all, the key point with relation to an E2 visa is the individual needs to be from a treaty country. And the U.S. has E2 treaties with many countries, but not every country. We have E2 treaties with about 85 countries, but we do not have them with the BRICS countries. So not Brazil, Russia, India, China, or South Africa. But if you are from an E2 country, then the E2 is a possibility. Otherwise, you have to go through an L1 visa, which has additional requirements. So if you're from an E2 treaty country, the first thing you'll need to do is really set up a business plan, decide what type of business you would like to be in the United States. Then you'll have to set up an entity in the United States. You have to set up a corporation or an LLC, register it with the Secretary of State in that state, get a tax ID number, set up a bank account, and then you can fund the company, and that's really the first step.
All right. Thank you so much. Thank you so much, David. I think that makes us hopeful, at least. And maybe, are there any tips or maybe additional things that folks can keep in mind when they are in a hurry to be out there in the US?
Well, I think, it's good to be in a hurry, but more importantly, to be in a hurry is to make sure that they're in a business that's going to be successful in the United States. So first of all, I recommend that they look at themselves, look at their history, look at what they're good at, and look where they could be competitive in the United States, because the business environment in the US is very competitive. And so rather than being in a rush, I think people should analyze where they think they can have an impact, where they can be successful in the United States. Once they've done that, yes, then they need to connect with advisors in the US, both an immigration attorney, a business attorney, to set up the US entity. And then another key thing is to find a general manager in the US that can kind of help them be feet on the ground, because there's a lot of things that they may not be able to do from overseas before they obtain the visa. And even if they come to the United States, they wouldn't be allowed to work until they obtain the visa. So hiring a general manager to be really feet on the ground will also be very, very key thing to help them to be able to move this ahead quickly.
Right. Thank you so much. Thank you so much, David, for, walking us through and giving us tips on how to quickly, get yourself ready for an E1 or an L1, for an E2 or an L1. Thank you. Thank you. So now moving on to my next question is, how can, a startup entrepreneur from a treaty country, demonstrate a substantial and non-marginal investment for an E2 visa while meeting current USCIS standards?
Definitely. So really, that's two questions. There are several requirements to obtain an E2 visa. One is the investment needs to be substantial. And then the regulations say that the business cannot be marginal, which is kind of a strange word. What does marginal mean? Well, they go on to explain that a marginal business is a business that only generates enough revenue to support the investor and his own family. And so the rule says the business cannot be marginal, which means that it needs to be successful enough and generate enough revenue to hire US workers. So really what it should have said is that the business will support US workers. And so I believe that goes back really to the business plan. The government needs to be able to review the business plan and see that the business plan makes sense, see that it's logical and believable that the company will be able to generate revenue so that it can employ US workers. So that's marginality. You asked me about substantiality. The regulations also say that the investment needs to be substantial. And I have my clients all the time ask me, David, how much is substantial? And I wish that the government would tell us exactly what they want. In another context, in the EB-5 program, the law specifically says 800,000 or 1,050,000. But in the E2 context, the rules only say substantial. So what is substantial? It really goes back to the same thing that I said relating to marginality. And that the investment needs to be enough so that the government believes that the business will be successful and generate revenue, both to support the investor and the US workers. However, I think there are some limits to what is substantial. Sometimes I have people asking me, David, can I apply for a visa with a $20,000 investment or $50,000 investment? Lately, I haven't seen E2s being issued with under $100,000 investment. And I'm often seeing people investing, around 200,000. Again, the law doesn't say, doesn't give a specific amount. But usually lately I'm seeing people investing at least a couple $100,000.
Right, David. And that's a lot. I mean, for folks out there who were just expecting to start something within 20, I mean, they have to go 5 times more. So
Well,
there you go. And
we're gonna get
yes,
to that
yes,
later, I believe. But sometimes if somebody doesn't have that type of funding, then an L1 visa would probably be a better route.
right. So we're getting to that. Thank you, David. Thank you for, telling us about USCIS standards and the E2 visa bit. And also, Vikas has joined with a few questions. Vikas, please stay with us. We are going to address your questions a little later, but thank you so much for joining. And now, moving on, David, what are the key industries or business models that are currently seeing faster approvals for E2 and L1 visa applications?
So what I can't tell you is what models are being approved or being approved more quickly because it's really wide open. What I can tell you is models that won't work. And models that won't work are the passive businesses. I have a lot of people telling me, David, I want to buy a house. I live close to Malibu. I want to buy a house in Malibu. It's going to cost $10 million. That's a substantial investment. Can I get a visa with that? The answer is no. It is an investment. It is substantial, but it's not going to meet the marginality requirement. It's not a business at all. It's not going to generate income for anyone. I have other people asking me if they can be passive investors in minority interests in companies. So can they be essentially investors and get visas? And the answer is also generally no, because that is not an active business that generates employment for U.S. workers. So what we're looking for is active businesses. Some common ones are restaurants. Restaurants require a lot of human capital and require a lot of funding. So that's a very common business. But I've seen people obtain visas from almost every industry. It simply has to be an active business and not a passive investment.
Okay. Okay. Thank you so much for telling us about that as well. And anything important about USCIS standards to keep in mind? Maybe something, when people out there are trying to fit themselves with an E2 or L1. Anything else to keep in mind?
There are a lot of things to keep in mind. The focus really is on will the business support the U.S. workers? That's a very key point to always keep in mind. A lot of people think, yeah, they can invest and get to the U.S. and kind of figure it out from there. But when they invest, they need to, when they apply for the visa, they need to submit a pretty detailed business plan. And the business plan needs to spell out, their business model, how they think they're going to be able to generate business, what they're going to do in the U.S., and how they're going to, generate enough revenue to create and maintain U.S. jobs. So I think that's a really key point, and it's going to be more important during the Trump administration.
Right. So the question is it going to benefit the United States? And
absolutely. I mean, I know that it will benefit the foreign investor, but what does the U.S. government care about? How it's going to benefit the U.S. They want to see that those funds have been put into the U.S. economy and spent. So it's not just that they take that 100 or 200,000 and put it in their U.S. business bank account. They want to see that most of that has been utilized and spent and pushed out into the U.S. economy, and that U.S. workers are going to be hired. So it's a win-win. The foreign investor will be able to live in the U.S. Their spouse will be able to work. Kids will be able to go to school. They'll be able to do business in the U.S. And the U.S. will benefit quite a bit from each E2 or L1 that comes into the U.S.
Absolutely. Thank you, David. Thank you so much for the detailed explanation. And now moving on, if a new entrepreneur already has an operating business abroad, what documentation is critical to establish the connection needed for an L1A visa?
Absolutely. So if they already have a business operating abroad, that's a huge head start. And so they will be able to obtain what we call a new office L1. But before they can apply, they need to set up their U.S. Entity. And the U.S. entity has to have a qualifying relationship with the foreign business. So that can mean that the U.S. business is a wholly owned subsidiary of the foreign business, that it's a sister company of a common parent, that it's at least a 51% subsidiary, or that the U.S. business has the exact same ownership in the same percentages as the foreign business. So we call this a qualifying relationship. And this is a very, very key initial issue that needs to be addressed each time.
All right, David. Thank you so much for that and for the detailed explanation. I think now we should move ahead to our next question, and that is, what factors should an entrepreneur consider when selecting the US location for their new business under an E2 visa?
Absolutely. So a lot of people just want to do business in the United States. Other people understand that the US is a very large, very diverse country with really 50 different jurisdictions inside of it. Each of the US states have their own cultures, their own laws, and they even have their own taxation systems. So before they set up business in the US, I believe that people should talk to a tax advisor to determine if one state will be better than another. I have a lot of people that want to do business in, say, Florida or Texas because there is no state income tax. I have other people that don't really care about taxation. They want to be by the beach. And so they're going to live in Los Angeles or Florida, some even in Hawaii. And so really it's a personal decision, taking into consideration the business climate, taxation, and personal preferences.
All right, David. Thank you so much for, getting us through, for establishing a good connection that is required for an L1A visa. Now, moving on, I have another question, and that is about E2 visas. So, how can small businesses, now, especially after the pandemic, I think we see a lot of new businesses coming up. I think during that time, almost every household, or many households, they started their new businesses from home, online and everything. So I think that trend is still on. And nowadays, everybody shopping online, I think it's become a very big thing, startup businesses and everything. So how can small businesses, and first time investors overcome the common challenges of proving their business viability for an E2 visa?
That's a very good question. You talked about people doing business, kind of side gigs from home. The new E2, the Foreign Affairs Manual relating to E2 visas says that an E2 visa can't operate out of a home office. But how can they do a good job of establishing that they are a viable business? I believe number one, even though the regulations say they can have a home office, they need to have physical presence. Next, a lot of businesses nowadays are service businesses. Even me as a lawyer, this is service industry. It doesn't take a lot of capital to set up a law practice. It takes a computer and a good connection to the internet. And many other businesses are like that. They don't require much capital investment. But to be a good E2 business, in order to obtain a visa, it has to be the kind of business that does require capital investment. So it has to be the type of business that requires an office or a plant or a facility and inventory. So these are some key points. That physical space, and it has to require that investment. And it has to be invested in the right thing. Yeah.
Okay. No, you were saying you can you can continue.
Okay. Yes. I was contacted by some people from Canada, and they had invested about 100,000, and they wanted to open up a business where they were going to set up Airbnbs. And it sounded good because I know in order to set up Airbnbs, they have to either purchase or lease a property. They have to outfit it with furniture and technology. And so I thought it could be good. When I looked at what they put their money into, they put their first 50,000 into courses on how to be successful in the Airbnb industry. And while those might be tax deductible according to the IRS, I didn't believe that those would be considered to be proper investments for the E2 visa. So the investment has to go into the right area.
Right. And well, when you say right area, like that has to still benefit US, and only then they can be considered, right? So if in case they do not benefit the US, or there is like a chance that the US does not need this kind of business, there are chances that they can never start that business, right?
Well, so first of all, you ask, what if the investment does not benefit the US? So I've seen some scenarios where somebody sets up a business, so they make an investment, they set up a storefront, and they purchase supplies and equipment, but then they purchase the inventory from a foreign country. And I'm asked, well, does that purchase count as part of the investment? It does, but I believe that it might not get full credit. I believe that the US government will probably favor purchases that come from the United States, especially under the Trump administration, where we're going to have the Buy American, Hire American policies. And so, yes, if the government, if the U.S. consulate does not believe that the investment is substantial, and this is, again, the numeric number is not set in stone. They don't feel like it's enough. If they don't like it, they can deny it. They have a lot of discretion to deny the visa application.
All right, David, thank you so much for, walking us through, L1A visa and how important is it, for an entrepreneur to prove that they are going to benefit the US, and of course that they are doing the right kind of business, and maybe they are very innovative. So yes, thank you so much. And now moving on, I
one other
have
quick
an
point. Oh,
sorry. Sorry, yes, David, please say.
if it's okay, one other quick point. Um, the business that they're in the United States needs to be legal according to U.S. federal law. And I've seen a few people from countries like Canada operating in an area that's technically legal in some other countries and legal according to some states, but not legal according to U.S. federal law. What I'm talking about is anything related to cannabis or marijuana. In California, according to state law, it's generally legal to purchase and if you have the right licenses to sell. But according to U.S. federal law, it's not legal. So people, if they want to obtain a U.S. visa, they should stay 100% away from any industry that has the taint of being connected to something that's illegal, even according to U.S. federal law.
Right, very important thing to keep in mind. So, folks, thank you so much, David, for highlighting that. And folks out there, that's a very, very important thing. So, Vikas, thank you so much for more questions. We are going to come to that. But I think at this moment, it's time for a short break. So, folks out there, you can also have a one-on-one discussion if you're loving David's ideas, advices, and knowledge, and maybe you want to consult him with regard to your case. Why not contact him as well? You can call him on his number, and his phone number is 310-570-4065. And you can even email him dfulmer@wolfsdorf.com. DFULLMER at WOLFSDORF.com. And yes, go visit www.wolfsdorf.com. Don't go anywhere. Stay tuned to Immigration and Jobs Talk Show. Well, I'm Napasa Pradhan with none other than attorney David Fulmer. Hello and welcome back, everyone, to Immigration and Jobs Talk Show. This is the second half of the webinar we are having, and I'm Napasa Pradhan with today's guest, none other than attorney David Fulmer. Yes, he is an amazing immigration attorney who is based out of Los Angeles, and it's such a great honor and a pleasure to have you here with us. Today, we're discussing about how entrepreneurs and investors can be on the ground doing business in the US in under 6 months. So it's been a great discussion so far, and we have a lot more questions to cover. And also, folks out there who have questions for us, Vikas and Sneha, we are going to take up your questions. And I would also like to ask you folks to also join us in this conversation. You know, you can participate by asking your questions in the comment section wherever you've joined us from. We are streaming live on YouTube, LinkedIn, Facebook, and X. And yes, David, it's been a great discussion so far. Thank you so much for doing this.
Thank you for having me. It's been a lot of fun.
Thank you. So I have another question, and that is what are the primary differences between E2 and L1 visas that we are discussing today, you know, both for entrepreneurs, and how should one decide the best fit based on their business goals?
Absolutely. So first of all, the first thing to look at is whether or not an individual is from a treaty country. So if they're from a treaty country, then both possibilities are on the table. But if they're not from a treaty country, then the E2 can be dismissed. Secondarily, the business needs to be majority owned by individuals from the treaty country. So if we have a transferee from a treaty country, but the business is majority owned by his partners who are from another country, that's not going to work. So first we look at the treaty country. If the individual is from a treaty country, then E and L are both on the table. Next thing we would look at is whether or not the investment is substantial. As I mentioned before, E2 does require a larger investment. And so if the investors were thinking that they were going to set up a business with a lower amount, let's say $40,000, $50,000, then they would definitely, they should definitely go toward an L1 instead of an E2. Now, if the investment is substantial and they're from a treaty country, then which is better, E or L? There's some factors to consider. First of all, for a new office, L1, they're only going to get a one-year visa, where with an E2, depending on where they're from, they might get a visa that's valid for up to 5 years. And so if they're looking at saving costs and kind of getting it done and not having to worry about it in the future, then perhaps an E2 is better than an L1. However, with an L1, the L1 new office rules do allow them to apply essentially based on a business plan. And so theoretically, maybe it's a little bit less work in the business setup to obtain an L1 than it is to obtain an E2. Now, the other big difference is that an L1 visa is a dual intent visa, where an E2 is not technically a dual intent visa. That means that when you obtain an L1, you can have the plan and intention to obtain permanent residency in the United States. Where with an E2, you need to have the plan to depart from the United States once you're done doing business in the United States. That's a big difference. Finally, an L1 visa allows for an opportunity for applying for immigration or green card under the EB1C category, where E2 does not necessarily present that opportunity. So these are some factors to consider when you're trying to determine which is better, E2 or L1.
Thank you so much for highlighting the differences, David. And I'm sure, I mean, folks out there who are in a dilemma where to categorize themselves, they have a clearer picture now. Thank you so much. And moving on, now I have another question, and that is, if an entrepreneur's visa is tied to a new business that faces unforeseen challenges or restructuring, what options do they have to maintain compliance and their immigration status?
That's a good question. And this comes up a lot because plans are great. But once they obtain the visa and arrive in the United States, sometimes business does not go according to plan. In fact, maybe it never goes exactly according to plan. But what happens if, they get to the United States on their E or L visa and it's really slow. It's hard to get customers. And so First of all, on an E2 visa, if they obtain a 5-year E2 visa, they do have a little bit longer to turn the business around. Maybe they can't maintain all of the employees throughout the whole 5-year period, but they need to make sure that they have been able to turn the business around by the time it's time to renew the visa. And secondarily, they cannot close the business. So let's say that somebody has an E2 visa and it's tough and they can't maintain all of their employees. If it's a retail store and they close the store and they're no longer in business, then they're no longer in status. So they need to keep on trying. Sometimes that means investing more capital. It might mean changing the business model slightly. It might even mean changing the location slightly. But they need to stay in business, to stay in status, and stay in compliance in the United States. If somebody gets a new office L1, they only get a 1-year visa. And so the pressure is on to be successful and to step up within the first year. And if business is tough, if the contracts aren't coming and the money isn't flowing in, they do have the option again to invest more money to maintain the business and to be able to get that extension after the first year.
Okay. Thank you, David. Thank you so much for, walking us through. And now moving on, I have this next question, which frequently comes in mind, and we find them a lot in our groups also. And, folks out there have this question. So how can entrepreneur, transitioning from a visitor visa to an E2 visa ensure that they meet the strict timeline requirements for operating the business in the US?
That's a good question. So first of all, I would hope that if someone is entering the US as a visitor with the plan of obtaining an E2, that they enter on B1 instead of B2. Because usually when people obtain a B visa, it's B1/B2. So if they enter the US on a B1, then they're going to have 6 months to either depart from the US, or technically they may be even able to file the change of status in the US from B1 to E2 status. So if they know what they're doing, and if they have 6 months, that should generally be long enough to go through the steps of, again, setting up the entity, registering with the Secretary of State, getting a tax ID number, opening a bank account, transferring the funds, and then setting up shop. So if they know what they're doing, 6 months is long enough. If they have no idea, then it's going to be more difficult. If someone has no idea what they're going to do, they should probably look into a franchise, because a franchise will kind of have the business plan spelled out. So they should probably talk to a franchise broker and see if there's an opportunity that they're interested in an area that they're interested in, and that's within their budget. And then a franchise should offer a way for them to be able to kind of roll forward pretty quickly, even if they don't know quite what they want to do.
Okay. All right. Thank you so much, David, for that advice and tip, I would say. So now moving on, I have this next question, and that is, for investors planning to use an L1 visa to expand their company into the US. So what strategies can help them build a stronger case for a new office, for a new office petition while ensuring the timely approval?
Absolutely. So first of all, it's really important to look at the foreign business and the person's role within the business to make sure that they're going to be able to be categorized as a manager. So, the L1A visa is the visa for foreign executives or managers that are transferring into the United States to be managers or executives in the United States. It's very important to kind of look at the position abroad first before you launch the case into the United States. So is the person a manager? A manager has 3 subcategories. It can be an executive in a large company, a C-suite executive. It can be somebody who is what's called a personnel manager, who manages 2 levels of staff beneath them, or it can be a function manager who doesn't necessarily have direct reports, but who manages a very essential function of the business through indirect reports. So first of all, do they qualify based on their current position? And that's really the first step before even thinking about launching that business in the US. If they don't qualify, they need a year of qualifying time. Maybe they should adjust their position and wait 1 year so that they qualify, and so they will not have any problems when they launch the business in the United States.
All right. All right. Thank you so much, David. I think that would really help all of us, and it has definitely given us a clearer picture on how to go about either E2 or L1, or where can they actually fit themselves in. And I think now we should definitely go address these questions we have from our viewers. And I will take up Sneha, our first viewer, and her questions. So she says, I've already set up a business in my home country, but I want to expand to the US. How quickly can I establish a US branch under the L1 visa? And what steps should I prioritize to ensure a smooth application?
So, first of all, again, it's great that she has her business set up overseas. That's excellent. The question is there enough going on in that business to support an L1 visa? So, it's going to have a number of employees in order for her to be deemed to be a manager. So I would, in an ideal world, I'd like to see it have 10 or 12 employees at least, and a structure that's with a hierarchy where she's at the top, there are mid-level managers beneath her, and then the workers below her. That would be what's called a personnel manager. So before she thinks about setting up in the US, make sure she's built up her foreign business. Also, the foreign business needs to be strong enough that when she transfers to the US, it continues to be in business. Because if she gets the L1 visa and the business outside of the United States, winds down, then the L1 visa is no longer valid. So it needs to be really built up and strong enough to be able to support the transfer. Next, the procedure of setting up the entity in the US is really quite easy. But the first thing she should do is talk to tax advisors and see if they have any suggestions on the structure and the location. There are a couple of ways it can be done. It can be done as a subsidiary of the foreign business, as a sister company of a common parent, or the shares could even be owned by her individually, as long as the foreign business and the U.S. business are owned by the same shareholders in the same percentages. So strengthen the foreign business, get tax advice, and then get an attorney to help you set up the U.S. entity.
There you go. It's always best to have a US attorney, to help you navigate or, guide you through any of your visas, because they are the experts and they know that each case is different and every case is special and every case needs special attention. So, yes, thank you so much, David, for taking that up for Sneha. And, I would like to share my screen now because we have more questions in our groups. So, I think I'd like to take them up first before we take up Vikas' question. So, let's take this one. This is from an anonymous participant asking, my L1B petition was approved on 15th of August in premium processing. Still, I have been waiting for the approval petition, and my company visa team is saying they are yet to receive the petition documents from attorney. Usually, how long does it take to receive the approved petition? That's the question.
So the question says that the application was filed through premium processing. And so when something is approved through premium processing, generally the attorney who filed the petition will receive the approved I-797 within about a week. And if it's not received within about a week, then the attorney or the petitioner should contact USCIS. Because premium processing was utilized, there's a little bit more customer service. And so the attorney or the petitioner can email premium processing to tell them they have not received the approved I-797. It should not take long. If it was approved in August, here we are in November, that's a problem. And that should be aggressively followed up on because there's no reason for that to happen these days.
Right, that means that is not a good scene. But thank you so much, David, for taking that up and for the answer. Now I have this next one. This is also from an anonymous participant asking, when looking at the wait times of interview waiver for L1 visa, it doesn't give any information on wait times. It's just blank. Also, when looking for an appointment for Dropbox for L1, it doesn't show any slots. Are there any changes to the process for L1 visa renewal stamping? Also, did anyone get it done in Mexico instead?
Okay, so we have a few questions here. First of all, I think first of all, they're asking about interview times for an L1 under visa wait time. So the Department of State has a web page that's called Visa Wait Times. So you can Google it, you can find it. It says Visa Wait Times. You type in the city, and it will tell you the common wait times for each different type of visa. And for some, and from consulates in some categories, it'll tell you the waiting time for interviews and interview waivers. So if it doesn't list it for interview waivers, sometimes what we have to do is kind of analogize it. So if it doesn't say L1 interview waivers, perhaps you can look and see what it is for H1 interview waivers and get a general idea of what it's going to be. Natasha, can you bring it up on the screen so I can see the rest of the question?
Sure.
When looking for an appointment, Dropbox L1 doesn't show any slots. It could be that they're not allowing for Dropbox appointments for L1s. If it's not showing any slots, or you may have to email the consulate and see if they'll respond to you about that. Processing in Mexico. So processing in third countries may be a possibility. I can't say I have done too many in Mexico lately, but it may be a possibility. What you want to make sure is if you're processing in a third country, you have a visa to get into that third country. That can be an issue sometimes. And you may want to contact the consulate to make sure that they're open to processing the visa there if it's a third country.
All right. Thank you, David. Thank you so much for that insight, and that was really helpful, I'm sure. Now, moving on, I have this next one. This is from Naluri asking, is it okay to apply L1A extension in premium now? Bunch of thanks in advance for your response here.
There's no reason to not apply for an L1 under premium processing right now. It's available, and generally these days people utilize premium processing whenever it is available. Sometimes there are strategic reasons when you won't want to, but in most cases people are utilizing premium processing on any category that's available, and I don't see a problem with it in general.
All right. Thank you so much, David, for taking that up. Now, I have another question, and this is also from another Facebook group, from an anonymous participant. What are supporting documents required for converting L1B to L1A category?
Okay, so that's a good question. L1B is for someone with specialized knowledge. L1A is for a manager. And so the assumption is that you were probably in your home country were working in specialized knowledge. When you transferred to the US, you were working specialized knowledge. And now you've been promoted into a manager, or you will be promoted into a managerial category. And so you'll have to prove that the employer does have a position for you that fits the managerial category. And so what does that mean? Usually you're going to have a detailed job description. You'll have to have an organizational chart to show the people that are going to report to you. And you usually have to demonstrate what titles and what duties those people have so the government can see that you really are turning into a people manager from a specialist.
All right. Very interesting. Thank you so much for taking that up, David. And thank you, anonymous participant, for the question. Well, I have another one. This is also from another group. Another anonymous participant asking, has anyone recently got their L1A extension stamped in Canada? Please share your experience. We don't want to travel all the way to India. So this person is from India originally.
Absolutely. Canada and Mexico technically have jurisdiction over people who are physically present in the United States. And so it is theoretically possible. I'm not saying it happening a lot these days, but it is possible. Obviously, it's a shorter trip. A lot of people still want to go back home because if they stay in Canada, they're going to probably get a visa to get into Canada. They're going to have to stay in a hotel for a week or 10 days. And there's usually a longer wait time if you're applying in a third country. So people from Canada will have priority over people who are third country nationals. So even though it's theoretically possible, a lot of people would rather go back to their home country.
Oh, that's very, very interesting, really. Maybe could you tell us more about it?
Well, yeah. So, if someone's on assignment in the United States from India, they're away from their parents, their siblings, and A lot of times there's a need to kind of go back and see family. So if they go back home to India, they're going to be able to see all of their family, kind of check that box off, and they're probably going to be able to stay with their family for free. But if they're applying in a third country, again, they're going to have all the expense of a trip, and they're not going to be able to see family. So a lot of times people prefer going back home instead of kind of making it into the annual family visit while they're getting visa stamped, as opposed to doing it in a third country.
Right. Very interesting. Thank you so much, David, for taking that up. And moving on, I have more questions. So let's take this one up. Another anonymous participant is asking, "Hi everyone, I'm heading to India for my L1 blanket visa stamping and currently see Chennai as the only available option for scheduling. Has anyone managed to book appointments at other consulates recently? Also, is it possible to schedule both for OFC and consular appointments on the same day since I see that option in the portal? Thanks in advance for your help."
So I can't say I have all of the information on exactly what the appointment booking is in India.
Yes.
Um,
But
yeah,
I
so
think we
maybe
didn't speak about the blanket visas, no? L1 blanket. So maybe if you have anything to say or especially highlight the important points about blanket petitions, it would be
absolutely.
great.
Yeah, I mean, blanket petitions are an excellent tool. Employers should definitely obtain a blanket if they qualify, because they don't have to submit every single application to the USCIS. Instead, they can apply directly at the US consulate. However, at the US consulate, there will be a little bit more adjudication, and the standard for adjudication of an L1 blanket at a consulate is a little bit higher than it is at the USCIS. And so you want to make sure you have a very strong case if you're utilizing the blanket.
All right, that's very important. Thank you so much, David, for taking that question up and also telling us about blanket petitions. Now, moving on, I have another question, and this is from another anonymous participant asking, "Hello, this one we've taken actually, right? We just took it. I think that's it. Okay, this is one last one. Hi guys, I need help. My husband's L1 extension petition and my L2 extension I-539 have been filed together on October 2024, while L1A extension is filed in premium processing. Mine is not. So it's still under process. My I-94 is expiring on December 20th this year, but I have a valid stamped visa till 2027. My husband received his approval notice. My questions are, if I travel outside the USA, will my I-539 be abandoned given it's the extension of the same visa category? Let's take
So
this
the
one
answer to
first.
that is yes. The I-539 is abandoned when you depart from the US.
Okay, and the second question is, can I re-enter USA with my husband's L1 approval notice and current visa?
Yes, you should be able to. You have a visa, you have your husband's L1 approval notice, he's still employed, you're still married. There shouldn't be a problem with that.
All right. Now, the third question is, if my I-539 is abandoned, do I need to apply for extension again with USCIS?
No, you do not. You will be admitted on a new I-94, so you do not need to file a new I-539.
All right. I think the last question is, I heard about flag polling where I get my I-94 extension using my husband's L1 approval. That's right. Will it
Correct.
affect my I-539 if I cross border to extend my I-94 based on my husband's approval notice?
So I think that's really a combination of questions 1 and 2 and 3. And so,
Right.
yes, I-539 will be abandoned, but yes, they should be admitted on a new I-94.
All right. Thank you so much, David. I think with that, we have covered most of the questions from our groups. And well, we have another live audience who has joined us on YouTube. This is from Rajesh. Hi, Rajesh. Thank you for joining us. He's saying, I am a Canadian and would like to know if I can apply for E2 visa based on my rental properties in USA and start a rental and property management business. Does this business apply under E2?
Yes, it could. So while just owning one rental property probably would not qualify, if someone had a number of rental properties and perhaps contracts with other companies to manage their properties, and if that business, again, meets the other requirements, substantial investment, if it had employees, so it met the marginality requirement, absolutely, this could be a valid E2 business.
Okay, there you go, Rajesh. I think that's good news for you. All the best. Now, let's take up Vikas. I'm so sorry, Vikas. I kept you waiting for so long, but here we are now. Let's take up your questions. He has a series of questions actually. So Vikas is saying, if I already have a tourist visa and want to explore potential business opportunities before applying for the E2 or L1 visa, are there restrictions I should know to avoid complications during my transition? Let's take this one first.
Absolutely. So number one, as I mentioned, they should enter on B1. So when they get to the airport, they'll be asked business or pleasure. They should say business. And if the government, if the customs officer asks them what kind of business, they can be honest and say, I'm thinking about applying for an E2 or L1 visa. I'm here to explore the opportunities. Next, if they get here and if they find the right business opportunity, they can do things like meet with a lawyer, meet with a corporate lawyer, meet with an accountant. They can do business meetings in relation to setting up the business, but they cannot work in the business. So once they've set up the company, if they want to do a soft launch before they obtain the visa, which is a good idea, they need to hire a general manager to perform the day-to-day management until they obtain their visa. Getting that first key employee to manage is very important in obtaining the visa. It also keeps them in compliance because it shows that they're not working illegally in the United States.
Right, right. Thank you. Thank you for taking that up. And he has more questions, so let's address them. If I apply for an L1 visa as an executive, how do I prove my role in my current company and show that my position in the US branch is necessary? And can you give examples of supporting documents that work best?
So it's really two questions. So first he's asking, how do we prove the position in the US is necessary? The government is generally not going to ask you to prove that it's necessary. If the company wants to launch an office in the US, obviously it has to have a genuine, profit motive. And if you have a business plan that shows that it will be profitable, that's all you have to prove. You don't have to prove that it's necessary, only that it appears that it'll be profitable and that it will be able to sustain business in the United States. So the next question you ask is examples of documents. Can you read the question again, Nipasa?
Can you give examples of supporting documents that work best?
Mm-hmm. Well, again, I think that the question might not be accurate, but the main supporting document to show that the business in the U.S. will be, again, generate profit will be a business plan. So that's the key document. It should be pretty detailed. And in the business plan, there'll be sections that will spell out, who the principals of the business are, who are the founders, what history they have, what plans they have in the United States. That's where you really make the sale to the U.S. government that this business will be successful, will be sustainable, will hire U.S. workers.
All right. Thank you for taking that up for Vikas. And Vikas, I think we've covered all of your questions. But if you still have any more further questions, you can keep commenting. And now let's take up Ganesh's question. So, what are the most effective and cost effective visa options for entrepreneurs and investors seeking to establish a business presence in the US within a short time frame under 6 months? And what are the key requirements? I think we've covered this in this
I think
entire.
that's the whole topic, right? But I think the
Exactly.
answer is this. There in the U.S. there are two investor visas. First, we have EB-5, which is an excellent program. It requires a minimum of $800,000 investment. And if somebody's not already in the United States, it's going to take them a number of years to get to the United States on the EB-5 program. So the cost-effective option is the E2 because it does not necessarily require 800,000. It could be 100, 150, 200,000. So that is the answer. It's E2, which is the topic of our discussion today.
Absolutely. And I think with that, it also helps us wrap up a bit and probably summarize rather in a nutshell this whole topic for today. But before we go, David, I would really like to say thank you first. But also, if you could, end this session with an end note and maybe some key pointers to keep in mind so that you can leave folks out there with some bullet minds they can think about as they leave this session.
Absolutely. Thank you very much for having me. I think that the key point is that, you don't have to beg a friend for a favor or for a job in the United States. Sometimes it's very hard to search for jobs from overseas. So if you have the funds or if you have a business, then you can kind of you can direct your own fate. You can make a plan to be able to move you and your family to the United States within a reasonable amount of time using either an E2 or an L1 visa. And it's not going to cost 800,000 like the EB5 program would. Now, if you have the 800,000, EB5 is definitely a wonderful route. And if you're in the United States already as a foreign student or on an H-1B visa, and EB5 is a great route. But if you're not, then you might want to look at an E2 or L1 as a way to move you and your family to the United States within a reasonable amount of time.
Wow. Absolutely. Thank you so much, David. And I wish we had a lot of audience. I mean, live audience, I would say, like, please give a round of applause for our guest today, none other than David, our filmer, who joined us from WR Immigration and also like folks, to add to how incredible David is. Well, he's a top-rated immigration lawyer and the past immigration section chair of the LA County Bar. So he was selected for inclusion in 2023 edition of the Best Lawyers in America, and in 2021 he was recognized as Best Lawyers Immigration Lawyer of the Year in Los Angeles. So I think that is a very great achievement, and thank you so much, David, for joining us and for sharing your very your time with us and all this knowledge that you could impart in this session. I'm really looking forward to have you join us again very soon.
Thank you very much.
And here's wishing you a very, very happy Thanksgiving, happy holidays to you and your family out there. Thank you so much for joining us. All right, so friends, thank you so much for joining us in this session. It was really great. Do not forget to check out David Fulmer and contact him if you want to have a one-on-one consultation, and also visit his website and send him an email. Yes, and these are his contact details. You can call him in this number, 310-570-4065. You can also email David. I think it would be best to email. So note down this email address, dfulmer@wolfsdorf.com, and go visit www.wolfsdorf.com. Thank you for joining us today. You can also email me, by the way. You can contact me if you have any questions with regard to immigration or jobs in the United States. And my number is 408-335-6444. You can email me, nipa@staffingly.com. And I have another great news, and that is Monday to Friday, 4 p.m. Eastern Time, me and my co-host, Sam, we join you with daily immigration dose here on Immigration and Jobs Talk Show. So I would like to say, please join us there in less than an hour. And until then, of course, don't forget to like, share, and subscribe to our channel. And also hit that bell icon so that whenever we have discussions and webinars like these, you are notified and you can join us. Thank you so much once again. Here's wishing you a good day ahead. Bye-bye.
Hi everyone, welcome to Immigration and Jobs Talk Show. I'm Rajni Bharara, your host, and before I move ahead, let me very quickly read out this very important disclaimer by watching our videos. You agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, after this very important disclaimer, welcome back everyone to Immigration and Jobs Talk Show. I'm your host Rajni Bharara, and today we are diving into a timely and relevant topic, especially as we are on the cusp of a pivotal US presidential election. The upcoming election could dramatically reshape US immigration policies, making it more crucial than ever for startup founders, entrepreneurs, and tech innovators to understand their visa options. For many, the H-1B has been the traditional route, but as we know, that path can be limited. So today we are exploring alternatives and uncovering solutions that might be better suited for startup founders looking to build their vision here in the United States. I'm thrilled to introduce our guest, Alyssa Hussain, who brings a wealth of expertise and insight to our discussion. Alyssa is a business and employment-based immigration attorney who represents companies and individuals seeking temporary or permanent legal status in the US through employment, trade, or investment. Her background is impressive. She has experience working with multinational technology companies, growing firms, and innovative startups. Alyssa's approach is all about strategizing with clients, guiding them through each stage. See, I'm so excited to introduce you that I've started fumbling. So I'm really sorry about that. So Alyssa's approach is all about strategizing with clients, guiding them through each stage of their immigration journey with dedication and passion. She earned her honors Bachelor's of Arts from the University of Toronto, majoring in gender studies, political science, and history, and holds Juris Doctor degrees from both the University of Windsor's Faculty of Law and Detroit Mercy School of Law. Licensed in Michigan and Ontario, Alyssa has handled complex immigration cases across Canada, the US, the Middle East, and Asia. Her work has spanned roles on the US immigration team at Deloitte with boutique firms specializing in startups, and now she's leading her own practice focusing on TNs, H-1Bs, O-1s, EB-1s, and NIWs, which is national interest waivers. So without any further ado, let me not fumble anymore and welcome Alyssa Hussain on Immigration and Jobs Talk Show. So Alyssa, very warm welcome to Immigration and Jobs Talk Show. This is your first time. How are you feeling?
I'm feeling good. Thank you for the very warm welcome. I'm excited to be here and excited to kind of share as much knowledge as I can.
Right. And, Alyssa, this topic is pretty unique and a little different than what we usually do. So what do you think? What can people, what would you like to say? What can people expect from today's episode?
Yeah, I think there's, a common perception that in order to work in the US, to gain permanent residence in the US, that you need to have an employer who's willing to hire you and sponsor you. And the purpose of today's presentation is to focus on kind of taking control of your own immigration journey, and especially for those who want to be entrepreneurs and run their own companies, and also take control of their immigration journey into their own hands instead of being tied to employers, which for many immigrants, especially born in certain countries, including India, those wait times, those dependence on your employer can be very challenging in terms of making life decisions. And so, yeah, I hope that this information is helpful in the sense of being able to recognize that there are other alternatives available, and kind of taking control of your own immigration journey.
Right. So, being an entrepreneur in your own country is so difficult because being an entrepreneur and starting your own startup, it's a difficult path than usually opting for a job because that's the most conventional way, right? And this is a little different than what usually people do. But if then trying to make it in a different country, in a foreign land, it must be so much more difficult than the normal path, right? So, what kind of cases have you handled? Let me just start with that. And how difficult is it for people to actually make it into a foreign land and build a successful business or a startup?
Yeah. I actually think that, I'm obviously biased, but I think that my foreign founder clients are, because they have so much more to navigate in terms of not only are they starting a company in the US, which is already challenging to begin with, they are, the odds are set against them in having to additionally handle US immigration, which has a further impact, right? When you're dealing with, fundraising and talking to investors, potential investors, you also need to be able to explain to them that you're not a risk, an additional risk, when they're doing their due diligence. So if anything, I think that foreign founders are the most equipped to handle, growing successful businesses in the US because they're just already faced with so much adversity in additionally having to navigate the US immigration side of things. In terms of the types of clientele I work with, it really ranges. I have people in tech. I have clients who have started retail companies. It really is so industry wide. It ultimately, which I think really allows for a lot of opportunity and really is focused on people's plans and career goals and what their long-term plans are. So I think that in some way it is, US immigration is very limiting, but on the other side of things, I actually think that it is also, there's like the world is your oyster in terms of what you want to pursue and how you want to pursue it. I think top advice I give to all my clients is as soon as you want to start your own company, I would say try and understand the US immigration side of things simultaneously while you're kind of thinking of your long-term strategies for your company, for yourself, and your long-term plans, because there is a way to align those. You just need to think strategically about it sooner than later.
Right, right. I mean, that's a great advice. But also, is it easy for a particular startups or a particular type of companies to make it, and in comparison to other kind of businesses, like maybe like you mentioned, tech companies? Is it easy for them in comparison to the ones who are maybe getting into a restaurant business or
Yeah.
different businesses basically?
Yeah, I would say, there's no one route that's easier than the other. It again is very case specific. But in terms of for professionals, those who are kind of pursuing a tech company for the most part, there is an easier sell in the sense of it's less of an investment, right? You don't need to make as much purchases in physical premises, in inventory. So in terms of like the cost perspective that you would need to demonstrate to the US government that this is a real and operating company and that it will be, you need to show that you have put enough into it to demonstrate that it'll get there. And that's harder on the more brick and mortar side of things. But that doesn't mean it's not impossible. There's other routes. E2 visas are generally more recommended for restaurants and for more of the brick and mortar companies versus like an O1, but that doesn't mean it's not doable. It's just more challenging, but yeah, I think that answers your question.
Right. It does. Thank you so much for getting into it and answering the question. Now, let me quickly, get into my questions that I've prepared for you. So my very first question to you is, so what key trends do you see in US startup visa programs compared to those offered by other countries?
Yeah. So I obviously focus on US immigration and most of my clientele are startups. I'm also licensed in Canada and am involved in some Canadian cases as well. I think the current climate of immigration, at least for the past 6 months, probably because of upcoming elections, because of economic, in terms of economies kind of struggling right now, there seems to be a tightening of immigration, at least, when it comes to the US, when it comes to Canada. But that doesn't mean that, you can time the system and necessarily wait it out, because I think there's no way to really kind of figure out when is the best time to pursue US immigration, and even international immigration for that matter, when it comes to investments, because, when you start your own company, everything's not going to align at once. I think it's really about paying attention to your company, what your goals are, and then using that to inform your decision about strategizing on the immigration front of things. So in terms of key trends, within the US, there's been, I think people are fearful of what's going to happen with the new administration and how matters are going to be adjudicated. And so there's been an influx in filing of cases. And so with that means that there have been more requests for more evidence. In terms of denial rates, I think I haven't in my own practice seen an increase. It still seems very, standard based off of what I've seen. But again, that's like, my sample size. But I do see immigration on the Canadian side of things where there are changes constantly happening, and it does seem like they are limiting immigration because there was in the past few years there's been an influx, and so they're trying to limit that. They also have an upcoming election as well, so these are considerations in terms of kind of how these programs are adjudicated or available. But on the US side of things, these programs don't really close down, right? Like the legal framework of temporary work visas and the green card routes have been available since the 90s. What changes is USCIS's guidance on how they're adjudicated, the reality of how they're adjudicated, and the types of evidence that can be used. So, particularly, we'll dive into this later in the section too, but in terms of for startups, USCIS has kind of broadened what, H-1B founders and O-1 founders can do to demonstrate that they meet the requirements so that they can sponsor themselves as a beneficiary through a company that they own. And their framework has allowed for this. However, that can change because of the political landscape or because of a change in administration. So these trends are, I think, always moving, but for the most part on the US immigration side of things have stayed fairly consistent. It's just how we need to document the eligibility that kind of has changed.
Right. So, but do you think, have you noticed that maybe the recent US policy changes has influenced, the attractiveness of the startup visa for international founders?
I don't know if it's just an increase also of people starting their own companies. I think there was some statistic, and don't quote me on who published it or where it was from, but I think it was post-pandemic where people really did start to take control of their own, just like their own employment overall, and did start to pursue, entrepreneurship. And I think that with that also means that immigrants are part of that conversation. And as there is, an increase in investment, the US obviously wants that investment to be inside the US. And so as they kind of open up these programs, and guidance on how they define the eligibility criteria, I think that has allowed for more startups to kind of pursue these routes with a little less challenge than they were met with before, because there was less clarity in the law. But that doesn't mean it wasn't happening. I think that USCIS has kind of moved with how the adjudications were going and provided clarity on this is permissible, to kind of make it more clear to founders that it is doable and that they likely will, so long as they meet the requirements and can demonstrate such that they will approve those applications.
Right. But then, also I would like to know, Alyssa, that do you think that there are specific sectors, I asked this question, but, still I would like to know that, do you think there are specific sectors like maybe tech, biotech, where other countries are outspacing the US and attracting founders through their visa program? Because, we recently had an attorney from Portugal, and we spoke with her regarding golden visa. And then we also have golden visa in, I guess, Dubey, right?
Dubai,
so yeah. So do you think that is also happening?
I think that the US market is very unique. Everyone's going to always want to enter the US market, even if these other countries are available. I think that for periods of time, the availability in these other countries may be, based off of people's life situations and their choices, that those may be options that they choose over going to the US. But I think that, it's one of America's, everyone just, not everyone, but there is always going to be this market of wanting to grow your company in the United States, to be able to kind of grow to that next level. So I say that to say that even while international countries are kind of opening up in their investment visas and even in their nomadic visas for freelancers, as we've seen an increase in, especially since the pandemic, as people are moving abroad and wanting to live internationally and work remotely. I think that there is and will continue to be a US market for startups. And I don't know if the opening of those programs has necessarily impacted the US immigration side of things. But that's, again, just my opinion, right? Like that, yeah.
No, of course. People can choose whatever countries, but they're always attracted to US. That's absolutely true. And
Yeah.
but then, could you provide like an example of a particular country that you feel that you must have noticed, notable success with startup visa program that you would want US to learn from?
That's a good question. I actually think that I'm not too well versed in the other programs, but it seems like for the most part, if you have sufficient funds, you can, they're kind of framed in that way that if you have sufficient funds, you're going to put that money at risk and purchase either a property or a business in these respective countries that is leading to a side of permanent residence or just residence in general. In those countries. And I think that there's also been some pushback from what I understand, again, not licensed abroad. But I think that the EU overall has been kind of looking into these programs specifically because there's some countries like Portugal that have opened up investment because of the nature of their economy and wanting to increase more international movement into their country. But then the rest of the EU isn't so open to those, everyone having access to those open borders. So I think that in some ways it's been working, but I feel like they're also kind of narrowing it down now in a way that is a little limiting. Whereas the US has just been fairly consistent. And if anything has made it a little bit more difficult, right? I don't handle too many EB-5s, but obviously like that pathway to an investment green card essentially is a very high threshold. It requires a large investment financially. But for the most part, most of the clientele that I'm dealing with are eligible for other work visas and even green card routes that don't require a huge financial investment. Those who can do it and generally and are eligible and have the funds available to do a 1.5 million plus investment, they will, right? That's the route that they're going to take. But I think that there are opportunities in the US based off of the current current work visas and green card routes that allow for little to no investment, but still a clear trajectory and plan of what that company and investment will be in the US, which is in some way an opportunity, but it is also very limiting because you need to meet certain eligibility criteria, right? Like for an O1 visa, it's great, but only if you can show that you're of what the USCIS defines as extraordinary ability. And sometimes that doesn't make sense in certain industries, right? Someone who is maybe pursuing retail or is pursuing a restaurant business may not have these particular awards and have earned this, a certain salary or have scholarly articles. Like it's very academic focused in terms of how it's been framed. So I think for those in tech or who come from a professional background, it does seem easier and that there are more routes available. Purely investment routes do require a little bit more of a financial commitment to have that opportunity in the US as well. But I do think, right, that if the US kind of lowers that requirement of what kind of investment is needed, it will open opportunity for more investment into the US. I just don't know if they're going to be open to that.
Okay, okay. I would also like to tell you, thank you so much for answering the question. A lot of people have also joined us and they are constantly posting their questions. If you can see,
Yeah.
let me quickly say hi to them. Dharmesh is here, Ishani is here, and I'm also getting questions on WhatsApp. So, hi guys, a big hi and a hello to you. And thank you so much for your question. We'll be taking them in a bit. But before I take your questions, I would again like to tell you that we are live not just on YouTube, but also on LinkedIn, Facebook, Twitter. So make sure you subscribe to us. The handle is Immigration Talk Show. And yes, you can also, post your questions on these platforms too with, of course, YouTube. So we'll be taking your questions in a bit. But before that, let me again discuss a few questions with Alyssa. So Alyssa, you mentioned different visas. So now let's discuss those visas which are for startup founders. So what are the key differences between O1A visa, EB2 NIW, and EB1A visa for startup founders, and which one would you recommend for someone just starting their business in the US?
Yeah. I really like this question because I think it allows me to also clarify something where I think sometimes people have a common misconception is that green card routes are very different from temporary work visa opportunities. And so from the three that you listed, right, there's O1, which is a temporary work visa, and then EB2 NIW, which is the national interest waiver, and EB1A, for those of extraordinary ability, is an eligibility criteria for a green card. So when assessing which one to pursue, I think it depends again on the circumstances of the founder's situation, but ultimately the EB2 NIW and EB1A are more long-term plans. They don't provide any work authorization in the US. So if you are abroad and you're not inside the US and you've already started your own company, but you eventually want to grow into the US and you don't have so much of a quick timeline on your hand, an immediate rush to go to the US, then pursuing an EB2 NIW or an EB1A, depending on your eligibility and demonstrating that, which we can kind of dive into, is a good idea, especially for people who are born in India, because wait times are very long for green cards for Indian-born nationals, and it's based off of country of birth, unfortunately, not on citizenship. So even if you did become a Canadian citizen, that won't really open any opportunity for a shorter queue for the green card. So what you do by kind of getting to this sooner than later is you are locking in what's referred to as a priority date. And your priority date is what determines when you can eventually apply for your green card. So locking this in sooner than later shortens your wait time for eventually securing a green card. I say that to say that if you are, if you have if you need to be in the US immediately and you want to start working on your US based company, then you need to secure underlying work authorization, which includes an O1 visa. There are other work visas that are options as well, which can be H1Bs, L1s, E2s. I think these are the four main ones that my startup clients will pursue in terms of underlying work authorization, while simultaneously either building up their profile to be eligible for an EB2 NIW or an EB1A, or pursuing that and submitting that application while they're growing their company inside the US. So in terms of which one is the best, it'll be very, case specific. I would say that, for people who aren't too familiar with the eligibility criteria, an O1A visa, you need to have a petitioner, which can either be your direct employer. It can be an O1 agent, which is a US citizen who kind of oversees your work and will be authorized by a lot of gig workers will use that. So they have like existing contracts and they freelance. And so the clients that they freelance with are willing to authorize this O1 agent to petition the O1 visa application for the individual. And then the third option is to have a US entity that you own petition you for your work, which is the startup founder route. You can, have a co-founder depending on your circumstances, or you can have a majority stake in the company as well. And there's certain requirements you need to meet to demonstrate an employer-employee relationship, which we can also dive into on this session as well, because I think that's the biggest crux of eligibility for these work visas that is specific to founders. But not only that, you then need to demonstrate that you are of extraordinary ability, which high level is, layman's terms may mean something different to everyone. But USCIS clearly identifies what those 8 criteria are. You need to meet a minimum of 3. And for different founders, for different industries, the types of evidence that we can kind of submit to demonstrate that you meet this criteria varies. Like I said, the regulations and the law is written in a very academic nature. So it's pointed towards, there's a criteria for scholarly articles, but someone who is in who's in retail, right? And in design, I mean, they may have written scholarly articles related to design and while they were in university or pursued academia, but for the most part, that's not the case. So really, it's about delving into what your industry is, the nature of your startup and your specific work, and then how you can use your experiences to date to demonstrate that you kind of have this corroborating evidence in those criteria. And so that's the O1A. In terms of the green card routes, then the O1A criteria is very similar to the EB1A criteria. Instead of 8 criteria, there's 10, 2 more that are related to arts. And it is a way higher threshold. For an EB1A, you don't need an employer to sponsor you, so you can self-petition. It is a first preference employment-based green card route, which also means that priority dates for green cards are a lot. It's a much shorter wait time, which is why they are very heavily sought after. But meeting the threshold for an EB1A is a very high standard. And so generally, based off of my client situation, we'll get them going on the O1 and we'll come up with a game plan of how to enhance their profile so that they're EB1A ready in the next year or 2, depending on, where they're at with their application at that point. We kind of do an assessment. We work together and identify what is feasible with their career. Sometimes getting publications going takes a long time versus one of the criteria is peer review. So that requires less work in terms of having to sit and publish content, but it does require more networking and engagement in the industry. So we kind of strategize on what makes most sense because you're also creating and growing your startup at the same time. And so there's only so much you can do while also pursuing your goals, right? You get so focused on the US immigration side of things, and then your company fails because you're just so focused on that. So it's really an alignment of understanding this is a long-term journey, but it's doable, and it's really about being as targeted as possible in your approach. And then the EB2 NIW has been a great route. I think, again, for the last 6 months in adjudication for both EB2 NIWs and EB1As, there's been an influx of people just applying to get their foot in the door. And not all these cases are viable cases, unfortunately. And so it's kind of backlogging the system and making it difficult for people who actually have viable cases to get approved, and it is increasing RFEs. And so, but like I said, you can never really game the system and figure out a best time to apply. If you are in a position where you are eligible, I would say still go for it. Work with an attorney who knows what they're doing and will work with you on kind of presenting the best case, but be prepared to be met with potentially an RFE, to be met with a bad adjudicator who may deny, and you may need to refile or you may need to litigate. The system, unfortunately, is not the best system, but there are mechanisms to kind of eventually get there. It's just, you got to be committed. But the EB2 NIW, just like high level, is demonstrating that you're going to be pursuing a proposed endeavor. Technically, this endeavor doesn't need to be clearly defined, but it won't be approved if there isn't clarity on what it is. So you need to identify what your proposed endeavor is, and then on top of that, demonstrate that it is in the national interest of the US so that they can waive the labor certification process, which is the more classic employer sponsorship route for green cards. The EB2 NIW also allows for self-petition, so you are not tied to your employer, which allows for greater flexibility too. But there are like additional eligibility criteria, but just high level in terms of whether you're selecting to pursue the EB2 NIW versus the EB1A. EB1A has a higher threshold. Most people who will pursue EB1As are primarily Indian borns, because for an EB2 NIW, if you are eligible, wait times for a green card aren't ridiculous, and you will, be likely eligible in the next few years to be able to either adjust your status or get a green card. So, and if you did pursue the O1 or any other of the startup visas, be it through an L1 or an H1B, you likely have at least 2 to 3 years of work authorization while you're waiting out for your priority date from your green card to be current.
Right, right. And also in cases like these, the role of the right kind of attorney for you also comes into play, right? You should have the right attorney to help you with your case, right? So guys, if you're looking for an attorney, and if you have a startup and if you want to get a visa and if you're looking for an attorney, so you can get in touch with Alyssa. Here are her details. You can email her on info@crossingfrontiers.ca, info@crossingfrontiers.ca. I want to spell it right so that people can note it down. And also, you can also please visit our website, which is www.crossingfrontiers.ca. Yes, do visit our website, and also you can write to her. You can email her. And now, Alyssa, thank you so much for that detailed answer. So I would also like to know for you, for founders who are early in their careers, so which visa option would you recommend for them, so that they can that would offer them the most flexibility to pivot or expand their ventures?
Yeah, I think it is, like I said, of the main 4, the go-tos, it really is dependent on, the nature of how they're kind of developing this startup in the US. And then there's also some like case specific based off of nationality for the E2, for example, versus if this is an intra-company transfer where someone has their startup that they started abroad and are now bringing to the US. So those are all considerations, but I'd say high level, like the pros and cons of the 4, I can kind of go through those. Like for the O1, a huge benefit is that, there's no limit on how many times you can extend. You first can get up to 3 years, and then technically every time you request an extension, you can only get 1 additional year each time. But if something major has changed in the trajectory of the company, we can kind of file this as a new employment. And so we can request 3 years on an ongoing basis with that. So the benefit of an O1 is that you're not limited in number of years like you are with many of the other visas, including H1Bs and L1s, which are limited to 6 years for an H1B and then 7 years for an L1A or 5 years for an L1B, which can be quite limiting. That time goes by so fast. So that's a benefit of the O1. A downside is that your spouse doesn't get work authorization from you having an O1 visa. They would have an O3, which has no employment associated with that. They would need their own employment visa in order for them to be eligible to work. And that is quite limiting for some families who both spouses do work. In terms, again, another limitation of the O1 is demonstrating that you're an extraordinary ability and that you meet that criteria. But I do find that many founders actually do not realizing that initially. So I would say, do your research, look online at the criteria, at the 8 criteria. You probably will check off at least 2 based off of, think deep about it, about your portfolio, about things that you've done to date. And most clients, when they come to me, at a minimum, have at least 2. And then we kind of work on pulling their profile together, seeing if we can kind of reach a 3rd or a 4th, or, I give them like a 3 to 4 month time frame. And I'm like, okay, focus on these ones and then come back and we'll reassess. So that can be limiting because you need time to do that and you need authorization to grow your profile if you're in the US. So you need a backup visa or something else that's keeping you inside the US if that's your plan and you need to start working immediately. So that is a limitation. In terms of H-1Bs, they are beneficial in that you don't need to demonstrate this extraordinary ability. As long as your role is in a specialty occupation and that you will be paid the prevailing wage and you can demonstrate that need, then it's sometimes easier to meet that criteria as a founder where you are quite early stage and haven't built up your portfolio so much. However, there's limitations to this. You need to be able to have enough funds to pay yourself the prevailing wage. For the O1 visa, there's no minimum amount that you need to pay yourself. Generally, we recommend, obviously, making sure you're compliant with local employment laws and all of that. But, you can pay yourself a larger portion through equity. And that can kind of, offset paying yourself a little less and demonstrating to USCIS the nature of your work, which is very common for founders. So the limitation of the H-1B is that you are, the Department of Labor has to, approve, and you need to demonstrate that you're going to be paid at least the prevailing wage of your occupation based off of your geographic area, which can be quite limiting. But there are strategies around this. Instead of submitting a full-time H-1B petition, you could submit a part-time one where you'll pay yourself hourly and within a range of hours that you disclose in your application. So some clients will do that. They'll start off only working 5 to 10 hours a week as they're growing their business, and then they will add on longer periods of time or switch to a full-time H-1B once they have sufficient funds for that. Like I said, a downside of the H-1B is you're limited to 6 years. Time spent outside the US can be recaptured into that 6 years. With one exception, under AC 21, if you meet any of those requirements, you can extend beyond the 6 years, but that is if you are pursuing a green card route. The other thing is that spouses cannot work, H4 spouses cannot work unless you have an approved I-140, which is the green card pathway, and then that will allow for work authorization for H4 spouses, which, again, pro or con, right? Another pro of the H-1B is that it's a dual intent visa. So for most US temporary work visas, they are non-immigrant intent, except for O1s. They're kind of quasi non-immigrant, quasi dual intent, but the rest of them, like TNs, H3s, these are all non-immigrant intent, which means that you cannot have the intent to permanently immigrate to the US. However, H-1Bs and L1s are dual intent. So if you have a pending adjustment of status for your green card, that won't implicate your intent issues with your underlying work authorization. So there's some benefit to that as well. And then in terms of L1s, so that's like, again, very case specific. You need to, high level, there's more eligibility criteria to it, but you need to have worked for your foreign startup, or it doesn't have to be a startup, your foreign company that you own abroad for one full continuous year in a managerial or executive capacity for an L1A. And then you open up your US operations and you keep your foreign operations going. And so you have hired a team out there who's running the foreign operations, and then you start up the US operations, work for it for one continuous year in a managerial capacity or executive capacity as well. That not only gets you a work authorization, which is the L1 visa, you also may be eligible for the EB1C, which is a green card route, which is like the EB1A is a first priority. So it's a good strategy for some Indian-born nationals to kind of take this route towards a green card that may be more plausible with their long-term plans. So sometimes that's a strategy too for founders. If you are willing and open to starting your operations abroad first and then coming to the US, then that's a route as well. I would say L1s are very USCIS kind of digs deep into them. You need to demonstrate the eligibility criteria. RFEs are very common. It's better if the individual moving is a professional in some capacity. The nature of their work will be professional. Doesn't mean it's not doable for others in terms of like a restaurant. It just is a little bit more challenging. You need to demonstrate more. USCIS asks for more supporting evidence for that. And then for the most part, you need to be able to demonstrate ability to pay, unlike for the O1. So you need to show that there's funds in the company that can pay you. And then for the EB1C, especially, that you will be able to pay yourself up until you get your green card. So you do need enough funds, which can be limiting. But an L1, like I said, is a dual intent visa, so that's good. Spouses get an open work permit based off of the primary applicant having an L1, so that's a benefit as well, because if your spouse will be working, then they're not tied to an employer except for to your startup, and probably just, dependent on their spouse, but that's another story. And then the next one is the E2 visa, which is a very common investment visa. And the limitation of it, well, there are a few, but the main limitation is that you need to be a citizen of a treaty national country. So you can look up the treaty countries. Canada is on that list, but India is not. But so a lot of people who have immigrated to Canada and have now attained their Canadian citizenship, which is a way faster process than it is in the US, can then do an investment into the US through an E2 visa. There's no minimum investment. Generally online, you'll read that people recommend $100,000 minimum. This is not a threshold that the US government has set. It's not a real threshold. I would say $100,000 plus is definitely a case that may be an easier sell to the government, but I've had successful cases where they've spent $15,000 to $20,000. Ultimately, you need to put the money at risk. You need to demonstrate that the company you're investing in, either through a purchase or through starting on your own, is going to be, you show your 5-year plan, your business plan, that you're going to, make some US hires, that you're going to be, creating enough income that's more than just to support your family. And that's kind of the threshold you need to demonstrate. And in terms of the amount of investment, it needs to be substantial compared to the nature of your business. So if someone is going to be starting a trucking company and only investing $15,000, that doesn't make sense, right? You need a fleet. You need to demonstrate that you have purchased some of these, that you have a place that you're keeping them, and
Right.
15,000 isn't going to cover that. So that's not realistic. Versus someone who has a tech company that's just starting with one computer and this software that they're developing, 15,000 may be doable. So it's really about spelling out the nature of the company, what the long-term plans are. And then there's a component of sourcing the funds, which is a part of the E2 visa, which is important. So depending on, you can get funds from, I was going to say anywhere, not anywhere, but it could be gifted to you from a family member. It could be VC funding. Ultimately, you just need to demonstrate that the funds were given to the applicant or the treaty national company, and that those funds are now at risk and being spent on the business. So that's kind of how we focus on the sourcing of it. And then for E2s, another benefit is that your spouse can also work. So of the 4, spouses can work on L1s and E2s in terms of the dependent visas, and sometimes on H1Bs, depending on people's green cards. But for O1s, they definitely can't. So these are all considerations based off of, everyone's, unique circumstances. So, yeah.
Right. Thank you so much for such detailed answer. Thank you so much for, explaining everything in detail. And that was really, really insightful, Alyssa. Thank you so much for that. So with that, I know a lot of people are waiting, and we also have to take the Facebook questions as well. But still, I would like to know one more question. So are there instances where a founder, might have initially opted for one visa, a type of visa, and then, after their business became successful, then they transitioned into and they opted for, a different visa?
Yeah. I've done a few of those. It's just all dependent on people's, situations. But like top of mind, what like a certain case stands out to me is someone who was on H1B. They were a founder. They started on a part-time H1B, and then they switched to an O1. And they did that because they were hitting their 6 years and they didn't have an approved I-140 at that point. So they were running out of time on their H1B, and they wanted to, and then they were eligible for an O1. So during that time when they were building up their startup, on a part-time basis through their authorized work on their H1B, they were profile building so that they could meet the O1 eligibility, so that they didn't have to leave the US for that 1 year and then come back and be reselected in the H1B lottery. So it's very common. I think if anything, for the most part, I would say once someone is a founder and on an O1, They generally won't switch to a different one because at that point, you have a little bit more flexibility, unless, of course, someone is looking for work authorization for their spouse or certain circumstances based off of, if they have travel and they want to be on a dual intent visa while their green card's pending, then they'll kind of consider something else. But I'd say most founders, once they're on that O1 route, they're now focused on their green card application and know that they'll continue extending their O1.
Right. Okay. Thank you so much again for answering the question. Now, let me quickly move to our audience's question. So, Kalpesh is here from LinkedIn and he says, interesting. Thank you so much, Kalpesh, for your comment. Let us know if you have a question, if you would like to know anything. Please post your question in the comments below and we'll be more than happy to take it. So let me start with Dharmesh's question. Dharmesh says, for founders seeking an E2 or L1 visa, how do you assess if the business and investment actually meet the minimum substantial or qualifying thresholds required?
So
we also have a part two. I'm so sorry. We also have a part two. And he says, are there common misconceptions about what substantial investment means? Okay, let's start with the first question.
Yeah. So in terms of substantial investment, that's required for the E2, not for the L1. But for the E2, like I said, I think we kind of did touch on this later on after Dharmesh posted his question. But basically, the investment needs to be, the argument needs, we need to be able to demonstrate that the amount you're investing is reasonable and substantial for the nature of your business. So we would really, demonstrate that through pulling your business plan, looking at what you have already spent on, and then the nature of your business. So if all you really need to spend in the next year is on marketing, and that's reasonably a few thousand, then we would demonstrate that would still be that's all that is really needed for your company, because the product is already developed. It's already been, it's really, there's not much more financial investment that needs to go in order to sell to clients. But again, like I said, if you have more inventory and you need it for the nature of your business, then we need to show that money is substantial for what it is. So there isn't a clear definition. It's about arguing to the officer why this investment amount is substantial compared to the nature of what you are going to be doing in the US. And then for the L1, there isn't a requirement of how much you need to pay yourself. Usually if it's on the lower end, officers will question, how true and operating your company is if you're not paying yourself a reasonable amount. But for the L1, the focus is more on demonstrating your qualifying relationship between the foreign office, the US office, and then specifically with your managerial or executive role abroad and in the US, or specialized knowledge. So that focus then is on including evidence that shows that you have proprietary knowledge, or that you were leading a team, or you led a function of the organization. So that is kind of how that will be documented.
Okay. So Dharmesh, I hope you have got your answer. In case you have a follow-up or anything else that you would like to know about, please continue posting your questions. We'll be more than happy to take it. Okay, so Lasha is also here from Facebook, and he says, I'm already in the USA. I have a work in social. Can I still participate into green card lottery? And if I win, do I have to leave the country?
I actually don't deal with too many of the diversity lottery. I think he's talking about the diversity lottery green card, which I think just opened up last month. Don't quote me on that. I don't handle too many of those. So I won't be able to answer this specifically, but I would say kind of reach out to an attorney who does handle. I know that there's quite a few attorneys who specifically also only handle the diversity visa green card. So, like Rajni said, I think the focus on finding a U.S. immigration attorney is really, dependent on their area of expertise, which is unfortunate because you want someone to kind of assess all of your options. But some of us are very, I am very experienced in working with startups specifically and within these various routes. And so I don't do so much of the diversity visa green cards, unfortunately.
But Lasha, we do have a lot of shows with a lot of attorneys on our channel, so you can, definitely subscribe to our channel, and we'll be bringing a lot of shows, and you can, ask your question, and we'll definitely ask one of our experts, and we'll reply to your question. But thank you so much for posting your question. We'll be replying to your question after asking to it from an expert. Now let me quickly take Ishani's question. So Ishani is also here from YouTube, and Ishani says a startup client is considering acquiring a US based company with existing employees on various work visas. What are the key immigration related due diligence considerations and potential risks we should assess to ensure a smooth transition?
Yeah, that's a really good question. You should definitely engage with a U.S. immigration attorney to make sure that prior to purchase, because you want to make sure that you've kind of done all your due diligence, which obviously you're trying to do as well. I would say focus on making sure that you have access to all the petitions that the US based company submitted on behalf of the employees. So you understand the commitment based off of financial commitment in terms of length of period of stay, if there's pending green cards. And then you also want to make sure that you do your I-9 and E-Verify compliance as well. If they have been compliant, for them to provide that documentation to you. And if they haven't, that you make sure you engage with an attorney so you can set up a system internally so that you can make sure you're compliant moving forward, and you can demonstrate that and paper trail that. Also, when you do the purchase, depending on the nature of it, whether it's a merger or acquisition, the nature of the employees' work visas, you may need to disclose this to USCIS just to let them know that there's been a change in ownership, but that's very case specific. So again, I'd recommend kind of engaging with an attorney to go through that with you, because you want an attorney's eyes on those, an immigration attorney's eyes on those petitions prior, ideally, to you purchasing over a commitment for foreign employees.
Okay. So Ishani, I hope you have got your answer. In case you have a follow-up, please also post it. And thank you so much for your question. And okay, so Lasha is also back, and he says, thank you so much. Of course, we are here to provide you information and provide you help. So thank you so much for being here. And let me quickly take Yuri's question now. And Yuri says, how do you evaluate the potential of visa options like the O1 or E2 compared to the H1B in terms of aligning with the startup's long-term goals? And then there's one more question. Then after you answer this, we'll be taking that.
Okay. Yeah, no, this is literally where I start off with my clients, right? If high level, they've consulted with me and we kind of know that they're potentially eligible for an O1 or an E2 and an H1B, then we unpack what makes the most sense based off of their plans. So if they already meet a lot of the O1 criteria, and then sometimes my recommendation would be to pursue that over an E2, because you don't have to put the money at risk yet. But if the nature of them, the startup, is that they're purchasing a company and the money's at risk anyway, then that may be the better route, because eligibility is for a longer period of time. If they do get married, or if they already are, then their spouse has that option. H1Bs are usually only applicable to people who have previously been selected in the H1B lottery, or are like simultaneously working with a cap exempt organization. So sometimes that's a limitation. And then at that time, I also want to know what long-term plans are. Do you want to pursue a green card? What are your plans? Do you want to change up your company? Are you going to start up a few companies? That's very common in the industry. And so how do we kind of want to frame your narrative for your green card application while you're pursuing your work option? So we kind of talk through that, and I try to understand your long-term goals and align that with what makes the most sense with the various temporary work options based off of that. And then also based off of adjudication at the time, right? E2 visas are not adjudicated for the most part by USCIS. They're adjudicated by the consulate office. So you're going in for an interview and someone's deciding on the spot whether you're eligible or not, versus an officer in USCIS who sits and goes through your documentation for days, right, or hours, and is really looking at everything very in depth. And so sometimes a strategy would be going to a consular office versus submitting it at USCIS, and there's strategies around that too. So it is all basically, I say short answer is it depends on your long-term goals and the nature of your investment and what you're trying to do in the US.
And so what if they don't have long-term goals? They're looking for, like quick advice or instant advice for just that moment. So how do you, manage that?
Yeah, I mean, I go into my consultations being like, do you eventually want a green card? Because if we need to assess that. But in terms of if that,
everyone does, right?
Sometimes a lot of Canadian citizens don't, because there's then tax implications of having a green card. So, and the proximity and all of that too. Sometimes it's not the long-term plan. Sometimes people just want to work in the US for 4 or 5 years and then go back home to their home country. When people tell me that, I say, if you are eligible for a green card, you should maybe still apply and decide at that time if you want to proceed with actually getting the green card versus not. Because, being eligible is, not too many people are. So if you want, that's a good opportunity to have. But again, very, very specific to the situation. But I would say in terms of evaluating, I do on consultations, I will do like high level of collecting as much information through our conversation as possible and giving you my high level advice on what makes the most sense. I would say in terms of the O1, E2, H1B, like I said, there's all the pros and cons I listed previously, and it'll depend on, do you want to have to pay yourself a certain amount, right? With the H1B, do you want to put those funds at risk for the E2? Do you meet the eligibility criteria of the extraordinary ability for the O1? So if you meet all 3 of those, then it's a strategy of, okay, which one has better adjudication? Which one are you currently most prepared for? And likely, I'd say if you meet all 3 of those, the E2 is probably the better option, assuming you meet all 3 of those criteria. And of course, this is just, with as little information as possible on the circumstances.
Okay, and her next question is actually on the tax implications. So she says, please do discuss potential tax implications for investor visas. Also outline the application timeline and required documentation.
Okay, so in terms of tax implications, I am not a tax attorney or a tax professional, so I would recommend, because it's very specific based off of your home country and any tax treaties. So I would very much recommend that you speak to a tax professional on that. Like I said, there are tax implications for becoming a green card holder in the US, in that giving up your green card in the future or your US citizenship in the future for tax purposes. So because the difference with the United States, this is, again, I'm an immigration attorney, not a tax lawyer, but just in terms of informationally, the difference with the United States versus other countries is if you move abroad, you still have to pay taxes to the US government. So sometimes people will have, made a change in plans and they want to retire in a different country and they're still paying taxes to the United States. And so they may want to abandon their green card or their citizenship for tax purposes. And when you do that, you are, when you abandon your citizenship, the US government will ask you if you're doing it for tax purposes. And then in the future, if you ever wanted to come back, that will implicate your US immigration journey and options available to you. So that's a consideration in terms of once you are a green card holder and or a citizen. In terms of for the visas, the work visas, that is different. You obviously, when you're working in the US, you have to pay US taxes. How that works with your home country and treaties will depend on where your residence is and based off of the nature of the country. So for that, I would say talk to a tax professional. In terms of I think this is about the E2, right? Outline the application timeline and required documentation. So documentation, for the most part, will vary based off of the nature of your business. I'd say high level, you need to be able to demonstrate that you have the formation documents, that you have the business plan, you have all of the source of funding documents, and then you need to demonstrate your eligibility, why you're best to kind of run this business, which could be your resume, supporting documents of previous work in the industry as well. And then for E2 timelines, they are specific to the consulate. So you submit E2 applications to the relevant consulate in Canada. That's in Toronto. They're the only ones that adjudicate the initial E2s. And the timelines vary, but generally what I've seen is that when you submit the application, you'll usually get an interview within about a month or 2 max. That can vary depending on how busy they are. And then once you go to your interview, if they approve your E2, they'll send you your passport within a week or two. So E2s, in terms of, I'd say the application preparation time is a lot longer, but once you submit it, it gets rolling a lot faster versus an L1 or an H1B that get adjudicated with USCIS. And then if you need a visa, you need to go to the consulate or embassy and apply for that visa before you can enter the US. So timing kind of varies based off of your circumstances.
Okay. Thank you so much for that detailed answer. Alyssa, Yuri, I hope by now you must have got your answer. Thank you so much for your question. Okay, so Alyssa, it's already 1. We have crossed the 1 hour mark. But if you have a little more time, we can discuss a few more questions because,
Okay, I can do a few more minutes, yeah.
Okay, great. Thank you so much for that. Let me quickly take Arjun Mehta's question. Arjun is also here and he says, what are the unspoken challenges of switching between visa types? For example, moving from F1 OPT visa to an O1 or an H1B. Are there risk founders might not be aware of when they ladder through visa categories like this?
Mm-hmm. It'll depend on, again, it's very important that you work with a qualified immigration attorney who's experienced in these, because what we'll do is we'll review to make sure that you were maintaining status in your previous visa status when we change status to one of the other ones. If there's a potential gap, while you were in F1, you were unemployed for a bit, but you went beyond the permissible time, and that may raise a potential issue, then we may advise to do a consular process for your application versus a change of status from within the US. So it's very important to make sure that your immigration attorney that you're working with is reviewing your previous applications, your previous status, asking you those questions. And another thing to consider for F1 to one of the other visas is that F1 is a non-immigrant intent visa. You need to be able to demonstrate that you maintained your ties abroad. It won't usually come up at the change of status to another work visa, but it may come up at the green card stage. So you want to make sure that you are keeping documentation of your compliance of all your visas in the US. Documentation of that is keeping records of when you attended school, that you attended classes, while you were working, your pay statements, when you switch jobs, make sure you just download them and save them somewhere so that when you're applying for your green card in the future, if any of those things are questioned, you don't need to then go back to your old employer. You already have it all saved. And if there were any gaps in employment, that you demonstrate the exact dates and documentation that demonstrates that, so that you can demonstrate that you were within appropriate grace periods and that you timely filed your next application. So that's high level, but again, it's very case specific. Biggest recommendation I give to everyone is keep documentation of your whole U.S. immigration journey, no matter what. It may never come up. You may never need to give it to you at CIS, but it's just the best way to be prepared for any potential questions.
Right, absolutely. And guys, if you want to get in touch with a good attorney for your case, so we have it right here. So you can get in touch with Alyssa. Her details are scrolling below, and also right there on screen. You can note it down. info@crossingfrontiers.ca. You can write to her on her email, and you can also visit her website, which is www.crossingfrontiers.ca. Let me quickly take Rohit's question also. Rohit says, I've heard that national interest waivers and IW can be used for founders, but what does a startup need to demonstrate in order to genuinely show national benefit or interest? Is there any practical guidance you can give on the merit of a tech startup here?
Yeah, so it'll really be about documenting the genuineness of your proposed endeavor. So letters of intent of potential clients you're going to work with, or if you already have clients for your startup because you have work authorization to work for your startup, including those. Including, for companies that are quite early stage, haven't really taken off the ground yet, I would definitely recommend including a business plan that clearly demonstrates what you're going to be doing in terms of staffing projections, financial projections. That's not on the national interest component, that's on the proposed endeavor component to show the genuineness of your company. But in terms of the national merit, the national interest component, you will really need to identify the market that you're going to be in, the types of clientele. So I'd say if you're in the semiconductor industry, and that's an industry that USCIS has like clearly, loves for national interest. There's a lot of supporting evidence in that. So you won't need to, the argument will be a little bit easier in terms of demonstrating the national interest versus someone who, is in real estate and in one geographic area. And, you could be probably in affordable housing, and that is a national interest argument, but is it siloed to one geographic area? Is it national? So it's really, really for national interest waivers. The good and bad thing about it is that it's not definable. It's really about how you demonstrate to USCIS the impact of the work you're going to be doing and demonstrating that it is in the national interest of the US. And so that can vary based off of the nature of your work and the nature of your startup.
Okay. Thank you so much again for that answer, Alyssa. And thank you so much, Rohit, for your question. I hope you have got your answer. In case you have a follow-up, continue posting it in the comments section. And whenever we get Alyssa back for an episode 2, we will be taking that question maybe on in that episode. For now, Alyssa, I'll take a few more minutes, maybe 5 more minutes or 2-3 more minutes, if that's okay for you. I would like to share my screen and show those Facebook questions. I would also like to get an answer to those Facebook questions. So I think I'm already sharing my screen. I don't know why am I not able to show it. I would like the control to help okay, it's here. Okay, so let me take it from the top. It's just posted 1 hour back, and let me zoom my screen a bit. So this anonymous participant says, trying to figure out where to schedule an H4 visa appointment for my spouse. Is Islamabad Consulate Embassy still conducting these interviews for first time? Okay, I think this is for Pakistan. But then here is one question from Hari Krishnan, and he says, if I book Dropbox appointment in Chennai, can I submit documents at Bangalore drop-off location? So is it possible?
I would say for all the consular related questions, because they're so specific to each consulate, each consulate does things differently based off of location. So at a minimum, what I'd recommend is they have their email addresses posted and their phone numbers for the most part. So reach out to them, and you can also specifically ask. And otherwise, your attorney should be able to answer this question, because if they are providing consular processing support as well. But each consulate is different. Things change on an ongoing basis. So I would recommend reaching out to the consulate.
Okay. I think that's a great answer. Thank you so much for that. And then there is this one more participant who says, hi guys, the salary mentioned in LCA is different from what is mentioned in the offer letter. So which one to tell when the visa officer asks for the interview about salary?
Yeah, I mean, this is very case specific. I'd want to look at the whole petition to make sure that what was disclosed is the offer letter's salary higher than what's been disclosed in the LCA. At a minimum, you need to, if it's drastically different, you need to be able to, you likely haven't disclosed to USCIS the actuality of your petition. So you may want to file an amendment of the LCA. Sometimes what I recommend for clients, especially for startup founders who don't know how much they'll be paying themselves, is to put a range so that way, if you end up paying on the lower end of the range, or if you eventually want to pay more, you can you have that wiggle room. At a minimum, you need to be paying above the prevailing wage. So I would, if you are going to the interview and you are going anyway, I would make sure that the offer letter salary is higher than the prevailing wage for the specific role and the location, which likely is the one in the LCA.
Okay. Thank you so much for that answer. And then there is one more participant who says, hello, everyone. I took 10 months of break due to health issues and did not travel to USA on H1. I have H1B valid till October 2025. Will it be any issue at immigration? And from past 3 months, my pay stub did not generate.
If you're outside the US, you don't have any obligation to be paid. USCIS only has jurisdiction on your work authorization while you are on US soil. Did not travel to the US on H1, so any of that time you were not using your H1 time, you don't need to demonstrate that you were being paid during that time.
Okay, okay. So after this, let me take maybe one more question for today's show, and then maybe we can wrap it up. So this participant says, I just appeared today, 4th of November, for consular interview at Chennai, and my visa H-1B was approved, but I have not received any blue slip from the lady who took my interview. Is it normal? And any idea by when can I expect my passport? I selected VFS Delhi for delivery. Please, if anyone can provide clarification, it'll be grateful.
Yeah, I mean, again, dependent on consulates.
Mm-hmm.
Yeah, but for the most part, I'd say unless you're put into administrative processing, which they may do afterwards too, even though they said it's approved, it could still happen. That may delay the process, but for the most part, once it's approved, you'll generally get your passport within a few weeks. And then if you don't within a few weeks and you haven't heard anything about administrative processing, then I'd recommend reaching out to the consulate to touch base on when you should expect it.
Okay. Thank you so much for those answers, Alyssa. I would really like to take more questions, but unfortunately, that's all the time we have. Thank you so much for extending the time too. And thank you so much for being here. And, it was a great episode. And thank you so much for that great debut on Immigration and Jobs Talk Show. And for our audiences, I would like to say to get in touch with Alyssa, you can email her. Her email ID is info@crossingfrontiers.ca. I would like to read it. info@CROSSINGFRONTIERS.ca. Yes, that's our email. And you can also visit our website, which is www.crossingfrontiers.ca. Thank you so much again for being here, Alyssa. There were so many questions still pending, and we were not able to cover all of them. So, if you're okay, we would love to have a second part to this episode.
Yeah, I would love to do that. I like this, and I think that the more targeted questions we get, as people are more informed too, then we can kind of unpack them more in detail as well. So I'd be happy to do another session. But I had a lot of fun doing this. I love talking about U.S. immigration for startups. So this was a lot of fun.
Thank you so much. Thank you so much for that, for those kind words. And we are going to see you very soon, and we are going to, schedule the show. We'll check your availability for a second episode. And thank you so much again for being here. And your answers were insightful, detailed. So thank you so much for being so elaborate and so detailed with your answers. Thank you so much again for being here.
Thank you.
Guys, that's it from our side for today's webinar. We are going to see you very soon. With an episode 2 of this webinar, and we are going to have Alyssa back soon. But until then, you guys keep on watching and keep on subscribing to Immigration and Jobs Talk Show. I'm Rajni Parara signing off for now. Take care and keep subscribing and keep watching Immigration and Jobs Talk Show. Bye for now.
Happy to be back here, and thank you so much for joining us. We are streaming live right now on YouTube, LinkedIn, Facebook, and also Twitter. And I'm happy to tell you that you can also participate in this webinar with us. But before we move ahead, I have this very important disclaimer, and that is, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So once again, thank you so much for joining us today. And we've got a great session lined up for you. And today we are diving into a topic that's vital for many businesses and workers across the United States, the H2 visa program. And so whether you are a business owner seeking to sponsor seasonal or temporary workers, or a worker instead in learning more about your options, this webinar will be invaluable. And I'm really thrilled to be welcoming our guest for the first time on Immigration and Jobs Talk Show, none other than Meagan Kirchner, who is the founder of Kirchner Law PLLC. With nearly a decade of experience in immigration law, Meagan has become an expert in H2A and H2B immigration matters, and she'll be walking us through everything today you need to know about, legally sponsoring workers and also exploring the processes of working as a seasonal temporary worker in the United States. So, yes, I think you can go grab a pen or paper if you're still the old school, or maybe even note down some pointers in your tab or your phone or your iPad. Thank you so much for joining us, and let's get ready to really learn some key highlights today and these insights that Meagan is going to, share with us. So, Meagan, thank you so much for joining us today. Really happy to have you here.
Hi, great to be here. Thanks for having me.
Yes, Meagan. I don't know if the introduction was enough, but we would love to know you much better. Please tell us about yourself and how busy you are these days.
Sure. Like many immigration practitioners, it's a hot time. There's with unemployment where it is, everybody is just looking for people to fill empty slots. The H2B and H2A realm is just extremely busy. I service employers all around the U.S. In both H2A, which is agricultural, and H2B, which is non-agricultural workers, and the seasonal temporary visa process. Been doing immigration for over 10 years now, and it is a hot segment right now, and we're all on pins and needles with the U.S. political climate, and just hoping we stay busy.
We are. I already feel it is, and especially with the elections just over just some time back, and everything changing right now. And in the next coming months, we're going to see a lot more changes. I think there's a lot on our plates, on everyone's plate. So
very much so. A whole another segment for that.
For sure, Meagan, for sure. And today's topic. So, what can folks out there expect from today's webinar from us?
Sure. So today's focus is really going to be on the H2B side of the seasonal worker program. The agricultural H2A side, it would have to be a whole nother show. But what you should learn, how an employer would get involved in the program, whether or not they would qualify, how the process looks, what the risks are, what compliance components they need to be aware of, what workers should know and what they should know their rights are in the process so that they are not taken advantage of. So really just trying to focus on giving a little background knowledge from start to end, on the employer side, and touch on the, employer rights side as much as we can.
We will. And I'm sure folks out there are very excited as well. So happy to tell you that you can participate wherever you're watching us. And if you have any questions, especially regarding the topic, please feel free to drop them in the comments. And Meagan is definitely going to be very happy to take them up later in the show. So I'm excited too, Meagan. Thank you so much for doing this today. And without further ado, I have a few questions lined up. So let's go ahead with the first one.
Sure.
So what are the key steps an employer must take to obtain a temporary labor certification from the Department of Labor for H2B workers, and what documentation is required?
So, just as a little bit more background, the H2B is a full-time temporary non-immigrant visa. It is seasonal. So unlike many other visa types, it's something you have to apply for every year. Unless you're doing a one-time need, that's a separate category for like a nanny or a caregiver. That would be for up to 3 years. The rest of the visas, the bulk of the H2B process, for your hospitality, landscaping, seafood industries, construction industries, those are seasonal or peak load, meaning it's an annual application. It involves 3 separate government agencies. That's Department of Labor first. We'll get into what that entails in a minute. The USCIS, U.S. Immigration Services, is the second agency, and the third would be Department of State. That's the consular processing. So that's where the worker would come in, and that's at the point that they would go get their visa. The first step in the process is critical. One of the key compliance components of this program is that all workers are paid at least a prevailing wage, which is mandated by the government. It's to ensure that they're receiving a fair wage based on the type of position they're working in, and the location and experience required for that position. So, it just really ensures that the program maintains its integrity and no one's being paid something that's too low for what they're working on. That's the first step in the process. All of these steps in this process can be time intensive. So it is very much sensitive to what part of the year you're applying for, what your dates of need are. So this prevailing wage step takes up to 60 days sometimes. So you really have, for all parts of this process, you need to allocate at least 6 months. You need to know at least 6 months ahead of time in order to ensure you have enough time to file with each agency. The way the program is set up is that there's 2 halves of the fiscal year. So that if you're based on your start date of need. So if your start date of need is in October, you'd really start prevailing wages more than likely in April, so that you can file in July. You file your H-2B application, which is an ETA 9142B. That's the second step in the process. Once you have prevailing wage, you can start that process. And again, if you're at April 1st start date or later in the second half of the year, it goes by the government fiscal year, which starts in October. My apologies. You will need to start that process probably in August of the preceding year. If you're looking for instance, starting an H-2B worker April 1st, 2025, you're going to need to have already started that process. It may be too late at this point to get a prevailing wage back in time to start the process for next spring. That being said, once you've gotten that prevailing wage and you file the second step in the process also with Department of Labor, that actual H-2B temporary labor certification, that would require you to set forth with the government whether you're filing for one-time needs, seasonal, or peak load. So that would entail documentation if you're a new filer, a new employer, establishing your seasonality, establishing your season and your need for the number of workers you're requesting. Typical documentation would be a statement of need, which again explains your business, your season, your industry. Taxes for the company, could be revenue charts, payroll showing when you have workers. Those are very common documents, as well as contracts. Really what you're showing at this stage is that your business operates either seasonally, meaning you only operate during the season, the times that you're telling the government you operate, or that you're peak load, meaning you operate year round, but there's a peak, there's an objective increase in your business or revenue during particular months of the year. That would be your season. So all of those kinds of business documents can prove that seasonality, prove that temporary need. Now, that application gets lodged with the government on one of 2 time periods, depending again on your start date of need. It's either July 3rd for October 1st filings or January 1st for April 1st filings. There's technically a 3-day filing window that you have at the beginning, but it starts on January 1st and July 3rd, unless it's a leap year. So that's when you file that application. The next step after you actually lodge the application with your supporting documentation is your company will be, this is what they talk about when they talk about the H-2B lottery. All of the employers are put into a pot in a computer and randomized. Your company will be assigned a group letter, A, B, C, D, and so on and so forth. And while that letter or that group doesn't truly dictate whether or not you get workers, it's more nuanced than that. It does impact the timelines, and more so for the spring visa half than the winter. That letter will determine whether you beat the cap from in all cases for the most part for the spring. It's there's enough employers or applications for the number of workers in Group A, for instance, in the spring to encompass the entire cap. So if you don't get it, that's not to say that if you don't get Group A, you're not going to get workers. We'll get into it later in the program over what the cap is, if there's other ways to get in under the cap or other mechanisms to file with supplemental visas. We'll talk about that in a little bit. But assuming you get in and there are still visas available to file the next step is filing with Immigration Services. You take your certification from Department of Labor and you file it with the USCIS. If you're approved, then you can move on to Department of State and file for the actual visas. There are more steps, such as recruitment, involved in the Department of Labor step before you get your certification, but we'll kind of delve into that a little bit later when we talk about recruitment and things like that. So there are a few more steps involved with Department of Labor before you get to USCIS, but that's kind of in a nutshell, the general steps.
Thank you so much, Meagan. Those are really good points to keep in mind. And thank you so much for highlighting, especially the documents required. So thank you so much. Folks out there, I know you are excited as well. Thank you so much for joining us. I'll quickly say hello to Tanya and Nishtha, who have commented with their questions. Please stay with us. We are going to take them up a little later. So right now, another question I have for you, Meagan, and that is, how does an employer demonstrate that there are not enough U.S. workers who are able or willing or qualified and available to perform the temporary work as required by the H-2B program?
Sure. So that is what I alluded to a little bit ago with the additional steps that are really happen between filing your temporary labor certification application with Department of Labor before you get certified. There's something called recruitment. At this point, the recruitment, every employer, once they get a notice of acceptance, they will, meaning that the government hasn't asked for any additional documentation, the government could issue what's called a notice of deficiency asking for more information. But if they don't do that, you get a notice of acceptance and then starts recruitment. The recruitment process is how the government essentially asks each employer to test the U.S. labor market to ensure there are no qualified U.S. applicants who can fill these roles. The recruitment period lasts 15 business days for most of these steps. However, every employer still beyond this recruitment period, at the close of which, at the end of the 15 calendar days, the employer will file a recruitment report which details every U.S. applicant, how they applied, whether or not they were hired, the outcome of that interview, if there was one, if they're able to reach them. Based on that recruitment report, the government will then certify the employer for either the full complement of H-2B workers requested, or they will reduce that number based on how many U.S. hires they make. So if you're asking for 10 H-2B workers and you are able to hire 2 U.S. workers, then you've proven to the government that there are 2 qualified U.S. workers. So your true need is only 8 workers. But in order to get to that process, there are a number of recruitment steps that every employer must take. The first of which is an internal posting notice in their job at the job site. So whether that is a break room or an HR office or a primary office, at least 2 spots at the place of employment must post this H-2B job order. So that would have the terms and conditions of the H-2B position, any job description, title, location, deductions, benefits, all of that information is required in this job order that gets posted at the work site. Now, in addition, that same posting, the same content at least, is posted on the state workforce agency. Every state has a different process for posting jobs that are available to local candidates. Think of it as like Indeed, but it's run by a state. So these postings get put online with the state workforce agency, and every employer must field applicants that are interested in the position. Another required recruitment step is, which again protects U.S. workers, is every prior U.S. worker that employer has had in the past year must get a copy of that job order so that they know they're hiring for that position again. The only exclusion would be workers that were terminated for cause or workers that quit or abandoned the job. So those workers would not get a letter, but other U.S. workers that may have worked seasonally in the past year would be entitled to know that this job is open again. Another item that could be by phone or certified mail is the best way. So the employer is protected and you can prove you've sent it to them, the last known address. Another less common recruitment step is if the employer participates in a collective bargaining agreement, they must publish that job with the CBA representative so that it's advertised across the organization. If the employer has a website or somewhere else internally, an intranet, they normally post jobs, that would also be somewhere that would need to have the job posted. If they have one. If they don't have one, it's not something that they need to create for the purposes of H-2B. It's only if it's normal course of business for them to post jobs in that manner. The last part of recruitment is performed by Department of Labor. Department of Labor will post the job order on seasonaljobs.gov and make it available nationally so that anybody who's looking for H-2B jobs or anybody that's looking for a job it'll come up on a search. So if someone searched landscaping in Richmond, Virginia, it may come up. It would be available on that website. So the last component that is important for U.S. workers is to know is that this job rec, even once that 15 calendar or business days have passed, while it won't impact the number of workers the employer is able to get with H-2B, they do need to continue to accept U.S.-based applicants up until 21 days before the start date. So it's not going to impact their H-2B worker count, but they do still need to field U.S. applicants. They are obligated to do so. Again, the purpose of that is just to ensure that there's no additional opportunity afforded to foreign workers over U.S. workers.
All right. Thank you so much, Meagan, for for the detailed explanation and helping us with the answer for that. Thank you so much. I have this next question for you.
Mm-hmm.
So, what is the current cap on H-2B visas for fiscal year 2025, and how can an employer access the additional supplemental visas announced by DHS?
Sure. The annual quota for H-2B has been 66,000 since the 90s. And it's divided into two halves. The first half of the government fiscal year on October 1st, is allotted 33,000. The second half of the government fiscal year, which opens on April 1st, is also allotted 33,000. The demand far outpaces supply for those initial visas year over year and has for a decade. So in 2017, they started issuing what are called supplemental visas. They are not in the regulations. They're not guaranteed, but the government does have the ability to issue additional visas if they elect to do so, if they can agree to do so. This year, they did announce that they will issue almost 65,000 additional visas for this fiscal year. However, the text is not yet available for the 2025 fiscal year, but if we assume it's the same as the past two fiscal years, which it has been largely the same as far as eligibility and compliance, then we can expect it to be broken down such that a portion of those additional visas will be allocated to the first half of the fiscal year and what would they call returning workers. So if you've never had an H-2B, you're not going to qualify for the supplemental visas under returning worker exemption. Those are workers that have had an H-2B at least one time with any employer in the past 3 government fiscal years. So if you had worked for anybody, you would be eligible if your employer wants to file for supplemental visas. So again, that is just a little bit of a security net for employers that miss the initial cap, that they have a second opportunity to try and take advantage of the H-2B visas for this year. There's also an allotment similar to that for the spring. In other words, if you miss the cap for April 1st in the spring, again, if you have workers or know of workers that have had an H-2B at least once in the past 3 years, they would qualify as returning workers. And there will be visas in the spring as well in that same category. Additionally, the spring has another category of returning workers. Typically, that is reserved for late season H-2B employers. So if your start date of need is not April 1st, if it's May 15th or later in the year, there's a separate carve out for supplemental visas in that for returning workers for those dates for those employers. The last option for supplemental visas is what used to be called Northern Triangle. Now it's called country specific allocation. It is open to workers from a specific set of countries that have never held an H-2B visa, but employers, there's a brand new cap from these supplementals. So if the employer will take recruits from this subset of countries, then there's a whole extra 20,000 visas available to employers who will recruit from these separate countries. Those are Haiti, Honduras, El Salvador, Guatemala. They just added Costa Rica, Ecuador, and Colombia last year. And so I think I might have missed one. Honduras, I think I'm not sure I've said that already, but those countries are a great option for employers who don't have returning workers and have missed the cap. Because the nice thing about that part of the supplemental visas is in the years that they've been offering those, that cap has not been hit to date. As, this first year for everything, but those are a more reliable and a little less risky pool of visas to pull from because they have been more open.
All right. So yes, thank you so much, Meagan, for saying that for us also and for the detailed explanation. Well, maybe you could highlight also, how the H-2B is different from the other employment visas, for folks out there who want to know where can they categorize themselves.
Right. So, as we know, there's an alphabet soup of non-immigrant visas available. All of them have their own eligibility requirements and stipulations. H-2A, those who are going to qualify for H-2B probably will qualify for H-2A from the worker standpoint. Employer standpoint, that's reserved for agricultural companies, employers that work in the agriculture section. It may be farms that do produce. It just depends. There's a lot of agricultural employers that take advantage of H-2A. There are other visas, so H-2A and H-2B generally don't require degrees. That's not necessarily true across the board, but it is the only category that's going to have people, without any required specific training. There may be experience or, training requirements employer to employer, but overall, if you're from a country that's on the eligible country list, which you can find online, there will be ways for you to get seasonal employment if you don't have a degree. Those are what H-2A and H-2B are really good for. As far from a worker standpoint or from a prospective visa holder standpoint. There's TN visas if you have a degree that, if you're from Canada or Mexico, there's a whole list of occupations and there's no cap for TN. So if you have a degree and you're from one of those countries, or if you're, an employer looking for a particular occupation that falls on the TN list, that's a great way to, have workers come in that way. TN, there can be some crossover for some of the occupations that are very similar to the kinds of roles that you may want for H-2B. For instance, a landscape architect would fall under a TN, or veterinarian or an animal breeder or something like that that's related to farms, but maybe you need someone with more skills, more training. So something like that. And there's a whole host of other visas I could go over. I don't know how many of them you'd like me to talk about.
But yes, thank you so much. Thank you so much for highlighting those differences of the H-2B and other employment visas. Thank you, Meagan. And Meagan, we have a viewer who has joined us. So nice of him. This is George from Nigeria. Really happy that you have joined us. So we would love to take a couple of questions from George if he has any. So Control, if you could just let him in. Yeah, please ask your question. George, are you there?
Yeah, can you hear me?
Yes.
Yes, we can hear you now. Great.
Okay. Um, the question I was gonna ask had to do with um, you loosening up a little bit regarding your policies. Um, like I said yesterday, everyone does not have to come to America. Okay.
Mhm.
If the government actually loosen up a little bit, let's say, just like what you're talking about, they have quarters they're giving for H-2B visas. So if you have search for remote, you tell the companies, look, you can get anyone outside of this country. They don't have to come to America, but they're going to be working on the remote basis, right? And
Mhm.
before you have to pay their salaries, then do what they call tax deduction from the salaries before you pay out, right? So I think if that would be looked at, it will be a very good idea, because one of the reasons why you have the Americans coming up with several immigration policies is because you have a lot of people
Can you hear it? I can't hear.
I think, yeah.
papers or documents are being expired, and then they also want to continue the work. Can you still hear me?
I
Yes.
missed that middle part.
Yeah.
I heard that if their documents are expired, but I missed a part
Hi,
of
can you
that.
hear me?
Yes, we can hear you. Could you just repeat the part where just some time back you were saying? George, are you there?
Yeah, I'm
I think. I
here.
think.
So
Okay.
did you get what I said?
No, we didn't hear the question part. I'm sorry.
Could you just repeat your question, please? The question you just asked some time back. George, if you're still there.
Yeah, I'm here.
Uh, so sorry, we couldn't get your question. Could you just tell us what your question was?
Okay, the question is, can American government look at, loosening up a little bit and allowing companies, independent companies, actually employ people from other countries without they coming to America and, the American government providing some sort of tax identification number for remote workers. I think if you encourage that, that would actually strengthen the job quality you have over there, and also
The government here in the U.S. has been very apprehensive about changing policy. I mean, like I said, just in my experience with H-2B, the quotas have not changed since the 90s. So while there may be many ideas that would be beneficial to both the U.S. economy and workers abroad, I would not expect there to be any meaningful change or positive additions to immigration, particularly with the upcoming administration change. I would not expect that to happen right now. That's not to say it would never happen, but I wouldn't expect a tremendous amount of change, at this point. There are many other countries that allow, such as things like digital nomad visas, where they can come work remotely from their home country in the U.S. and do things like that. We don't have anything like that here. Our immigration categories have been fairly static for quite a long time. We have not had comprehensive immigration reform since the 90s. And with the polarization of this topic overall, from an employment and family-based side, I just would not expect there to be any change. There may be many great ideas that people could bring to the table, but adoption or passage of that would be very difficult in this climate.
Thank you so much for taking that up. And George, do you have any other questions? George, are you still there? All right. Thank you so much, Megan, for taking that up for George. I think there might be some network issue, but I hope George got the answer he was looking for.
Sure.
And if he has any further questions, I'm sure George will drop them in the comments or maybe rejoin us soon. Meanwhile, I think let's take up Tanya's question. I run a small landscaping business and want to hire workers for our busiest season. How do I start the process of sponsoring workers under the H-2B visa? And are there specific forms or steps I need to prioritize? I think we touched on this earlier already, but if you could just highlight, anything.
Yes. If it's landscaping, I would assume your busiest season would fall in the spring. So at this point, the first step is starting to file a prevailing wage application with Department of Labor. That's the very first step required, no matter where you're filing, what position you're filing. So you just need to know what position you're filing for and get that application lodged with the government. You can't move on to any other step if you don't do that first. So you should find someone that can file that for you. I have a great number of landscaping clients. So I'm very familiar with that process from start to finish. At this point being mid to late November, it would be very tight to try and get that filed for next spring. Unfortunately, it's not impossible, but timing would really have to work out in your favor. That's the first thing you need to prioritize. And if the only other thing I can say that is if you have workers you want from a particular country, make sure they're on the country list. I get a lot of questions that say they know somebody from X country and that country is not eligible for H-2B at all. So if you're wedded to one particular person, make sure that they qualify before you bother starting the process.
Great. Thank you so much for taking that up for Tanya, Megan. Thank you so much, Tanya, for participating with your question. And I have more questions lined up, but let's take up Nishta's question first. I've worked under an H-2A visa before. Can I apply for H-2B visa next, or do I need to wait for a certain period of time before reapplying? And how soon can I reapply for an H-2 visa after my current one expires? Is there a limit or on how many times I can apply?
Mm-hmm. Okay, so the answer is it depends. For part of that. So if you have been on an H-2A visa, whether or not you can apply for the H-2B visa, it just depends on how long you were here on the H-2A visa. So one of the eligibility requirements for H-2 workers, whether that's H-2B or A, you have up to 3 years of H eligibility, at which point if you enter, say, January 1st, 2020, then your H authorization would have expired in January 2023. So you have 3 full years of eligibility. You can reset that by, if you've been outside the US for 3 consecutive months, then you reset your H time and you get another 3 years. So there's no limit to the number of times you can be on an H-2 visa, A or B, but there are time limits for each stay. So if you were to come in, like I said, say April 1st, and you change employers, so you're never out of the country for more than 3 months, then you're going to be limited to 3 years. And at some point during that 3 years, you need to reset. You need to be outside of the US for 3 months to get more H time. And that, you can certainly have an H-2A visa, go home, get an H-2B visa, and come back. That's fine. You can do both. There's nothing to preclude you from participating in both programs. You just need to make sure you're aware of what your limit is and make sure that you've been out to reset that clock at least for 3 months if you're here for that long.
Okay. Okay. Thank you so much for taking that up for Nishtha and for the detailed explanation, Megan. And now we have Samuel. Samuel is on YouTube. He also has a question asking administrative processing in H-1B visa for 9 months. What can be the cause?
There is not very much transparency for administrative processing. For instance, if I, as the attorney, email the consulate and ask, why is this an administrative processing? What do you need from me? What do you need for the worker? They will give me a canned response that just says it's an administrative processing and we'll contact you if we need anything. There could be a whole host of reasons why you might be in administrative processing. Your name, it could be something as simple as your name is similar to someone who has some overstay issues or a travel issue or is on a list somewhere, flagged in the system. It could be that you've overstayed. It could be that they're unsure of your intent to return home. That's called, immigrant intent. They could be questioning whether or not you will stay permanently if you're issued the visa. There's a whole number of reasons that we'll probably never know the answer to, unfortunately. For instance, I just had someone try to process in South Korea, and she has no red flags. She's no criminal history, one prior U.S. visit. There's nothing on paper that should have precluded her from being issued a visa, but she was put in administrative processing briefly, and then, certainly not 9 months. But the reason they gave ultimately for being refused was that they questioned whether or not she would return to her home country at the end of the visa. There's the consular officers are given a great bit of discretion to review the applications, and they don't give us a lot of transparency. I said South Korea for that process. So, there can be and this would come up from any country, anybody from any country on the eligible list. And sometimes there's a surprise like that. For instance, that client, it was a surprise to have that happen. There were no indications prior to going to that interview that there would be any issues. So I wish there was some way to find out why you're in administrative processing.
Right.
But there's not very many good ways to do it.
All right. Thank you so much. Thank you so much for taking that up for Samuel. Samuel, if you have any further questions, you can keep commenting and we'll be addressing them very, very soon. Thank you. And now let's take up Mukesh's question. This is also on YouTube. He asks, if our company hires an H2 worker who doesn't show up, what are our obligations and potential liabilities? And what happens if an H2 worker gets injured on the job? Are we liable?
So I'll take up the first part of the question first. So if you have H2 workers and someone disappears, they abscond. That's typically if they haven't reported to work for 5 days, they have been non-responsive, they're AWOL, they've been absent without leave for at least 5 days. You can report them as an abscondment. So, and you are required to report them if you know they're not coming back. For instance, if they've quit or left in some way, and they're not coming back, and you haven't given them permission to leave. People leave all the time, but your obligation as an employer is within 2 days of knowing that they're not coming back. So they told you they weren't coming back, or it's been 5 or more days, and they haven't reported to work. No one knows where they are. You can assume that they've absconded. You have to report the departure to the government. You have to report it to Department of Labor, and you have to report it to Immigration Services. That will insulate the company from being on the hook for the 3-quarter guarantee when the worker's not there. So that's one of the compliance requirements. We didn't get a chance to get into those today. But on the employer side, one of the requirements is the 3-quarter guarantee, meaning that it's a full-time position, 35 hours or more. Mm-hmm. You have to, as an employer, offer them at least 3/4 of those hours offered, whether you say it's 35 hours or 40 hours. If you have to report them as missing or absconded, or if you fire them, you still have to report them as an early departure. It's one of the compliance requirements is to report a missing worker. As far as workplace injury, That falls outside of the scope of immigration, and it's going to be based on your state law, whatever your state workman's comp is. You would be liable in the same fashion as you would a U.S. worker. So if would be liable for workman's comp for a U.S. worker, it's going to apply for an H-2 worker. Now, on the worker side of that, if they're injured on the job and need surgery and can't travel and the end of their visa is coming, they need to look at changing it from an H-2 visa to a B visa, a visitor visa, and do a change of status so that they're not here unlawfully on the H-2 because they're no longer working. So it comes up in rare cases, but yes, if someone's injured, they need to make sure, and they can't travel home for treatment, we have to be able to make sure they stay in status.
Right. Thank you so much, Meagan, for highlighting and for giving us such important points today. And thank you for also taking up Mukesh's questions at the same time. Thank you, Mukesh, and you can keep commenting if you have more questions. Now, coming back to our questions, Meagan, I have another question, and that is, what are the robust protections in place for both American and foreign workers, under the H-2B program, and how must employers ensure that these protections are met?
Right. So there's many protections for both U.S. and foreign workers. On the U.S. side, there's basically it boils down to making sure that a possible U.S. worker is not treated in any less fairly or afforded any fewer opportunities or no more requirements than would be required of a U.S. worker. For instance, if you're filing a landscaping position, a corresponding worker couldn't be required in the U.S. to have 5 years experience when you require 0 experience for a foreign worker. So, each business, when they file the application with the Department of Labor, has to sign an attestation with all these compliance requirements listed, noting that they understand what those requirements are and that they will abide by them while they're participating in the program. Now, workers, to start out with, for corresponding workers or foreign workers, they should get before they start, or if they're a corresponding worker and they already be working, because that could be a worker that's worked for a year or less with the same employer. So again, corresponding worker means it's a U.S. worker either present, already working, or one that you hire during the recruitment process that performs substantially similar duties, same job. That would not be your secretary or your landscape manager if you're coming in as a groundskeeper. If you're just doing a landscape laborer job, corresponding workers on the U.S. side would be the same position, not something that's unrelated. So again, the employer can't impose any requirements or obligations they wouldn't impose on the H-2B worker, and they also, have to pay them at least the same as they're paying the H-2 worker. Now, anyone in the H-2B process, which is going to apply to corresponding workers as well as H-2B, because if you have H-2B, then you have corresponding workers more than likely. A big component is prevailing wage. That prevailing wage is the first step. I talked about the employer process, but it's important for the workers because when you get the terms and conditions of employment before you start, which tells you what kind of job you're applying for, where it is, who you're working for, what the wages are, whether or not there's overtime, what benefits are included. All of that is given to you, so you can track it. You can make sure you're being paid what you should be, and that includes the prevailing wage. Every position is set by the government, and you have to at least make the H-2B prevailing wage, so you get that protection. Also, in H-2B, you're going to need to be paid at least every 2 weeks. They can't pay you once a month. There has to be regular paychecks. It's another requirement. On that same note, every employer is required to provide you with a pay stub, which provides you with the hours offered and the hours worked, the pay rate, overtime rate for every pay period. So that should be something that you get. Also, deductions. Unlike H-2A, which does not have to have with tax withholdings on it, H-2B does have tax withholdings. So your federal taxes and Social Security withholdings are withheld from your paycheck as required by law. But any other deduction aside from those lawful, required deductions, the employer has to have your approval to deduct it. So if you One difference between H2A and H2B is that H2A housing is provided. H2B, the worker is responsible for their own housing. That being said, some employers will give workers the option to stay in employer housing, which means you pay fair market rent and utilities. If you are opting into that as a worker, you have to either pay the employer directly, or you can have it withheld from your paycheck. So things like that, health insurance, rent, utilities. Let's see, what's another common one? Loans, things like that could be a deduction on your paycheck need to be approved by you. And they need to be on your pay stub so that you can see what the deduction is. So, you just need to know what's coming out of your check, and you're entitled to know that. I talked a little bit earlier about the 3-quarter guarantee on the employer side. It's another thing for employees is that H2B is a full-time role. If you are offered 35 hours on your contract, you are entitled to at least 3/4 of those. If you're offered 40 hours, you need to be offered at least 32 hours, so you've got some minimum protections to make sure you're not doing nothing. You're getting paid for the work that you expected to be here to perform. And if they don't have enough work, they're still required to pay you for it. If it's rained, and it goes for every 12-week period. So there's a calculation for that you can look up. The employer should be aware of, that's an important guarantee to make sure you're paid as the contract says. Another important item that comes up is tools and equipment. There's no reason you should be charged for tools and equipment. That the employer provides all tools and equipment to perform the job. So that should not be something that happens. Another important note for protection for workers is visa fees. There's under no circumstance should the worker be paying for visa fees. You may pay them at the consulate. Some employers will do that, but you have to be reimbursed the first work week when you get here. Inbound travel, also something that is covered by the employer as part of the H2B program. That one is most employers will prepay it for you. Some may pay it when you get here. The regulatory requirement is that as long as you stay, you have to stay for half the employment contract to get the inbound transportation. But with federal wage requirements, a lot of times they just pay that with your visa fees up front because they can't take you below the federally mandated minimum wage by virtue of withholding that, by not having you reimbursing that travel. So the bulk of you will have your travel reimbursed when you get here, if not prepaid. Same thing, if you complete your contract, you do not leave early, you're not terminate, you're entitled to have the employer cover your return transportation. So you finish the work contract at the end of the season, your employer is responsible for sending you back to your point of origin. So that wherever country you came from, you get travel reimbursement back to your home. Very important. Same thing if you're terminated, you still get return transportation. The only time you don't get return transportation is if you quit early, or if you transfer to another H2 employer, then that new employer is responsible for paying your travel to the new employment site. So those are very important. Another very important thing that workers should know, and this comes up not in the employer context, it is an employer compliance requirement. Employers should sign something if they're using a recruiter, the employer should have something signed that the recruiter says that they're not going to charge workers a fee. No H2B worker should pay an employer or a recruiter a fee to be referred to H2B. Very important. It's not something that you should be responsible for. And violations for this, there are audits from Department of Labor, there are site visits, inspections. Employers are required to maintain an audit file with all of this documentation, copies of your pay stubs, copies of reimbursements. The employer should have copies of all of this. And workers also, there should be an H2B rights poster that the employer posts in the work site. That also will have details on how you can whistleblow, how you can report it. There's anti-retaliation components as well, so that the employer can't retaliate if you report wrongdoing or mistreatment.
Wow. Those are, I mean, a great number of protection rights and laws and rules and regulations you highlighted. And thank you so much, Megan. I think once you have the passion to work and you have the right documents and you're on the right path, I think nothing can stop you.
Right.
So thank you, Megan. And we have Samuel who's back with another question. I think we should take that up. He's asking, can my spouse, who is my dependent on an H-1B visa that is in administrative processing, apply for a visiting visa?
There's nothing to preclude her from doing so.
Okay.
But again, there's very little transparency into that application process. So, it's possible for a spouse to also be put in administrative processing for anybody can be put in administrative processing for any visa, for them to review it. But there's nothing, just because you have a visa pending, that also doesn't mean she couldn't apply for her own H-1B, her own visitor visa. There's nothing to preclude, again, assuming she's eligible or can qualify. Your being in administrative processing isn't going to prevent her from doing something else. Even if she's on an H-4, she could still theoretically apply for a visitor visa.
Mm-hmm.
Whether or not it's approved, is anybody's guess.
That's cool. Thank you so much for taking that up. And Samuel, I hope you've got your answer. Thank you for participating. I have another question, Megan, and that is, how does the H-2B program ensure that foreign workers are not exploited by the employers?
Right. So that a lot of the same things will apply from the compliance requirements. All of those compliance requirements are in place so that workers are not exploited. You have a prevailing wage to ensure the worker is not paid too little. There's, again, reporting opportunities with Department of Labor to report employers that are, misusing the program, so that your protections remain in place. There's also, depending on your state, there may be nonprofit or volunteer groups that can also provide services to help if you are, being subject to mistreatment. So, all of these protections and compliance requirements that you should be entitled to, they can be enforced in the same way. Though you can report them and they can be subject to penalties for that. And I don't know if we'll get to the penalty question or whether I should cover that here, but there are penalties that the employer can suffer based on that, depending on what the violation is. Again, the anti-retaliation requirements are important for that. Workers can file a complaint with the Wage and Hour Division with Department of Labor for any of those violations, for being charged a fee, not making your hours, not being paid the correct wage, being denied. Again, another thing that it doesn't come up often, but when there's severe negligence or mistreatment of workers, another thing you should report absolutely is if your employer is holding your passport. Your employer should not have your passport or your visa. You should have free autonomy to leave at any time. Be aware of as a worker, the terms and conditions of your visa, and make sure you're not, by leaving, having an issue with your status because you're no longer at the employer. So, there are things to consider for that, but it shouldn't deter you from reporting mistreatment.
Right.
I don't know if you want to jump ahead to the repercussions for employers. I know that's another question, or if I should just get to that later.
Yes, we could get to that a little later, or maybe in our next episode as well, because there's so much to talk about H2B. But I would also like to tell our folks out there, that it's always best to consult an attorney and be guided with your case, because every case is different and needs proper attention. And I would say, why not contact attorney Meagan Kirchner in her number, and her number is 434-226-0586. You can note it down. You can also email Meagan. Her email address is meagan@kirchner.immigration.com. You can check out the spelling on the screen and go visit www.kirchnerimmigration.com to get to know more about Meagan. Thank you so much, Meagan. It was really great. But of course, so much to talk about this. I think we should definitely do another episode on H2A and H2B visas again.
Sure. Be happy to.
Yeah. But before we go, what do you have to say about Trump and starting 2025? What can we expect, maybe, or what do you think the immigration scene is going to look like?
I was just at a conference in DC with other immigration attorneys on Friday, and we're all just ready to buckle up for the ride. H2 in particular was a little more insulated from some of the trials and tribulations that came from the administration last time. A lot of the other employment visas, family-based visas, are going to have much tighter scrutiny. Requirements may change. It's going to be more difficult. Again, I know you mentioned a lot of people file on their own, but particularly with this administration change, having an attorney navigate the process will be more important than ever, because it's going to change, and it will change quickly, and more than likely not in any way that makes it easier.
I know everybody is so anxious, and I really hope that things fall in place as soon as possible, or at least folks out there get to know what can happen or what may happen with their case. So thank you so
Right.
much, Meagan, once again. It was great having you, and I really hope to see you in the coming week.
Nice to be here, and thank you for having me, and best of luck to everyone watching, and reach out if they have any questions.
Yes, absolutely. Thank you so much. And also Samuel, and then we had George who had joined us. Unfortunately, the line was a little disturbing, but I still hope that, George, if you have any further questions, you can comment, because after the stream has ended, this is going to be published, and it'll be really nice to have you comment with your question. And I'm sure, Meagan, you can address that. I will I will put that up to you.
Yeah.
You do.
Sure.
Yeah. Anything else you want to say to the folks out there with regard to the topic before we leave them? Because I feel like we're just ending it so abruptly right now.
Yes, where this is just the tip of the iceberg for the H2 world. I wasn't really able to dive in at a really granular level as far as what employers need to do, how long it takes.
Yes.
So I really just want everybody to know that it can be a long process, but with the right help, and starting at the right time, it doesn't have to be a painful process, as long as you start. But their timelines are critical for this program.
Right, right. Thank you so much for that hopeful note and an end note. Thank you, Meagan. And you have a splendid week ahead, and I'll see you soon.
You as well. Thank you.
Thank you. And folks out there, thank you so much for joining us on YouTube, LinkedIn, Facebook, and Twitter. It was really nice having you, and especially with your questions in the comments. So feel free to like, share, and also subscribe to our channel. Hit that bell icon so that whenever we have discussions like these, you are notified. And really, I'm also looking forward for Meagan to join us again in the coming week, because there's so much to discuss about H2 visa, and I'm sure you too have a lot more questions. So thank you so much for doing this today, and don't go anywhere, because we have more webinars and discussions lined up on Immigration and Jobs Talk Show. Hello, viewers. Thank you so much for joining us today. This is Immigration and Jobs Talk Show, and I am Napasa Pradhan. I'm going to be your host for today's session, and it's going to be a wonderful one. So, before we dive into today's topic and I introduce you to our special guest, I really wanted to wish you a very good morning, good afternoon, good evening, wherever you have joined us from, whatever time zone you have joined us from. Thank you so much for doing this. And there's an important disclaimer I need to read out. And that is, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. And friends, thank you for joining us today here at Immigration and Jobs Talk Show. We are streaming live on YouTube, LinkedIn, and Facebook. So feel free to drop your questions if you have any, in the comment section, wherever you're watching us from. And we'll try to get as many as we can in this session today. But before we go on to today's topic, today we have a very special guest with us, someone who is a prominent figure in the field of immigration law. And she is Sophie Alcorn. She's the founder of Alcorn Immigration Law and has been recognized as the top 10 immigration attorney in the state of California. She's also the host of the Sophie Alcorn podcast and the author of the best-selling book, Ask Sophie, The Founder's Guide to Visas and Green Cards, currently based out of San Francisco Bay Area. It's such a pleasure and an honor to have you with us, Sophie. Thank you so much for joining us
Hi,
today.
Nivasa. It's so wonderful to be back. Thank you so much for having me. There's a lot of exciting updates, and I'm eager to share my knowledge and answer questions. So thanks for the opportunity to be here.
Thank you so much. Thank you so much. And talking about it, I mean, let's get to know what are your thoughts on the latest update on the second lottery coming up for H-1B cap.
Yes, it's so exciting. So a couple days ago, USCIS just announced they are going to conduct a second lottery, or the random selection for the previously submitted H-1Bs. So this means that if an employer put you in the lottery in March and you were not selected in April, you now get another chance. And it's really exciting. And it's also super exciting for most people in the world because they've already reached the master's cap of the 20,000 set aside for people with advanced degrees from the US. And so it means that everybody is eligible for this second lottery now. So if you have a master's degree and you're going for the master's cap, great, you still get another chance, but everybody else who just has like a bachelor's degree or the equivalent, they also get a second chance. So it's really exciting.
It is. For folks out there, I mean, all this while, everybody were like, is there a second lottery going to come up? And, oh, by the way, is there any chances of maybe a third lottery maybe after this?
Right, right. It's so erratic every year. I mean, one year they had like 4 extra lotteries, and then other years they've had 0. And so it really fluctuates. I'm sure they try to do their own like predictive analysis and statistical modeling to try to get the right number, but there's always fluctuations, interest rates, layoffs, employers, whatever. So I don't know if there's going to be another this year. I have no idea, but I'm just really happy this is happening now. I wish I knew when it was happening, but I don't. They just said soon. And if you previously registered, you're going to find out about it through your USCIS online account. And typically, they give employers 90 days to file the petition after the selection has happened, and it would still be to target an October 1st start date. So we have August, September, October. So theoretically, you could probably request a later start date than October 1st if your employer wanted. You could choose a start date up to 6 months into the future for the I-129 H-1B petition. But we'll see. Like, if you wanted to still try to make it by October, and I don't know, let's just imagine this happens next week, I think there would still be ample time for an employer and for a visa interview to go through the process. So it's really exciting.
Exciting, it is. Let's stay hopeful, folks, I would just say, and all the very best to all you folks out there who have the second chance. Let's pray for the best, okay?
Yeah.
So, yeah. And let's get to today's topic. Our topic for today's discussion is top visa options for employers for a quick hire, H-1B versus H-1B exempt versus L1 versus O1. And basically, it's the second episode, but since we couldn't cover it properly in the first episode, maybe, Sophie, if you could just give us, like a roundup, or like what can folks expect from us in today's webinar?
Wonderful. Okay. Well, I will share a little bit more. And thank you for the warm introduction. I really appreciate it. You know, I started my law firm. My dad was an immigration lawyer. My mom's an immigrant from Germany. And I just see the grit, resilience, determination, creativity, innovation that come from our immigration system in the US. And I believe that we should live in a world where every kid has the chance to grow up and live their dreams. And so that involves, you know, removing artificial barriers like immigration to allow people to live their best lives. So happy to keep in touch with everybody. And you had an amazing disclaimer. This is mine. This is not legal advice. Talk to a lawyer if you need individual legal advice. Obviously, whatever questions you ask are not confidential. This is just an educational service. And in my slides, I do have this QR code, which is our consultation booking link if you do need help. And let's see. And would you like me to now go into some of the overview about some of the background on H-1Bs and Ls for a few minutes? Would that work for you?
Yes, we should do that. I think without further ado, let's get on to whatever you have for us today. And we are absolutely ready. And I hope the folks out there are as well.
Wonderful. Well, I'll go through my slides. Feel free to jump in if anything's unclear, but I'll try to go through them in maybe, 5 to 10 minutes, give everybody a brief overview of H-1Bs, cap exempt H-1Bs, L-1s, other types of visas, green cards, and then we can turn it over to questions. Okay?
Absolutely. Thank you so much.
All right. You're
Let's
so
go
welcome. Okay. So high-level immigration context. Lots of reasons people want to come to Silicon Valley where I practice immigration law. They want to launch new technologies. They want to increase their profit. They want to move really fast. They want to work with the brightest minds from the world. They want to raise money and venture capital from US investors. Now, you're probably all very familiar with this in the audience, but in general, the US has visas, green cards, and citizenship. So most people, like from India, for example, would come here on a non-immigrant visa, such as a B1, B2 visitor visa for 10 years, where you can stay 6 months at a time, or an F1 student visa. And then after you're here, you have various options, such as changing your status, maybe if you got selected in the H-1B lottery, or you're going to pursue an O1 visa for extraordinary ability. And then you can be sponsored for a green card, either by a family member or an employer usually. And a green card is the same thing as permanent residence. Sometimes it's called an immigrant visa. If you're already in the US, you can get it through a process called adjustment of status. You might be qualified for a work permit along the way. There might be travel restrictions at some point, but you would get an advance parole document to allow you to travel. And then 5 years after having a green card, if you want to naturalize and become a US citizen, that's something you can apply for yourself. You don't need an employer. And once you're a citizen, you can sponsor your parents for green cards. And you always have to pay taxes in the US, but you can be gone as long as you want. So lots of advantages for that. So most people come here on a visa and then get a green card. Some people do, like some folks from India who are EB-1A qualified. They might, for various reasons, choose to apply for the green card from India before moving here, but usually that can take several years. So often people want to move here quicker through a visa. And then there's a lot of international students in the US. Along the way, they can have work options such as curricular practical training, optional practical training, pre-completion or post-completion, the 24-month STEM OPT extension, after the up to 12 months of regular OPT after they graduate. And historically, the hope was always, I'm going to go to the US, I'm going to graduate, I'm going to get a job that'll sponsor me for the H-1B. They'll put me in the lottery every year until I'm selected, and then they'll sponsor me for a perm and an I-140. But several big companies recently announced that with all the tech layoffs, they're no longer engaging in their perm programs for their employees. So these this path is not as secure as it used to be. And so, definitely excited to provide alternative options. So for work visas, the most common, we talked a little bit about the H-1B lottery, so that's very exciting. It is possible to hire people with H-1B transfers, and you would need current or previous H-1B status. the new US employer has to proactively file the H-1B visa transfer petition. They have to prove that they have the ability to pay the prevailing wage. And if somebody's already maxed out their 6 years on H-1B status, there are ways to get extensions beyond the 6 years through a law called AC-21. And that is based on having a perm or an I-140 approved. And then you can get either 3-year or 1-year extensions. So lots of people from India utilize that. Now, we did get a question about what is a cap exempt H-1B. So these are H-1Bs that do not require the lottery. They are available at any time of the year. And the best way to use it to have a job at a private company is to obtain 2 concurrent H-1Bs at the same time. So step 1 is to either get a part-time job at a qualifying cap exempt employer. So that could be a university for a part-time teaching assistant job. It could be at a nonprofit associated with a university or a nonprofit research institution. There are various global talent fellowships and organizations that have sprung up to support this. So you basically work for them for 5 hours or 10 hours a week to get your first H-1B. And then while you're doing that job, you don't have to go through the lottery to get a second concurrent H-1B with a private employer. So your other employer can then sponsor a part-time or full-time concurrent H-1B. So that's been very, very beneficial. And just to recap, those cap exempt organizations that you could get the first job at include universities, government research organizations, nonprofit research organizations, and nonprofits affiliated with universities. Okay, so those were H's. And just another note on H's before I move forward, because we work with a lot of startup founders. We've gotten H-1Bs approved for CEOs of pre-revenue startups, even where they're the 100% owner, and even where there's no major venture capital investor. The government is very interested in allowing folks on H-1B to become startup founders because they recognize the innovation potential that people on H-1B have to develop new critical and emerging technologies and AI and ML and other areas. So if you are on an H-1B and want to be a founder before getting a green card, it is definitely possible. And you could even do that with a cap exempt H-1B. Okay, so now for employers, another option that they look at would be an L1 intracompany transferee visa. And the basic setup would be there's, and we work with a lot of startups. So typically for a startup, it would be a parent company with an office in San Francisco, maybe incorporated in Delaware, and it has like a wholly owned subsidiary, like private limited company in India. And there's people who've been employed at the Indian office for at least 1 year out of the last 3 years as managers or executives or people with specialized knowledge. And now the US office is transferring them over to be a manager, executive, or person with specialized knowledge in the US. So you can come for up to 3 years initially, or 1 year if it's a new office. You can get 2-year extensions. The L1A can be extended up to 7 years. The L1B can be extended up to 5 years. And the other really cool thing about the L1A for managers and executives is that it provides a path to the EB1C green card pathway, which is the fastest. EB1 is the fastest green card pathway. So if you're from India and you don't qualify for extraordinary ability yet, it can be very helpful to get that EB1C approved as well. Now, the O1s are also very popular right now. It's typically a 3-year initial petition for extraordinary ability. And then beyond the first 3 years, you can either get 1-year extensions or new 3-year petitions can be renewed indefinitely. If you are from India, you get a 5-year multiple entry visa in your passport. The O1 visa interviews are usually pretty fast. To qualify for an O1, you need 3 of the 8 categories that are pretty well established. So that could be like awards, people writing about you, what did you create or invent? Are you a leader? Are you a member of organizations that are hard to get into? Are you a judge of who is an expert in your field? Are you an author or a speaker? Have you earned a high amount of money relative to your other people in a similar role in your geographic area? So these factors can be mixed and matched. You can do it if you are a founder, a researcher, an engineer, a TikTok influencer, an inventor. We just mix and match the categories in different ways. And the other cool thing about the O1 is you can be self-employed, you can have multiple streams of income, you can have one job at an employer, you can have many projects. So it's a very flexible thing, although the drawback would be that your spouse does not automatically get a work permit. So just various factors to keep in mind. And I am absolutely here to help, and we'll be sharing my contact information more, but you can always reach out to me and my firm at alcorn.law. And my book, Ask Sophie, is available on Amazon and Audible. And yeah, okay. So there we go. That is the overview. And I'm so delighted now to ask questions, to, answer questions or chat or anything else that would be helpful.
Thank you so much, Sophie, for that wonderful presentation, I would say. And you made it so much clearer with all these slides you had to provide for us. So
thank you.
Really happy to have you. All right. So was good. And I'm sure folks already have questions. I can see actually. So Rocky Berman, thank you so much for your questions. Raja Shaker, hi, thank you. Just stay with us. We will take up your questions. And absolutely great. So far, so good. So a lot of things going on. I mean, as far as immigration is concerned, and with the elections coming up, I think everybody, they have questions in their head. What is going to happen if Kamala Harris is going to be selected, or what is going to happen if Donald Trump is going to be selected? What do you think? What do you have to share with our folks out there?
It's been such a roller coaster this year, and I'm always like recalculating what the immigration landscape will look like. Okay, here's what I can say about both as it stands now, not knowing what the outcome will be. So first of all, we've had a lovely 4 years of this Biden administration from an immigration perspective. We got out of the COVID backlogs. Consular processing is back to decent times for most countries around the world. Premium processing is available for more cases. The online lottery H-1B system's working. So there's been a lot of improvements. And also for startup founders, international entrepreneur parole is now another option as well. If you get the levels are about to increase, but say you get $320,000 of investment from a U.S. angel or VC investor, that could qualify you for our equivalent of a startup visa now. So all those things are wonderful improvements from this Biden administration. If there is a Republican administration, what we saw during the last Trump administration was the Muslim ban, high levels of RFEs for H-1Bs, stopping H-1Bs for computer programmers, litigation about H-1B third-party contractors, slower processing times because State Department officials were leaving their consular posts. The whole system got slower, and there was more friction. That being said, one of the things that former President Trump mentioned on a podcast with some venture capital investors a few weeks ago was that he's actually in favor of a proposal that Hillary Clinton originally came up with, which is essentially like the staple the green card to the diploma sort of idea, which is like, look, if you're smart enough to come here and be enrolled in our universities on an F1, you should theoretically have a path to a green card and citizenship. So what that looks like, I have no idea in practice. I think if there's a Republican administration, it would take some resolution of the US-Mexico border and asylum situation that would need to get clarified before anybody's going to move forward on high skilled. But if that's in place, high skilled would become very easy. If it's a Democrat administration, like under Harris, for example, I think we'll see general similar positive trends to what we've seen for the last 4 years, but she's also very different, and she might have mean, she's been focusing very intently on the southern border, on getting investment into Latin American countries to try to create more economic abundance there. So there's less migration flows to the US. So her stance on high skilled is probably slightly different. Maybe she'll be more proactive, but in general, I think the Democratic Party wants to see an increase of high skilled, even for example, making O1s and EB1A and EB2 and IW self-petition green card pathways more accessible. So that's my analysis now. Now, depending on who either of them hire to actually implement their campaign ideas, then that's like a completely different thing as well. Because remember, President Trump was kind of like pro high skilled. He wanted a skills based thing like Canada and Australia when he ran before. But then the person he put in charge of immigration had very different perspectives. So, well, I don't know.
So true. And there are things changing. There's still a few more months, so anything can happen.
Yeah, anything. It's going to be a wild ride in the reality TV show of American politics for the next several months. But in general, what I've been telling people is, if you want to move here and you're eligible now, like, don't dilly dally. It would probably be a good idea if you qualify to just get it done now, and then at least you're in line, in the queue, waiting, and then that would be an advantage for whatever happens in the future.
Yes, just keep your game up. I think, see what chances you have and try to put your game up. I think, that's how it always works. All right. Thank you, Sophie. That was very nice and good to know your views on this as well. So let's get back to our topic and let's get back to the questions folks have for us as well. All right. So let's take a few let's take this one from Rajat. Rajat is asking on YouTube. If someone is selected in the first round of the H-1B lottery and their employer submits a petition, is there still a possibility that they might not receive a call for a visa interview from the embassy?
It would be very, very rare and unlikely. So typically what would happen is the employer had to submit the petition by June 30th. And the employer could pay for premium processing, but doesn't have to. So you could find out if they did. If they did, you should have already gotten an approval or a request for evidence by now, because it's been a month and they are supposed to take action within 15 days. If your employer does not want to pay for premium processing, then you are able to. So you can ask them to upgrade it, and you can, in that situation, you can personally pay the $2,805 to ask for premium processing. Once there is a decision, your petition will go through the electronic system to be transferred to the State Department. And then you should be able to schedule your visa interview at a consulate of your choosing based on the available processing times of the different consulates, which fluctuate a lot. And then you go for your visa stamping interview. And usually the visa is granted pretty directly after that. There is a situation called administrative processing, where the government can do additional background checks or look at the company that's sponsoring you, or maybe there's maybe your name is similar to somebody else's, so they have to disambiguate your background check with somebody else's. So that can take a long, indeterminate amount of time, but that's extremely rare. So in most cases, but you don't just randomly receive a call for a visa interview. You have to work with your employer and your immigration attorney to proactively schedule the visa interview. It's not just going to magically happen. You have to take action.
Right. Plus this year, I think it was very beneficiary centric. So only employers or people who were registering for the folks with H-1B, only they get to see what the status is, right?
Yeah, the employers are responsible for the process. So they create the online accounts, they put their candidates into the system. Exactly. So you need to be kind to your HR person so that they're willing to share information with you. Don't annoy them too much.
For sure. So, but anyway, I mean, a call, if it ever happens, it's only going to go directly to the employers, right? not to
Yeah,
the
yeah.
person.
The employer has to check the online system to see if there's been an
Exactly.
update and to see if you've been selected.
Right. Thank you. Thank you, Rajat, for your question. I hope that's pretty clear now since Sophie has answered that. Should we take up another one, Sophie, from the audience?
Let's do it. Let's do it.
Okay. This is from Pedoju. Filed H1B with my PG from India, post graduation from India. I want to know that my application will be in regular pool. In regular pool only, no? Yeah.
Probably, yeah, because the U.S. master's cap is for people who got an advanced degree from a qualifying. So, like, if you had a master's degree from the U.S., you would go into the master's cap. But if you have a master's degree from India, you would go into the regular cap. But everybody in the world is going to be included in the next round, in the second lottery round. So you should be included in the regular pool now.
Okay. All the best, Peduju. I hope you make it. Let's take another one. This is also from YouTube. This is from Rag. Heard elsewhere from Sophie that L1s are heavily scrutinized and not encouraged to jump into. What do you have to say about your own comment, Sophie?
Thanks for holding me to task, Rag, and thanks for listening to various things I've said in the world. I'm trying to make this more accessible for people. This is something that fluctuates a lot. So I would say recently we've been quite successful with L1s. Sometimes there's trends in the immigration lawyer forums where it's like, what the heck? They have 10 employees and there was still a horrendous RFE. So I think it just fluctuates, but really the principle that I would take away from the last few years from Republicans and Democrats alike is if you want to get an L1, you need to have like a functional company abroad that's going to keep going without the person who's transferring to the US. That organization, let's just say in India, needs to have employees, a revenue stream, growth plans. If you're the sole employee in India, you're not going to be able to transfer to the US. They want to see that you're supporting a multinational growing business. Now, the smallest possible size for the foreign employer, I think that we've gotten it improved with like 5 to 10 employees to transfer an executive to the US. So it doesn't have to be that big, but it should still have a presence. And then you should be able to withstand any L1 scrutiny. I think that's my current approach.
Thank you so much. And Rag, I'm sure you are a total immigration enthusiast. I mean, really good to have you back on our show because I remember you from yesterday's show as well. So thank you, Rag. And yeah, thank you for watching Sophie and her comments as well. Sophie, you're watched, so be careful.
I know. I go
All
to
right,
coffee
so-
shops now in the Bay Area, and when people I'm like, I don't know if you're recognizing me or if you're just looking at me. I don't know. But if you see me in
I'm
real
sure
life,
people
say hi.
recognize you. And you
What's
just go walking around like that? I'm sure they recognize you from your book, from your podcast.
I'm in the heart of Silicon Valley, and so now I'm like, I don't know.
Yeah, wow. You will meet, what do you call people are, I mean, your, what do you call them? Who will have to look after you?
Oh, I hope not.
Gods, like not gods. There's another word. I'm so sorry.
Security
That's just slipping out of my mind. But yeah. All right.
Need a
Let's
bouncer?
take this
No,
one
no,
from
no.
Rocky. Yeah.
Okay.
Heard about H1B exempt visas, but I'm not sure how they work. Can you tell me about the advantages and disadvantages of pursuing H1B exempt status for my company and how it differs from regular H1B visas?
Yeah. Thank you.
This is a long one.
And thank you, Rocky. This is a great question. So I mentioned it a little bit in the presentation. The disadvantage of pursuing cap exempt H1B status is it takes time and money. And so if you get somebody selected in the lottery, overall it's cheaper, but it's just risky because they might never get selected. There's about a 25% chance. So if you have a company and it's like a for-profit LLC or corporation or something doing business with revenue, for your organization to become cap exempt itself, you would have to like incorporate a new 501c3 and have revenue there and like set up a whole additional company. Most employers don't want to do that. Most employers would work with one of these nonprofit affiliated with universities institutions to do the cap exempt H-1B sponsorship for their employees. And so that's worked very successfully for candidates around the world, for my clients for years. And there's different organizations springing up with different price points to do that and different offerings. The drawbacks of working with them are you're paying another organization to employ your candidate for several hours a week. Your candidate has to do other stuff that fits with the educational nature of the nonprofit, like training American students on an internship that they have. But you can set that up to be beneficial for your company and have a domestic talent pipeline as well with, students who are familiar with the work you're doing. So your employee, has some additional obligations they need to maintain during the whole course of the H-1B, or until they get selected for the lottery, or until they get a green card. But if you're, if your organization has cash flow, and if getting somebody to the US is important and urgent, and if that person is not otherwise qualified for like an L1 or an O1 or some other type of visa, and if you don't want to go through the pain of trying to organize a part-time TA-ship with an H-1B at a university yourself for your candidate, I mean, these are wonderful cap exempt organizations that can help you get somebody to the US working with you in person in like 2 to 3 months with very little risk. So from that perspective, it can be worth it. It's a different cost benefit analysis for every employer. So.
All right. Thank you so much. I think that makes it very clear. I mean, to Rocky, thank you so much, Rocky. Very interesting question. And Sophie as well for taking that up.
Thank you.
Moving on, I think we will take up your questions, folks, but I think now it's time for a short break. So if you have questions and want to contact Attorney Sophie Alcorn directly, why not call her in this number, 855-644-2581. And you can email her hello@alcorn.law. That's how you can get in touch with Sophie Alcorn. She is also the founder of Alcorn Law and a best-selling author. Thank you so much. And definitely go visit www.alcorn.law to get to know more about Alcorn Law. And thank you, folks, for being here. Don't go anywhere because we're going to definitely talk more for the top visa options out there for you. So stay with us here on Immigration and Jobs Talk Show. This is Nipasa Pradhan with Sophie Alcorn.
Thank you so much.
IT consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at nipa@higheritpeople.com or visit our website www.higheritpeople.com.
Hello and welcome back, everyone, to Immigration and Jobs Talk Show. I am Nipasa Pradhan, and today we are discussing on this topic, top visa options for employers for a quick hire, H-1B versus H-1B exempt versus L1 versus O1. And this is the second episode with none other than our guest for today, Sophie Alcorn. So good to have you, Sophie, once again. And welcome back to this second half of this webinar. I hope you're having a good time.
Thank you so much. I am. I love all the questions, and it's so great chatting with you about all this. So thanks for the opportunity to be here.
Thank you. It's truly an honor and a pleasure to have you. And folks out there, for those of you who have been seeing Sophie and you know that she's a familiar face, let me tell you a little more about her. She is Sophie Alcorn, the founder of Alcorn Immigration Law, and has been recognized as the top 10 immigration attorney in the state of California. And she also is the host of the Sophie Alcorn podcast and the author of the best-selling book, Ask Sophie, The Founder's Guide to Visa and Green Cards. And maybe, Sophie, would you like to tell us what sorts of things do you discuss in your podcast, maybe, and how's it going?
Sure. Yeah, the podcast is really fun for me, and I hope everybody subscribes and listens. I will put the link in the chat window so that you can find it on Spotify and Apple Podcasts. But it's a weekly podcast, and it's about everything I am interested in. So definitely subscribe. It changes all the time. Most recently this year, and the archive is, I think, a tremendous resource because I have over 100 episodes on what is an H-1B, what is an O-1, what is an L-1, how do I get a green card, how do I consular process, what do I do with an RFE? So I did that for 100 episodes. Then I wanted to change it up. So recently I've been interviewing people. My most recent nerd fascination is outer space immigration, which I think as a planet we need to prepare for the future.
Wow, that's very exciting and futuristic for sure.
Yeah.
So you can tell us more. That's totally out of the box, or out of this world.
Out of these, absolutely. I've been interviewing space law professors, space startup founders, former fighter pilots, people doing intellectual property law for space tech. It's fascinating stuff, and it's really brand new territory. And I just want to make sure that when we have hotels in space and a moon base and people are going to Mars, that we have a clear, clean, wonderful immigration system that allows people to effortlessly go between the Earth and other destinations. And like that kids born in space will have a citizenship after multiple generations so they can come back, right? This is like far-fetched sci-fi, but I love it.
Me too. You say it sounds so exciting, and wow, yes, we're going to have some immigration law for space too, for sure.
Yeah, I would love to be in the room and help write the treaty because the law is super antiquated, I figured out, and people who, like, technically, if you send something into outer space, it's still the property of your country. And if it lands back in your country, it's like it never left. But if it lands in somebody else's country, then there would be immigration and export. But if you're just like on the moon, you're still in the US or in India, if that's where you left from. But you can't own property in space. You own your equipment, but you don't own the surface of the moon. So it's super confusing. And there's like a lot of legal concepts. Like if you have a slip and fall in a space hotel, do you have to take it to the UN, or is there some like private right of action? So I'm just fascinated. I want to help with this. Now for the fall with the podcast, I was just at the Capitol yesterday in Washington, D.C., and I've been really involved in conversations about artificial intelligence and bringing startup founders to the US and helping people to be able to innovate these new technologies. And so for the fall, my focus for the podcast is going to be talking to bipartisan lawmakers, former members of Congress, about prospects for high-skilled immigration reform, because it's something I'm really, really passionate about.
Very nice, very nice. And talking about AI, it's taking over so many spaces, workspaces, whether it's media or any field for that matter. So do you have to say a little bit about artificial intelligence as well?
Oh, God. Well, it's affecting everything. And if people don't know it yet, then maybe have a look, because it is happening. And it's one of those things that's like happening exponentially. So it's like, oh, doesn't matter, doesn't matter, doesn't matter. And then all of a sudden it's like, oh, wow, it matters. It's happening. And there's huge potential for innovation in the field. And, it's even going to affect like our power grid to have data centers that can actually, run all of these LLMs and different like GPUs and LPUs and all of that. So there's a lot of like logistical and infrastructure opportunities. So if anybody wants to, this was my learning yesterday, knowing about AI and electrical engineering with the power grid is like a job of the future that will be very, very important in the United States, definitely in the national interest. So there's like new opportunities like that coming up all the time. And Biden's executive order very much promotes AI as well as any other critical and emerging technology in the national interest. So if you want to pursue one of these fields, there's funding, there's visa and green card opportunities. Like we want you here. And there's a lot of potential for what you can create that can help the world.
So folks out there who are still fortunate to be a student maybe so far, I think you can think about pursuing something with artificial intelligence, because I think that is the future for sure.
Absolutely. And it's not even just artificial intelligence, which is the other interesting thing. And I'll provide this link to your team.
And it's not just future. I mean, it is happening already.
It's happening now, but our government isn't just interested in AI. It got all smushed together in the AI executive order, but it's advanced computing, advanced engineering materials, advanced networking, AI, biotech, clean energy, data privacy, cybersecurity, autonomous vehicles, human machine interfaces, quantum, semiconductor, space tech. So there's actually a lot of really, really exciting opportunities for careers.
Sure. So thank you so much, Sophie. I mean, that was very enlightening, and I'm sure folks are going to be more interested to get to know more about this. So don't forget to check out Sophie Alcorn, folks. Her, information is scrolling on the screen. You just note them down. And we will go on to the questions now, because we just have a little more time. And Rag, who had questioned us earlier, has more questions for us. What documents should the employer periodically submit to the USCIS during the L1 visa holder's tenure?
Great question, Rag. There's no like random compliance checks where you just have to send in information as an employer, but they will evaluate everything on the renewal, such as the extension. So at that point, you're going to need to be able to show that your company is still doing business, revenue, tax filings, your org chart, that the job still exists, that the person's been working there, that you've been paying them properly, if they've, been growing in their career at all or their responsibilities. All of those things are super helpful to show.
Thank you so much, Rag, for your question again. And Rag says that he liked the NVCA podcast of yours. Very nice.
Thank you. Appreciate that. That was a fun one. The National Venture Capital Association is a really great organization. They actually litigated to keep to keep the International Entrepreneur Parole Program, which is like our startup visa, to keep it alive. And it's been really great working with them. Silicon Valley investors are very interested and motivated to keep immigrant entrepreneurs coming to Silicon Valley. So there are supporters for immigrants who are very vocal and who definitely do a lot to help.
Lovely, lovely. Thank you so much for sharing that as well. And thank you, Rag. Like I was saying earlier, you totally are an immigration enthusiast, and it's lovely to see that you're following up. Thank you for joining us here. Yeah. Let's move on to Raja Sekhar. H-1B visa petition was selected in the initial lottery, but the employer is now facing financial difficulties and may need to withdraw the petition. If we withdraw the petition, can we still participate in the second lottery, or will that impact our client's eligibility?
Withdrawing the petition will remove the beneficiary's eligibility. So it would be really lovely if this employer could maybe just wait a few weeks to see if this person is chosen in the second lottery before making any sudden moves. So an H-1B, let's just pretend this person gets selected. The H-1B has to be filed in good faith. So if the employer is having financial difficulties and really would never hire this person, they just shouldn't file it. If they're having financial difficulties, but they would still love to have this person work on October 1st, but they just don't know if their financials would qualify, it might be worth it to move through with the petition. Maybe the person will get selected. And, you know, if they have to fire you because they can't pay you after October 1st, at least at that point, you would have, you know, approved H-1B petition. You would have been counted against the lottery, and then you could try to do an H-1B transfer to another employer.
Mm-hmm. Thank you. Thank you for taking that up. I'm sure Raja Sekhar is very happy with your answer. All right, let's take up this next one. This is from Ankit. I have heard that O1 visas are a great option for hiring top talent quickly, but I want to learn more. Can you explain the eligibility requirements and application processes for O1 visas and how they differ from H1B and L1 visas?
Great question, Ankit. Absolutely. So in one sense, they're all visas. There's a petition with USCIS. You can pay for premium processing. USCIS will make a decision. Once there's an approval, you go schedule a visa appointment. You get a visa in your passport. You come in. You do the job you said you would do. So they're all similar in that respect. But who qualifies is very, very different. So the H-1B, super straightforward. Bachelor's degree or equivalent, company that's offering you a professional job that has the ability to pay you. That's that. Super easy to get through. The L1 is like, hey, you've been working for us abroad for a year and we got to transfer you here now to help run things in the States. The O1 is a different beast. It's saying, hey, Ankit is the very best XYZ, the very best AI enterprise SaaS AI startup founder of India, you know, focusing on helping the healthcare vertical. And now, because he's so extraordinary in India, we want him to be able to come to the US to do XYZ, whatever you want. Start a company, get a part-time job, get a full-time job, be a consultant, do all of those things at once. So the O1 is very different. It's like, hey, we already know you're the best at something in your country. So come on here, tell us what you're going to do, but you can basically do anything you want as long as you get pre-clearance for that and set it up in the petition. So there's a lot of flexibility. It doesn't have to be from your home country. You could be famous in a third country. You could be famous in the US. And what famous means is very, there's a lot of grace within that standard. So if you think that you even might have 3 of the 8 criteria for an O1, whether you're a researcher or a TikTok star or like an entrepreneur, at least get an assessment from an attorney. Will do that for you because it's a really great option. If you're not married or if your spouse doesn't need to work, it's a really, really great option because you have a ton of job flexibility in your field. It's basically like having a work permit to do whatever you love. So definitely would encourage people. And the other critical thing I just want to mention is you do not need to have an employer to petition you. You can also have an agent. And this is something we copied and pasted from Hollywood where movie stars have agents. Now we're doing that for Silicon Valley clients where software engineers have agents. So that's the method by which you don't have to have just one job. We can include an itinerary of your services. You can have projects come and go, consulting work, startups, all of that. So if you don't, you know, you could even get the O1 first through an agent, through a subset of jobs, and then go to I don't think big tech likes to hire people with O1 agents, but they could just transfer your O1 to them. Or a small company would be like, oh yeah, you can just work part-time for us. Great. We don't have to do your visa. Great. So it's a really wonderful option.
Yes. And like you were saying, I mean, especially if you're talking about famous people, it's not like a one-man band or anything. I'm sure they'll have managers, they'll have people who make them who they are, makeup artists or dress up artists. I don't know.
I had one guy at a big tech company that was like, do you think I qualify? I've written like 40 letters of recommendations for my direct reports and they all got extraordinary ability, but can I qualify? I'm like, yes, sir. very, very qualified. So there's lots of different
Yeah.
ways to qualify.
Right, right. And then there's also the P3, right, which is pretty similar, a little different.
Yeah.
That
Yeah.
also, so, but Ankit, I would just say it's always best to consult an attorney where you tell them your whole case, your whole situation, and they can guide you best where you fit. So,
Absolutely.
yeah. All right, let's move on now. We have another question. This is from Afreen. Is there a minimum salary for a job in H-1B status? What status would my spouse and children have when I am granted H-1B status? Also, I want to know in details how concurrent H-1B visa work.
Okay. There is a minimum salary for a job in H-1B. It depends on the job, your level of responsibility and experience, and the geographic area. It is the employer's responsibility, working with the immigration attorney, to calculate it's called the prevailing wage for your job. So there's a government website. You can do like a government wage search on the FLAG Department of Labor website to try to estimate it, but it's part of the legal process to figure it out. The spouse and children of an H-1B holder have H-4 dependent status, which does not automatically authorize spouses to work, but everybody can be here with you. Kids can go to school. They're considered your kids till they're 21. And then how does the concurrent H-1B visa work? Well, the two programs that I'm aware of right now, one of them, they both involve your employer's participation. So really you should have your employer reach out to my law firm to figure out how to support you. But two of the programs I've worked with, the more established one is called Open Avenues Foundation. They have the Build Fellowship. And the new one is called the Parachute Project, and they have different pricing models and different requirements. There may be more out there as well, but those are the two I've heard of.
Lovely. Thank you, Afreen, for your question, and Sophie as well for taking that up. All right, we have Ankit again. Another question. Can I sponsor an employee for an O1 visa if they are already in the US on a different visa status? Such
Absolutely.
as an F1 or J1. Yeah. Okay.
Yeah, that's just called a change of status. And then if they want to go for a stamping interview for the new O1 petition, they can schedule that. But that's very straightforward as long as they're maintaining valid F1 or J1 status. The exception is if somebody is subject to the 212E 2-year foreign residence requirement for their J1 because they got government funding or a Fulbright scholarship or something, they're supposed to go back home for 2 years after their J1. But even if they are subject to that 2-year requirement, they can still qualify for an O1. They're just not eligible for a change of status. They have to go back in consular process to activate it.
Thank you. Thank you for taking that. All right, this next one, this is Nirlep. He has two questions. We'll take this first one first. Can I sponsor an employee? Oh, this is the same one. Sorry. Are there any specific requirements or procedures for converting their status to an O1 visa? And how will it impact their stay in the US?
Yes, it is a specific process. So you have to meet the O1 requirements. You have to do the O1 change of status petition. If you have selected a change of status to O1, when their I-797 approval notice comes, it will have the start and end dates for the requested O1 status, which will take effect automatically when they're in the US on that date. So this becomes their new I-94, and they will have a new date by which to leave the United States.
Okay. Thank you. Thank you for your question, Nirlep. And thank you, Sophie, as well. Rag also says thank you. Thanks, Sophie and Napasa. So sweet. Thank
You're
you.
welcome.
Thank you. I think we have covered most of our questions, but just in case if I've missed anything, let me just have a look. Yeah, I think that is. Oh, we have this next one. This is from Esther. What can be like a hindrance for your H-1B petition filed? How long does it take to get a response from the USCIS currently?
What can be a hindrance? Well, you have to meet the requirements. So if the government wants to scrutinize the employer's ability to pay you, or if they are concerned that it's not a specialty occupation under the laws about if that job role qualifies, they might issue a request for evidence. If they're concerned whether you've been maintaining your status, they could ask you for more documents. So those are some of the common requests for evidence triggers. Now, how long does it take to get a response? It depends on if you have requested premium processing. If you did, then it's 15 days to get an answer. And if you didn't, it's usually many months. Let's check this out. I'm just looking at the USCIS case processing time website. So if you are being sponsored by an employer in California for an H-1B to be issued abroad, then, and if you don't choose premium processing, they're going to take 6 months to make a decision on the petition. So most of my clients proactively choose premium processing every single time because they can't wait around for this. But it's a range depending on where you are, where the company is, when you filed it, but it's usually many months. But you can always upgrade. If your employer didn't want to pay for premium processing, you can be like, hey, let me pay the $2,805 myself, and then you can get it done.
There you go, Esther. I think you have your options there, and all the best. It should work. Yes. And thank you so much. I mean, I think with this, we can wrap up our show for today because I think we've covered most of our questions from the audience, and it was a lovely presentation, making things so much clearer for us. You know, today we spoke about top visa options for employers for a quick hire, and of course, the different visas. Thank you so much, Sophie. And maybe before we go off, if you could just give an end note to all our audience out there, and yeah, that'd be great.
Absolutely. Thank you, Nipasa. Well, this was really fun, and I love everybody's questions. And thank you for those folks who have been following my work. I really appreciate it. That always feels great to hear that I've been able to help you and maybe make a little bit of a difference in your life. So that's super exciting. In summary, I just want to end on a positive note because I feel like people don't realize how much power and control they have over their immigration destiny. So like if you have a burning desire to move to the US, to live here, to get a green card, yeah, you can do it by, 90 Day Fiance, marrying somebody, falling in love, probably fall in love first and then marry them. You can do it by getting a job. Those are very unreliable. So I built my practice on people who are self-petitioning their own way. And that way, whether it's an O1, whether it's an EB2 national interest waiver, I-140 self-petition, followed by an upgrade to like an EB1A for extraordinary ability to fast track your green card. Like I've really built my practice on helping people take responsibility for their immigration into their own hands. And I just want to encourage everybody, like it is so wonderful when you have a kind employer who respects you and who wants to help you through this journey. That's like the best. But if you don't have that yet, you don't have to just like wait around wondering. You can actively build up your profile to qualify for many types of options. So I just want to give you that note of encouragement and hope that this is actually within your control, which surprises a lot of people. So, so thank you for that opportunity, Nipasa.
Thank you so much. Really, I mean, you're giving us a total different perspective, and absolutely nothing better than depending on your own self, who you can trust entirely. So why not?
Exactly.
Thank you. Thank you, Sophie. It was really wonderful to have you. You have a great day ahead, but I would really love you to join us once again. So I will look forward to that.
I would love that anytime. It's so fun chatting with you. Thank you for doing this. And thank you to your amazing team as
Thank
well.
you.
Okay. Bye-bye.
Thank you. Yay. Awesome. Bye-bye. Have a great day. And folks out there, thank you so much today. It was really lovely having all your questions as well. And thank you. Sophie, you were amazing once again. Let me tell you that. And folks, feel free to contact Sophie. Her number is 855-644-2581. And you can even email her hello@alcorn.law and visit her website, www.alcorn.law.com. Sorry, www.alcorn.law. That's her website. And thank you, friends. You can even contact me. And if you're looking for a project placement, H4, green cards, anything related to immigration or jobs, feel free to contact me as well. My number is 408-335-6444. And my email address is nipa@higherITpeople.com. And visit our website, www.higherITpeople.com, to get to know more about us. For now, this is it, but definitely stay tuned to our space. Our handle is Immigration and Jobs Talk Show. Don't forget to subscribe to us, like, share, and also look out for another webinar that I'm going to be joining you with, another guest, and that's going to happen at 2 p.m. EDT. So look out for that. Thank you so much for joining us now, and have a great day ahead. This is Nipasa Pradhan signing off from Immigration and Jobs Talk Show.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees, global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444. Good afternoon, everyone. Thank you so much for joining us. Welcome to Immigration and Jobs Talk Show. This is Nipasa Pradhan, and I'm going to be your host for today. And it's lovely being here. So, sorry, it's not just good afternoon. It may be good morning or good evening. So, thank you so much wherever you've joined us from whichever time zone. So, welcome to Immigration and Jobs Talk Show, and I'm really happy to be here. We are streaming live right now on YouTube, LinkedIn, Facebook, and X. And I'm really glad that you have joined us. And before we proceed with today's webinar, I have this very important disclaimer, and that is, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, yes, and you can also participate, by the way, in this session, friends, by commenting whatever questions you have, especially with regard to today's topic of discussion. And that is Trump's new team, a fresh start or a nightmare for immigrants. I'm sure all of you folks have many questions and are probably in a dilemma whether it's going to be good or it's just going to get worse for you. So today, here in this webinar, we are going to discuss this further. And joining me is someone who needs no introduction, who has been a part of Immigration and Jobs Talk Show, makes it a point to be here. So I'm very happy to welcome once again none other than employment-based immigration law attorney, but also a true advocate for the immigrant community, from defending H-1B RFEs and NOIDs to guiding students on F-1 OPT visas and offering expertise on TN and E3 visas. Justin has been a beacon of hope. So please help me welcome him back to the show. Hello to Justin Rivera from Wasden Immigration Litigation. Thank you so much for joining us.
Thank you for having me. That was a very nice introduction. I appreciate it.
It's been a while, I mean, I take it for granted sometimes, and maybe I don't say good things about you or let folks out there know. So maybe we have new friends. This is none other than Attorney Justin Rivera, today's special guest, and he's going to help us today on this topic. We're going to talk a lot on Trump's new team. So before we head start, Justin, what do you have to say to everyone out there?
Well, anybody that's here that's celebrating, an early happy Thanksgiving to you, because that'll be coming up this week. If you're here in the U.S. celebrating that, happy Thanksgiving. I hope you have a short work week. But yeah, in regards to today, we'll just try to delve into, I think, a lot of what many people are doing right now, which is trying to kind of wrap our heads around what a new administration is going to look like and the impact that it's going to have on immigration in the country. And you can do that kind of by looking at who's being put in influential positions within the administration, and what have those people said about immigration, and what that possibly means they'll be actually doing moving forward.
Absolutely, friends. Thank you so much, Justin. And so, yes, don't forget to participate. And before that, if you have friends who would be interested in getting to know this more about today's topic, Trump's new team and its effect on immigration, please feel free to share this link with everyone or your friends out there and ask them to join in this discussion. So, yes, thank you so much once again. And let's go ahead, Justin. I have this first question. This is regarding Pam Bondi, and she has a history of aligning with Trump's agenda, including her role in his impeachment defense and her work with America's first policy institute. So, how do you foresee her policies impacting immigration cases, especially regarding federal prosecution priorities?
So I think, obviously, it's a fortune teller argument here of what are you predicting or what can be done. But I definitely think that, there is an avenue to go after criminally, go after people that are, found to have committed visa fraud. Usually that's something that's applied to companies, organizations, usually the higher up individuals within the organization. And so, could they use that avenue moving forward more liberally than they have in the past? I definitely think it's an option. In regards to Pam Bondi, just kind of reading up on her and looking at kind of her record, I think she's probably going to be basically doing what Trump is asking her to look into. And from her perspective, I think the immediate things are probably not going to be immigration and that enforcement of, maybe fraud allegations against individuals. Now, that's not to say that couldn't happen, because honestly, it would be a pretty interesting tool for them to try to utilize if their goal was to actually start trying to crack down on the companies rather than the individuals, as a method of kind of limiting how some of the organizations that have been able to get away with using H-1Bs would be able to use them moving forward. So I definitely think it's something to look into and think about. I do know that, from my understanding of Pam Bondi, her relationship with Trump had something to do with I guess the fact that he gave a donation to her of like $25,000 or something like that to her reelection campaign, and not as a direct result, allegedly, but maybe the fraud investigation into Trump University in Florida was no longer something that was being discussed or put on the docket. So that's on the Washington Post. You can see the inference formed there. But what that really kind of tells me is it's like you're going to see with a lot of these appointments, it looks like it's more of a loyalty issue rather than a skills issue. It's, is this person willing to carry out what it is that he wants to put forth with his administration? And so, yeah, I would say, would it shock me if there were more cases brought against people for visa fraud, especially the employers? The people who are actually signing the H-1B forms? No, it wouldn't shock me at all. And honestly, if I were them, it would probably be something I would utilize.
All right. Thank you so much, Justin, for giving us a sneak peek into your thoughts about Pam Bondi, and thank you so much. You can also go check out the post on Washington Post, and the news is out there already. So thank you. On that note, Justin, we also have Amay on YouTube asking a question. Amay, please stay with us. We will take up your question in a bit. Hang on. For now, I have another question, and this is about Matt Gaetz. Although he withdrew his nomination, the controversy surrounding his potential appointment raised concerns. So, does the consideration of such a figure indicate a shift in how the administration might handle immigration related ethical and legal matters?
So yeah, I mean, I don't know really if we're going to be able to frame it specifically through the prism of immigration, but I think what we saw with Gates's attempted appointment was the fact that there are still guardrails in place, regardless of how tenuous those guardrails are. There's still going to be some level of qualification required for these people being put into these positions. And the fact of the matter was that Matt Gaetz, he wasn't really qualified for the position that he was going to be put into. That being said, as well, would he have gotten the position were it not for his ethical issues? It's very possible. But what it really kind of does show me is that there is still going to be pushback on appointments, which is a positive thing. That people still should be held to a high standard. But in terms of immigration and kind of how I think it's kind of interesting, you could maybe draw this small parallel from it, but the fact that Trump was even willing to try and appoint Gaetz in the first place, it's not that surprising, and it's a bit indicative of his strategies. A lot of times they just kind of throw stuff at the wall and see what sticks. So if I'm looking at it from that way, I wouldn't be that surprised if you see a lot of quick changes to immigration that come in, and a good amount of them end up being invalidated by the courts. Just because they don't hold legal muster. So that wouldn't shock me. I definitely think that they are more willing to act and then just kind of see whether or not the court will let them act, rather than make a prepared, concise, well-researched change that's going to stick. So that would be my thought process, would be don't be surprised if you're seeing, within that first month of the administration handover, changes, fairly drastic changes in proposals that may or may not actually hold up in a court, but are still going to cause hiccups in the immigration system.
All right. It's scary how the situation is for many immigrants out there, I think. And with all these new picks, I think the situation is getting even more tensed. What do you say, Justin?
Uh-oh.
Can you hear me?
Yeah, sorry. The quick little hiccup right there.
No worries.
I'm here.
Yeah, I was just saying, like, with these new picks, it's just getting scary. So, what do you think?
Actually, someone just commenting about, I think it's Dr. Oz was allegedly being given an appointment. No, I know, Sakshi. I know. It's not ideal for me. I think for a lot of people who are looking at the individuals that are being named to these positions, there is a little bit of a wow factor to it, because I think in the first administration, I think Trump was a little more reeled in just by the nature of the fact that, like, it was fairly surprising for most people that he won. And I think there was a little bit of period where the Republican Party was kind of like, we're going to put we're going to put guardrails up. We're going to have people appointed, Rex Tillerson. There's going to be people put in positions that are experienced and qualified and know what they're doing. What we did learn, though, from that administration was there was a pretty high level of turnover, and that turnover basically correlates to, if you're not doing what he wants, you're going to lose your job. We saw it with Jeff Sessions. And then he even ended up having problems with Barr, which was, another person he had appointed himself for the AG spot. So the other thing to think about too with this is kind of a shelf life. How long are these people actually going to hang in these positions and actually stay and deal with kind of the turmoil that this administration is inevitably going to bring? So that'll be something I think we're going to have to consider as well.
Right. Right, Justin. Thank you so much that also was a very good insight, I would say. And we have Malutek USA and even Sakshi joining us with their questions. And I think that we can take Malutek's question for now, if you don't mind.
Yeah,
So it's
sure.
asking Canada, Australia, and UK reducing temporary issues and student visas. Why Republicans act more left than Canadian Trudeau? 10,000 of American tech workers are unemployed, desperately need job. Okay. What do you have to say?
Okay. I think so. I've been kind of monitoring the Canada situation pretty closely because I found it very interesting. So during the initial Trump administration, Trudeau, who is still in a position of authority, Trudeau was very open to immigration. He was basically saying, like, oh, if you're not wanted in the United States, come to Canada. We want you here. We're more than willing to take people on. They looked into expanding their immigration regulations to bring in a higher influx of people. That may have come back to bite them. About probably around last year, the middle of last year was where I started seeing it. That's not to say it's not something that's been existing before, but I did start seeing a lot of attention on it in the middle of last year, and it's at the forefront this year. Trudeau's already made statements that he's reversing course. They are taking steps to curtail and limit immigration moving forward. He has made the spigot argument, which he's claiming that the spigot, the water spigot, has been turned too far one way and needs to be turned back the other way. That's his stance. I've been playing through my 34 years. What's up?
Sorry.
Oh, it's okay. But anyway, that's he's a politician. He's dealing with the vibe of what's going on in his country presently. But as a result, yes, I think you're seeing Canada move towards more restrictive immigration policies. Australia, I think I've also seen is possibly trying to reduce immigration. I'm not as well up on the UK. Why Republicans would act more left than Canadian Trudeau. If you're saying why would the Republican Party embrace immigration, legal immigration in the United States? Because legal immigration in the United States is beneficial to the United States economy. It's been well established. So there wouldn't be really any valid justification. I think that the whole point of these programs like the H-1B program are to create the necessary guardrails that prevent U.S. workers from being kind of left out in the cold by, allowing there to be people who are going to be able to do the same job for less money. That's why you have the labor condition application that establishes the wage levels. These things are stringently enforced, both when someone applies for the H-1B and through FDNS's site visit systems when they actually go out and make sure that the person's complying with the conditions of the H-1B. So that all being said, it would not shock me if the Republican Party acts differently than the Biden administration. I know people are very quick to jump the gun and say, well, what has Biden actually done for legal immigration? Like, how is it that different than it was under Trump? I will tell you firsthand, as someone who practiced under the Trump administration, it was significantly different. You were dealing with an entity in USCIS that was borderline adversarial. It wasn't more so our job is to process these applications. It was we're looking through these applications almost with an assumption that there's something deniable in what's being presented to us. And I think that's what you're going to see as the biggest difference. And it will show you that the Republicans are not more left than any of those other countries. They are going to seek to draw out the time it takes for an application to be processed. They're going to do that using requests for evidence that I'm sure will become more detailed and require more information than is currently necessary. They're going to do that by attempting to limit validity periods any way they can, meaning, they're going to probably go back to trying to find ways to cut down people's requests for 3 years. Whether or not that will hold up in court, we will have to wait and see. But I'm sure that they'll be taking from the pages that they've used previously in order to grind the system as slowly as they possibly can. On top of that, yes, it's completely possible that they're going to be introducing new ideas and new ways to try and make the system even more difficult than it is presently, with the underlying goal being that they want employers to just not have to deal with the program, and if they do things like increasing the wages, making it to where you have to pay even more to have someone employed on an H-1B. That's one avenue that they may look at. They may look at curtailing the definition of specialty occupation, making it more stringent to where it's more difficult to qualify for the position. They might make it harder for the employees to qualify with their degrees, unless their degrees are absolutely one-to-one correlated to the job duties being performed. So these are all things that they're going to do. And if they didn't do them, it would surprise me. But these are all things that I definitely think they want to do. And with Stephen Miller, who I'm not sure if we're planning to talk about today or not, but with Stephen Miller in probably a more influential position in this administration than he had been previously, all of these things are going to be on the table. And it's not really, to me, a matter of if, but when, and whether or not they've now also decided to find new things that they're going to be putting forth. I believe I saw last week, towards the end of the week, something about the dismissal of a case that had been backed by a Miller group where they were going after, once again, the H-4 EAD. So it was another attempt for them to go after some part of immigration to curtail it, to make it more difficult for people that are here on that H-1B visa if their spouse can't work. That didn't hold up in court. But you got to remember, they were challenging something. They're moving into a situation where they're going to be taking part in the rulemaking process. And that's going to change how they're approaching it and what they're trying to do. So all of that is to say, for Malutech, I don't think that the Republicans are going to be acting more left than the Canadians. I don't think that that's going to be the case at all. I think you're definitely going to see them crack down on legal immigration. It's not going to be the forefront of what gets people's attention, especially initially. Where everyone's eyes are going to be drawn is where the election seemingly was decided on in a large part, and that's the border. And the actions that are taking place at the border to curtail entry. And I think that's going to be what gets the headlines. But at the same time, it wouldn't shock me if they're able to walk and chew gum at the same time and also move forward with making those changes to legal immigration.
Right. Thank you so much for taking that up for Malu Tech USA, and thank you, Malu, for participating with your question.
I think it's a good question. I think it's also indicative of, in a lot of places, you're seeing a protectionist shift. I think you're seeing people in countries that are moving more so towards not maybe being outright anti-immigration, but being more selective in their immigration process. I think to say that is something that's moving forward in Western countries, I think to say that it would be realistic.
Right. But yeah, coming back to Stephen Miller, talk about his first family separation, including travel ban and all that. So what do you foresee? This could also influence this term as well. So how's it going to be, you think, for immigrants?
So I think, I apologize. I think we have a question on him. I don't remember the name of the border czar that has been appointed. But I remember, I've heard about him. Tom Homan. Thank you.
Tom Homan, yes.
So Homan has really talked about his ability to enforce actions at the border, right? And it's when you really think about it from an immigration perspective, when you're reviewed for admission to the United States, that's a pretty big part of a process, because at that time you're being, assessed by an officer who makes a determination as to whether or not you are admissible to the United States, right? So for most people that are legal immigrants, this is a very quick part of a process. If you've been in before, you come in, you know what you're doing, you go through CBP, it's no problem, right? It wouldn't surprise me if the enforcement activities being promulgated at the border begin to bleed out into other facets of entry. And so what I mean by that is this: I've already actually seen it. I was reading about it before our discussion today. Homan has already come out and made a point about illegal immigration at the Canadian border. Basically saying, there's problems at the southern border, but what about the northern border? we have issues there too. We need to be, we need to be more stringent in how we're reviewing people there as well. And so I think for a lot of people that are, that travel between Canada and the US, maybe people that are on intermittent L visas, TN visas, things of that nature, I think you're going to see a heightened level of scrutiny. I think it's going to be created initially under the guise of trying to curtail illegal immigration, but it's going to bleed into the other facets of immigration as well. And I think that that's going to be, it's going to create a difficulty where one previously hadn't existed. So I would say it's pretty imperative for people moving forward when you're getting ready to really consider traveling and how you're going to re-enter, where you're going to re-enter, what documents you're presenting when you re-enter, and being prepared for detailed questions being asked in relation to not only that, but any of your previous immigration history in the United States as well. Because, I mean, we've already seen things that are popping up under the Biden administration that have been popping up for a while now, but issues with, people who have been on their H's for years that are now being questioned about F1 employment with, companies that have been blacklisted, basically, that USCIS has now come out and basically said, if you worked with this company, if you worked with this company, then you're basically de facto fraud. Like, you've committed fraud based on the connection to the company. So I think that is something that's going to need to be very well thought out by people when they're immigrating or coming into the US, looking at what is it that you could be asked about in your immigration history or about your current job or any of those things that could lead to additional questioning or additional scrutiny. Because all of that, I think, is going to be on the table. Because if you're not readily prepared, you put yourself in a bad situation. You put yourself in a situation where you're going to be questioned by an officer. You may not remember some of the facts. You may misspeak one time. That's really all it takes. Is one misstatement or one slip up, and it's enough to put you in a circumstance where you could be an expedited removal and end up having your visa canceled. So I don't say all of this through the desire to fearmonger. It's not my intent to make people scared to travel. I've also seen, people online already are starting to get upset. They're saying, "Oh, my attorney's telling me if I have any travel, it needs to be done before January." Mid-January, because they don't want people stuck by any changes that are made. This is ludicrous. I've never done anything wrong. You have to understand that as an immigration attorney, our job is to advise. And usually when we're advising, we're trying to take the most conservative approach or strategy possible, because what we want to do is minimize risk. That's our goal. We minimize the risk that an individual has either when they apply for something or they go to a visa interview or they re-enter the US. That's the goal. Not to make you scared, just to make you informed. And I'll put it this way. If we didn't say these things and then in the middle of January you travel and something happens and you're stuck out of the US, who are you going to blame? You're going to blame us for claiming that we didn't tell you not to travel. And so that's why that's happening right now. It's really not because we want to make people fearful. It's more of we don't know exactly what's going to happen. And the best idea when that's the circumstance is to just minimize the risk as much as possible. But yeah, to just kind of button that question about Homan's leadership, the border policies, I think you're just going to see a lot more difficult issues with entry that you probably weren't dealing with in the past couple of years. I just think it's going to be a lot more scrutiny. They may bring back some of the issues that had existed beforehand, which were things like, did you do a second master's degree and do day one CPT? Did you go to some of these universities that are looked at as maybe less than compliant with F1 requirements, just things like that. And then there, obviously employer issues and stuff like that. So I just think all of that's going to be on the table.
Yes, absolutely. And talk about the borders are. We can expect a lot of difficulties for sure, as we've already spoken about. Maybe RFEs getting more and more. Maybe they would want more evidence than already required. So stuff like that is what we have been discussing. And I think there's more to discuss on this. There's so many new picks, and Well, I would just like to say thank you to Pavan also for joining us with your questions. Just stay with us. We will take up your questions. All right. And yeah, Justin, getting back to our questions, earlier I had asked about Stephen Miller also, because we have seen a lot of family separations and also, travel ban as well. So I think this is going to be a little more tough on immigration, immigrants now, right?
Yeah, and I mean, obviously, I think if you're sitting on this call and you're somebody that's on, a non-immigrant visa, you're sitting there thinking, well, what is the applicability of that to me? I'm not entering the country illegally. I'm not doing anything wrong. I'm not doing anything illegal. Okay, so that's fair. It's a fair assertion. But aside from the fact that there's a whole human rights issue regarding the family separation issues. I think it was Tom Herman is his name. I think Tom Herman, when he was asked about family separation, he said something along the lines of like, "Well, no, we're not going to separate them. We'll make sure they're deported together." That was the solve to the Homan thanks. I'm gonna see what's gonna suck is that I'm not gonna remember his name, and then he's gonna be the bane of my existence for the next 4 years, and so he's gonna make sure I remember it. But yeah, so I get that, okay, well, maybe it's not applicable to me, but I'll have you look at it from this perspective. From this perspective. I remember during the last Trump administration, something that they had tried to do at the outset was deny people's extensions and then say you're now unlawfully present, which means you can be deported, basically. Yeah. And then there kind of became a quick run where we were kind of running around like, are they issuing notices to appear for these people? Are they going to be coming after them to put them in deportation proceedings? Because people need to understand this. If your status, let's say your H-1B extension gets denied and you're no longer lawfully present in the U.S., you can depart. You have an opportunity where you can leave the U.S. You have a timeline where you're able to leave. And, outside of having to admit that you had a prior denial and maybe explain the denial, there's not going to be that wide reaching of a problem that comes back to bite you on that. If you were to get placed in deportation proceedings, that completely changes the game. That's a situation where if you leave without appearing in court, there's implications, and then there's implications of how long do you have to stay while everything is waiting? How do you sort things out? Can you apply again to get yourself back in status? So I do understand people being like, I don't know how that's going to affect me. It can affect you because the policies, like I've kind of been reiterating on this call, that are initially utilized for people that are illegally immigrating, they can bleed out and subsequently be used in the future against people who have come into the country legally and then lose their status because, they've had a denial or something like that. So while I'm very hopeful that doesn't happen because it would just really complicate our jobs even more, it's not to say that they can't utilize that. And so just thinking backwards from that, I just think that, if it does happen, it's horrible, but I hope it doesn't. But I think people should be aware that it's something that I know they have on their table. It's in their arsenal of things that they might want to do.
I mean, imagine being like the second or the third generation in the country and suddenly like you and your family are having doubts if you can still be in the country or not. So
yeah, I mean, all that stuff's frustrating. I mean, I would not be shocked for a second. During the last administration, they really cracked down on the F1 program. They did. They went a lot harder at STEM OPT than they had ever done before. It wouldn't surprise me at all if they went after that again. I think that it's something that because you got to think about it this way. If they want to curtail immigration, what's one of the easiest ways they can do that? They stop people from coming in and doing F1s and working in the U.S. on OPT and STEM OPT. If you cut that out of the process, then those people have to leave the country. And yes, they may still go into the lottery, but it's probably going to be harder for them to get sponsored because they're no longer working in the U.S. They're working overseas in their home countries. So yeah, I think that's definitely on the table. It wouldn't shock me at all if they tried to come out with basically new enforcement mechanisms for the F1 program.
All right, let's just hope for the best and look forward. All right. Well, now, Justin, let's take up Rag's question. He's here on YouTube. He's saying, hi, Napasa and Justin. With the flurry of cases coming in, will the attorneys' efficiency be compromised, resulting in more RFE or rejections?
So I don't know if it'd be the attorney's efficiency that creates the issue with RFEs. The issue with RFEs are you prepare a petition as best you can. You try to cut off all lines of inquiry where they reasonably exist. But if you're dealing with a circumstance where the goalposts are being moved constantly and in real time, it's going to create problems. And that's what creates the increase in RFEs. Things like changing how you look at specialty occupation or how you make that definition. Things like how you look at how someone qualifies for a position, trying to reintroduce things like, project documents or proof of specialty occupation work. Those are all the things that are, in my opinion, are going to lead to an increase in requests for evidence. That's really the big issue with it. I think that the goal is not only to just increase the probability of denials, it's to increase the time that it takes to go through the process. It's to draw this out and make it more difficult so that it becomes a circumstance where employers just don't want to deal with it. I think that's really the underlying goal. And that comes from mucking up the system by making things harder when they shouldn't be. When it comes to, rejections, rejections are circumstances where when you're filing a case, there's something missing in the case or deficient, or it's sent to the wrong location. Those are things that typically an attorney should be able to deal with, regardless of what administration is in a position of authority. Where that could become problematic, just speculating here, because we've already seen it with Biden in some regards, is just changing things. Making quick changes to forms and saying, actually, you know what? You got to use this form edition. And we're not going to backdate it, so you got to start using it as of December 1st. And the form came out on November 26th. Well, if you're a normal, business immigration attorney, you've probably got X amount of cases pipelined that have already gone through that process, went to the client for signature, and they're in line to be filed. If you don't catch those before they go out, those will be rejected. So that's definitely something that could happen. Just making constant, updates and alterations to the forms. But at the same time, if that's going to be something that they do, then it's going to become incumbent on the attorneys to make sure that they're doing their due diligence at the time of filing, to make sure that everything that goes out is correct and proper. Because that's really the only way you're going to combat it. The other thing they can do too is they can move around the mailing locations, which is annoying, but we do try to stay on top of that as much as possible. That's a lot. AILA deserves credit for that. AILA does a lot with making sure that any of those changes that happen are kind of blasted out to the attorney so that we're aware of it. But those are avenues that they could take to increase rejections.
Yes, I mean, changes and updates, these are very, very important things, and it's very important to stay updated. So folks out there, just keep on researching and keep looking out for new changes. Because I mean, I remember we had a lot of fee changes and, like you said, address changes, Dropbox location change and stuff like that.
Right.
And this led to a lot of, cases becoming invalid because of the wrong fee and etc.
Right. And so that's another one too, that obviously, like when you talk about mechanisms to make the process more difficult, fees are such an easy one. Fee increases are always a great way to hit the bottom line of the sponsoring petitioner. So if they're able to kind of combine increasing fees with shortening validity periods, that's a win-win for them, because it puts them in a circumstance where they're really making it harder for the employer. But yeah, that would be my answer to that, Raj. Thank you for your question. I appreciate it.
Yes, thank you so much, Rag, for participating. And if you have any more questions, we're still here. So, Justin, my next question, this is about Pete Hexet's political appointment as Defense Secretary. This brings attention to his hardline stance on national security. So do you think this could lead to increased militarization of immigration enforcement, and what might that mean for immigrants at the border?
So I will say this is actually something I've really been thinking about. Maybe not necessarily for the border, but it's something that has been crossing my mind, and that is, what is the impact on legal immigration of increased conflict abroad, whether that be in Europe or in the Middle East? Do we see Do we see some sort of proclamations coming out as a result of those conflicts, limiting immigration for people from those countries, or limiting immigration overall? I say that as someone who, we had a discussion before this call, for something I had just been dealing with, where it looks as if that there are people from a certain country that's engaged in a conflict right now that are basically just being denied U.S. visas under a very interesting strategy, where they're being told that they cannot overcome a presumption of immigrant intent. And by doing this, it's kind of almost become this blanket justification for a denial, where they're just saying 214B, no presumption of, you have not overcome presumption of immigrant intent. Therefore, you are not able to qualify for, let's say a B visa to the United States. My wonder is that a strategy that could potentially become weaponized moving forward as the conflicts in the Middle East increase? Hopefully they don't increase, obviously, but it's pretty hard to watch the news every day and see what's going on, and think that the next 4 years are going to be really chill, and not involve more foreign conflict. But does that conflict create an even higher inclination, desire in the United States for this protectionist nature, where you're basically saying, like, we're severing ties, we're keeping Americans in their bubble, and we'll let people in from a couple different countries, but other than that, we're just staying with what we're doing? Maybe, I don't know. We'll have to wait and see. But that's something I've now been worried about. I'm starting to think about, right, what is the impact specifically of what country you come from and your immigration, not even how you qualify for something, or is it a valid petition? That, I think, is going to be on the table as well.
Right. And I mean, we've seen a lot of cases and a lot of announcements about becoming anti-Muslim and not allowing, countries with major religion as Muslim, not to allow them to come in to the country. Right. So, and plus, like what you were saying about the case, imagine, you being denied a visa in spite of doing everything right, having all the documents.
Yeah, I'll just come out and say it. It's pretty much being talked about already. I'm talking about people from Russia, just specifically. Yes. There's been a big increase in 214B visa refusals, specifically for people from Russia. It's a blanket denial, basically, that's being issued. And I'm kind of wondering, how is this strategy employed moving forward with other countries in the event that those people from those countries, their countries embroiled in a conflict? So we'll have to see. But like you said, the so-called Muslim ban is another issue that's something that's probably going to get attention coming in day one. So we'll have to see the impact of that as well.
Right, Justin. Thank you so much for taking that up. I think we should get back to Malu, because he has another question for us on YouTube, asking, wage levels won't get enforced for H-1B. I know H-1B visa employees working for $70,000 per year, whereas citizens working for client for same position has double the salary.
Yeah, so if you're asking about wage levels being enforced, the wage levels should be enforced, because you have to pay a specific wage level based on where somebody's working and residing. Where they sit is what's going to dictate the amount of money that they're paid for the position, based on what kind of position that is in the labor condition application. There's really two ways that USCIS and DOL can attack and attempt to undercut wage levels. The first of which is, when you apply for a position, you have to determine what the wage level is at the outset of the filing. There's 4 wage levels. Wage level 1 is entry level, experienced, quasi-managerial, high level, four across the board. USCIS has the ability to question whether or not the position qualifies for the wage level provided. They've done that pretty stringently when it comes to what's called level 1 wages. So that's the lowest wage level. Basically, that level 1 wage level is only applicable at this point to absolute entry level positions. People just out of college with degrees that are maybe just now starting to work in their specific industry. They maybe have internship experience or something like that. But as a result of that, you can't use level 1 to go in and undercut a position that doesn't meet that standard. So that's the first way in which you're really not able to game the system as much as it could have been gamed in the past. The second issue is, if the company is actually paying someone under what's in the labor condition application, that's a DOL violation, and that can be reported. So not only would I tell you, Malu, if you see this going on, not only would I say feel free to report it to the Department of Labor, tell those people that are employees, if they're being paid under the amount of money that's in the LCA, to report this to the Department of Labor, because this is a violation. And those companies should be held accountable for what they're doing, because what they're doing is illegal. So that's kind of my opinion of how you fix a system that even has like some small issues in it, rather than just kind of make this blanket proclamation that like the H-1B system is bad. Understand that there are ways that you can work within the confines of the system. I will tell you this, I file H-1Bs all the time. It's been very rare for me to see anybody getting paid $70K a year. I think that is a tough beat at this point to find people that are going to be getting paid around $70K. Even when you're paying on the lower end of wage levels, I think that obviously location matters. If you're in California, you're getting a very high salary. If you're in Iowa, the wage levels might be a little bit lower. So it does depend on where you're located. But that being said, yeah, I think I've done 4 or 5, maybe 6 LCAs last week. And I can't remember one of those LCAs being for $70K. I think probably the aggregate among those was close to $115 to $120. And some of those were even higher. So yeah, I mean, look, is there a notion that the H-1B is utilized as a way to undercut wages in the US? I think that, yes, that's an assertion that's been made. Can you do that now in the current 2024 iteration of the H-1B? I don't think so. I think it would be very, very difficult to do. And I'll do you one more, Malu. I will definitely tell you this. On top of that being reported to the DOL if someone's violating and paying under that wage level, I definitely think you're going to see a big increase in FD&S visits. I think you're going to see people coming in now. I think you're going to see more officers getting paid to do site visits all across the U.S. to go to client locations or employer locations or even home locations if they're on the LCA. And they're going to be asking those kinds of questions. Things like, what are you being paid? Seeing if that complies. All of that stuff, if it's a violation and the company is violating the conditions of the LCA, they need to be held accountable. They absolutely need to be held accountable, because that should not be the underlying purpose of why someone is utilizing an H-1B.
Right. Right. Thank you so much for taking that up. And I'm sure Malu is very happy with your answer, very detailed. And thank you, Justin, for taking that up. See, he has something to say already. Many of us have been replaced by H-1B visa employees. So H-1B wage level need to increase to 120,000 to minimum.
Okay. Well, I mean, that's
what
so. You're asking. You're asking me, you're saying, do H-1Bs undercut the wage level of U.S. employers, of U.S. employees? I've come back and said no. And now you're saying, well, the wage level has now gone up to 120K minimum. Well, that means that the wages are higher. So I'm sorry, I don't really know how else to answer your question. The underlying purpose was to prevent wage abuse, right? By hiring people that are paid less money to do the same job. So if that's no longer the case, then it seems that the program is being implemented in the way that the people wanted it implemented in.
They say they need to increase it to 120K minimum. So, okay, I think that's what he... But yeah, thank you so much, Justin. And I hope that, Malu, you have your answer to your question. But anyway, Justin, I have my next question. And I think without discussing about Elon Musk, this wouldn't be complete. So with Elon Musk advising on government efficiency, do you think his involvement would lead to changes in how immigration processes are streamlined? Or do you think his focus will be on wasteful spending, which will result in reduced resources for immigration service?
So I would definitely say this, USCIS is fee-based, meaning that the money that they get is generated by fees that come into them. So in that regard, I don't think you'd see much of a change, because they're just going to basically do the same, pardon my language, but they're going to do the same crap they always do. If they're going to say, we don't have enough money, and then, we need to raise fees because we need more money. And then processing will stay almost exactly the same, and we'll wonder where the money's going. But In that regard, I don't foresee it being that big of an issue. Musk, I'll be honest with you, he confuses me to a little bit because I don't really know what his long-term goal is. For example, my understanding was that the Trump administration wants to get rid of electric vehicle incentives, which would seemingly be directly harmful to his own organization. And then I've also seen that, one of the agencies that they want to cut funding from is NASA, which I think, again, would negatively impact his SpaceX program. So I don't know if his goal is to somehow put himself in a circumstance where his companies benefit from these changes, but then other people don't. I'm really not sure. Yeah, maybe he does want to be president. Who knows? Well, I don't know if he can't be president. I don't think he was born here.
Yes, I don't think.
So I don't know, maybe, but I definitely think that he's enjoying the amount of sway that he has presently.
Attention, yes.
Because he's in every picture, basically seated at the right hand of Trump. So yeah, I think he's enjoying that. I think him and Vivek, what they're actually able to do and what they say they're going to do are probably going to be two different monsters. Because this really kind of gets back to the whole appointment issues with Trump. It's almost never a matter of just if that person's going to quit, it's a win, eventually it's a situation where the person gets worn down and just leaves. So we'll see what he's actually able to do versus what the impact of it'll be. When it comes to immigration, I've never really heard Musk come out and have any sort of anti-immigrant sentiment. I can definitely tell you through the grapevine that Tesla utilizes a lot of employees that are on NIV visas.
Yes.
So I definitely think that he's, someone that benefits from the H-1B program. So it'd be odd to see him kind of, bite off his nose to spite his face or whatever the term is. But yeah, we'll have to kind of wait and see. I would be surprised if it has long-ranging impact on immigration. The things that could have an impact on immigration for him from a business immigration perspective are what are the implications of these kind of cuts to government contracts, and government projects? Because I will say that I've worked with companies that, there may be a consulting company who the third party is actually a state agency, and what is the impact of that funding that's coming from the federal level to the state level for that project? And does it mean that they cut employees or whole cloth, get rid of that whole project in the first place? That's something that I think could be a problem. But it's going to have to just be kind of wait and see. I know that they introduced a couple of policies that they want to talk about, but it's all broad strokes. There's no actual how-to of it. And until that really comes forth, we're not going to have the full scope of the picture. But yeah, hopefully out of everybody, Elon's at least the only person in Trump's ear saying, hey, immigration's a good thing.
Yes. Thank you so much, Justin, for that view. Well, I have a few questions on, our Facebook groups and also our YouTube channel. So let me see.
Yeah, I could try to do one or two, but I am cutting time pretty closely, to be honest.
Sure. So let's go with quickly. These are just comments. Maybe you can just tell us your views on these. So this was on our channel saying, so conservative Republicans support people immigrating legally, but the border has been invaded by unwanted and the poor. We cannot financially support people who never put into our tax system, but want the financial benefit as a worker recipient. Yeah.
I think there's a pretty easy way to just say what this person's saying. Trump wants to block illegal immigration from coming in. People validly understand that undocumented immigration is a problem in the United States. The system does not operate efficiently, and it doesn't operate the way that it's supposed to. I personally will even go one step further and say when people that are immigrating to the United States come in and they're working on work visas, I think that it's a little bit ridiculous that part of the employer's job now is to throw an extra $600 into their petition, specifically to deal with issues at the border. The so-called asylum fee that has been added into these employment-based applications, I think is unfair. I don't think that it's necessarily appropriate for legal immigration, for people who are sponsoring people here in valid non-immigrant statuses, to have to take on the additional burden of dealing with problems that are occurring at the border. I understand that frustration. I also think that it must be incredibly frustrating for someone who has been in this country legally for 10 or 15 years that is still sitting here waiting for an opportunity to apply for a green card, be told that, you know, the big issues in this country aren't you. The big issues in this country are people coming in from the southern border and, you know, claiming asylum. And that's really where everyone's attention is going to lie. So I understand that anger. I get it. What I don't understand is this disconnect that seems to exist for some people that are here legally, that have immigrated here legally, this disconnect that Trump only has issues with illegal immigrants and Trump's only going to be creating enforcement activities that only goes after people that are in the country illegally. Donald Trump may believe that in his heart and soul. Stephen Miller doesn't. And Stephen Miller is the person that's going to be architecting the policies that are going to dictate the next 4 years. Yes. That's where the disconnect I see gets frustrating for me, because I really don't want to hear people complaining when we're a year and a half into this process and legal immigration has gotten more difficult. I don't want to hear the complaints about, oh, well, you know, I didn't think this was going to happen. We were telling you it was going to happen beforehand.
Yes.
So I don't want this head in the sand crap that is inevitably going to spew up as a result of that. So yes, to this person's point, I get it. The southern border is a mess. It needs to be addressed. Honestly, it looks like it was pretty high on the list of reasons why Trump won. And that's something that he's going to be tasked with fixing over the next 4 years. We'll see how he does. I hope he does well. I hope that we're able to create avenues that create positive results where we're able to curtail this problem and make it better. I also hope at the same time he does things that benefit legal immigration. But we will see. Is it likely? No. So yeah, that's kind of all I have to say in relation to that comment.
Thank you so much, Justin. That was really valuable. And this next one is, I hope Trump bans sanctuary cities and ban illegal immigrants from getting any benefits from America.
Okay, we're kind of we're spinning on the same wheel that we were on previously.
I hope so also.
You know, and look, I get it. Like, there's definitely going to be a lot of showdowns that happen over the next 4 years with illegal immigration. There's going to be issues related to state government versus federal government. You know, the enforcement of immigration by local officers, I've already seen as an issue that people are bringing up. The idea of sanctuary cities being challenged or being brought up as well. All of this, in my opinion, really comes back to this notion that of people who came here the right way are frustrated that people who didn't come here the right way are getting benefits. And they're getting, you know, it's a feeling of animus that I'm trying to do things correctly. I see people not doing things correctly, but those people not doing things correctly seem to be getting more attention and a better break in terms of benefits than what I'm receiving. Okay. I hear that frustration. I understand it. All I can say is what I do professionally, you know, and what I've done professionally over the past couple of years, dealing with this exact administration and what we're going to deal with its new iteration. You're not going to just escape the impact of immigration policy changes merely by virtue of entering the country legally. It's not going to mean, you know, do I think that Trump's going to hunt down everyone that's on an H-1B and deport them? No, of course not. That's not going to happen. But we are going to see a tougher 4 years play out than we have seen under the Biden administration. And that's just a fact. It's going to be what we deal with. And that's regardless of what they do with illegal immigration.
So
if you are happy that these changes are being made in relation to illegal immigration, okay, that's great. But do understand, if you are an immigrant and you are in the United States right now, or you want to immigrate to the United States, the world that you're going to be looking at by the middle of next year is going to be very different from the world as it is what we're speaking about presently.
Mm-hmm. Right. I think, thank you so much, Justin, for that. Last but not the least, if you would just like to take up this last comment from Rag, Will legal immigration get a day one surprise, or could there be a bit leeway?
I genuinely don't know. I mean, I don't think it really makes sense for them to come out and make drastic policy changes in relation to legal immigration on day one. I think they're going to want to serve the master, which is the masses in their desire to make changes at the border. So I really think that's going to be what policy A is for them, is going after making whatever changes they think are necessary. I think they're definitely going to reinstitute the Remain in Mexico program. I have heard that they are trying to institute a similar program in Canada. So that'll be interesting because I didn't know that there was a lot of people trying to come in through Canada to claim asylum. Usually you hear about it coming from Mexico. So I know that those are going to be things that they're probably putting in at the outset. I definitely think that, the family separation thing is going to be big. And then how they handle different policies with removals and stuff like that. That's all going to be big. That's going to be, like I said earlier in our call, that's going to be what gets the eyeballs. What's not going to get the eyeballs outside of the immediate community that handles immigration on a day-to-day basis are going to be the policy changes that they implement throughout the duration of the 4 years that they're in. Because I think obviously don't agree with the things Stephen Miller does, but have to give some level of credit where credit's due. He's had 4 years to sit on the things he did last time, and he's had an opportunity to probably make changes and corrections to things that he was not able to get done before. So you're going to see, you're going to see somebody that's coming in with plans and ideas that he's going to want to implement. But yeah, maybe day one, will there be 150 RFEs issued the day Trump takes office? No, I don't think so. I think you're probably looking at more of a slow burn.
All right. Thank you. And Rag already says, thanks to Pasa and Justin. Great updates. Thank you, Rag, for participating.
Thank you for your time. I'll try to come on next time we get together with just something more positive.
Sure.
But
Justin, it's really, but it's seriously always a pleasure to have you here. Thank you so much. Today was great. I mean, it was a great and interesting discussion about all these picks that Trump has made in his new team. So thank you so much for doing this today.
Absolutely. Thank you very much for having me. You guys have a great week. Have a great Thanksgiving. And I'm sure I'll talk to you soon.
Yes, me too. And here's wishing you and your lovely family a very happy Thanksgiving as well. Happy holidays.
Happy holidays. Bye.
Bye-bye. So folks out there, thank you so much today for joining us in this very important discussion. And it was great having you. Please don't forget to like, share, and subscribe to Immigration and Jobs Talk Show. We are on YouTube, LinkedIn, Facebook, and also on X. So thank you so much. And stay tuned because we have more webinars lined up. And I think in just 15 minutes, we're going to have another. So yes, watch out. Immigration and Jobs Talk Show. It's Napasa saying bye for now.